We ask that the United Nations Human Rights Commission send representatives to the United States to interview the political prisoners and prisoners of war, particularly Oscar Lopez Rivera at Marion, Illinois and Alejandrina Torres at MCC San Diego, California, since transferred to Pleasanton Federal Correctional Institution in California, and report on their conditions. We further ask that the Commission establish a committee to review and monitor their prison conditions. 2.7.d. North American Anti-Imperialists and U.S. Government Repression. Elizabeth Fink. 1990. My topic is the North American anti-imperialists, but I should clarify that and say that I will speak about one North American and one European anti-imperialist, because Sylvia Berardini is not a North American. She lived here and carried out her political activities here, but she is European and hopefully in the near future, she will return to Europe. What Safia says is absolutely correct. The vast majority of people in prison are third world people, but there are any number of white people who are political prisoners in the U.S. Once having made that decision and having had the entire wrath of the U.S. on their backs, they face the same conditions that every political prisoner faces. These people made a choice to do what they did. They all have a history of community activism and primarily had a history of support for national liberation struggles. Marilyn Buck, who was a member of the Students for a Democratic Society in the 60s, and editor of New Left Notes, went to San Francisco and became a support person for the Black Panther Party. She received a sentence for purchasing ammunition in the early 70s that she is still serving today in 1990. It is that history that has given her the kind of sentence she has now, which is a ridiculous 70 years. Not only is she already doing 70 years, but she faces another 45 in the Washington resistance case. After it is over, she will have served what they want to give her over 100 years in prison. What they want to do to her and the rest of the resistance people is never let them see the light of day. Marilyn has been in the D.C. jail with the others since her arrest. They occasionally receive recreational periods during the weekend, but they never get to see the sun. These people have not seen the sun for 5 years. Ray Levasseur is another person who never gets to see the sun, because he is imprisoned in Marion. He began his activist career as a mill worker in the mills of Maine, went to Vietnam. After his tour of duty he worked for the Students Organizing Committee in Tennessee and then returned to Maine where he was a member of the Vietnam Veterans Against the War. He did community activism work in Maine and founded an organization called SCAR, which dealt with prison reform. In 1975 he made a decision, along with others, that, based on the repression against him, based on the existence of a death squad in Portland, Maine, he would go underground. He was captured in 1984 and received a 45-year sentence. The government wanted to give him a 105-year sentence, but they did not get what they wanted. Thank you, Ray Levasseur. Many of us have seen Through the Wire. We have seen the pictures of Susan Rosenberg on the picket line when she was only 14. These people have a long history of political activism. Sylvia and I met in December of 1966. At that time, she was an organizer in Madison, Wisconsin, doing anti-war activity. She came to New York, worked in support of the Black Liberation Movement, and found herself in prison. Because, once you align yourself with these kinds of struggles, that is what happens when the wrath of the U.S. government falls on your shoulders. Safia talked about the disparity of sentencing and the enormously long prison terms. This is true for these people as well. The disparity of sentencing between the right wing and the left wing in this country is well known. If you possess 2,000 pounds of dynamite in Pennsylvania and you are a member of the Order of the Posse Comitatus, you are going to do 6 months in jail. If you bomb a series of abortion centers in Florida, and you stand up in court and say, "I'm proud of what I did," you are going to get 5 years and your wife will receive probation. If you do the most outrageous of criminal offenses and you are a member of the right wing, you are going to get out of prison. However, if you are Linda Evans and purchase 3 guns, you can expect a 40-year sentence. If you are found to be in possession of weapons, which under a normal situation will get you 10 years, you will receive 56 years if you are Tim Blunk and Susan Rosenberg. The US will want you to receive the maximum sentence, but how long you actually serve in prison depends on us and the fight that has to be waged. The same thing occurred in Silvia Berardini's case. The circuit court considered her conviction a closed question, and the judge gave her maximum time. She then went to Brooklyn and refused to cooperate with the grand jury investigating the Puerto Rican independence, and the judge added an additional 3 years to her sentence. These people all suffer under the worst conditions of confinement, too, the conditions of political prisoners in America. All of them are primarily in federal custody, although Judy Clark, Kathy Boudin, and David Gilbert are in state custody in New York State. There have been a number of serious struggles that have been waged against the federal government around their custody. One that we must all take some pride in is the fight that we made around Lexington. When you watch the movie Through the Wire, you get the feeling that it was the lawsuit that closed Lexington down. That is a lie. Lexington was closed down by all of you. It was going to be closed down even before we filed that lawsuit. They told us they were going to open another prison in New Mexico. They were going to open another prison in Mariana because they did not want to deal with Lexington. Certainly, the lawsuit pushed them over the line, but we were at the line when we filed that lawsuit. Silvia Berardini was transferred to Mariana 4 days ago, and I have been in contact with her. Because of our campaign against Lexington, Mariana, though it is a terrible prison and we hate it, is not a control unit. It does not have the social and sensory deprivation that Lexington did and that Marion does. Safiyat talked about Marion. I do not want to say any more. It is a nightmare. It is the incarnate of evil. I was there last week. It chills your bones to walk into that place. I saw some people who had traveled from Chicago. They had a 5-month-old baby with them. They would not let them visit because the baby was not on the visitors list. They had driven 9 hours. They were not even going to have a contact visit, but they still would not let that little baby in. These people were crying and the guards just didn't care. The worst thing in prison is to be ill. It is the one thing that everybody hates and, in a political situation, is even worse. A great number of political prisoners have had serious medical problems. Marilyn had a tumor on her neck, which was not treated properly. Sylvia requested to see a gynecologist for 8 months before she was allowed to see a doctor, only to discover that she had contracted cancer of the uterus. She required 2 operations and radiation therapy. Laura, who probably has non-specific non-A, non-B hepatitis, is constantly sick and has not received treatment. However, the most serious case is that of Alan Berkman. Alan Berkman received only a 12-year sentence, and the US government was very upset about that. Alan was diagnosed as having Hodgkin's disease. It was only because he had a judge who was a humane person that he was treated properly. But now, he has suffered a relapse. The government knows he is sick, but instead of transferring him to the Mayo Clinic Hospital in Rochester, the Bureau of Prisons has announced that they are going to transfer him to Marion. Marion, where the water is contaminated, where he will sit in a cell and wait for maybe 3 weeks, even though he has a relapse of cancer, before they send a doctor to examine him. The doctor will sit around, maybe wait a month and a half, maybe 2, and then say, "Oh, well, you have cancer now. We will take you to Springfield." Springfield is a morgue. It is not a hospital. It is a morgue where they put people and kill them. Rather than take him to Rochester, rather than have another judge order that Alan receive medical care and be taken to Georgetown or some hospital, they are going to put him away, lock him up and hope that he dies. Since they were not able to give him the maximum sentence, they want to give him a death sentence instead. The situation with Alan is really critical. We must organize a letter-writing campaign right now and demand that Alan receive proper medical care. We must do everything in our power to prevent the government from murdering Alan, which is exactly what they intend to do. 2.8 Verdict of the International Tribunal on Political Prisoners/Prisoners of War. 1990. Members of the Special International Tribunal. Frank Badohu. Barrister and Solicitor. Javad Bolis. Attorney, Palestine. Lord Anthony Gifford. Barrister in London and a member of the Northern Ireland Bar and Jamaican Bar. Member of the House of Lords, United Kingdom. Norman Peach. Professor of Public International Law and Constitutional Law at the University of Hamburg, Germany. Coordinator. Dr. Luis Nieves Falcon. Jose Roberto Rendon Vasquez. Attorney and Professor. Faculty of Law and Political Science. Universidad Nacional Meyer. de San Marcos, Peru. Selena Romani. Professor of Jurisprudence, Constitutional Law, and Human Rights. City University of New York Law School. Toshiyuki Tanaka. Professor of Political Science at Melbourne University, Australia. George Wald. Professor Emeritus of Biology at Harvard University. Nobel Prize winner for Biology, USA. Special Prosecutors. Lennox S. Hines, ESQ. Jan Sisler, ESQ. Robert Boyle, ESQ. Bruce Ellison, ESQ. Roger Wareham, ESQ. Counsel to the Tribunal. Daniel Nina. Richard Harvey. I. Constitution of the Tribunal. The Special Tribunal on Violations of Human Rights of Political Prisoners and Prisoners of War in United States Prisons and Jails was convened by 88 sponsoring and endorsing organizations from all parts of the United States. The members of the Special Tribunal assumed jurisdiction pursuant to accepted principles of international law approved and adopted by the world community under the United Nations Charter, in accordance with the precedents of the Nuremberg and Tokyo tribunals and following procedures approved by the Economic and Social Council of the United Nations. The tribunal received extensive written and oral evidence from political activists and experts testifying in support of a detailed indictment of the United States government, alleging, inter alia, the denial of the right of peoples in the United States and Puerto Rico to self-determination, the criminalization of the legitimate struggle against illegal acts committed by the government of the United States, the denial of the rule of law to those engaged in such struggles and the use against them of torture, inhuman and degrading treatment. The Special Tribunal does not sit as a court of law but, like the Bertrand Russell tribunals on the U.S. war against the Vietnamese people, this tribunal applies principles of customary international human rights law. Article 38 of the Statutes of the International Court of Justice recognizes the authoritative effect of the findings of such tribunals on contemporary standards of international law. The defendant government and its agencies are bound to respect international human rights law, not least because Article 6 of the Constitution of the United States provides that treaties and other international agreements are the supreme law of the land. Although customary principles of law require petitioners to exhaust the domestic remedies before having recourse to international fora, the overwhelming weight of testimony presented to the tribunal showed that the courts and judicial officers of the United States routinely refuse to allow petitioners to raise defenses based on international law and that relief under the law is routinely denied. Therefore we find that petitioners have in fact exhausted all domestic remedies and that the Special Tribunal is entitled to review all of the cases presented for its consideration. The Tribunal is satisfied that all appropriate steps were taken by petitioners to inform the defendant government and its agencies of the nature and purposes of the Tribunal hearings, including the service of the indictment on President George Bush and other appropriate federal and state officials, and that every opportunity was given to defendants to attend and present testimony. Although defendants failed to avail themselves of the opportunity to testify, many of the documents and expert witnesses indicated fairly the basis of the government's opposition to petitioners' claims, and the tribunal has duly noted defendants' views in reaching its findings. In examining the evidence and reaching its conclusions, the tribunal has taken and employed the following definitions. Self-determination. the right by virtue of which all peoples are entitled freely to determine their political status and to pursue their economic, social, and cultural development. All peoples may, for their own ends, freely dispose of their natural wealth and resources without prejudice to any obligations arising out of international economic cooperation, based upon the principle of mutual benefit and international law. In no case may a people be deprived of its own means of subsistence. Of the International Human Rights Covenants, 1966. Prisoner of war, those combatants struggling against colonial and alien domination and racist regimes captured as prisoners are to be accorded the status of prisoners of war, and their treatment should be in accordance with the provisions of the Geneva Conventions relative to the treatment of prisoners of war, of August 12, 1949. Genocide, any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial or religious groups as such. A. Killing members of the group. B. Causing serious bodily or mental harm to members of the groups. C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D. Imposing measures intended to prevent births within the group. E. Forcibly transferring children of the group to another group. Political prisoner, a person incarcerated for actions carried out in support of legitimate struggles for self-determination or for opposing the illegal policies of the United States government and/or its political subdivisions. 2. Overview. 1990 has been a landmark year in the worldwide campaign for the recognition and freedom of political prisoners. The release of Nelson Mandela, Walter Sisulu, and other anti-apartheid fighters, and the negotiations for the release of all South African political prisoners, have shown that even the most repressive and intransigent regimes must at some point acknowledge the existence of political prisoners and account for their treatment and continuing imprisonment. For decades the South African government denied the existence of political prisoners, branding imprisoned anti-apartheid fighters as criminals and terrorists. However, the growing liberation struggle of the people of South Africa and worldwide solidarity forced the government of South Africa to abandon this farcical denial of political prisoners. Similarly, the triumph of the liberation struggle of the Namibian people led by SWAPO resulted in the independence and self-determination of Namibia, constituting a resounding affirmation of customary principles of international human rights law. Ironically, the U.S. government has expressed strong support, albeit selective, for the freeing of political prisoners throughout the world. At the same time, however, the U.S. government vociferously denies the existence of political prisoners at home and resolutely echoes a familiar refrain that those who claim to be political prisoners and prisoners of war are simply terrorists and criminals. This tribunal presents a unique and important opportunity to review carefully petitioners' contention that the U.S. does indeed hold political prisoners and prisoners of war. The tribunal members have approached this responsibility with the utmost of seriousness and careful scrutiny. The U.S. government must be held to the same standard of international law and human rights safeguards that it subscribes to for the other nations of the world. The denial of the existence of political prisoners and the consequent failure to afford such prisoners the fundamental protections of humanitarian international law constitute serious violations of human rights which, if found to be true, would require the immediate attention of world public opinion and rectification by the U.S. government. Numerous supporting documents which are delineated in the appendix were also submitted. Of particular interest were documents of the counterintelligence program of the U.S. Federal Bureau of Investigation showing its program to disrupt and neutralize leaders and organizations of the African American, Puerto Rican, Mexicano, Chicano and Native American self-determination struggles. As we will spell out in more detail in the body of this document, the tribunal finds that the U.S. judicial system has been used in a harsh and discriminatory manner against people struggling for self-determination within its borders and Puerto Rico, as well as against other political opponents of the U.S. government. Some have been falsely accused and had evidence favorable to their defense destroyed or suppressed. Others have been tried on overbroad conspiracy charges which rely on associations and beliefs as an essential element, and many have been tried in an armed camp atmosphere saturated with prejudicial publicity designed to intimidate and prejudice the juries before whom they were tried. Most of the petitioners have also received draconian disproportionate sentences and have been subjected to torture, cruel, discriminatory and degrading punishment. We also find that the Black and Mexican people living within the borders of the United States and Native American and Puerto Rican people have the fundamental right to exercise self-determination and to seek and receive support from other opponents of repression, and that the U.S. government has carried out a consistent pattern and policy of repression against these peoples, their leaders, and supporters. We further find that captured combatants in a legitimate national liberation movement are entitled to the special protected status of prisoner of war and should not be tried and imprisoned by the U.S. government as criminals. Rather, these captured national liberation fighters must be held separately under conditions in accordance with the Geneva Convention and immediate steps taken to transfer these combatants to neutral countries until all hostilities cease between their movements and the U.S. government. We are mindful that the U.S. judicial system is promoted by many here and throughout the world as one of the most progressive and protective of individual rights. The claim that the U.S. does not have political prisoners has gone generally unchallenged. We believe that the evidence presented at the tribunal overwhelmingly established the opposite case. The U.S. government uses its judicial system to repress the legitimate political movements opposing the government. It is of critical importance for the international human rights community as well as all freedom-loving people to bring to world attention the plight of U.S. political prisoners. 3. The right to self-determination. Over the last 30 years, since the passage in 1960 of the historic United Nations General Assembly Declaration on the Granting of Independence to Colonial Countries and Peoples, which called for the speedy and unconditional end to colonialism in all its forms and manifestations, the right to self-determination has evolved to a peremptory norm of international law, a norm accepted and recognized by the international community of states as a whole, from which no derogation is permitted. Of particular importance to the codification of this fundamental right is the Universal Declaration of the Rights of People, which affirms that the peoples of the world have an equal right to liberty, the right to free themselves from any foreign interference and to choose their own government, the right, if they are under subjection, to fight for their liberation. This assurance is specified in Article 1, every people has the right to existence, and Article 6, every people has the right to break free from any colonial or foreign domination, whether direct or indirect, and from any racist regime. In addition, UN Resolution 2625, known as the Declaration on the Principles of International Law Concerning Friendly Relations and Cooperation among States in accordance with the Charter of the United Nations, adopted by consensus in 1970, provides authoritative clarity to the character and importance of the right to self-determination. Its preamble affirms that the principle of equal rights and self-determination of peoples constitutes a significant contribution to contemporary law, and its effective application is of paramount importance for the promotion of friendly relations among states. The Declaration mandates that every state has a duty to promote the principle of self-determination and to assist the United Nations in its realization so as to improve relations among states and to bring a speedy end to colonialism, having due regard to the freely expressed will of the peoples concerned. The right of self-determination as a peremptory norm of international law has been confirmed by the International Court of Justice in its advisory opinion on Namibia and in its decision in the Western Sahara case. As the Vienna Convention on the Law of Treaties provides, a peremptory norm of international law cannot be abridged or superseded by any act of sovereign will, including a treaty. Finally, the two international covenants on human rights are initiated by a common Article 1 indicating a place of primacy for self-determination. All peoples have the right of self-determination. By virtue of that right they freely determine their political status and freely pursue their economic, social, and cultural development. The tribunal heard evidence by Puerto Rican, Native American, Black, and Mexicano witnesses of their people's national development, characteristics, and continuing history of oppression. Witnesses also testified to the long train of repression against the organizations and leaders of their people. Each of these peoples satisfies the objective and subjective criteria for self-determination. Each perceives themselves as separate people and each suffers special targeting and oppression by the U.S. government. 3. 1. Native Americans. This tribunal received ample evidence on the history of the Native American people's struggle for their right to self-determination and on the genocide committed against this people by the United States government. The history of European and Native American relations reveals theft of 99% of the land base and genocidal practices of war, disease, alcohol, starvation, and deculturalization, which reduced the indigenous population from approximately 12.5 million to less than 227,000 by 1890. Meeting substantial resistance, if not outright defeat, at times seeking alliances against others, what became the United States government entered into some 371 treaties with the indigenous people of North America during the 18th and 19th centuries. The importance of these treaties was embodied in Article 6 of the U.S. Constitution as the supreme law of the land. By this principle, the United States government has incorporated into its domestic law the content of the treaties signed with the Native American people. However, as was pointed out consistently in the evidence presented to the tribunal, the U.S. government has systematically violated or refused to respect the terms of the agreements reached with the Native American people. Therefore, this tribunal recognizes that, first, the Native Americans constitute a people within international law definitions who are carrying out a struggle for self-determination. Moreover, this tribunal takes notice that, despite all the treaties signed by the U.S. government with the Native American peoples, the U.S. has consistently denied those treaty rights to these peoples. In decisions of the U.S. Supreme Court such as Cherokee Nation v. Georgia, 30 U.S. 5 Pet 1 and Worcester v. Georgia, 31 U.S. 6 Pet 515, the court established the principle that Native American people are domestic and dependent on the U.S. government, thus denying their right to self-determination. After these two Supreme Court decisions, the so-called plenary power doctrine was initiated by the U.S. government, which denied the right of the Native American people to organize and govern themselves. This, for example, is the pattern followed by the enactment in 1924 of the U.S. Congress's Indian Citizenship Act. Through this act, U.S. citizenship was imposed upon the Native American people. In addition, in 1934 the U.S. Congress enacted the Indian Reorganization Act, by which the U.S. government decided to organize tribal councils to resemble corporate boards. The intention behind this was to reduce the autonomy of the Native American peoples to govern their own affairs. Thus, this tribunal, after carefully hearing various witnesses and taking judicial notice of many historical aspects of U.S. government policies toward the Native American peoples, considers that the practices of the U.S. government are in breach of Common Article 1 of the United Nations International Covenants of 1966, guaranteeing, amongst other things, the right of the people to self-determination. Second, this tribunal considers that the U.S. government has also conducted a policy of genocide against these people. The tribunal follows the definition of genocide as established by Article 2 of the Convention on the Prevention and Punishment of the Crime of Genocide, 1948. This tribunal recognizes the most cruel policies occurred in the early years of the U.S. Republic, when a plan of physical extermination was conducted against the Native American people. After failing to completely exterminate them, a new policy was designed to impose compulsory assimilation, so as to destroy the history and culture of the Native American people. Tactics employed to achieve this end include the criminalization of Native religious practices, forced transfer of children through mandatory indoctrination at boarding schools for extended periods, adoption by non-Indians, enactment of laws designed to destroy traditional culture, example by prohibiting the holding of land in common. Implementation of policies such as termination and relocation were combined by the U.S. government with declarations that certain groups of living peoples were extinct. Systematic involuntary and uninformed sterilization of Native American women has compounded these genocidal policies, as has the use of the blood quantum method of identification to statistically manipulate out of existence certain groups of Native Americans. Native Americans are the poorest population group in North America, with the highest incidence of infant mortality, death by exposure, tuberculosis, plague disease, malnutrition, and teen suicide. The average life expectancy of an American Indian male is 44.6 years, and for females it is less than 3 years longer. For white males the figure is 74 years. The policy of genocide has been legitimized by different laws approved by the U.S. Congress. For example, the General Allotment Act used to deprive the Native American people of the land that they consider common and sacred. In addition, this tribunal has taken notice of documents that proved the collaboration by the Bureau of Indian Affairs during the 1970s, together with the Indian Health Service, in the systematic performance of involuntary sterilization on Native women. This particular practice, in conjunction with other practices of the U.S. government, clearly manifests a pattern of committing genocide against the Native American people. 3. Puerto Ricans. Of the four peoples represented before the tribunal, the right to self-determination for the people of Puerto Rico is the clearest and most recognized by the international community. With a separate territory, language, and culture, the plight of Puerto Rico constitutes one of the last remaining classic colonial cases in the world. Beginning in 1973 and 1976 and then in each succeeding year, the United Nations Special Committee on Decolonization has reviewed the case of Puerto Rico, reaffirmed the right of the Puerto Rican people to self-determination and called upon the United States to stop all interference with the free and full exercise of that right. The U.S. has refused to follow these mandates and has consistently used all its coercive powers to block the case of Puerto Rico from being considered by the entire General Assembly. The Decolonization Committee resolutions, plus pronouncements from the non-aligned countries and the International Association of Democratic Lawyers, provide authoritative support for Puerto Rico's right to self-determination. Even the President of the United States, George Bush, in his recent call for a referendum on the island's status, has acknowledged that the Puerto Rican people have not chosen freely their present relationship with the U.S. This tribunal also adopts the findings and verdict of the Permanent People's Tribunal on Puerto Rico, which declared in part that Puerto Rico and its people have the right to freely determine their political, economic, social, and cultural condition in accordance with the Algiers Declaration and the principles of international law. That the Constitution of the Commonwealth of Puerto Rico is not the proper way for the Puerto Rican people to exercise their self-determination right, whereas in the referenda which have been carried out on the island, the required guarantees which govern the true exercise of said right, in accordance with the resolutions of the UN, have not been observed. That the U.S. has an international duty to respect the right of Puerto Rico to its self-determination, in accordance with the obligations it has conventionally and customarily assumed. Regrettably, the United States government refused to participate in the Barcelona Tribunal and has ignored its findings. As clear as the Puerto Rican people's right to self-determination is the historical record that such right has been denied to that people. Testimony established a military, political, psychological, economic, ideological, cultural, and linguistic domination by U.S. colonial power over Puerto Rico since the beginning of the U.S. invasion and occupation. The evidence also was compelling as to the use of repression against the National Movement for Independence, its leaders and organizations. The Nationalist Party and its supporters were fiercely repressed in the 1930s and again in the 1950s when a mass resistance to U.S. attempts to eliminate the independence movement resulted in the killing and arrest of hundreds of people. Today that repression continues. 17 prisoners of war or political prisoners are serving draconian sentences, exiled from their homeland to jails in the United States. The FBI and the grand jury system are used to investigate, intimidate, and intern independence activists and supporters. Thousands of others have been placed under surveillance and on subversive lists for their pro-independence sentiments. Presently 9 more independence activists and leaders face conspiracy charges in Hartford, Connecticut, hundreds of miles from their homeland. It should also be noted that some of the colonial conditions imposed on the people of Puerto Rico have genocidal characteristics. These include the forced sterilization of 33% of Puerto Rican women of childbearing age, the economically forced migration to the United States of 1/2 of Puerto Rico's population, the consequent deculturalization of the population, and one of the world's highest rates of suicide, drug abuse, and mental illness. We again quote from the verdict of the Barcelona Tribunal as to the obligation of the U.S. government to Acknowledge the political prisoner status of those Puerto Ricans incarcerated due to their work and militancy in favor of Puerto Rico's independence, and to grant a general amnesty to all Puerto Ricans currently incarcerated because of their involvement in the struggle against colonialism. Relinquish the current powers the U.S. Congress has to amend and approve the decisions made by the representative bodies and government of Puerto Rico. Completely transfer any power the U.S. Congress or the U.S. government may have over Puerto Rico, to a deliberative body with constitutional character, made up of representatives from all the political and social forces of Puerto Rico chosen on an equal elective basis. Negotiate such measures, as a transitional status of the juridical and political condition of Puerto Rico, until the self-determination right is effectively exercised. We further call upon the United States government to accord prisoner of war status to those Puerto Rican prisoners captured as anti-colonial combatants. 3.3. Black people in the United States. It is an uncontested historical fact that Africans, forcibly brought to the area which would become the United States, came from various tribes and regions of Africa. In addition, these kidnapped Africans spoke many tongues and were forged into a new and distinct people, with distinct problems, requiring unique solutions, during the 3-century ordeal of chattel slavery. It is also historically documented that these Africans and their descendants were considered 3/5 of a human being, thereby necessitating an elaborate system of laws, cultural norms, and religious canons to deprive people of African descent of their rights as human beings and, by extension, to deprive them of their right to self-determination. In 1865, at the end of the U.S. Civil War, the U.S. government abolished slavery, freeing the kidnapped African slaves. Rather than allowing this freed people to choose or reject citizenship and to freely exercise the right to self-determination, the 14th Amendment imposed citizenship upon them, as the Jones Act of 1917 would later do to Puerto Ricans and as the Indian Citizenship Act did to the Native Americans in 1924. There have been various strategies, necessitated by a system of white supremacy, pursued by black organizations in the United States in their efforts to obtain freedom and justice for their people. The main strategies at work today within the black movement are the struggle for independent political power, forms of community control and autonomy, and some groups who advocate independence of the new African nation. UN General Assembly Resolution 2625 expresses the options available to a people entitled to exercise the right to self-determination. The establishment of a sovereign and independent state, the free association or integration with an independent state, or the emergence of any other political status freely determined by a people, constitute modes of implementing the right of self-determination by that people. Whichever strategy prevails that brings about genuine self-determination is for black people in the United States to decide. However, it is clear that the black people of the U.S. have not been allowed to freely exercise their right to self-determination. The evidence overwhelmingly established an unbroken pattern of repression against black organizations and activists fighting for their human, political, economic, and civil rights. While the tribunal recognizes that the right of self-determination for black people in the U.S. has not previously been established by international bodies or tribunals, we do not feel that this lack of precedent is determinative of the issue. Rather, this tribunal believes that the evidence presented before us strongly supports the claim that black people living within the borders of the United States are a distinct people entitled to self-determination. Equally compelling is the evidence that black people in the U.S. have been forcibly denied the freedom to exercise that right. From the inhuman outrage of slavery up to the present circumstance of attacks on community and political organizations, black people in the United States have never been given the opportunity to choose their destiny. The documents submitted which establish this conclusion are the FBI counterintelligence program and the testimony on the targeting and repression of the Black Panther Party, Republic of New Africa, Student Nonviolent Coordinating Committee, Southern Christian Leadership Conference, the MOVE organization and the Black Men's Movement Against Crack. The evidence also established that the Ku Klux Klan and other white supremacist hate groups functioned with impunity and often with the complicity of the government in committing acts of violence and intimidation against the black community. The history and treatment of black people in the United States also supports a claim that the U.S. government is guilty of the crime of genocide against the black people. There is no question that during the kidnapping of Africans in the slave trade, and in the barbaric Middle Passage to North America, millions of blacks were killed. In addition, during the more than 200 years of chattel slavery, black people were wantonly murdered, savagely brutalized, and denied all basic human rights. The condition of black people living in the United States today strongly suggests that policies of the U.S. government are designed to lead to the elimination of black people. The tribunal was presented with evidence that 1. The infant mortality rate for black people is double that for whites. 2. Black women, regardless of class, are twice as likely to bear low-weight babies than white women. 3. The gap in life expectancy rates between blacks and whites has recently widened from 5.6 to 6.2 years, and blacks today have a life expectancy already reached by whites in the 1950s, or a lag of about 30 years. 4. The rate of survival for black males over 40 years old in Harlem, New York City, is lower than for men in Bangladesh. 5. Dangerously high blood pressure is a hidden cost of racial prejudice, at least for some blacks. 6. In New York City, increasingly large numbers of women of childbearing age are dying, combined with the deaths of men in the same age group. The result is the destruction of families and the orphaning of tens of thousands of children, most in low-income African American neighborhoods. 7. AIDS is more and more becoming a disease of poor, black, and Hispanic heterosexuals in the inner city. It is the leading killer of black women in the 15 to 44 year age group in New York and New Jersey. 8. Unemployment for blacks is double the rate for whites, and nearly 50% of black teenagers are unable to find work. 9. White families earn 45.5% more than black families. 3. For Mexican people living in the United States. Mexican people living in the north of their country came under the authority of the U.S. government after the Mexican-American War of 1841, a war generally recognized as expansionist and unjust, and which deprived Mexico of 50% of its territory. After the conquest and occupation, there was a continuing policy of brutal repression and exploitation of Mexican people throughout the occupied territories, including numerous lynchings and other killings. Mexicano people organized resistance to, and have fought against, this occupation. Among the most famous Mexicano resistance fighters are Tiburcio Vázquez, Joaquín Murrieta, and the Cortés and Espinosa brothers. Also, Juan Nepomuceno Cortina from Texas, who for 15 years waged guerrilla warfare against the U.S. government. Armed clandestine organizations also emerged like La Mano Negra and Las Gorras Blancas. In 1915, the Plan de San Diego was another armed uprising calling for self-determination and independence of the occupied territories. It was violently repressed. Armed rangers and other law enforcement agencies that formed in California, New Mexico, Texas, and Arizona were essentially private vigilantes organized to repress Mexicanos with the consent of the U.S. government. Between 1915 and 1920, about 5,000 Mexicanos were killed along the border by the Texas Rangers, who have also been used to police migratory labor, striking unions, civil rights activists and organizations, and to beat up Mexicano-Chicano candidates running for elected positions. The FBI and grand jury have been used to repress the Mexicano-Chicano resistance movement. Beginning in the late 1930s, the FBI has consistently investigated and monitored Mexicano-Chicano organizations such as LULAC, the GI Forum, the Asociación Nacional Mexico-Americano. In the 1950s, the FBI created the Border Coverage Program as part of COINTELPRO. It maintained offices both in the occupied territories and Mexico. Additionally, the Border Patrol and the Immigration and Naturalization Service are special police agencies created primarily to be used against the Mexicano people. All these repressive actions are supplemented by the terrorist activities of the Ku Klux Klan against Mexicanos/Chicanos. The homes of Mexicano/Chicano resistance fighters have been bombed and many have been killed. Among the latter are Ricardo Falcon, Rito Canales, Antonio Cordova, and Lo Cista Boulder. The tribunal heard that a United States border separates the Mexicano/Chicano people and that since the 1850s Los Rinches, a police terror force, have killed 20,000 Mexicanos/Chicanos. There have also been countless lynchings by North Americans. There is a high incidence of poverty, malnutrition, and a proliferation of drugs. Not only is there a high rate of premature births, but although Mexicanos/Chicanos comprise 8% of the U.S. population, 25% of all pediatric AIDS cases are found among Mexican/Chicano children. Overall, there is a grossly disproportionate incidence of AIDS infection compared with the general population. Mexicanos/Chicanos have also been subjected to a policy of cultural assimilation, principally directed toward their Spanish language. The issue has become more acute with the newly imposed legislation compelling the use of the English language only and forbidding the use of Spanish in all official activities, including schooling of Mexicano children. The tribunal recognizes the claim that the Mexicano/Chicano people living within the borders of the United States are a people entitled to exercise their right to self-determination. 4 Puerto Rican prisoners of war. Among the petitioners are 13 Puerto Rican women and men, most of whom have been held in U.S. prisons since 1980. They are serving literal life sentences for their involvement with the clandestine Puerto Rican Independence Liberation Group, Fuerzas Armadas de Liberación Nacional. They are combatants in a struggle against colonialism and for national liberation in accordance with Article I, Paragraph 4, of Additional Protocol I to the 1949 Geneva Conventions, extending POW protections to include armed conflicts in which peoples are fighting against colonial domination and alien occupation and against racist regimes, in the exercise of their right of self-determination. Pursuant to the resolutions of the United Nations General Assembly on the Rights of Colonial People and the Legal Status of Combatants Struggling Against Colonial and Alien Domination of Racist Regimes, which provides that combatants struggling against colonialism are to be accorded the status of prisoners of war and their treatment should be in accordance with the Geneva Convention, these Puerto Rican combatants are entitled to be treated as prisoners of war. The U.S. has refused POW status to these anti-colonial fighters, claiming that it is not a signatory to the additional protocols. This refusal to accept universally recognized humanitarian protections for peoples fighting colonialism, apartheid, and alien domination should not and does not preclude the according of these protections. Colonialism has been identified as a crime for over 3 decades. The UN General Assembly has consistently asserted that colonized and dependent people have the right to use all means available, including armed struggle, to resist colonialism. And, since the General Assembly Resolution 3103 was passed in 1973, captured anti-colonialism combatants have been entitled to POW status. This protected status for people fighting colonialism is specifically designed to assist the customary international law right to self-determination and to deter the colonial power from perpetuating the crime of colonialism. The expansion of the definition of international conflicts in the additional protocols to the Geneva Convention, to include those struggling for national liberation, also constituted recognition by the international community that the protection of anti-colonial fighters was to be elevated to a customary norm of international law. Clearly today, if not in 1977 when the additional protocols were first enacted, now that colonialism has been universally condemned and almost eradicated from the world, those who fight against colonialism are entitled to special protection and should not be criminalized by the colonial power. We find, therefore, that Puerto Rican combatants who have asserted their right to POW status are entitled not to be tried in the U.S. courts but to be protected under the Geneva Convention. We believe that these prisoners who have been illegally incarcerated and criminalized for over 10 years should be unconditionally released or at the very least, transferred to a neutral country. Certain other petitioners who are people struggling for self-determination for Black people in the United States and Native American people have also asserted the right to be considered as prisoners of war. We believe that these claims have merit as these are peoples fighting against alien occupation or racist regimes. However, the evidence before the tribunal does not allow us to reach a definitive conclusion at this time, and we recommend that there be further investigation into these claims. v. White North American opponents of United States government policies. Testimony was presented on behalf of white North Americans who have been imprisoned for protesting U.S. foreign and domestic policies and against militarism, war, and nuclear armaments. The actions of these petitioners have taken a variety of forms, from symbolic acts of sabotage of weapons of war by the Plowshares Group, to armed actions against U.S. military or corporate targets supporting apartheid and intervention in Central America. The petitioners involved in these activities share a common belief that it is their responsibility as citizens of the United States to engage in acts of resistance intended to prevent or impede ongoing criminal activity in the conduct of the policies of the U.S. government. At the trials of these petitioners, United States courts have routinely denied them the opportunity to present a defense based upon a citizen's right to resist illegal state conduct and based upon their religious and/or political motivations. The tribunal heard from an expert witness on international law that these defenses are well grounded in the First Amendment to the United States Constitution as well as the Tokyo and Nuremberg war crimes tribunals. We conclude that the United States government has criminalized and imprisoned white North Americans who have struggled in solidarity with national liberation movements and other peoples struggling for self-determination, for peace and against nuclear armaments and against racism, sexism, and other forms of discrimination. 6. Criminalization and denial of the rule of law. Whereas it is essential, if man is not to be compelled to have recourse, as a last resort, to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. Preamble to the Universal Declaration of Human Rights. December 10, 1948. It is a violation of international law for a state to attempt to criminalize the struggle of peoples to achieve self-determination. According to the authoritative United Nations Resolution 2625 of 1970, every state has the duty to refrain from any forcible action which deprives peoples of their right to self-determination and freedom and independence, and Resolutions 3322 and 3324, which condemn the imprisonment and detention of people fighting colonialism. We have heard testimony of the development of a system of repression in the United States which uses the courts and judicial system as a key element to deny people's rights to self-determination and to disrupt people organizing to oppose illegal U.S. government policies. The evidence shows that the U.S. government is using a strategy which parallels certain other states confronting insurgent movements, through the creation of repressive and anti-democratic modifications to the legal system aimed at the suppression of radical political opposition. This counterinsurgency strategy allows for the enhancement of the power of law enforcement to surveil and infiltrate political groups as well as to coerce cooperation with police investigations and to criminalize political association. The testimony showed that federal agents are authorized to spy on and infiltrate political, community and religious groups, and substantial evidence was received of such activity. In addition, the tribunal was informed of the use of highly sophisticated electronic technology to carry out video and audio surveillance at the homes and workplaces of members and supporters of the Puerto Rican Liberation Movement. Additionally, litigation in Puerto Rico has recently revealed the existence of more than 100,000 dossiers collected by the police on activists and supporters of the cause of independence who have been labeled subversives by the police because of their legitimate desire and work to end colonization. The FBI also uses an internment power through the federal grand jury to force cooperation with investigations into political activities under pain of imprisonment for refusal. The grand jury, a secret proceeding under the direction and control of the government, is used as a tool to intern political people. The government issues subpoenas to a secret hearing where there is no judge and where defense counsel is barred from attending. The coerced witness can be stripped of his/her fundamental right to remain silent and forced to answer all questions about political associations and activities. A refusal to appear or answer results in civil contempt penalties of up to 18 months or criminal contempt, which has no maximum limit of sentence. Scores of activists in political movements have been imprisoned over the last 15 years through this process. The government has even resubpoenaed activists who have already served time in prison for refusing to collaborate with grand juries, in full knowledge that the person has not collaborated and will not do so in future. This effectively constitutes internment without trial or just cause. Political activists are often charged with violations of broad conspiracy laws which rely on evidence of political associations and beliefs to prove criminal agreements. Two special statutes, Seditious Conspiracy and the Racketeer-Influenced Corrupt Organizations Act, specifically allow for the criminalization of membership in political organizations and national liberation movements. These statutes have been used to incarcerate political activists with lengthy sentences. The seditious conspiracy law specifically criminalizes opposition to U.S. governmental authority and has been used particularly against the Puerto Rican independence movement to criminalize its resistance to colonialism. Under this law, a mere agreement to oppose U.S. authority with force, without proof of any act taken in furtherance of that agreement, is subject to a 20-year sentence. Political prisoners in the U.S. are also victims of false charges and prosecutions in which evidence favorable to the accused is deliberately suppressed. The tribunal was presented with evidence of three particularly serious cases: Geronimo G. Jagaprat, Leonard Peltier, and Doraba bin Wahad, in which the government deliberately destroyed and concealed evidence which would have established their innocence. Those charged with politically motivated offenses are frequently held in preventive detention. Specifically, the evidence showed that the U.S. government's use of the Bail Reform Act of 1984 violates international law by designating as dangerous to the community persons who struggle for self-determination. This statute enables the government to jail its opponents for years without trial by means of indefinite preventive detention, thus denying the right to speedy trial or to release pending trial. When the FBI arrested 15 Puerto Rican independentists on August 30, 1985, the government invoked this law to detain every accused. In spite of the community's clamor for these activists to be released, the courts found almost all of those arrested to be a danger to the community and held them under punitive isolation for periods between 18 months to almost 4 years without trial. The last to be released, Filiberto Ojeda Rios, who had triple bypass open heart surgery, was released only because the U.S. courts held that his lengthy pretrial custody had become an embarrassment to U.S. democracy. Ojeda was retained for another year within 3 months of his release, as a result of a 3-year-old charge arising out of his original arrest. Excessive pretrial detention violates international law provisions Article 2 of the Universal Declaration of Human Rights and Article 9 of the International Covenant on Civil and Political Rights, as well as Article 8 of the American Convention on Human Rights, 1969. The tribunal also received evidence of a series of repressive measures employed in political trials. Of particular concern was the evidence indicating a deliberate attack by the U.S. government on the independence and impartiality of the trial jury. The media have been used to poison attitudes in the community from which that jury will be selected. Just as disturbing is the use of anonymous trial juries. Under the latter system, by declaring the necessity to keep jurors' identities secret, those same jurors are inevitably prejudiced into believing that they have cause to fear the political defendants. This fear is further exacerbated by the intentional and excessive militarization of courtroom security employed to turn political trial courts into armed encampments. The tribunal was informed of the use of multiple metal detectors, concrete bunkers, armed marshals, sharpshooters on roofs adjacent to courthouses and, in one case, the erection of a special bulletproof glass partition to separate the accused from the public. The tribunal also heard that trial venues are manipulated, particularly in the case of Puerto Rican activists, to deny them a trial in their homeland by their peers. Also, politically accused persons are routinely denied the right to present a full defense, including issues of necessity and justification under international law. The use of the judicial system to repress political activists violates Articles 6, 7, 8, 9, and 10 of the Universal Declaration of Human Rights and Articles 9 and 14 of the International Covenant on Civil and Political Rights. Such conduct further violates Article 5 of the International Convention on the Elimination of All Forms of Racial Discrimination, 1966. We find most disturbing that the U.S. government continues to incarcerate certain petitioners despite documentary and other proof, disclosed after conviction, conclusively establishing that they did not commit the offenses for which they have been tried. Excessive and inhumane sentences. The evidence showed that the United States government metes out the longest sentences of any country in the world to its political prisoners. Such excessive and disproportionate sentences imposed on persons active in self-determination struggles and in support of those struggles constitute torture, inhuman and degrading treatment in violation of Article 1 of UN Resolution 3452, the Declaration on Protection from Torture, 1975. Most of the political prisoners and prisoners of war are serving the equivalent of natural life in prison. The Puerto Rican POWs, many of whom have already spent more than 10 years in prison, have sentences averaging 67 years. The judge who sentenced them stated that he would have given them the death penalty if it had been within his power. Mumia Abu Jamal currently sits on Pennsylvania's death row under sentence of death. Leonard Peltier has served over 13 years of 2 consecutive life sentences. Sundiata Akalai is serving life plus 30 years. Herman Bell, Na Washington, and Jalil Bottom are each serving 25 years to life. Evidence was presented demonstrating that the political beliefs of petitioners have been used as a basis to impose, in many instances, sentences of life imprisonment. Moreover, it is clear that the sentences imposed upon petitioners are grossly disproportionate to sanctions imposed upon members of right-wing and/or racist organizations convicted of similar offenses. For example, an assassin of Chilean diplomat Orlando Letelier was permitted in a plea agreement, wherein most charges were dropped, to receive a sentence of 12 years. Conversely, petitioner Yuki Kumura, arrested with 3 pipe bombs in his car, was charged with 12 separate offenses and received an aggregate sentence of 30 years. In 1986, a man convicted for planning and carrying out bombings, without making warning calls, of 10 occupied health clinics where abortions were performed received a sentence of 10 years and was paroled after 46 months. By contrast, petitioner Raymond Levasseur was convicted of bombing 4 unoccupied military targets in protest against U.S. foreign policies and received a total sentence of 45 years. Another acknowledged abortion clinic bomber received 7 years following his arrest in possession of over 100 pounds of explosives in a populous Manhattan apartment building. Petitioners Tim Blunk and Susan Rosenberg, charged with possession of explosives in a storage facility, each received sentences of 58 years. A Ku Klux Klansman, charged with violations of the Neutrality Act and with possessing a boatload of explosives and weapons to be used in an invasion of Dominica, received an 8-year sentence. Petitioner Linda Evans was convicted of purchasing 4 weapons with false identification and was sentenced to 40 years, the longest sentence ever imposed for this offense in U.S. history. The evidence also established that petitioners have been denied parole as a penalty for refusing to renounce their political beliefs and associations. 7. Torture and cruel, inhuman, and degrading treatment. As part of the system of repression in the United States, we heard testimony that the government uses the prisons as a key element in its efforts to deny peoples the right to exercise self-determination and disrupt people organizing to oppose U.S. policies. The evidence established that the defendants use political beliefs and associations as a basis for classification and placement in highly punitive and restrictive isolation units. The testimony of Dr. Stuart Gratian, a psychiatric expert on the serious and harmful effects of long-term isolation and solitary confinement, made a profound impression on the tribunal. Evidence was also received which showed that in the early 1960s the U.S. prisons adopted a policy to put into effect brainwashing practices to modify the behavior of political prisoners and resistors. Further, with full knowledge that conditions of solitary confinement, small group isolation, and restricted sensory stimulation cause adverse psychopathological effects, the evidence also showed that the defendants have created and maintained prisons and control units embodying these conditions, such as the U.S. Federal Penitentiary at Marion, Illinois, the Women's High Security Unit at Lexington, Kentucky, and New York State's Shawangunk Correctional Facility. The U.S. Penitentiary at Marion, condemned by Amnesty International as violating virtually every one of the United Nations standard minimum rules for the treatment of prisoners, holds more political prisoners and prisoners of war than any other prison in the United States. Prison officials place political prisoners at Marion and retain them there for years although they do not meet the stated criteria for assignment there. A U.S. court which found the conditions at Marion to pass constitutional muster was nonetheless forced to describe them as sordid and depressing in the extreme. Locked in their cells over 22 hours daily, the prisoners at Marion are denied meaningful human interaction and essential sensory stimulation. Their visits are non-contact through glass, and they are required to submit to a strip search before and after visits. Their only source of drinking water is contaminated with carcinogenic chloroform and is reliably suspected of containing dangerous levels of toxins. The Women's High Security Unit at Lexington, Kentucky, which was closed in 1988 as the result of a national and international human rights campaign, was also condemned by Amnesty International, which found that the Federal Bureau of Prisons deliberately placed political prisoners there in cruel, inhuman, and degrading conditions because of their political beliefs. The conditions included 2 years of isolation in subterranean cells, daily strip searches, sleep deprivation, and denial of privacy to the extent that male guards were able to observe the women bathing. Expert medical testimony demonstrated that the conditions were calculated to destroy the women psychologically and physically. We find that the defendants place political prisoners and prisoners of war in such prisons, and under such conditions, as part of their efforts to destroy them and to repress the struggles which they represent. The evidence showed that in addition to the use of isolation in control unit prisons, the defendants also use other prison conditions as a means of breaking political prisoners and prisoners of war. These conditions include assassination, torture, sexual assault, strip and cavity searches, including such searches by male staff on women prisoners, punitive transfers, false accusations of violating prison rules, censorship, denial of religious worship, harassment of families, limitation of visits, and denial of necessary medical care. Several political prisoners with cancer have been subjected to lengthy and punitive delays in diagnosis and treatment. Alan Berkman, suffering from Hodgkin's disease, has nearly died several times because prison officials have withheld necessary medical treatment and refused to place him in an appropriate medical facility. Kawesi Balagoon, suffering with AIDS, was not diagnosed until 10 days before his death. Sylvia Beraldini's palpable abdominal lumps were ignored for months, only to reveal that she had an aggressive form of uterine cancer. The evidence also showed that the courts of the U.S. have consistently condoned and sanctioned the application of such punitive and harmful conditions and their application to political prisoners and prisoners of war. We find that the defendants' treatment of political prisoners and prisoners of war constitutes torture, cruel, inhuman and degrading treatment in violation of Article 6 the Universal Declaration of Human Rights and contravenes most of the United Nations standard minimum rules for the treatment of prisoners. The U.S. government is also in breach of the First, 8th, and 14th Amendments to the Constitution of the United States and their equivalent provisions in the various state constitutions, the Declaration on the Protection of All Persons from being subjected to torture and other cruel, inhuman, or degrading treatment or punishment, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, the International Covenant on Civil and Political Rights, the American Declaration of Human Rights, and the Geneva Convention and the protocols thereto. Verdict. Based on the factual and legal foundations stated above, the Special Tribunal declares: 1. Within the prisons and jails of the United States exist substantial numbers of political prisoners and prisoners of war. 2. These prisoners have been incarcerated for their opposition to U.S. government policies and actions that are illegal under domestic and international law, including the denial of the right to self-determination, and resistance to genocide, colonialism, racism, and militarism. 3. The U.S. government criminalizes and imprisons persons involved in the struggles for self-determination of Native Americans, Puerto Ricans, and Black and Mexicano-Chicano activists within the borders of the United States. 4. Those peoples legitimately struggling for national liberation are not to be treated as criminals, but must be afforded the status of prisoners of war under the Additional Protocol I to the Geneva Convention. 5. The U.S. government also criminalizes and imprisons white North Americans and others who have worked in solidarity with struggles for self-determination as well as for peace and against nuclear arms, against racism, sexism, and other forms of discrimination. 6. The criminal justice system of the U.S. is being used in a harsh and discriminatory way against political activists in the U.S. 7. The use of surveillance, infiltration, grand juries, preventive detention, politically motivated criminal conspiracy charges, prejudicial security, and anonymous trial juries deprive political activists of fair trials guaranteed under domestic and international law. 8. Political people have been subjected to disproportionately lengthy prison sentences and to torture, cruel, inhumane and degrading treatment within the U.S. prison system. Further, the tribunal calls on the U.S. government to 1. Release all prisoners who have been incarcerated for the legitimate exercise of their rights of self-determination or in opposition to U.S. policies and practices illegal under international law. 2. Cease all acts of interference and repression against political movements struggling for self-determination or against policies and practices illegal under international law. The Special International Tribunal on Political Prisoners and Prisoners of War in the United States received testimony from the following witnesses. Dr. Imari Obadil, representative of the Black Movement. Ms. Asada Shakur, former political prisoner. Ms. Eve Rosen, representative of the White North American Anti-Imperialists. Sister Ann Montgomery, former political prisoner and representative of the Plowshares Communities. Ms. Elizabeth Murillo, representative of the Mexican people living within the borders of the U.S. Ms. Rita Zengadita, representative of the Puerto Rican National Liberation Movement. Mr. Jorge Farinaxi, Puerto Rican activist in the National Liberation Movement, and on bond, awaiting criminal trial. Mr. Bobby Castillo, former political prisoner and representative of the Native Americans. Mr. Ward Churchill, representative of the Native Americans. Mr. Michael E. Deutsch, expert on U.S. repressive strategy against movements opposing U.S. policy and seeking self-determination. List of witnesses continued. Ms. Mary O'Melveny, expert on disparate sentencing. Ms. Patricia Levasseur, former political prisoner. Mr. Majid Barnes, representative of the Black Movement. Ms. Alberta Africa, former political prisoner and member of MOVE. Dr. Stuart Gratian, expert on the psychopathological effects of long-term solitary confinement. Mr. Rafael Cancel Miranda, former political prisoner and representative of the Puerto Rican National Liberation Movement. Mr. Doraba bin Wahad, former political prisoner and representative of the Black Movement in the U.S. Mr. Bob Robideau, former political prisoner and member of the Native American Movement. Professor Francis Boyle, expert on international law. Mr. Jamie Delgado, former political prisoner and representative of the Puerto Rican National Liberation Movement. Ms. J. Safia Elijah, expert on conditions of confinement of political prisoners and POWs in the U.S. Mr. William Morales, former prisoner of war. Documents submitted by the movements. Brief in support of new African political prisoners and prisoners of war, Imari Obadil, Kwame Afa, Chokwe Lumumba, and Ahmed Obafemi. Report of the International Indian Treaty Council. We will remember, Leonard Peltier Defense Committee. Memorandum of Support and Clarification, American Indian Movement of Colorado. Agents of Repression. Ward Churchill and Jim Vander Wall. The COINTELPRO Papers, Ward Churchill and Jim Vander Wall. FBI COINTELPRO documents on the Puerto Rican independence. Black, Native American, Mexican, and anti-imperialist movements. Statement of Eve Rosen. Los medios de represión utilizados por el Gobierno de los Estados Unidos en control del pueblo de Puerto Rico y sus medios de liberación nacional y los intentos de criminalizar la lucha puertorriqueña por la independencia, comité unitario contra la represión y por la defensa de los presos políticos. Álvaro Hernández and Alberto Aranda, Chicano political prisoners. Committee to free Álvaro Hernández and Alberto Aranda and the Movimiento de Liberación Nacional Mexicano. Statement of Sister N. Montgomery. Documents submitted by former political prisoners. Statement of Majid Barnes. Overview of the black struggle in the United States as it relates to political repression and United States domestic policies of genocide, Doraba bin Wahad. The case of Doraba bin Wahad and the existence of black political prisoners in the United States, Doraba bin Wahad and Robert J. Boyle. Affidavit of Doraba al Mujahid bin Wahad. The State of Black America. 1990, The Urban League. Statement of Alberta, Africa. Statement of Jorge Farinaxi. Leonard Peltier, writ of habeas corpus. Affidavit of Attorney Bruce Ellison. Statement of Patricia Helen Levasseur. Transcript of interrogation of Jeremy Manning. Legal dossiers of political prisoners and prisoners of war held in the United States. Submitted by Freedom Now Campaign for Amnesty and Human Rights for Political Prisoners in the United States. Documents submitted by expert witnesses. Political Prisoners and the Denial of Fair Trials, Michael E. Deutsch. The improper use of the federal grand jury, an instrument for the internment of political activists. Michael Deutsch, 75 Journal of Criminal Law and Criminology, 1159. New developments in U.S. judicial repression, the use of counter-insurgency methods against the Puerto Rican independence movement. Michael Deutsch, The National Lawyers Guild Practitioner. Memorandum on disparate treatment of political prisoners and prisoners of war by United States authorities on sentencing and parole eligibility, Mary O'Melveny. Conditions in confinement. J. Safiyat Elijah. Report of International Jurists. Visit with Human Rights Petitioners in the United States. Report and Findings. Report of Amnesty International on the United States Penitentiary at Marion, IL. Report of Amnesty International on the Women's High Security Unit at Lexington, KY. The Right of Citizen Resistance to State Crimes, Francis Boyle. Preserving the Rule of Law in the War Against International Terrorism, Francis Boyle, 8 Whittier Law Review 735. The Hypocrisy and Racism Behind the Formulation of U.S. Human Rights Foreign Policy, in honor of Clyde Ferguson, Francis Boyle. 16 Social Justice 71. Written Statements by Individual Petitioners. Section 3. The Quincentenary, Dissing the Discovery. As the U.S. and Spain prepared to make a major spectacle of the fact that in 1492 a drunken sailor was discovered by a sophisticated group of peoples indigenous to what is now known as the Americas, many in the U.S. prepared to use the opportunity to focus on the plight of oppressed nationalities in general and native nations in particular. The selections in this section focus mostly upon work produced during this year that had an emphasis on political imprisonment. One cannot look at indigenous issues in the U.S. without significant mention of the case of Leonard Peltier. Leonard Peltier was a member of the American Indian Movement who, in 1977, was convicted and sentenced to 2 consecutive terms of life imprisonment for the murder of 2 FBI agents. These agents were killed during a 1975 shootout on the Pine Ridge Indian Reservation. Even often conservative Amnesty International has stated that although Peltier has not been adopted as a prisoner of conscience, there is concern about the fairness of the proceedings leading to his conviction. Post-1992 documents on Peltier, especially from the International Indian Treaty Council, are also included here. 3.1. Weeding. Christos. 2006. My garden in autumn, I want to send you this wind. Dancing through madronas. Alder trees going gold. Sun-piercing fog as the buoy sings her bells. These 2 geese going south who cause me to pause. Root in muddy hands. For their hoarse calls to everybody else. As they circle over the sound. This heat soothing my sweaty shoulders. Smell of lavender I've gathered for winter letters. This birch who brings me home. Moment of no walls, no locks, no guards, no torture. No lonely cruel years. These 2 apples. Not quite ready to pick. Who hang pale yellow blushed in dapples. They're the only ones and the first to grow. After years of tent caterpillar infestations. I refused to spray with poison. I planted this tree about the time they locked you up. Next year I pray for a better crop. And you? Biting into one. On the way. To visit your mother. Or go fishing. Any place you can smell the wind. For Leonard Peltier. 3.2. Conference on the Oppressed Nationalities within the U.S. 1492 to 1992. A quincentenary of continual resistance to genocide, colonialism, racism, and political internment. December 6 and 7, 1991 in celebration of International Human Rights Day, December 10, 1991 University of Illinois at Champaign-Urbana. On October 12, 1992, the eyes of the world will be upon the Americas and particularly on the United States. On that date, many in Europe and their Euro-American descendants will celebrate the 500th anniversary of the discovery of the Americas by the Admiral of the Ocean Sea, Christopher Columbus. Most of the rest of the world will remember 500 years of oppression, 500 years of genocide, racism, and colonialism. In reality, 500 years of resistance. In the United States, the official circles will look upon that day as the day of their real birthday. As the great Caribbean thinker Frantz Fanon so ably observed in his book The Wretched of the Earth, 2 centuries ago, a former European colony decided to catch up with Europe. It succeeded so well that the United States of America became a monster, in which the taints, the sickness and the inhumanity of Europe have grown to appalling dimensions. Like their European forebears, the Euro-American settlers in the U.S. set upon a course of stealing the land from native peoples first and, later, that of Mexicans and Puerto Ricans, of forcibly extracting labor from the Africans and, even worse, of attempting to strip all peoples of color of their humanity, of attempting to objectify these people to the point where they would lose their sense of self-worth, their sense of human dignity, where all they would see in their cradles was a strong, armed, sharp-eyed, chain gang captain, as the great poet from Martinique Aimé Césaire would poetically describe. Underscore 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 underscore. This Chicago-based event, held after the dissolution of Freedom Now, but prior to the broad activities around the quincentenary, brought together many of the key leaders involved with the 1990 Tribunal on U.S. political prisoners. Discussing historic and contemporary analysis about the nature of colonialism within the U.S., including the conquering of native nations as well as the continued occupation of the internal colonies of Puerto Rico, the Mexicano/Chicano nation, and the new African nation, the conference centered around a call for united action in 1992. With the political prisoners as a center point for this call, the conference succeeded in bringing together several hundred participants from diverse political, geographic, and national backgrounds. The event was sponsored by the African American Cultural Center, Casa Cultural Latina, La Raza Movement, Frente Estudiantil de Liberación Nacional, If Not Now Movement, Progressive Resource/Action Cooperative, and the Student Government Association. In a period of world history when many of the progressive forces seem to be in disarray, when the West has proclaimed that it has won, and that history has ended, and that a new world order is being ushered in to guarantee the continual control by Euro-Americans, we are called upon, not to celebrate the past 500 years of European domination. A domination that was initiated half a millennium ago with the onslaught of the European menace, which through pillage, plunder, violence, and hatred guaranteed the development of their region of the world, and forced upon the rest of humanity a course of underdevelopment and self-hatred. We are called upon, instead, to study the roots of the resistance of the forebears of new Africans, Native Americans, mulattoes, and mestizos. It is imperative to learn the mysteries of their persistence and presence in these Americas 500 years after the Europeans attempted to annihilate these populations with the only superior thing they possessed, their instruments of war. It is against this backdrop of the two legacies of the Columbian quincentenary, the legacy of pillage and genocide and of oppression, on the one hand, and the legacy of the continual resistance of peoples of color on this continent on the other, that a conference on the oppressed nationalities within the U.S. is scheduled to be held at the University of Illinois at Champaign-Urbana. Goals and objectives of the conference. The conference will seek to bring together experts as well as activists from the various national liberation struggles within the U.S. to delve into and reflect upon the two legacies of Columbus for people of color within the U.S. frontiers, and to explore ways and means of confronting the 1992 Columbus Quicentennial celebrations. This conference will have the following specific objectives: to undo the myth of the European discovery of the Americas and Columbus as the embodiment of the European spirit of adventure and of rugged individualism. Columbus and the Europeans who accompanied and later followed him were conquerors and not discoverers of a new world. To understand that one of the true legacies of Columbus was that he initiated the process of objectification and dehumanization of people of color through the introduction of the chattel system in the Americas. To understand the true history of the U.S. as the country that became the depositor of the worst features of the European legacies of colonialism, genocide, and racism, which were institutionalized in its constitution, a constitution that provides for a federalist system based upon the incorporation of land, but the marginalization, exclusion, and even destruction of the inhabitants of those lands. For example, in Article I, Section 2, of the U.S. Constitution, it is stated that representation shall be apportioned among the several states, according to their respective numbers, which shall be determined by adding to the whole number of free persons, and excluding Indians, 3/5 of all other persons. In other words, Indians were to be excluded as historical subjects, as human beings. As persons, blacks were to constitute 3/5 of a human being. Some may point to the fact that this was changed by the 13th and 14th Amendments, but it should be noted that the 13th Amendment reads, "Neither slavery nor involuntary servitude, except as a punishment whereby the party shall have been duly convicted, shall exist in the United States." One look at the racial makeup of today's penal population will suffice to indicate what groups of people held as wards of the state who have no rights. The prison population is overwhelmingly people of color. To understand the true legacy of genocide, colonialism, and racism, so in the words of Native American activist, Susan Sharon Hoyjo, we can turn our attention to making the next 500 years different from the past ones, to enter into a time of grace and healing. In order to do so, we must first involve ourselves in educating the colonizing nations, which are investing a lot, not only in silly plans, but in serious efforts to further revise history, to justify the bloodshed and destruction, to deny that genocide was committed here, and to revive failed politics of assimilation as to the answer to progress. These societies must come to grips with the past, acknowledge responsibility for the present, and do something about the future. It does no good to gloss over the history of excesses of Western civilization, especially when the excesses are the cause of deplorable conditions today, p. 32. To rediscover, analyze, and celebrate the heritage of a culture of resistance that grew and developed alongside, and in spite of, the dominant Euro-American culture of domination. A legacy that dates from the heroic resistance fighters, such as Uraoan, Cuauhtémoc, Toussaint L'Ouverture, Sojourner Truth, Denmark Vesey, Batenses, Lolita Lebrun, Tiburcio Vasquez, Ricardo Falcon, Chief Joseph, Crazy Horse, Malcolm X, to the embodiment of that tradition today, the jailed or exiled patriots Leonard Peltier, Geronimo Prat, Assata Shakur, Alejandrina Torres, Oscar Lopez Rivera, as well their allies such as Sylvia Berardini, Alan Berkman, and Susan Rosenberg. 3.3. Dissing the Discovery, Political Prisoners and Prisoners of War in U.S. Prisons to celebrate the Columbus Quincentenary and affirm 500 years of resistance. Meg Starr, Barbara Zeller, co-editors of Dissing the Discovery 1992. From the first Native American warriors captured by Columbus's soldiers, political prisoners have been both part of and a result of resistance to imperialism and genocide. In the spring of 1992, several of us who have done defense work in support of political prisoners and prisoners of war in the U.S. wrote and asked the prisoners to comment on the Columbus madness. This booklet represents the unedited complete text of all the responses we got. As such, this collection is not reflective of the breadth of national struggle within these borders, nor of the proportion of revolutionary women spending their lives behind bars. To the prisoners who responded, thanks. To those who didn't, we hope that our letters reached you through the prison censors. What a year this has been. Smirking at the end of the war on Iraq, the imperialists started celebrating 500 years of genocide, rape, racism, and conquest. All over the world, their celebrations have been met with resistance. Wherever the replicas of the Nina, Pinta, and Santa Maria have landed, Native American activists and others have demonstrated and disrupted. Right now, the corporation that contracted to bring the boats over is nearly bankrupt, and some of their engagements have been cancelled. An activist from the American Indian movement poured blood on himself in the strangely bloodless encounter exhibit that has been touring the U.S. In Guatemala, indigenous leaders from throughout the continent converged and marched on October 12, 1991. The ties between indigenous peoples of the Americas has been strengthened as 500 years of resistance has been celebrated throughout the continent. The rebellion in Los Angeles shook the complacency of U.S. imperialism. In Washington Heights, where the Dominican community rebelled against police violence and murder, one of the chants linked today's rebellions to the history of militancy dating back to the Taino struggles against the original conquistadors. Underscore 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 underscore. As a part of the campaign around the 500th anniversary of Columbus getting lost at sea, Resistance in Brooklyn co-founder Meg Starr and longtime anti-imperialist activist Barbara Zeller put together a booklet of writings by U.S. political prisoners. Several hundred copies of Dissing the Discovery were distributed, mainly in New York City. It was part of an ongoing effort to give the political prisoners an active voice at all major U.S. radical and progressive events. If we knew and could name all the acts of resistance committed this year, it would have an empowering effect upon us. The impact of all that shared feeling and action would dent the sense of powerlessness and isolation that imperialism creates and depends on. This is why we wanted to bring you the voices of our prisoners. They were taken from us in the first place to attack our movements and intimidate activists. Now they are held under the ultimate conditions of isolation and disempowerment, yet they continue to resist. This fact can strengthen us all if we keep in contact with them. We ask all of you to think of your own creative ways to keep the political prisoners and prisoners of war with us in our lives and campaigns. We have printed the authors' addresses, write to them. We have also printed a partial listing of groups that do support work around peace and POWs. Finally, we dedicate this booklet to the millions of people over 5 centuries who were imprisoned or gave their lives to the fight against imperialism. We are highlighting Leonard Peltier and Mumia Abu Jamal, two comrades whose cases deserve particular attention this year. Free them now. 3.3.a The Real Columbus, a book review of Hans Koning's Columbus, his enterprise. David Gilbert. 1992 is the quincentennial of Columbus landing in America. It will be a year marked by lavish celebrations and strong protests peaking on October 12. Hans Koning's iconoclastic Columbus, his enterprise presents the historical Columbus, a man greedy in large ways and cruel on a continental scale, as opposed to the hagiography we were taught in school. The main section of this book was first published in 1976. Monthly Review Press issued this 1991 edition with a new introduction and a useful afterword by Bill Bigelow on using this book to help teach critical thinking in the high school classroom. Contrary to the myth, Columbus was not unique or even unusual in holding that the world was round. This was the predominant understanding among educated Europeans at the time. Where he bucked the conventional wisdom was in his firm belief that the world was much smaller and Asia much more extensive than the prevailing estimates. Thus Columbus mistakenly calculated the westward distance from Europe to Japan to be only 1/4 of what it actually is. This miscalculation was the basis for his staunch belief that the trip was within the range of the ships of his day. What was extraordinary about his character, in Koning's view, was his fierce determination to effect his vision and his ability to convince others to support him. Also, Columbus did have the good luck and the sailing knack to start from the Canary Islands, much farther south than the Portuguese sailors who had tried the western route before him. Thus his 3 ships picked up the strong trade winds blowing west that could carry them to America before their provisions ran out. Columbus professed a fervent Catholicism and wrote passionately of his mission to convert the heathens. Before setting sail, Columbus demanded and obtained for himself and his heirs the extravagant terms of 10% of all the wealth that would arrive by this new route to Asia, forevermore. On October 12, 1492, Columbus made his first contact with Native Americans, the Arawaks, in the Bahamas. He described them in his log: "Some brought us water, others food. They later swam out to the ships, and brought us. They willingly trade everything they own. They do not bear arms, and do not know them. I believe they could easily be made Christians." But none of these Arawaks ever was converted. The Spaniards' insistence on seizing captives, their forcing of Arawak women to be sex slaves, and their thirst for gold caused a deterioration in relations. All the 10 commandments were rolled into one for Columbus: profit. On the second voyage, still having failed to find the fabled Asian wealth by 1495, Columbus seized 1,500 Arawaks and picked the 500 strongest to cram into his ships returning to Spain. 300 souls survived the journey to be sold into servitude, but so many of them died in captivity that his version of the slave trade could not prosper. Columbus intensified his obsession for gold. Underscore 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 underscore. Originally reprinted with permission from Downtown Magazine. The quest centered on the island of Hispaniola. There, a few gold ornaments and various confused myths about Asia led Columbus to convince himself that he had found the fabled land of overflowing fields of gold. In reality, Hispaniola just had a few rivers carrying grains of gold in alluvial form. Koning's passage, Death of a Nation, vividly presents the unbridled gold lust and unspeakable human cruelty at the heart of the enterprise. It is worth quoting at length. Every man and woman, every boy or girl of 14 or older, in the province of Cibao had to collect gold for the Spaniards. Every 3 months, every Indian had to bring to one of the forts a hawk's bell filled with gold dust. The chiefs had to bring in about 10 times that amount. In the other provinces of Hispaniola, 25 pounds of spun cotton took the place of gold. Whoever was caught without a token was killed by having his or her hands cut off. There are old Spanish prints that show this being done. The Indians stumble away staring with surprise at their arm stumps pulsing out blood. There were no gold fields, and thus, once the Indians had handed in whatever they still had in gold ornaments, their only hope was to work all day in the streams, washing out gold dust from pebbles. It was an impossible task, but those Indians who tried to flee into the mountains were systematically hunted down with dogs and killed, to set an example for the others to keep trying. By that time there was no longer a possibility of mass resistance. The island was so well pacified that a Spaniard could go anywhere and take any woman or girl, take anything, and have the Indians carry him on their backs as if they were mules. Thus it was at this time that the mass suicide began. The Arawaks killed themselves with cassava poison. During those 2 years of the administration of the brothers Columbus, an estimated 1/2 of the entire population of Hispaniola was killed or killed themselves. By 1540 the entire Arawak nation on Hispaniola, perhaps up to 1 million people, had vanished in a total genocide. The killing off of the Native Americans also became the impetus for the massive trade in African flesh to provide slave labor in the Americas. While not the focus of his book, Koning does mention that, for example, in Haiti in 1804 there were only 600,000 surviving descendants of the estimated 2 million Africans that had been imported into that area throughout the slave trade. As we approach the quincentennial, Columbus' individual character is not really that important. Even if he personally had been a saint, what matters is the nature of the era he ushered in. The glorification of Columbus has been used as a perfume to cover the stench of the ensuing conquest. As it happens, Columbus was indeed a fitting representative of a much larger enterprise based in colossal greed, unprecedented genocide, and the horror of slavery. The standard textbook version of Columbus is nothing but the unabashed propaganda of the conquerors. 3.3.b. If Columbus had not come. Sundiata Akali. Every now and then I catch myself daydreaming of what I'd be, or have been, if Columbus had not come. Frankly, I can only conjure up fuzzy images of being surrounded by kids somewhere on a sunny beach in Africa. I guess that proves that Asita knew me better than I knew myself, or that perhaps 20 years of imprisonment has somewhat clouded my childhood ambitions. In any event, I would have been perfectly happy to have been simply left alone, that is, left undiscovered by European explorers, left free to live my life as I chose, and left free to depart this world peaceably, hopefully having left it a little better place than when I entered. But the reality is that Columbus came, and he came as a conqueror, a murderer, a robber, and a racist. It changed my life forever, although yet unborn. Wherever Columbus and other European explorers went, they murdered, raped, robbed, kidnapped, enslaved, cheated and lied. They called it many names, discovering the New World, spreading Christianity and Western civilization, and pioneering, but reduced to its lowest term it was simply murder, incorporated. They murdered in Africa, Asia, Oceania, and in the Americas. And whenever they went, people resisted. They fought. Even when defeated and enslaved, people continued to resist. They slacked in their work, sabotaged, ran away, stole, cheated, lied, mugged, robbed, rioted, and rebelled. U.S. imperialism today continues the tradition of Columbus, but in a more sophisticated manner, and under a different set of banners, stopping communism, protecting human rights, and spreading democracy and the free market system. Now they murder through the U.S. Army, Third World proxy armies and death squads, paid assassins, the police, and the death penalty. They rob through taxation without representation, high prices for shoddy goods and services, starvation wages, and through unjust fines and penalties. They kidnap through children's courts that rule mothers unfit and then send their children to detention centers and orphanages for adoption. They cheat by supplying inadequate health care, inadequate schools, and inadequate housing. They lie through their mass media rife with stories and innuendos which paint non-white people as nothing but a bunch of welfare queens, Willie Horton rapists, crackheads, street criminals, black racists, winners, slackers, and polluters of the world with illegitimate babies. So it's not too surprising that there are people who still resist today. Nor is it surprising that instead of individual and anarchistic acts of resistance slacking work, stealing, mugging, robbing, and rioting there would be those who sought/seek to organize the individual acts of resistance into a coherent mass. Marcus Garvey of the UNIA, W.E.B. Du Bois of the NAACP, Martin Luther King of SCLC, Malcolm X of the NOI/OAAU, Huey P. Newton of the BPP, and Assata Shakur of the BLAT. In response to such resistance, America cranks up its big lie machine and sends in its police to murder, maim, suppress, and imprison them as common criminals, thugs, bandits, cop killers, and the like. And so goes the cycle, from one generation to the next. There are over 150 political prisoners and prisoners of war from the last generation still imprisoned today. They are PP/POWs because they are imprisoned for organizing mass resistance to, and for resisting themselves, the colonization and genocide, and modern-day enslavement of oppressed nationalities here in America, by U.S. imperialism. The next generation will do no less and is already beginning to stir itself against the legacy of Columbus. They carry on a 500 years tradition that will never end until today's Columbus, and all his admirers, wish that he had not come. 3.3.c. Autopsy. Wo Pashai Tui Mondo Ian Wilanga. 5-pointed skulls on a field of blue. Razor-edged lines in a bone-white land and blood red. Running long as rows of cotton. As forced marches from tribal lands to reservations. A cloth haunted by the ghosts of Dred Scott, Chief Joseph, Emmett Till, and others whose spirits do not lie still, but wail in the night of this seamless weave. 3.3.d. In history's back pages, the African/Native American alliances. Wo Pashai Tui Mondo Ian Wilanga. The pages of history are replete with testimonies, by European explorers, traders, etc., of the grand levels of the advanced civilizations of both Indians and Africans. Often it was the case that these civilizations, which Europeans encountered, contrasted with conditions of widespread barbarism in their own countries of Europe. And typically, though not without exception, the native peoples of both Africa and the Americas greeted their European discoverers with friendliness and hospitality. We know, however, how this friendliness and hospitality came to be rewarded. The agents of death of Africans were the same as and similar to those employed in the slaughter of Native Americans. Underscore 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 underscore. Both of these texts by Wo Pashai Tui Mondo Ian Wilanga originally reprinted with permission from Mo Better News. 3.3.e. A short story still untitled. Alberto Rodriguez. Esquivel stared into the phantom's eyes as lightning entered her, tearing out her entrails. As she lay down, her life pouring out of her, she could see the people of her Yakayaki vanishing, no one escaped. The old Bohite woke from her herb-induced trance, exhausted. Huazion, the Yakayaki's cacique, sat on his dujo surrounded by Nita-Inos. I saw what looked like men, said the cacique, but they covered their white skin. They came in 3 large canoes, but came onto the shore in smaller canoes. They have set up a camp near the shore and are there now. They did not see me for I did not want them to. They are gods, interrupted one of the Nita-Inos. We must go and pay homage to them. No, said Esquivel. They come to kill and enslave us. All the Nita-Inos began to talk softly among themselves. Many of them did not like her because they felt that the Yakayaki's Bohite should be a man. Their fear of her powers and their cacique's great respect for her kept them from voicing their opposition. The cacique listened quietly and patiently to the chatter of the Nita-Inos. Finally he stood up and said, "We must stay away from these strangers until we know why they come." Soon the whole Yakayaki was talking about the strangers. They are gods. No. They are not. Esquivel says that they come to destroy us. That old woman does not know of what she speaks. Our Bohite has always been truthful to us. Tomorrow some of us are going to gather some yucca, maize, batata, and yahusha and give them to the strangers as offerings to pay homage to them. I will only give offerings and pay homage to our god Yokahu and our semis. The next morning Hwazyon, his wife, Shugwux, and Esquivel watched as a small procession left the Yakaiki toward the strangers' camp. They never returned. Several days later the cacique called together his bravest warriors Agimaka, Goorioyoan, and Uradamaka. He told them, "We must go and find out what happened to our people who went to the strangers' camp." The cacique put on his guanan. All of them carried makinas as well as bows and arrows. They quietly approached the strangers' camp, and what they saw filled their eyes with horror. Some of the Nitainos had been tied to trees, their bodies flayed. Most were dead, those who were alive prayed to Yokahu to let them die to end their pain and suffering. Some women lay dead on the ground, their bodies spread grotesquely in pools of blood. Those who were still alive were tied up. The children wept openly. Without hesitation Hwazyon, Agimaka, Goorioyoan, and Uradamaka hurled themselves against the strangers. They fought valiantly, but their wooden makinas were no match for the strangers' weaponry. Several of the white strangers were injured, but all the Taino warriors were quickly killed. During the struggle Karmaj, one of the children, was able to free herself from her bonds and escape into the forest. This was soon discovered and a search party set out to recapture her. Karmaj ran as quickly as she could. Upon reaching her Yakaiki, she fell from exhaustion. Karmaj soon woke and found herself in Shugwix's bohio. Esquivel poured cool water over her brow. "What happened, little Karmaj?" asked Shugwix. For a moment she could not respond, for it all seemed a fantasy. "Please," insisted Shugwix. "What happened to the Nitainos, your father and mother, your brothers, all those who went to the strangers' camp? Where is Hwazyon?" Karmaj sat up and rubbed her eyes with her hands. She then began to speak. "We all marched right into the strangers' camp. At first they were friendly, smiling, laughing and eating the food we brought them. They were especially interested in the gold of the Nitainos. Several of the strangers went into the forest with one of the Nitainos. Soon they returned without the Nitaino. They were very angry." Karmaj lowered her head and began to cry. Shugwix embraced the girl and began to softly caress her hair. "Please, Karmaj, tell us what happened," pleaded Shugwix. "When the strangers returned," continued Karmaj, "they were very angry. They spoke to their cacique who they called the Admiral. Then the white-skinned men turned on us. The Nitainos and all the men were captured and tied up. Many fought back and were killed or tied to trees and cut with shiny blades. Some of the women were killed because they fought back. Those who didn't had terrible things done to them and then they were tied up. We must leave the Yakaiki right now," said Esquivel. "The strangers will come here and destroy us. We must flee into the mountains." "Where is Hwazyon, my husband, our cacique?" asked Shugwix. "Dead," cried Karmaj. Shugwix stood silently for a moment. She then walked out of her bohio into a brilliant sun. All the Tainos of the Yakaiki were in the baiti in front of the cacique's bohio. Shugwix began to speak in a strong, vibrant voice. "Our cacique is dead. The white strangers have come to destroy us. They will come to our Yakaiki to kill or enslave us. If we are to live, we must go into the mountains." The people were confused and began to talk among themselves. Several of the surviving Nitainos as well as several young boys not yet old enough to be warriors stared at Shugwix, but when she looked straight into their eyes, they looked away. Esquivel and Karmaj came out of the bohio and each stood at Shugwix's side. Esquivel placed a cacique's guanan on Shugwix's neck while Karmaj placed a makina in her hand. The women Aliquin, Sudi, and Sumaj went to their bohias and returned armed with their now dead husbands' weapons, to stand by Shugwix. Later when the invaders marched into the Yakaiki it was completely abandoned. The Tainas found a redoubt in the forest. All learned how to use weapons and all searched for food. Late into the night, Esquivel sat with Shugwux. The one called the Admiral, said Esquivel, wants the shiny metal we use to make the guanin and the night-nose ornaments. He cares nothing of how many of us he kills. Then we will hide forever, said Shugwux. No, my cacique, replied Esquivel. We cannot hide forever, for the Admiral will never stop searching for us until he destroys us all. What are we to do? Asked Shugwux. Kill the Admiral, said Esquivel. The next day Esquivel and several others went into the forest in search of berries. As she bent over to pick the little fruit to satisfy her hunger, she heard a noise behind her. She turned around as quickly as her old body would allow her. Esquivel stared into the bearded white phantom's empty pale eyes as a cold blade entered her, tearing out her entrails. As she laid on the ground, her life bleeding away from her, she could see the people of her Yakayaki being slaughtered or captured. Shugwux, Algan, Sudi, and Sumit shot arrows at the white invaders, giving some of the children a chance to escape. They all fled deeper into the forest. Shugwux realized the futility of running away. She gathered all that remained of her Yakayaki and together silently marched to the white invaders' camp. When they finally reached it, the invaders had boarded their canoes and were rowing toward their large canoes. Shugwux knew where Huazion had a war canoe hidden. It was still there when they reached it. They pushed it into the water, climbed in and started to row toward the white men's canoe. The Admiral watched the Taino's canoe approach with both curiosity and suspicion. Shugwux stood at the head of the canoe waving her machina over her head. As the war canoe approached the Admiral's ship, she shouted, "Please Yokahua, give us the strength to kill the Admiral, so that you good people can live. Dear sir. As I know, many will be rejoiced at the glorious success in my voyage. I have discovered a great many islands inhabited by numberless people, and of all I have taken possession without opposition. The people are so unsuspicious and so generous with what they possess, that no one who has not seen it would believe it. They never refuse anything that is asked for. They even offer themselves, and show so much love they would give their very hearts. I was very attentive to them, and strove to learn if they had any gold, seeing some of them with little bits of metal hanging at their noses. I took by force some of the natives, that from them we might gain some information. They are still with me and still believe that I come from heaven. As for monsters, I found none except in one village inhabited by a people considered in all the isle as most ferocious. They possess many canoes. The women have no feminine occupation, but use bows and arrows of cane, and eat human flesh. Many other things of value will be discovered by the men I left behind me, as I stayed nowhere when the wind allowed me to pursue my voyage. Thus I record what has happened written on board the caravel, off the island of San Juan, on the 15th of October 1493. Yours to command. The Admiral. Christopher Columbus. 3.3.f. The Uprising. Raymond Luc Levasseur. The Los Angeles Uprising isn't about a free lunch or integrated lunch counters. It's about those whose lives have been disinherited, displaced, discriminated against, and disenfranchised. It's about 500 years of European exported genocide. The entire state of California sits on stolen Indian and Mexican land. There is nothing legitimate about this kind of theft, nor the institutional racism and violent repression that accompanies it. The most intense flames of this uprising have burned in predominantly black South Central LA. This community is one of many emanating from the African diaspora and its historically developed land base in the Black Belt South. Today's resistance draws its lifeblood from the earliest slave rebellions and is embodied in the descendants of Malcolm X. There is no middle of the road after the Middle Passage. There are common threads between the LA uprising and the Palestinian Intifada. Both defy overwhelming superior police and military forces. Both constitute dispossessed nations fighting for basic human rights. And at the heart of their struggles is the right to national identity and land. The LA uprising has broken through one of oppression's fundamental realities, its disarming effectiveness at turning its victims against each other instead of their oppressors. The rising has redirected the rage of its participants against the moral bankruptcy of capitalism and white supremacy. As of this writing, the battleground has claimed 50 lives in 4 days, most by police gunfire. In the usual course of events, LA's killing grounds would take 2 weeks to claim as many lives. The significant difference is that instead of passively waiting for death to stalk them, the people went on the offensive. Or what might be considered a vigorous self-defense, since they were going to die anyway through police violence, internecine warfare, alcohol and drug poisoning, and social neglect. The uprising resulted in extensive property damage. While there was some needless destruction, the people's firebombs were strikingly accurate at rooting out capitalism's ghetto infrastructure. For the most part, people avoided damaging schools, mosques, churches, and housing. Most damaged property was corporate and absentee-owned. More than one Bank of America branch was torched into oblivion. These are the businesses that bleed the community with overpriced staples of life, then take the money and run. These are the purveyors of unlimited supplies of alcohol. It was like pouring salt on leeches as the profiteers squirmed in their suburban enclaves. When faced with uprising and mass resistance, the government has historically responded with military intervention. From one decade and century to another, Watts, East St. Louis, Chicago, New York, the police and military have combined to exact a fearful death toll. It was during the 1965 Watts Rebellion that Darrell Gates, the Bull Connor of LA, drew his first blood as a police commander. From Watts, black rage swept through Cleveland in '66, and Newark, Detroit, and other cities in 1967. After returning from Vietnam, I traveled to Detroit and saw the immense destruction. In Vietnam I've seen extensive bomb damage from the door of a helicopter. In Detroit, I saw it from the asphalt. Both areas burned in wars for self-determination. The deployment of federal troops is predictable, but uprisings that trigger deployment demand attention and demonstrate the potential power of the people. This is not a time for apology and accommodation. If I began writing all the names of those murdered and beaten senseless by the police, I'd be writing until forever. I could never catch up with the reality. With each death is a killer cop who walks free. I know I've written this before, but it's something I can't forget. It shouldn't be forgotten. I will write but two: Philip Pannell, a black teenager from Teaneck, New Jersey, who died from a police officer's bullet as his hands were raised over his head. And Ralph Kennedy, a personal friend, who was murdered in cold blood by police in Baltimore, Maryland. No civil rights inquiries were initiated into these murders. There rarely are. It took 50 deaths in LA and the US government's embarrassment in the court of world opinion to legitimize a federal inquiry into the Rodney King case. Thousands have been arrested in LA, and the federal and state governments have formed a special task force to prosecute them. Steal a pair of shoes and go to jail, rip off the livelihood of a people and you're rewarded with profits and high office. These prosecutions will be punitive and vindictive. Years after the Watts Rebellion, some of its participants are still in California prisons. Black nationalist Ahmed Evans was sentenced to death following the Cleveland uprising. I first met Ralph Kennedy after he'd been railroaded to prison in the wake of the 1968 rebellion in Nashville's black community. Colonial rebellions strike fear in the bowels of American capitalism, and it'll spare no effort to imprison the most rebellious. Still in prison, some for decades, are those women and men who represent their people's aspirations to be free: Leonard Peltier, Geronimo Pratt, Mumia Abu-Jamal, Gary Tyler, Alejandrina Torres, Abdul Haq, and many others. As Mandela put it, there's no easy walk to freedom. The federal deployment in LA includes elements of the U.S. Marshals Service, who made their notorious mark in history tracking fugitive slaves, the racist dogs of the Border Patrol, and the Bureau of Prisons. The presence of the latter is a further indication of what lies in store for the rebellious poor: more prisons in a country that's already choking with them. The U.S. has more steel cages than any country on earth, and imprisons more blacks per capita than South Africa. I live in this compressed nightmare of a gulag. Each year of my imprisonment, I've endured the exile with those from America's barrios and ghettos, including South Central and East LA. There's no denying this apartheid reality or the necessity to break its chains. Nat Turner said that the struggle for freedom was not a war for robbery or to satisfy passions. Opportunists exist everywhere, but most of that unleashed the power of mass resistance did not act with criminal intent. They are pursuing their very survival. Their intent is to demand respect and gain some measure of control over their lives and community. What criminal intent exists is primarily represented by police violence and a system that fosters and protects the real criminals, that rotten element that lives in bourgeois splendor derived from exploiting and defrauding society's most vulnerable. Their rapacity is exceeded only by their ruthlessness and disregard for the value of human life. The rule of class and white supremacy ensures they can operate with impunity. No doubt the system will attempt some band-aid application to problems reflected in the uprising. This has been attempted before, but hasn't worked. That's one of the messages from the streets. Government money, with all its bureaucratic strings, may alleviate some conditions in the short term, but it cannot deal with the basic causes that underlie a people's subjugation. There's only one serious context in which to discuss money, and that is reparations. Billions of dollars in reparations. Millions of acres of land in reparations. However, a government and general population that applauds the agonizing death of Iraqi children caused by U.S. bombing raids will not seriously consider reparations simply to quell the impact of 50 death and property destruction in L.A. The situation is desperate but not hopeless. To rise from ashes and bondage requires a well-organized and militant resistance that's willing and prepared to take it to the limit. For America's most oppressed, there's no viable alternative to revolutionary nationalism and socialism. There was widespread participation by Mexicans in the LA uprising, though the media has manipulated coverage to keep them voiceless. Their involvement is understandable given the conditions of survival and the fact the America occupies their land. Los Angeles was forcibly taken from the Mexicans in 1846. There was marginal participation by young whites in LA as well as in actions in other cities. This is encouraging, but it is not enough. Historically, white people have laid claim to privilege based on race. There are exceptions, but they're not the rule. White power rules in America, as is clearly evident in the presidency, Congress, Supreme Court, and corporate boardrooms. You can see it in the faces of the swine wearing the badge of the LAPD. You see it in celebrations of Columbus. There are those that embrace the racist ideology that permeates this country, others are simply complacent when confronted with its effects. Both are part of the problem. For the predominantly white left and broader groupings of progressives, there exists a heightened call to action. Where are the millions who created a vibrant anti-apartheid movement? Where are all those that provided political support and material aid to Nicaragua and El Salvador? Where are the near million strong that attended the recent pro-choice demonstration in Washington? And where the hell is organized labor? It's time for this conspiracy of silence to end. For poor and working class whites, the choice is clear: collaboration with a system based on white supremacy, or combating it. When John Brown was asked why he fought to end slavery, he replied, "I act from principle. My objective is to restore human rights." When Malcolm X was asked what whites who care about black people's struggle could do to support them, he replied, "Do as John Brown did." It's time to get down to dismantling the apartheid legacy of slavery. It's time to organize a 20th century abolition movement, and to provide aid and assistance to freedom fighters. It's way beyond the time of no return. 3.3.g. A letter from Mark Cook. Mark Cook. Dear friends, I sincerely believe in the abolition of all economic, social, and political double standards. These are the basis for violations of human rights. I find no pleasure in celebrating the invasion of the African continent and the carrying away of the African tribes to the Americas for purpose of slavery. I adopt no double standard to support the 1992 U.S. celebration of the invasion and 500-year colonization of the Americas. True, the invasion of the Americas was a historical turning point for many people, but that event in history extended into unaccountable, disgraceful acts which violated and continue to violate the human rights of the native tribes in the Americas. Unwarranted invasions of lands and acts of genocide against the peoples are not to be celebrated. Such celebration gives credence to overt violations of human rights. I join the native tribes in the Americas in memorializing this day as a permanent day of mourning for the native tribes in America and as a permanent day of repentance for those who benefited from that invasion 500 years ago. We must now and forever assert ourselves as abolitionists against violations of human rights throughout the world. We shall very likely be criminalized for being the activist conscience of the world, but we are needed to make clear that barbarism has no place in a civilized world. Be an abolitionist for a better future for us all. Love and struggle. 3.3.H. Prayer from the Americas. Marilyn Buck. 1988. After reading Eduardo Galeano's La Memoria del Fuego. Oh my God! So gold and pure. My golden God. In whose name I offer blood, washing the new world red. My God of gold, more brilliant than the sun. I say to you, the Son of the one God died to save our sins, not their sins, and they must pay. My God, praise him with gold. Cultures must fail. Destruction must reign on all who would stop my holy mission. I, man of the Inquisitions. 3.3.I. Rejecting White Supremacy, Thoughts from a North American Brother. John Lohman. Repression breeds resistance. Resistance means struggle. Struggle brings results. Unity leads to victory. These are only slogans, easily and often tossed around, yet they are widely understood because they are grounded in reality. Any political activist, and certainly any revolutionary, has spent at least some serious time considering resistance, struggle, unity, and methods to victory. A minimum level of unity among the exploited and oppressed, among the victims of all sorts, is a prerequisite for achieving any positive results and of course total victory. The US is a country racked by racial, class and gender inequalities. The recent uprising in LA gave Bush's New World Order a very public and well-deserved black eye. The good people of Los Angeles put the issues of forceful struggle and rebellion back on the front burner. The central issue in the LA rebellion was racism. The racism of the white cops who savagely beat Rodney King, of the judge and prosecutor who sent the trial to the white suburb of Simi Valley, of the white police-oriented jury who sided with the cops, and generally of the miserable conditions of life that millions of African people live in South Central Los Angeles and around the country. The U.S. was founded and built on genocide and theft of the lands and lives of people of color, the indigenous Native Americans, the Africans brought here as slaves, the Mexican and Puerto Rican people whose land was taken and incorporated as states or colonies. Since those times, immigrants of color, Asian, African, Latino, have continued to face discrimination and prejudice, including vigilante Klan-type attacks. John Lohman. From the founding of the USA, its major institutions have been and are inherently racist, and by racist is meant white supremacist. White supremacy is both an ongoing ideology and day-to-day reality. It is permeated throughout the culture and life of this country. Any number of examples can be drawn from all areas of life to show this, and it's hard to believe that anyone living here could not be aware of it. In fact, feigning ignorance or wondering what black people want is but another manifestation of white supremacy. Certainly all blacks and other people of color have no doubt that racism is a reality of life in America. The left and progressive community and movements are not immune to racism. This isn't to say that any credible or sincere progressive, let alone revolutionary group or movement tolerates overt white supremacy, but as products of this society, even the opposition movements are affected by this most central flaw of U.S. society. Raising this issue is not meant to elicit some kind of liberal guilt-tripping or despair. As leftists and revolutionaries, and particularly those of us who rely on the insight of Marxist tools of analysis, it does mean that we should renew our efforts at understanding the pervasive and insidious role that racism plays, so as to continue to expose it and root it out. The fight against racism is a moral, social, political, economic, and just struggle. But most importantly, without recognizing, confronting and overcoming white supremacy, revolution in America will never succeed. That is, people's history in the U.S. is replete with examples of strong struggles being sabotaged and defeated because racism was effectively used to split the people. On the positive side, there have always been organizations and individuals who have fought against white supremacy. In the mid-1800s, the Working Man's Party and the Knights of Labor organized black workers and class unity. John Brown and his people used force and arms to battle racism and racists. The IWW stood for and defended all labor. The CIO and communists organized blacks and white. In the 50s and 60s, whites joined in civil rights efforts and supported black liberation. Support for national liberation and anti-imperialism is understood by many today as an essential part of fighting for socialist revolution within the multinational reality that is the US of A. All these positive examples, unfortunately, are outweighed by the more usual practices of racial discrimination and prejudice. Whites are taught early and often to fear and dislike people of color, especially blacks. Not all white people go for this or go for it forever. Rejection of racist attitudes is a positive first step, but must be followed up with a broader understanding. White supremacy isn't just a twisted ideology based on ignorance and falsehoods about culture, history, etc., it is also a means and justification for denying the right of nationhood to people of color. The U.S. is a multicultural and multinational entity. People from just about every nation and culture have come to live here, with most retaining some of their customs. More substantially, the U.S. consists of several actual nations. By nation here is meant the historically accepted and internationally required basis of people having a common history, language, culture, land, and economic relations. The dominant USA nation originated from European settlers. This nation was founded and is still largely ruled by wealthy white males. Although genocide was committed against the indigenous people of the Americas, nations of Native Americans still exist. Africans, kidnapped and carried to this continent as slaves, have by their long history and reality evolved into a separate new African nation. Puerto Rico, lying far from U.S. shores, but politically, economically and militarily controlled by the U.S., is clearly a nation in bondage. The battle against white supremacy has to recognize and take up support for the right of nations to self-determination. This is a crucial basis for building multinational unity among all those victimized in one way or another by the U.S. By recognizing a people's right to determine their own national destiny, lay the foundation for the unity of equals. In a similar way, men recognizing women's right and need for equality and an end to sexist stereotyping and activities, is a necessary basis for a united effort of men and women in the freedom struggle. Serious and lasting unity only comes about through recognizing and understanding other people and their realities. This means differences and similarities, so we can see each other as equals, perhaps different but with a mutually shared basis for joining in the face of a common enemy. Not all exploitation and oppression is the same, yet we all can join together in the effort to deal with our different levels and types of oppression. It makes sense to do so, and in fact success depends on it. The various attempts at putting forth theories of the end of history, the merging of classes and the "this is as good as society gets," by apologists of this New World Order aside, reality in the U.S., as we know it from our own lives, is and always has been a class-divided and class-clashing society. The government tries very hard to get as many whites as possible to identify with the interests of the ruling class with imperialism. Material incentives and ideology are both used to deceive and mislead the majority of white people, the poor and working class, including most of what's called the middle class. Too often they have been successful in swaying a lot of our people to reject their own working class interests and support imperialism. White revolutionaries today need to look back historically to people like John Brown. We need to take an active role in opposing the violence and oppression of both the state and any racist or fascist groups. We need to win over our people ideologically and practically. We need to, and we can do this. It is in our own class interests to oppose most everything that Washington does and stands for. It is in the interests of the white working class to flat out oppose white supremacy, to support the right of nations to self-determination and progressive national liberation. This is the necessary basis for multinational working class unity in the U.S. Further, it's the foundation for an even broader progressive unity of various classes and groups who all could and need to be part of the freedom struggle right here in the midst of America. What a post-imperialist America would look like is too early to call. Supporting a people's right to self-determination doesn't automatically translate to a series of small states with rigid borders, though. There could be separate new states, a confederation, or new single state. As a socialist and internationalist, I can envision our being able to give birth to a truly democratic, just, multinational society, based on social equality and mutual cooperation, free of war and harsh economic disparities, committed to improving the health of our planet for the sake of our children and all humanity. These are some beautiful and bold concepts. They are also fully achievable, necessitating only that we continue in our freedom struggle striking down white supremacy, rejecting the centuries-long abomination of racism and genocide, instead, reaching for and pushing forth the tradition of John Brown and the Wobblies, militant multinational struggle based on support for national liberation and unity in the battle for socialist revolution. 3.3.J. Maroon Tunes. Larry Giddings. History, her story, our story. Reflected in our eyes. Reflected in our hair. Reflected in our skin. Not like a mirror. More like music. And rhythm. Credit, Eric Drucker. Half-breed, quarter-breed. Octoroon, métis. Mestizo, cross-breed, dog blood. A bit of the tar brush. Underscore 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 in the wood pile. With a Moorish tint. Race mixin', house mixin'. World beat. The language of love, hate, war. And more. Red, black, yellow and white. 500 years of swimmin' in the pool. Cymbals clangin'. Heartbeats bangin'. An Oriental love song. An African chant. An Arawak brew. With a Celtic crew. A maroon tune. Fires in the night. Riding in the maelstrom of conquest. Rebellion in the blood. We are the new world. And we ain't lookin' for no order. No myth of purity. No genetic border. Outlaws, outlawed, runaways, wild. Livin' on the run. Osceola drinks in. The sound of the drum. And smiles. The child lives. And so. He's won. Fires burn. In our hearts. With knowledge of. Our past. 500 years of runnin'. To an equation. That claims. You are not who you are. A chain of slavery. Ancient. Passed by caste and class. Aristocratic blue bloods. Your time has come at last. Your fears are alive. And singing. We know who we are. 500 years they helped us. To grow upon these shores. They hid us in their valleys. Fed us with their knowledge. Visions and lore. They took us in their families. So the children would live. They showed us it was stronger, by far. To give. 500 years of slavery, genocide, and war. And still we hear the drums beat. The songs grow. We are the children of your future. We know who we are. This is Turtle Island. Our memory is alive. We have joined with those that help us to see this future come. We are the colors of the rainbow. We will be here when it's done. Mixed, like you, mixed, like me. We are the New World. The Iroquois could see 500 years of slavery, genocide, and war. The native people of this land have brought us together. Over their dead bodies, a hemisphere is waiting to hear our song of life. Reflected in our eyes, reflected in our hair, reflected in our skin. Dancing to the rhythm. We are the New World. We know who we are. Riding in the maelstrom of conquest. Rebellion in our blood. We are the New World. And we ain't looking for no order. No myth of purity. No genetic border. Credit, Eric Drucker. 3.3.K. What are we celebrating? Edwin Cortez. 500 years of America. I make my plea. It has been 500 years of misery. Columbus set sail in the Nina, Santa Maria, and Pinta, and conquered the Aztecs, Taínos, and Incas. Conquista became a household word. In order to satisfy the king's lust for gold. Colonialism led to mercantilist/capitalist penetration. In complete opposition to native civilization. Our forefathers were cleverly outfoxed. Subsequently exterminated by smallpox. Africans were forced to endure indentured servitude. To labor on foreign soils by the multitudes. Slavery is genocide, which some escaped by suicide. The Mexicano people taught them land cultivation, which the European transformed by brutal mutilation. Mexico was invaded by military fleets, and its northern borders incorporated by the U.S. colonial elite. Imperialism, an accursed damnation, invaded my nation, and to invoke your resistance tradition is to be labeled a terrorist and accused of sedition. Struggling for freedom's sake. Incarceration becomes your fate. Once, again, I make my pleas. Because I witness this misery. The imposition of capitalist/imperialist construction has led to 500 years of environmental destruction. Is science and technology for liberation? Or for our extermination? Do we continue our lives in desperation? Or take the risk of liberation? Let's do away with exploitation. And create a system that will last for generations. There will be no classes. Only the liberated masses. Let's regain our patrimony. In order to live once again in harmony. While imperialism perpetuates its lie. Our nations are forced to die. For those who fight. Armed struggle will be their might. Let's begin a new era for justice and human rights. Which could be just as powerful as dynamite. Let's undo the 500 years of misery. And become the makers of our own history. 3.3.L. 1992. Elizam Escobar. We must understand history as a live process. In today's debates and polemics about the events of 1492, more than a long-time dead man, or a long-time dead empire, one must judge and condemn those who continue in the present the injustices and atrocities of the past. Yesterday's adventure of discovery is today's misadventure of concealment. In this sense, while hypocrisy reigns in the celebrations of 500 years of the discovery, the United States keeps Puerto Rico under a direct colonial subordination, postponing for eternity our decolonization process while it champions conveniently the independence of other countries. It is easy to judge and condemn yesterday's Columbuses but difficult to do it with today's colonists and neo-colonists. 1992 is not just a symbolic date but a real historical opportunity to reconceive independence and self-determination for peoples and nations, as well as the individual. But these processes of liberation will not necessarily lead to a mature freedom unless they are transformed into total processes strong enough to defeat the alienated fragmentation of the postmodern individual and the apoliticalness of serial collectivism. This alienated fragmentation of the individual and the apoliticalness of serial collectivism can form a kind of mental colonialism that is epidemic and very difficult to defeat. We the progressive and revolutionary forces must oppose this extraordinary force with the power of truth. And this power must be headed at all possible levels by the power of the imagination. Through this political power of the creative minds we must rediscover and reinvent new and necessary ways of cultural resistance that could lead to total processes of liberation. This means, for example, that at the cultural level we should look for the ways to transform the pseudo-democratization process into a real one and push it to its limit. And, simultaneously, to provide an immediate content to the liberation of the human spirit through the work of art. This immediate content provided by the creative process is essential to maintain the necessary amount of faith not only of the future but of the present. It is also necessary, in order to oppose the plagues of global capitalism, the mistakes of monk socialism, and all postponements of revolution. Those plagues unraveled by capitalist lechery cannot be detained by merely taking state power or by merely going through a national liberation process. Revolution must be a total event dealing not only with problems of political direct power, but with all aspects of our spiritual and material existence. And any form of liberation must be understood as a process leading us to a responsible and mature praxis of independence and liberty, where there should be no antagonistic contradiction between the individual and the collective, between difference and egalitarian society. Specifically the renovation of Marxist thought and the incorporation of the radical existential experience of the excluded into the new political conceptions of reality and views of the future are of vital importance in order to keep liberation struggles and revolution alive. The artist, then, must incorporate, somehow, directly or indirectly, or both, the reality of this future that is already here with us. 3.4. Freedom Now. Meyer 1993. Every major social change movement throughout U.S. history has included leaders who have been jailed at some point during the struggle. These political prisoners, from backgrounds as diverse as the movements they worked for, have often played pivotal roles in pushing society toward greater justice and peace. In the 1700s there was Thomas Paine, in the 1800s, Nat Turner and John Brown. A list of past U.S. political prisoners must include Sacco and Vanzetti, Crazy Horse, Emma Goldman, Mother Jones, Lolita LeBron, and Rosa Parks. Socialist Eugene V. Debs ran for president while in prison for opposing WWI. He stated that while there is a soul in prison, I am not free. Today there are over 100 political prisoners, serving long sentences in U.S. prisons. Though the names of former Black Panther Sikau Odinga, white anti-imperialist and lesbian feminist Linda Evans, or Puerto Rican patriot Dulcia Pagan are hardly household words, their struggles for liberation are as significant as any waged in the decades before them. Many of today's political prisoners, like those in the past, belong to what are considered by the government to be fringe groups. Some are radical pacifists who accompany their prayer vigils with hammering on nuclear weapons until those weapons are inoperable. Some are Native Americans struggling for self-defense and autonomy after 501 years of broken treaties and genocide. Others are black nationalists fighting to liberate their people from economic and social oppression forged by centuries of slavery. Over a dozen of the political prisoners in jail today are Puerto Ricans struggling for independence against the colonial status that even the United Nations recognizes. Still others are radical environmentalists who believe that protecting Mother Earth will take much more than lobbying. Military resistors, who believe that in addition to filing for conscientious objection, one must also refuse to fight in war, are also included among the ranks of modern political prisoners. A quick review of these fringe groups should reveal that a common factor among them is a deep commitment to not just talk about political change, but to take action. Underscore 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 underscore. This text first appeared in the November/December 1993 issue of the Nonviolent Activist magazine of the War Resisters League. The groups and movements mentioned above have long been the targets of government harassment due to their radical political stance and actions. It is often for the very effectiveness of these actions and wide appeal of their messages that the government considers these activists a threat. The counterintelligence program of the 1960s and 70s used infiltration, wiretapping, forgery, agents provocateurs, and assassination to divide and conquer various groups, most notably the Black Panther Party, the American Indian Movement, and the Puerto Rican Independence Movement. As documented in Ward Churchill and Jim Vander Waal's Agents of Repression, illegal U.S. government activity resulted in the murder of dozens of black nationalist and Native American activists. In addition, some leaders were forced underground, some escaped into exile, and still others were framed and are now in prison. Targeted political prisoners commonly received blatantly prejudiced trials, unusually harsh prison sentences, and severe prison conditions. Well over half the current political prisoners are a direct or indirect result of COINTELPRO, the government's hope being to destroy existing movements and to dissuade new activists from social change movements through fear. Forgetting or ignoring the plight of political prisoners is one clear way that progressives may inadvertently bolster that hope. Defining political and prisoner of war. There are many variations and definitions of what a political prisoner is. Clearly there are those who think that, due to the criminal nature of poverty and racism in the U.S., all people imprisoned for petty crimes in the larger capitalist context should be considered political prisoners. Arguments have been made, for example, that all blacks in U.S. prisons are political prisoners due to the relationship between the U.S. government and people of African descent. It can also be argued that all Puerto Ricans living in the U.S., in and out of jail cells, should be considered imprisoned by Puerto Rico's colonial status. Some plowshares activists, many coming from a radical Catholic perspective of not separating oneself from the poor, have felt uncomfortable being placed in special categories apart from the rest of the prison population. There are also prisoners who have committed clearly non-political criminal acts, but who have become politicized while in prison. Lawyers and former prisoners speak of many examples of social prisoners who claim to have taken on a revolutionary ideology in order to get attention and support from the outside world, only to shed their ideology once on the outside themselves. Of course, countless examples can also be provided of politicized social prisoners whose commitment to progressive change was unwavering. Leaders such as Malcolm X and George Jackson were developed in the jailhouse university. Most commonly, however, political prisoners are defined as those who have been imprisoned due to political work or associations that they had before being imprisoned. For most people in the U.S., the letters POW are inextricably linked to MIA and relate to captured U.S. soldiers of the war in Southeast Asia. For oppressed nationalities organizing for justice, however, the POWs who are among the political prisoners in U.S. prisons are revolutionary heroes. According to the UN protocols set forth in Geneva, a prisoner can qualify for internationally recognized POW status if he is a combatant struggling against colonial and alien domination and racist regimes. Special treatment standards have been set for such prisoners by various UN agencies. Those who have claimed POW status have most often been active in underground or semi-clandestine groups, such as the Black Liberation Army, or in armed self-defense groups, such as the security wing of the American Indian Movement. Not every POW claim, however, is associated with an armed action. Leonard Peltier, for example, though openly admitting his membership in AIM and commitment to self-defense, has steadfastly denied involvement in the murder of 2 FBI agents, for which he was convicted and is serving 2 life sentences. Many of the Puerto Ricans claiming POW status were charged with nothing more than membership in the Armed Forces of National Liberation. Though the FALN claimed responsibility for several armed attacks, and some of the individuals accused did have weapons or the wherewithal to construct them, many of the Puerto Rican POWs are combatants in association only. Charged and found guilty of seditious conspiracy, they proudly admit their involvement in the movement to free Puerto Rico of colonialism, though no charge or proof of violence has ever been executed. The basis for the POW claim lies in the position that the U.S. has waged and is waging a war against these oppressed nations. Dr. Imari Obadile, a colleague of Malcolm X, articulated this theory in a classic pamphlet entitled War in America, as did Puerto Rican nationalist lawyer Pedro Albizu Campos, who cited the illegality of the 1898 U.S. takeover of Puerto Rico. Some political prisoners do not assume POW status. These include members of oppressed nationalities who were never associated with armed groups, or whose politics differed from this interpretation of the U.S. at war, and non-combatants struggling for self-determination or against illegal policies of the U.S. government. Supporters of liberation movements are included in this group, such as Silvia Berardini, an Italian national whose case has prompted Italian parliamentarians to demand her extradition back to Europe. Prisoners of conscience typically refers to the plowshares and disarmament prisoners, who often face less severe sentences but who occasionally, such as in the case of Helen Woodson, get slapped with an extraordinary 18 years for a nonviolent action. Radical environmentalists, such as the Earth First activists who carry out nonviolent direct action to protect all species, also fit into this category, as do military resistors. The last military resistor, Hawaiian Kelly I. Carmack, refused to report for duty after the centennial of the U.S. overthrow of Hawaiian Queen Liliuokalani, at which 15,000 sovereignty supporters marched. He was released in July. Freedom Now. Since there have been political prisoners, there have been support networks working for their release. Ranging from friends and family members to community, state, national and international religious and political organizations such as Amnesty International, to radical lawyers to government officials domestically and abroad, political prisoners count on supporters on the outside to voice their bid for freedom. In 1989, a coalition of religious activists, artists, pacifists, Black nationalists, Native American organizers, Puerto Rican independentistas, anti-imperialists, Chicano, and others came together to form a campaign entitled Freedom Now. Two major goals of the Freedom Now campaign were to bring the issue of political prisoners to a place of prominence within the various movements represented in the coalition, and to bring the human rights issues relating to the prisoners to an international audience. The special tribunal was seen as a vehicle that could accomplish both of these objectives and be used as a stepping stone to presentations at the United Nations, World Court, and other international assemblies. By December of 1990, when the tribunal took place in New York City, an initial list of 95 political prisoners had been generated. Over 1,000 observers from all 50 states and many countries attended. Eminent sociologist, educator, and lawyer Dr. Luis Nieves Falcon coordinated the four-day proceedings. The judges, including British Lord Anthony Gifford, U.S. Nobel Prize recipient Dr. George Wald, and African jurist Frank Badohu, issued a powerful call for the release of all political prisoners. Many of the groups involved with Freedom Now helped coordinate activities at the time of the Columbus Quincentenary, raising the issues of political prisoners alongside the issues of colonialism. A second tribunal, the International Tribunal of Indigenous Peoples and Oppressed Nations, was put together in October 1992, building upon the themes of the 1990 testimony. More recently, grassroots educational work is increasing with the development of a letter writing and postcard campaign on the part of the National Committee to Free Puerto Rican POWs, and the publication of a new book by the Campaign to Free Black Political Prisoners/POWs. The Interfaith Prisoners of Conscience Project of the National Council of Churches has launched the Sponsor a Prisoner project, whereby local congregations can link up with prisoners and help break down the dehumanizing process of prison. Myriad other community groups continue their efforts. Of course, much work and education remains to be done. Political prisoners are the conscience of the left. They come from diverse political and social backgrounds yet share a deep commitment to justice. Their struggles for a more just world have landed them in the place most representative of the hypocrisy of our free and just society. As activists, our responsibility is not only to carry on their struggles but also to continue to struggle for their release. 3.5. International Tribunal of Indigenous Peoples and Oppressed Nations in the USA. October 2 to 4, 1992. San Francisco, California. 3.5. That everyone resist. That no one stay behind, the legend of Populva. On October 2 to 4, 1992, the eve of the 500th anniversary of Columbus's invasion of the Americas, a historic International Tribunal of Indigenous Peoples and Oppressed Nations convened in San Francisco, California, USA. Initiated by the American Indian Movement and joined by representatives of the Puerto Rican, New African, and Mexicano movements as well as progressive white North Americans, the tribunal placed the U.S. federal government on trial for grave crimes against humanity. As the contemporary inheritors of the Columbus legacy of colonialism, genocide, and political internment, representatives of the U.S. government Attorney General William Barr in Washington, D.C., and John Mendez, the U.S. Attorney in San Francisco were formally served with the indictment on September 23, 1992. In a published statement to Reuters News Service, the U.S. government acknowledged receipt of the indictment and stated that it refused to avail itself of the opportunity to offer a defense of the federal government. During the weekend of October 2, over 1,000 people from every region of the U.S., as well as Canada, Spain, the Philippines, Germany, Puerto Rico, Hawaii, Haiti, South Africa, and Peru, attended or participated in the tribunal. A distinguished panel of international judges, each with long experience in human rights, heard testimony, deliberated for 12 hours and rendered the preliminary verdict contained in this volume. Following the tradition of other international tribunals, such as the Bertrand Russell Tribunal, which judged U.S. war crimes during the Vietnam War, this tribunal's findings will be brought before the United Nations and other international bodies. It is important to underscore that the authority of the tribunal and its verdict rests in its scrupulous adherence to international law and the urgent demand by our peoples that the U.S. government be held accountable for its historical and present-day crimes. With 1993 designated by the United Nations as the Year of Indigenous Peoples, it is our hope that this verdict will make a serious contribution to our people's effort to assume our rightful place in the international community. From the outset of this process more than a year ago, the aims of the tribunal were defined as to destroy the myth of the European discovery of the Americas and make clear that Columbus and the Europeans who later followed him were conquerors and not discoverers of a new world. To provide a forum for a broader understanding of the human right to self-determination for Native Americans, Puerto Ricans, New Africans, and Mexicans. To understand the history of the U.S. as a country that became the inheritor of the European legacies of colonialism, genocide, and racism. To demand the immediate, unconditional release of the more than 100 political prisoners and prisoners of war from the different movements, such as Leonard Peltier, Eddie Hatcher, Norma Jean Croix, Alejandrina Torres, Oscar Lopez, Geronimo G. Jaga, Mumia Abu-Jamal, Sylvia Beraldini, and many others presently in U.S. prisons. For our peoples and nations, the common experience of 500 years of resistance teaches us all too well that the U.S. has never respected moral principles, treaties, or international law. From the regime first imposed upon us in the Caribbean by Columbus 500 years ago, up to the present-day New World Order proclaimed by the U.S. government, the pursuit of wealth and domination has brought only genocide and ruin to our sacred Mother Earth. Now that the end of the 20th century is nearly upon us, it is time for this predatory way of life to end. This criminal system is driving us all, from every part of this planet, into the 11th hour of global crisis. With the urgent need to restore justice, balance, mutual respect, and dignity foremost in our minds, our movements humbly bring this indictment and verdict to our peoples and the world. Preliminary finding of fact and order. Distinguished jurors composing the International Tribunal. Francisca Villalba Moreno, J.D. Attorney and expert on international law and political prisoners from Spain. Dale Marie Standing Alone, leader of the Blood Tribe, member of the Blackfoot Nation in Canada. Norbert George, member, Board of Directors of the Society for Threatened Peoples, the second largest human rights organization in the world. Mitsuya Yamada, poet and author, formerly on the National Board of Directors of Amnesty International USA, interned in Idaho during World War II. Dr. Ray Richardson, Professor Emerita, Black History, co-founder and co-owner of Marcus Bookstores, specializing in books by and about Black people, and well-respected elder in the Black community. Adora Faye de Vera, former political prisoner from the Philippines, poet and founding member of Kaiba, the Philippines' only women's political party. Rory Snow Arrow Fawcett, J.D. Professor, Native American Studies, University of California at Berkeley. Distinguished witnesses appearing before the International Tribunal. Charge of genocide. Native Americans. Dr. Kakuni Blaisdell, Pro-Hawaii Sovereignty Working Group. Professor Elizabeth Parent, Head of Native American Studies, San Francisco State University. New Africans. Oba T. Chaka, Professor, San Francisco State University. Daramola Cabral Evans, Epidemiologist, Hartford Hospital. Mexicans. Maria Ortiz, Mexican Democratic Forum, San Jose, California. Puerto Ricans. Deborah Santana, Puerto Rican environmentalist. Rafael Cancel Miranda, Puerto Rican national hero. Charge of human rights violations. Native Americans. Sage La Pina Wintu Namdapam, human rights activist. Tom Goldtooth, environmental coordinator from the Red Lake Band of Chippewa, acting co-director, Indigenous Environmental Network. New Africans. Emory Douglas, founding member, Black Panther Party. Maja Shakir, co-coordinator, International Campaign to Free Geronimo G. Jaga. Mexicans. Ricardo Garcia, Regeneration Human Rights Group. Jose Rico, co-founder, Frente Estudiantil de Liberación Nacional. Puerto Ricans. Carmen Vazquez, Board of Directors, National Gay and Lesbian Task Force. Perry Thomas, poet and author of Down These Mean Streets. Charge of political prisoners and prisoners of war. Native Americans. Bob Robideau, co-defendant of Leonard Peltier, National Coordinator, Leonard Peltier Defense Committee. Ward Churchill, Professor, University of Colorado, noted author and co-director, Colorado American Indian Movement. New Africans. Watani Tihimba, former political prisoner, National Secretary of the New African Peoples Organization. Mexicans. Ricardo Sanchez, former political prisoner, Professor, Washington State University. Puerto Ricans. Carlos Ortiz, National Coordinator of the National Committee to Free Puerto Rican Prisoners of War and Political Prisoners. White North Americans. Rita Bo Brown, former political prisoner. 3.5.b. Indictment of the Federal Government of the United States of America for the commission of international crimes and petition for orders mandating its proscription and dissolution as an international criminal conspiracy and a criminal organization. All citizens of the world community have both the right and the duty under public international law to sit in judgment over a gross and consistent pattern of violations of the most fundamental norms of international criminal law committed by any member state of that same world community. Such is the case for the International Tribunal of Indigenous Peoples and Oppressed Nations in the United States of America that convenes in San Francisco during the weekend of October 2 to 4, 1992. Its weighty but important task is to examine the long history of international criminal activity that has been perpetrated by the federal government of the United States of America against the indigenous peoples and peoples of color living in North America since it was founded in 1787. Toward that end, I have the honor to present to the members of this tribunal the following charges against the federal government of the United States of America under international criminal law. In light of the gravity, severity, and long-standing nature of these international crimes, and also in light of the fact that the federal government appears to be irrevocably committed to continuing down this path of lawlessness and criminality against indigenous peoples and peoples of color living in North America and elsewhere, I hereby petition the members of this tribunal to issue an order proscribing the federal government of the United States of America as an international criminal conspiracy and a criminal organization under the Nuremberg Charter, judgment, and principles as well as other sources of public international law specified below. For that reason, I also request that the members of the tribunal issue an order dissolving the federal government of the United States of America as a legal and political entity. Finally, I ask this tribunal to declare that international legal sovereignty over the territories principally inhabited by the Native American peoples, the New African people, the Mexicano people, and the people of Puerto Rico resides in the hands of these respective peoples themselves. In this regard, I should point out that the final decision of this tribunal will qualify as a judicial decision within the meaning of Article 38 of the Statute of the International Court of Justice and will therefore constitute a subsidiary means for the determination of rules of law for international law and practice. The Statute of the International Court of Justice is an integral part of the United Nations Charter under Article 92 thereof. Thus, this tribunal's decision can be relied upon by some future international criminal court or tribunal, as well as by any people or state of the world community that desires to initiate criminal proceedings against named individual for the commission of the following international crimes. The decision of this tribunal shall serve as adequate notice to the appropriate officials in the United States federal government that they bear personal responsibility under international law and the domestic legal systems of all peoples and states in the world community for designing and implementing these illegal, criminal, and reprehensible policies and practices against indigenous peoples and peoples of color living in North America. Hereinafter, the federal government of the United States of America will be referred to as the defendant. Bill of Particulars against the Federal Government of the United States of America. The Native American Peoples. 1. The defendant has perpetrated innumerable crimes against peace, crimes against humanity, and war crimes against Native American peoples as recognized by the Nuremberg Charter, judgment, and principles. 2. The defendant has perpetrated the international crime of genocide against Native American peoples as recognized by the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. 3. The defendant has perpetrated the international crime of apartheid against Native American peoples as recognized by the 1973 International Convention on the Suppression and Punishment of the Crime of Apartheid. 4. The defendant has perpetrated a gross and consistent pattern of violations of the most fundamental human rights of Native American peoples as recognized by the 1948 Universal Declaration of Human Rights. 5. The defendant has perpetrated numerous and repeated violations of the 1965 International Convention on the Elimination of All Forms of Racial Discrimination against Native American peoples. 6. The defendant has systematically violated 371 treaties it concluded with the Native American peoples in wanton disregard of the basic principle of public international law and practice dictating pacta sunt servanda. 7. The defendant has denied and violated the international legal right of Native American peoples to self-determination as recognized by the 1945 United Nations Charter, the 1966 International Covenant on Civil and Political Rights, the 1966 International Covenant on Economic, Social, and Cultural Rights, Fundamental Principles of Customary International Law, and Jus Cogens. 8. Defendant has violated the seminal United Nations Declaration of the Granting of Independence to Colonial Countries and Territories of 1960 with respect to Native American peoples and territories. Pursuant thereto, the defendant has an absolute international legal obligation to decolonize Native American territories immediately and to transfer all powers it currently exercises there to the Native American peoples. 9. The defendant has illegally refused to accord full-scope protections as prisoners of war to captured Native American independence fighters in violation of the Third Geneva Convention of 1949 and Additional Protocol I thereto of 1977. The defendant's treatment of captured Native American independence fighters as common criminals and terrorists constitutes a grave breach of the Geneva Accords and thus a serious war crime. 10. The defendant has deliberately and systematically permitted, aided and abetted, solicited and conspired to commit the dumping, transportation, and location of nuclear, toxic, medical, and otherwise hazardous waste materials on Native American territories across North America and has thus created a clear and present danger to the lives, health, safety, and physical and mental well-being of Native American peoples in gross violation of Article 3 and Article 2 of the 1948 Genocide Convention. Inter alia, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. The New African People. 11. The defendant has perpetrated the international crime of slavery upon the New African people as recognized in part by the 1926 Slavery Convention and the 1956 Supplementary Convention on the Abolition of Slavery, the Slave Trade, and institutions and practices similar to slavery. The defendant has illegally refused to pay reparations to the New African people for the commission of the international crime of slavery against them in violation of basic norms of customary international law requiring such reparations to be paid. 12. The defendant has perpetrated innumerable crimes against humanity against the New African people as recognized by the Nuremberg Charter, Judgment, and Principles. 13. The defendant has perpetrated the international crime of genocide against the New African people as recognized by the 1948 Genocide Convention. 14. The defendant has perpetrated the international crime of apartheid against the New African people as recognized by the 1973 Apartheid Convention. 15. The defendant has perpetrated a gross and consistent pattern of violations of the most fundamental human rights of the New African people as recognized by the 1948 Universal Declaration of Human Rights and the two aforementioned United Nations Human Rights Covenants of 1966. 16. The defendant has perpetrated a gross and consistent pattern of violations of the 1965 Racism Convention against the New African people. The defendant is the paradigmatic example of an irremediably racist state in international relations today. 17. The defendant has denied and violated the international legal right of the New African people to self-determination as recognized by the United Nations Charter, the two United Nations Human Rights Covenants of 1966, customary international law, and jus cogens. 18. The defendant has illegally refused to apply the United Nations Decolonization Resolution of 1960 to the New African people and to the territories that they principally inhabit. Pursuant thereto, the defendant has an absolute international legal obligation to decolonize New African territories immediately and to transfer all powers it currently exercises there to the New African people. 19. The defendant has illegally refused to accord full-scope protections as prisoners of war to captured New African independence fighters in violation of the Third Geneva Convention of 1949 and Additional Protocol I thereto of 1977. The defendant's treatment of captured New African independence fighters as common criminals and terrorists constitutes a grave breach of the Geneva Accords and thus a serious war crime. The Mexicano people. 20. In 1821, Mexico obtained its independence from Spain as a sovereign mestizo state, extending from Yucatan and Chiapas in the south, to the northern territories of California and New Mexico, which areas the defendant today calls the states of Texas, California, Arizona, Nevada, Utah, New Mexico, and Colorado. Nevertheless, in 1836 so-called settlers under the sponsorship of the defendant began the division of the Mexicano people and state by causing the division of the Mexican state of Coahuila, Texas into the Mexican state of Coahuila and the so-called Republic of Texas. 21. In 1846, the defendant perpetrated an unjust, illegal, and unjustifiable war upon the remainder of the sovereign people and state of Mexico that violated every known principle of public international law in existence at that time, including, but not limited to, the Christian doctrine of just war, which was the reigning standard of customary international law. As a result thereof, the defendant illegally annexed close to 51% of the territories of the sovereign state of Mexico by means of forcing it to conclude the 1848 Treaty of Guadalupe Hidalgo under military duress. For these reasons, this treaty was and still is null and void ab initio as a matter of public international law. The defendant acquired more Mexican territory through the Gadsden Treaty of 1854. 22. Since these 1848 and 1854 treaties, the defendant has perpetrated the international crime of genocide against the Mexicano people living within these occupied territories, as recognized by the 1948 Genocide Convention. 23. The defendant has perpetrated the international crime of apartheid against the Mexicano people living within these occupied territories, as recognized by the 1973 Apartheid Convention. 24. The defendant has perpetrated a gross and consistent pattern of violations of the most fundamental human rights of the Mexicano people living within these occupied territories, as recognized by the 1948 Universal Declaration of Human Rights and the two aforementioned United Nations Human Rights Covenants of 1966. 25. The defendant has perpetrated a gross and consistent pattern of violations of the 1965 Racism Convention against the Mexicano people living within these occupied territories. 26. The defendant has denied and violated the international legal right of the Mexicano people living within these occupied territories to self-determination as recognized by the United Nations Charter, the two United Nations Human Rights Covenants of 1966, customary international law, and jus cogens. 27. Since the militarily imposed division of the Mexican state, the defendant and its agents have militarily occupied other portions of the Mexican state, have sought to influence the outcome of the Mexican Revolution of 1910, have practiced a consistent pattern of intervention into Mexico's internal affairs, all of which have resulted in the arresting distortion and deformation of the Mexican social and economic order. In this regard, defendants' so-called North American Free Trade Agreement constitutes nothing more than an attempt to impose its hegemonial imperialism, economic colonialism, and human exploitation upon the people and state of Mexico. 28. The defendant has illegally refused to apply the United Nations Decolonization Resolution of 1960 to the Mexicano people and to these occupied territories that they inhabit. Pursuant thereto, the defendant has an absolute international legal obligation to decolonize both the Mexican occupied territories and the Republic of Mexico immediately, and to transfer all powers it currently exercises there to the Mexicano people. The people and state of Puerto Rico. 29. Since its illegal invasion of Puerto Rico in 1898, defendant has perpetrated innumerable crimes against peace, crimes against humanity, and war crimes against the people and state of Puerto Rico as recognized by the Nuremberg Charter, judgment, and principles. 30. The defendant has perpetrated the international crime of genocide against the Puerto Rican people as recognized by the 1948 Genocide Convention. 31. The defendant has perpetrated the international crime of apartheid against the Puerto Rican people as recognized by the 1973 Apartheid Convention. 32. The defendant has perpetrated a gross and consistent pattern of violations of the most fundamental human rights of the Puerto Rican people as recognized by the 1948 Universal Declaration of Human Rights and the two aforementioned United Nations Human Rights Covenants of 1966. 33. The defendant has perpetrated a gross and consistent pattern of violations of the 1965 Racism Convention against the Puerto Rican people. 34. The defendant has denied and violated the international legal right of the Puerto Rican people to self-determination as recognized by the United Nations Charter, the two United Nations Human Rights Covenants of 1966, customary international law, and jus cogens. 35. The defendant has illegally refused to apply the United Nations Decolonization Resolution of 1960 to Puerto Rico. Pursuant thereto, the defendant has an absolute international legal obligation to decolonize Puerto Rico immediately and to transfer all powers it currently exercises there to the Puerto Rican people. 36. The defendant has illegally refused to accord full-scope protections as prisoners of war to captured Puerto Rican independence fighters in violation of the Third Geneva Convention of 1949 and Additional Protocol I thereto of 1977. The defendant's treatment of captured Puerto Rican independence fighters as common criminals and terrorists constitutes a grave breach of the Geneva Accords and thus a serious war crime, an international criminal conspiracy and a criminal organization. 37. In light of the foregoing international crimes, the defendant constitutes a criminal conspiracy and a criminal organization in accordance with the Nuremberg Charter, judgment, and principles and the other sources of public international law specified above. The federal government of the United States of America is similar to the Nazi government of World War II Germany. Indeed, the defendant's president, George Bush, has proclaimed a so-called New World Order that sounds and looks strikingly similar to the New Order proclaimed by Adolf Hitler over 50 years ago. Conclusion. Like unto a pirate, the defendant is hostis humani generis, the enemy of all humankind. For the good of all humanity, this tribunal must condemn and repudiate the federal government of the United States of America and its grotesque vision of a new world order that is constructed upon warfare, bloodshed, violence, criminality, genocide, racism, colonialism, apartheid, massive violations of fundamental human rights, and the denial of the international legal right of self-determination to the indigenous peoples and peoples of color living in North America and elsewhere around the world. Consequently, this tribunal must find the defendant guilty as charged on all counts specified above beyond a reasonable doubt. This tribunal must also issue an order that formally proscribes the federal government of the United States of America as a criminal conspiracy and a criminal organization. This tribunal must also issue a separate order mandating the dissolution of the federal government of the United States of America as a legal and political entity. Finally, this tribunal must declare that international legal sovereignty over the territories inhabited by the Native American peoples, the New African peoples, the Mexicano people, and the people of Puerto Rico, resides, respectively, in the hands of these peoples themselves. The very lives, well-being, health, welfare, and safety of the indigenous peoples and peoples of color living in North America and elsewhere around the world depend upon the ultimate success of your deliberations. Respectfully submitted by Francis A. Boyle, Professor of International Law, Special Prosecutor. Dated, September 18, 1992. 3.5.c. Verdict of the International Tribunal of Indigenous Peoples and Oppressed Nations in the United States of America, San Francisco, California. Native American peoples, New African people, Mexicano people, and Puerto Rican people. Plaintiffs versus the Federal Government of the United States of America. Defendant. Preliminary findings and order. This matter having come before the International Tribunal of Indigenous Peoples and Oppressed Nations in the United States of America, hereinafter tribunal by request of representatives of the Native American peoples, the New African people, the Mexicano people, and the Puerto Rican people, the indictment of the federal government of the United States of America for the commission of international crimes and petition for orders mandating its proscription and dissolution as an international criminal conspiracy and a criminal organization having been presented by Special Prosecutor Francis Boyle, the Native American peoples having appeared personally and by counsel, Brian Savage, the New African people having appeared personally and by counsel, James Simmons, the Mexicano people having appeared personally and by counsel, Guillermo Suarez, the Puerto Rican people having appeared personally and by counsel, Dennis Cunningham and Rachel Laderman. The white North American people having appeared on the issue of political prisoners personally and by counsel, Marilyn Kalman, the United States government having failed to appear personally or by counsel, the tribunal having completed its preliminary consideration of the testimonial evidence, the documentary evidence, the argument of counsel, and otherwise being fully informed of the premises, finds that 1. The defendant, the federal government of the United States of America, has been duly served with summons and process. 2. This tribunal has jurisdiction over the parties, in the name of the peoples whom the plaintiffs represent. 3. The plaintiff parties consider that the judgments of this tribunal qualify as judicial decisions within the meaning of Article 38 of the Statute of the International Court of Justice. 4. The following sources and principles of law are applicable. A. The Nuremberg Charter, Judgment, and Principles. B. The 1948 Convention on the Prevention and Punishment of the Crime of Genocide. C. The 1973 International Convention on the Suppression and Punishment of the Crime of Apartheid. D. The 1948 Universal Declaration of Human Rights. E. The 1965 International Convention on the Elimination of All Forms of Racial Discrimination. F. The 1945 United Nations Charter. G. The 1966 International Covenant on Civil and Political Rights. H. The 1966 International Covenant on Economic, Social, and Cultural Rights. I. The 1960 United Nations Declaration of the Granting of Independence to Colonial Countries and Territories. J. The Third Geneva Convention of 1949 and Additional Protocol I thereto of 1977, and United Nations Resolution 3103-15. K. The 1926 Slavery Convention. L. The 1956 Supplementary Convention on the Abolition of Slavery, the Slave Trade, and Institutions and Practices Similar to Slavery. M. The 1960 United Nations Decolonization Resolution. N. The 1969 American Convention on Human Rights. O. The 1981 United Nations Declaration on the Elimination of All Forms of Intolerance and of Discrimination based on Religion or Belief. P. The 1984 United Nations Declaration on the Right of Peoples to Peace. Q. The 1989 United Nations Convention on the Rights of the Child. R. The 1987 United Nations Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. S. The Principles of the Common Law. T. The Principles of the Civil Law. U. International Custom. V. The General Principles of Law recognized by civilized nations, and W. Judicial decisions and the teachings of the most highly qualified publicists of the various nations of the world. Native Americans. 5. With respect to the charges brought by the Native American peoples, the tribunal finds, by unanimous vote, the defendant, the federal government of the United States of America, is guilty as charged in. The defendant has perpetrated innumerable crimes against peace, crimes against humanity, and war crimes against Native American peoples as recognized by the Nuremberg Charter, Judgment, and Principles. The defendant has perpetrated the international crime of genocide against Native American peoples as recognized by the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. The defendant has perpetrated the international crime of apartheid against Native American peoples as recognized by the 1973 International Convention on the Suppression and Punishment of the Crime of Apartheid. The defendant has perpetrated a gross and consistent pattern of violations of the most fundamental human rights of Native American peoples as recognized by the 1948 Universal Declaration of Human Rights. The defendant has perpetrated numerous and repeated violations of the 1965 International Convention on the Elimination of All Forms of Racial Discrimination against Native American peoples. The defendant has denied and violated the international legal right of Native American peoples to self-determination as recognized by the 1945 United Nations Charter, the 1966 International Covenant on Civil and Political Rights, the 1966 International Covenant on Economic, Social, and Cultural Rights, Fundamental Principles of Customary International Law, and Jus Cogens. The defendant has violated the United Nations Declaration of the Granting of Independence to Colonial Countries and Territories of 1960 with respect to Native American peoples and territories. Pursuant thereto, the defendant has an absolute international legal obligation to decolonize Native American territories immediately and to transfer all powers it currently exercises there to the Native American peoples. The defendant has deliberately and systematically permitted, aided and abetted, solicited and conspired to commit the dumping, transportation, and location of nuclear, toxic, medical, and otherwise hazardous waste materials on Native American territories across North America and has thus created a clear and present danger to the lives, health, safety, and physical and mental well-being of Native American peoples in gross violation of Article 3 and Article 2 of the 1948 Genocide Convention. Inter alia, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. Hawaiian peoples. 6. The tribunal further accepts a motion by the prosecutor for the Native American peoples to amend the face of the indictment to include the following allegation, which the tribunal unanimously finds has been sufficiently proved by the evidence it has received. The federal government of the United States of America has perpetrated crimes of genocide against the Kanak Maoli and has engaged in actions constituting gross violations of their human rights and their right to self-determination, all of which threaten to render the Kanak Maoli extinct. New Africans. 7. With respect to the charges brought by the new African people, the defendant, the federal government of the United States of America, is, by unanimous vote, guilty as charged in. The defendant has perpetrated the international crime of slavery upon the new African people as recognized in part by the 1926 Slavery Convention and the 1956 Supplementary Convention on the Abolition of Slavery, the slave trade and institutions and practices similar to slavery. The defendant has perpetrated innumerable crimes against humanity against the new African people as recognized by the Nuremberg Charter, Judgment, and Principles. The defendant has perpetrated the international crime of genocide against the new African people as recognized by the 1948 Genocide Convention. The defendant has perpetrated the international crime of apartheid against the new African people as recognized by the 1973 Apartheid Convention. The defendant has perpetrated a gross and consistent pattern of violations of the most fundamental human rights of the new African people as recognized by the 1948 Universal Declaration of Human Rights and the two aforementioned United Nations Human Rights Covenants of 1966. The defendant has perpetrated a gross and consistent pattern of violations of the 1965 Racism Convention against the new African people. The defendant is the paradigmatic example of an irremediably racist state in international relations today. The defendant has denied and violated the international legal right of the new African people to self-determination as recognized by the United Nations Charter, the two United Nations Human Rights Covenants of 1966, customary international law, and jus cogens. The defendant has illegally refused to accord full-scope protections as prisoners of war to captured new African independence fighters in violation of the Third Geneva Convention of 1949 and Additional Protocol I thereto of 1977. The defendant's treatment of captured new African independence fighters as common criminals and terrorists constitutes a grave breach of the Geneva Accords and thus a serious war crime. Mexicano people. 8. With respect to the charges brought by the Mexicano people, the defendant, the federal government of the United States of America, is guilty as charged in. Since these 1848 and 1854 treaties, the defendant has perpetrated the international crime of genocide against the Mexicano people living within these occupied territories, as recognized by the 1948 Genocide Convention. The defendant has perpetrated the international crime of apartheid against the Mexicano people living within these occupied territories, as recognized by the 1973 Apartheid Convention. The defendant has perpetrated a gross and consistent pattern of violations of the most fundamental human rights of the Mexicano people living within these occupied territories, as recognized by the 1948 Universal Declaration of Human Rights and the two aforementioned United Nations Human Rights Covenants of 1966. The defendant has perpetrated a gross and consistent pattern of violations of the 1965 Racism Convention against the Mexicano people living within these occupied territories. Puerto Rican people. 9. With respect to the charges brought by the Puerto Rican people, the defendant, the federal government of the United States of America, is, by unanimous vote, guilty as charged in. Since its illegal invasion of Puerto Rico in 1898, defendant has perpetrated innumerable crimes against peace, crimes against humanity and war crimes against the people and state of Puerto Rico as recognized by the Nuremberg Charter, Judgment, and Principles. The defendant has perpetrated the international crime of genocide against the Puerto Rican people as recognized by the 1948 Genocide Convention. The defendant has perpetrated the international crime of apartheid against the Puerto Rican people as recognized by the 1973 Apartheid Convention. The defendant has perpetrated a gross and consistent pattern of violations of the most fundamental human rights of the Puerto Rican people as recognized by the 1948 Universal Declaration of Human Rights and the two aforementioned United Nations Human Rights Covenants of 1966. The defendant has perpetrated a gross and consistent pattern of violations of the 1965 Racism Convention against the Puerto Rican people. The defendant has denied and violated the international legal right of the Puerto Rican people to self-determination as recognized by the United Nations Charter, the two United Nations Human Rights Covenants of 1966, customary international law, and jus cogens. The defendant has illegally refused to apply the United Nations Decolonization Resolution of 1960 to Puerto Rico. Pursuant thereto, the defendant has an absolute international legal obligation to decolonize Puerto Rico immediately and to transfer all powers it currently exercises there to the Puerto Rican people. The defendant has illegally refused to accord full-scope protections as prisoners of war to captured Puerto Rican independence fighters in violation of the Third Geneva Convention of 1949 and Additional Protocol I thereto of 1977. The defendant's treatment of captured Puerto Rican independence fighters as common criminals and terrorists constitutes a grave breach of the Geneva Accords and thus a serious war crime. White North American political prisoners. 10. With respect to the charges brought by the white people of North America, the defendant is, by unanimous vote, guilty of holding white North Americans as political prisoners. Additional findings. 11. In light of the foregoing findings, this tribunal also, by unanimous vote, finds the defendant guilty as charged in paragraph 37, which, as amended, reads: In light of the foregoing international crimes, the defendant constitutes a criminal conspiracy and a criminal organization in accordance with the Nuremberg Charter, judgment, and principles and the other sources of public international law specified above, and the federal government of the United States of America is similar to the Nazi government of World War II Germany. 12. With respect to the following charges brought by the Native American peoples. 6 members of the tribunal find the defendant guilty as charged in paragraph 6, which reads: The defendant has systematically violated 371 treaties it concluded with the Native American peoples in wanton disregard of the basic principle of public international law and practice dictating pacta sunt servanda. One member of the tribunal reserves the right to consider the documentary evidence further before making a final determination. 4 members of the tribunal find the defendant guilty as charged in paragraph 9, which reads: The defendant has illegally refused to accord full-scope protections as prisoners of war to captured Native American independence fighters in violation of the Third Geneva Convention of 1949 and Additional Protocol I thereto of 1977. The defendant's treatment of captured Native American independence fighters as common criminals and terrorists constitutes a grave breach of the Geneva Accords and thus a serious war crime. 3 members of the tribunal reserve the right to consider the documentary evidence further before making a final determination. 13. With respect to the following charges brought by the New African people. 4 members of the tribunal find the defendant guilty as charged in paragraph 11, which, as amended, reads: The defendant has illegally refused to pay reparations to the New African people for the commission of the international crime of slavery against them in violation of basic norms of customary international law requiring such reparations to be paid. 3 members of the tribunal reserve the right to consider the documentary evidence further before making a final determination. 3 members of the tribunal find the defendant guilty as charged in paragraph 18, which reads: The defendant has illegally refused to apply the United Nations Decolonization Resolution of 1960 to the New African people and to the territories that they principally inhabit. Pursuant thereto, the defendant has an absolute international legal obligation to decolonize New African territories immediately and to transfer all powers it currently exercises there to the New African people. 4 members of the tribunal reserve the right to consider the documentary evidence further before making a final determination. 14. With respect to the following charges brought by the Mexicano people. 6 members of the tribunal find the defendant guilty as charged in paragraph 20, which reads: In 1821, Mexico obtained its independence from colonial Spain as a sovereign mestizo state, extending from Yucatan and Chiapas in the south, to the northern territories of California and New Mexico, which areas the defendant today calls the states of Texas, California, Arizona, Nevada, Utah, New Mexico, and Colorado. Nevertheless, in 1836 so-called settlers under the sponsorship of the defendant began the division of the Mexicano people and state by causing the division of the Mexican state of Coahuila, Texas into the Mexican state of Coahuila and the so-called Republic of Texas. One member of the tribunal reserves the right to consider the documentary evidence further before making a final determination. B6 members of the tribunal find the defendant guilty as charged in paragraph 21, which reads: In 1846, the defendant perpetrated an unjust, illegal, and unjustifiable war upon the remainder of the sovereign people and state of Mexico that violated every known principle of public international law in existence at that time, including, but not limited to, the Christian doctrine of just war, which was the reigning standard of customary international law. As a result thereof, the defendant illegally annexed close to 51% of the territories of the sovereign state of Mexico by means of forcing it to conclude the 1848 Treaty of Guadalupe Hidalgo under military duress. For these reasons, this treaty was and still is null and void ab initio as a matter of public international law. The defendant acquired more Mexican territory through the Gadsden Treaty of 1854. One member of the tribunal reserves the right to consider the documentary evidence further before making a final determination. C5 members of the tribunal find the defendant guilty as charged in paragraph 26, which reads: The defendant has denied and violated the international legal right of the Mexicano people living within these occupied territories to self-determination as recognized by the United Nations Charter, the two United Nations Human Rights Covenants of 1966, customary international law, and jus cogens. Two members of the tribunal reserve the right to consider the documentary evidence further before making a final determination. D6 members of the tribunal find the defendant guilty as charged in paragraph 27, which reads: Since the militarily imposed division of the Mexican state, the defendant and its agents have militarily occupied other portions of the Mexican state, have sought to influence the outcome of the Mexican Revolution of 1910, have practiced a consistent pattern of intervention into Mexico's internal affairs, all of which have resulted in the arresting distortion and deformation of the Mexican social and economic order. In this regard, defendant's so-called North American Free Trade Agreement constitutes nothing more than an attempt to impose its hegemonic imperialism, economic colonialism, and human exploitation upon the people and state of Mexico. One member of the tribunal reserves the right to consider the documentary evidence further before making a final determination. E6 members of the tribunal find the defendant guilty as charged in paragraph 28, which reads: The defendant has illegally refused to apply the United Nations Decolonization Resolution of 1960 to the Mexicano people and to these occupied territories that they inhabit. Pursuant thereto, the defendant has an absolute international legal obligation to decolonize both the Mexican occupied territories and the Republic of Mexico immediately, and to transfer all powers it currently exercises there to the Mexicano people. One member of the tribunal reserves the right to consider the documentary evidence further before making a final determination. Now therefore, it is ordered, adjudged, and decreed that the defendant cease and desist from the commission of the crimes it has been found guilty of herein. This tribunal reserves the right to issue further relief after full consideration of the evidence. 3.6. Shasta Woman, The Story of Norma Jean Croix. B. 2008. The saga of Norma Jean Croix is but one of many in the ongoing racism and genocide endured by the indigenous people of this stolen land we so-called modern ones call the USA. Norma Jean was 24 and had known for some time that she liked women, but that's another story. This one begins July 16, 1978. It was another hot summer in Yreka, a northern California town full of deadly gold rush history. On this day, she, along with friends and relatives, was enjoying a weekend street fair filled with dancing and home visits and, of course, drinking. They all decided to go to Grandma's house in the country, but first they needed to stop at the local mini-mart for cigarettes and other supplies. It was near midnight, and the clerk became verbally abusive with Hootie, accusing them of short-changing him. This was merely life as usual for Indian youth who were treated every day in this way by the locals and their cowboy mentality. There was a scuffle of sorts, when the clerk became physical in his abuse. Just as Norma and her friends ran out of the store, a police squad car rolled by and the clerk yelled, "Get them!" Thus began the chase. The police radio squawked about a carload of Injuns. One cousin woke up from a nap in the back seat and tried to shoot the headlights out of the pursuing night riders. His single shot didn't even hit the road. When they got to Grandma's, 3 took their chances by running into the darkness. 2 surrendered and were handcuffed, beaten, and strategically placed in the direct line of fire. Norma Jean and one cousin ran up a hill covered in sagebrush. She was shot in the back. The cousin was shot in the groin as he raised his hands in surrender. The cops also committed friendly fire and got one their own in the hand. Hootie had managed to get to the back of Grandma's cabin to check on her. An off-duty cop, Hit's son, who had also been drinking, opened fire on Hootie without warning. One bullet entered the buttocks and traveled down the leg. The second bullet tore through the rear upper arm, exiting out the front. Hootie took the old single-shot .22 rifle, turned and fired. Hit's son died immediately. More than 200 automatic weapon rounds were fired by the police. The ensuing trial and ridiculous sentences were but further proof of the history of fear and racism directed at Shasta and Yurok and Karuk Native people of Northern California. Hootie got the death penalty and Norma Jean got life. Years later this same history would be brilliantly used by San Francisco attorney Tony Serra as grounds for self-defense in Hootie's bid for a new trial in 1985. It was culturally and logically proven beyond a shadow of a doubt that a native person from this region should expect to be murdered by a policeman who was repeatedly shooting him/her in the back. He was found not guilty in May 1990. However, even though they were co-defendants, Norma Jean received no benefit from this decision. His was a death penalty case that afforded him mandatory appeals. She got none of that and so remained in prison. The obvious lesbian Butch Shasta Native woman, Norma Jean Croy, was also denied parole at least 4 or 5 times. While working on a San Francisco 1992 international tribunal focusing on 500 years of colonialism and political prisoners in the USA, I was approached by Hootie, who had a hard time saying it, but got it done. My sister is a lesbian and she needs your help. And this was the birth of the Norma Jean Croy Defense Committee that became an amazing grassroots cooperative working group of mostly women. White activist dykes and Native women, their families and communities, came together with no funding. Attorney Diana Samuelson was the legal expert who worked out of Tony Serra's office with access to all the pertinent files. Nilak Butler, who survived Wounded Knee, John Ella LaRose, Yvonne Wanrao, and several other women of all red nations did amazing jobs within their community. We became regular visitors at Chowchilla Prison for Women in the almond orchards of California. Many benefits were held wherever possible, most being within the lesbian/gay community of the SF Bay Area. Artists donated their time. Out of Control Lesbian Committee to support women political prisoners placed Norma Jean on its list for commissary funding and included her regularly in the Out of Time newspaper. Hundreds of speaking gigs were held. Many envelopes were stuffed and many potlucks were eaten. Information was regularly presented at the lesbian and gay pride events in the SF area and beyond. Every opportunity that could be found was used to spread the word. In 1993 the International Indigenous Peoples Conference declared Norma Jean Croy a political prisoner and declared her case evidence of the government's continuing assault on Native peoples that followed the FBI incident at Oglala, North Dakota. 2 films were made about the case. Shasta Woman, by me, was made totally by volunteers and was shown at the SF International Lesbian and Gay Film Festival in 1994. I did receive some funding from the Paul Robeson Fund for distribution and was able to send a few hundred copies across the country and some to Europe. Steve Potapov did a longer film, Reasons to Fear, The Cultural Defense of Hootie Croy, which was released after Norma's release in 1998. People understood this case instantly. It was the epitome of racism and classism and homophobia for thousands to easily recognize and realize. It transcended any simple definition of political prisoner. It was the reflection of all colonialism that could not be denied. It was the base for all the murder and rape and enslavement and oppression that is American history. Norma Jean Croy was released and credited with time served in February 1997. Many celebrations were held. Norm stayed around the Bay Area for a few years trying to work and love and live. But really she ain't no urban Indian. She lives in the country of Northern California and is a very happy farmer now. Some folks see her from time to time and she is not drinking and is in good health, doing well and smiling. We wish her continued good health and happiness. 3.7 United Nations Draft Declaration on the Rights of Indigenous People. Leonard Peltier. November 30, 2004. Sisters, brothers, friends, and supporters. Indigenous peoples of the United States are no strangers to hardship and abuse at the hands of the oppressor. We also are no strangers to treaty negotiation and betrayal. Between 1778, when the first treaty was signed with the Delawares, and 1868, when the final one was completed with the Nez Perces, there were hundreds of treaties between the U.S. government and the Indian nations. Not one of these treaties was honored by the government. The United Nations itself says that human rights must be applied to all peoples without discrimination. Accordingly, the United Nations Draft Declaration for the Rights of Indigenous Peoples was adopted by the UN Subcommission for the Prevention of Discrimination and Protection of Minorities in 1994. The text of the declaration has been endorsed and supported by hundreds of indigenous peoples and organizations around the world as the minimum standard required for the recognition and protection of indigenous peoples' rights internationally. However, there have been continued attempts by some states to undermine efforts to protect the human rights of the indigenous peoples. We cannot allow our rights to be negotiated, compromised, or diminished by the oppressor or by the UN process, which was initiated more than 20 years ago. Yesterday, the indigenous peoples delegates declared a hunger strike and spiritual fast inside the United Nations Palais des Nations in Geneva, Switzerland, to call the world's attention to these attempts to weaken the draft declaration on the rights of indigenous peoples. This week, I urge you to send expressions of solidarity to our brave sisters and brothers and letters of support for the adoption of the current text of the UN Draft Declaration on the Rights of Indigenous Peoples. Thank you for caring. Mitakai Oyasin. In the Spirit of Crazy Horse. 3.8 The International Indian Treaty Council and Indigenous Prisoners' Struggles. The work for American Indian Movement political prisoner Leonard Peltier has taken many forms over many years. On the international level, the International Indian Treaty Council has long been a leader of the work, especially relating to the United Nations and official intergovernmental bodies. The documents included over the following pages include some significant IITC resources. The IITC had also actively attempted to bring attention to the ongoing persecution of indigenous prisoners who try to practice their religious beliefs in U.S. prisons. The documents included over the following pages are some examples of this work. 3.8.a Excerpt from a written intervention to the United Nations Commission on Human Rights. 60th Session, March 15 to April 23, 2003 Agenda Item 11, Civil and Political Rights. A. Detention. The Justice Department as a branch of the United States government, has a legally binding trust responsibility to protect traditional native religions, spiritual and cultural practices. The international community recognizes that persons under detention are not exempt from human rights protections and accords this vulnerable population special protections. In January 2003 testimony was presented at U.S. Civil Rights Commission hearings in Albuquerque, New Mexico, addressing violations of the spiritual, cultural, and religious rights of Native prisoners in the U.S. federal and state prison systems. Leonard Foster, coordinator of the National Native American Prisoners' Rights Advocacy Coalition, director of the Navajo Nation Corrections Project and board member of the IITC, testified that prisons in Arizona, California, Texas, South Dakota, Montana, Kansas, Colorado, Utah, Minnesota, and New Mexico continued to violate religious freedom provisions mandated for American Indian prisoners by both U.S. and international law. In November 2002, Mr. Foster presented similar violations to the U.S. Department of Justice Civil Rights Division in Washington, D.C., including a. Denials of access to traditional ceremonies. B. Lack of equal access to religious and spiritual leaders. C. Lack of equal access to religious items. D. Denial of the right to wear long hair or traditional hairstyle according to the religious customs of respective Indian nations. E. Denials of access to ceremonial foods. F. Transfer to state facilities where American Indian religious practices are prohibited. And G. Denial of access to traditional counseling and ceremonies, including requested last rites ceremonies for American Indian inmates on death row. Both federal agencies committed to investigate and address these problems, but to the knowledge of those involved, nothing has been done to date. Since that time, the IITC and the National Native American Prisoners' Rights Advocacy Coalition have received reports of new and continuing violations, including State of California Department of Corrections grooming regulations mandating forced haircutting, despite requests for religious exemptions for Native prisoners, and continued denial of sweat lodge ceremonies by the Texas Department of Corrections. Recent court cases filed by Native prisoners and their advocates have upheld these denials, confirming the lack of effective redress through domestic remedies. Prison officials cited security concerns, which seems to be all that is required for the Justice Department, now a part of the new U.S. Department of Homeland Security, to forego civil and human rights protections, including freedom of religion guaranteed by its own constitution. These violations of federally and internationally protected rights have been presented at congressional hearings in 1978, 1992, and 1994. Similar testimony has been presented by the IITC to this commission in various past sessions, as well as at the World Conference Against Racism in 2001 and to the UN. Special Rapporteur on Religious Intolerance, Mr. Abdel Fattah Amor, on his visit to the U.S. in 1999. These policies directly affect the spiritual well-being and cultural survival of virtually every Indian nation because of the high population of incarcerated Indian prisoners. The adoption and enforcement by state and federal prison systems of policies and regulations to protect against religious intolerance and racial discrimination is essential to ensure Native American prisoners access to healing and recovery through traditional religious practices and worship. We call upon this commission to recognize the urgent need for international oversight and further investigation of these serious ongoing human rights violations in order to ensure that the freedom of religion for Native prisoners is protected. 3.8.b. Written intervention submitted to the United Nations Commission on Human Rights regarding the new restrictions of religious practices in U.S. state and federal prisons. 61st Session, March 14 to April 22, 2005. Agenda Item 11, Civil and Political Rights including the questions of religious intolerance. Read by Lenny Foster, IITC Board Member. The American Indian prisoners in the United States prison system are facing new restrictive policies on their religious and spiritual practices that make healing and rehabilitation in the traditional manner virtually impossible. These new restrictions include a 4-hour time limit on the sweat lodge ceremony that includes the heating of the stones, which takes 2 hours and 2 hours for the actual ceremony. Rushing through an ancient old ceremony is not proper because the ceremony is very sacred. The deliberate attempt to shorten the hours and circumvent the ceremony is sacrilegious and undermining the seriousness and sacredness of the spiritual healing and blessings. B. Supervision of the sweat lodge by the chaplain is not necessary because it takes away time from other spiritual and cultural activities such as the talking circle, drumming sessions, and pipe ceremonies that also mandate the presence of the chaplain. C. Rationing of the firewood has deliberately undermined the heating of the stones because the stones need to heated for at least 2 hours or else the stones are cold and the sweat lodge is not complete and/or beneficial to the healing and prayers. D. Mandating the English-only requirement for the ceremony is discrimination and racist because the native language is used and needed for the songs and prayers to be blessed by the Creator. When the traditional ceremonies are held in the ancient and sacred way and manner, the native prisoners receive the beneficial rehabilitation and spiritual healing. The sweat lodge ceremony has been the foundation of the healing and recovery from alcohol and drugs, and it has been a very positive therapy for the native prisoners. All the traditional practices and beliefs are very important for the rehabilitation and recovery, or the experience of incarceration becomes nothing more than warehousing human beings. Leonard Peltier, who has been incarcerated in the United States Penitentiary Leavenworth, Kansas for 28 years, is a traditional practitioner of these practices and beliefs and is a beneficiary of this religious freedom struggle. All American Indian nations and spiritual leaders need to be consulted to rectify these new policies. To deny these basic human rights and show indifference to a dignified spiritual healing is tantamount to a cultural genocide of a young generation of American Indian prisoners. Thank you. 3.8.c. Urgent Appeal to United Nations Working Group on Arbitrary Detentions, Part 4.c, Leonard Peltier, AIM activist and human rights defender. July 6, 2005. Dear members of the Working Group on Arbitrary Detentions, please receive the respectful greetings of the International Indian Treaty Council. On September 12, 2004, the IITC submitted a communication to the United Nations Working Group on Arbitrary Detentions regarding the conviction and imprisonment of Leonard Peltier, considered by the IITC and many others throughout the world as a political prisoner of the United States government. The working group acknowledged this communication by telefax, dated October 7, 2004, also informing that the communication had been sent to the government of the United States with a formal letter concerning Mr. Peltier's detention. We understand that the working group has not received any response from them. It has been reported to us that on the morning of July 1, 2005, Cyrus Peltier went to visit his grandfather at the United States prison at Leavenworth, Kansas, as he has for the last 13 years. He was stopped at the visiting area and was told, "He's gone." Upon further inquiry, the grandson was told that Mr. Peltier had been transferred to the United States prison at Terre Haute, Indiana, USA. As the attached letter from the Leonard Peltier Defense Committee informs, Mr. Peltier was transferred on June 30, without notice to his family or attorneys. He is being kept in indefinite solitary confinement, without fresh air, without telephone privileges, without stamps for letters out. He is now 60 years old, a respected elder, and in frail health. He has many health problems including diabetes and will be without medication soon. We also understand that he is being denied access to his spiritual guide and practice. Mr. Peltier is and has been a model prisoner throughout his incarceration, in spite of its injustice. The authorities have not explained the reasons for the transfer or their callous treatment. As reported by our communication of September 2004, the Federal Bureau of Investigation spent a great deal of money to lobby against Mr. Peltier's receiving clemency and release from President Clinton during Mr. Clinton's last year in office. In another communication to the IITC, the LPDC also informs that although the Bureau of Prisons may argue that the placing of a transferred prisoner in solitary confinement is a routine procedure until all the appropriate paperwork is processed, the timing of this action adds to its cruelty since it was carried out right before the long weekend preceding this 4th of July. That solitary confinement, without human contact, continues to this day. We urge the Working Group on Arbitrary Detentions exercise its mandate under Urgent Appeals, Part 4.c in the case of Leonard Peltier. We again urge the Working Group to visit Mr. Peltier in prison. He is now located in solitary confinement at U.S. Penitentiary Terre Haute. As the attached letter from the LPDC requests, we are sending this communication to other relevant human rights mechanisms including the Special Representatives of the Secretary General on Human Rights Defenders, Mr. Adolfo Stavenhagen, the Special Rapporteur on the Human Rights of Indigenous Peoples, and Mr. Wilton Littlechild, member of the Permanent Forum on Indigenous Issues. We hope that they will join with you and your efforts on behalf of Mr. Peltier. If you have any questions or comment, please do not hesitate to communicate with us at the addresses found in the letterhead. We would very much appreciate acknowledgement of receipt of this urgent communication and updates on its progress. For all our relations. Alberto Saldamando, IITC General Counsel. 3.8.d. Letter from Leonard Peltier Defense Committee to International Indian Treaty Council. July 6, 2005. We are appealing to you on behalf of Leonard Peltier, an internationally known Native American political prisoner who has been in prison in the United States for almost 30 years. We recognize the work of the International Indian Treaty Council over many years to present the profound miscarriage of justice and human rights violations to which he has been subjected by the United States government at United Nations, in particular to the UN Commission on Human Rights and its Working Group on Arbitrary Detentions. We are requesting your urgent assistance in response to a new crisis situation which has further violated his rights and is currently threatening his health. Last Thursday, June 30, Mr. Peltier was moved without notice to his attorneys or his family from United States Federal Prison at Leavenworth, Kansas, to United States Prison at Terre Haute, Indiana. He is arbitrarily being held there in solitary confinement indefinitely. He was a well-respected model prisoner at Leavenworth. He is an elder, has many serious health problems, and poses no threat to the system. There is no basis for subjecting him to this kind of treatment. At Terre Haute he gets no fresh air, no phone privileges, he cannot write out because they give him hoe stamps, his medications will run out in a couple of days. USP. Terre Haute does not have a good record of taking care of prisoners' medical needs. We are asking with great urgency that you pass on this report on his status and ask for intervention on his behalf to the United Nations Commission on Human Rights, the Working Group on Arbitrary Detentions, and any other human rights bodies or rapporteurs you deem relevant. Thank you in advance for your efforts. 3.8.e. Resolution on Leonard Peltier. Commission on Prisoners' Rights. August 3-7, 2005. Whereas, the International Indian Treaty Council has consistently continued to support Leonard Peltier, his human rights and his immediate release. Whereas, a new crisis situation has arisen in which Peltier has and may be successively transferred to different prisons without the knowledge of his defense committee, family, and attorney and held in solitary confinement indefinitely without his basic human and prisoner rights. Whereas, the International Indian Treaty Council has taken the case of Leonard Peltier to the international arena, including the United Nations Commission on Human Rights as recently as July 2005, and whereas, the Leonard Peltier Defense Committee respects and appreciates this work of the International Indian Treaty Council, and now therefore be it resolved that the International Indian Treaty Council reaffirms its support of Leonard Peltier and will continue its work in support of his freedom on the international level, and that it will continue to appeal to the United Nations High Commissioner for Human Rights, its Working Group on Arbitrary Detentions, Special Rapporteur on Indigenous Human Rights, the Special Representatives of the Secretary General on Human Rights Defenders, members of the Permanent Forum on Indigenous Issues, the Office of Multilateral Affairs, Democracy, Human Rights and Labor of the United States State Department, Amnesty International, Human Rights Watch, the United States Bureau of Prisons and any other national and international agencies it deems useful to safeguard his human and prisoner rights, and be it further resolved that the International Indian Treaty Council will have a direct and structured process of communication with Leonard Peltier and his defense committee where the two entities will report to each other on a regular basis, that Leonard Peltier personally and through his designated representatives to be determined by Leonard Peltier, will have an active role in the International Indian Treaty Council's work at the UN on behalf of Leonard Peltier, and all claiming to represent Leonard Peltier will be verified by Leonard Peltier personally and by his defense committee headquarters wherever they may be located, and underscore 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 underscore. This resolution was adopted by consensus at the 31st Anniversary International Indian Treaty Council Conference hosted by the Confederacy of Treaty 6 First Nations, at Ermineskin Cree Nation, Alberta, Canada. Be it finally resolved that this resolution shall be the policy of the International Indian Treaty Council. Guatemala City, July 8, 2005. USP. Terre Haute. Director. Dear Director, With great concern I have received the news about Mr. Leonard Peltier's situation in the Terre Haute prison, in Indiana. There is no need to adopt such measures: solitary confinement, no post-mail or phone calls, lack of medicines, with him. He is elder, he was a model intern in the Leavenworth jail and he is sick. I appeal to your conscience, to your sense of humanity, so that the basic human rights of Mr. Peltier are fully respected. Moreover, it is necessary that Mr. Peltier, a very well-known and respected Native American leader, be transferred to a better penitentiary. Many indigenous leaders and members of indigenous peoples all around the world are very worried about Mr. Peltier's treatment, which we have found very indignant and inhumane. We send you a call to urgently revise the conditions in which Mr. Peltier remains in jail. I do hope that the authorities hear of this humanitarian call. The entire world, especially the indigenous peoples, will thank you. Section 4. Campaigning to end colonialism in Puerto Rico. In the early 1980s, when many of the Puerto Rican political prisoners discussed in this chapter were first arrested, they were demonized in the popular press as terrorists. Even some progressive forces suggested that they were crazies. By the 1990 tribunal, there was more widespread support, especially from within the Puerto Rican community, but those who suggested that most of them would be released within 10 years were considered utopian and unrealistic at best. In 1999, the majority of the Puerto Rican patriots were granted clemency and set free. The full story of the steadfast vision, leadership, and commitment of the architects of that successful campaign cannot be told here in a few documents and pages. That effort achieved what it did because of an understanding of the material conditions and sentiments of the masses of the Puerto Rican people at home and in the U.S. A strategic analysis coupled with hard work brought that campaign across class, race, and traditional political divisions, to form alliances that, for a time, characterized the identity of the Puerto Rican nation. What is presented here are primarily some of the papers that helped to bring the campaign beyond its original and most dynamic base. Also presented are efforts, as the campaign was nearing success, to link the issue of the Puerto Rican prisoners to the issue of U.S. militarism and colonialism as practiced by the U.S. Navy occupation and bombing of the island of Vieques. This linking of peoples and issues should provide a signpost for future possibilities. Clearly the U.S. continues to try to silence the Puerto Rican shout for freedom, as evidenced by the 2005 assassination of 72-year-old independentist radical Filiberto Ojeda Rios, the 2008 arrest of alleged Macheiro leader Avelino González Claudio, and the continued grand jury investigations calling on testimony from prominent Puerto Rican activists in New York. The struggle must also continue. 4.2. Puerto Rico, the cost of colonialism. Underscore 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 underscore. This articles in the following pages were included in the booklet Puerto Rico, The Cost of Colonialism, published in 1992 by the Fellowship of Reconciliation's Task Force on Latin America and the Caribbean. The booklet was offered, the task force wrote, as one remedy to the lack of general information available about the Puerto Rican colonial reality, and particularly to deal with the North American progressive movement's lack of support and solidarity with the Puerto Rican people's struggle for self-determination. 4.2a. Why focus on Puerto Rico? Matt Meyer 1992. The 1990s began with the United Nations calling upon all nations and peoples to use this decade to finally remove the blight of colonialism from the face of the earth. They felt that this may be a realizable goal. Since 1981, however, the UN Decolonization Committee has recommended that the General Assembly consider Puerto Rico a non-self-governing territory, which obliges the U.S. to submit an annual report regarding its treatment of Puerto Rico. Several years ago, a process began that was intended to lead to a Puerto Rican plebiscite resolving its colonial status. As that process has been forestalled by the U.S. Congress and events around the world have led to independence of former republics and colonies, Puerto Rico remains a glaring example of justice denied. Yet a great outcry from the progressive community, in the US or around the world, has yet to be heard. Rather than answer the question, why focus on Puerto Rico? I find it more useful to ask, why not? Given the outpouring of material and political church support for a decolonization process in southern Africa, why not focus on the last major remaining colony of the Americas? Given the United Nations call for a decade to end colonialism, and the 1992 quincentenary call of indigenous nations to celebrate 500 years of resistance and work toward a future of reconciliation, why not focus attention on what is now the world's oldest direct colony? Given the wealth of solidarity offered over the last decade to our sisters and brothers in various Latin American countries, why not develop massive and mainstream solidarity for the Latin American nation that, along with Mexico, is interwoven into the very fabric of U.S. life and history? Given the consistent pacifist leadership in opposing militarism, intervention, and weapons of mass destruction, why not put significant resources toward the elimination of the major foreign military base in our own hemisphere, the Puerto Rican staging ground for all major regional interventions? In so many ways, Puerto Rico seems to be a perfect point of progressive unity. Why, then, have so few peace and justice groups made Puerto Rico work a priority, especially in light of the U.S. State Department's priority maintenance of Puerto Rican colonial status? One reason is simple to understand, but difficult to deal with: oppression that is close to home is always harder to combat than oppression that is at a safe distance. This truism may especially challenge us in these times of harsh economic depression, as we walk over homeless people on our way to vigils protesting some injustice overseas. For most North American progressives, however, it is an exercise of race and class privilege to seek elsewhere for that moral activist work. Most of us are not faced with the stark realities of survival that dictates bread and butter politics based in our own neighborhoods, communities, nationalities. It is, in fact, our primary moral task to overcome our personal and institutional racism and classism by understanding the struggles of those just down the block, of those who live across the tracks, yet whose experiences within U.S. society are qualitatively different. Puerto Rico offers us the unique opportunity to engage on two levels of struggle, for Puerto Rico is both within and outside of the United States, and Puerto Ricans in each place experience unique forms of colonialism. Underscore 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 underscore. This article was the introduction to the booklet Puerto Rico, The Cost of Colonialism, published by the Fellowship of Reconciliation's Task Force on Latin America and the Caribbean. Perhaps a reason for reluctant support of Puerto Rican progressive movements stems from the fact that concrete resistance already exists, though in an indigenous and hard-to-define form. A strong sense of self-determination, autonomy, and self-definition, added to a shrewd sophistication regarding the nature of U.S. society, has placed Puerto Rican activists in a position of leadership under which some white activists may feel uncomfortable working. Anti-colonial resistance movements, furthermore, have not come together under a single consistent organization or united front banner, making solidarity subject to sectarianism, inconsistency, and short-term interest. These movements have also faced significant repression, with leaders jailed, killed, and blacklisted by Puerto Rican and U.S. intelligence and police agencies. Fear of repression among North American supporters is not unwarranted, as several have faced similar, though less severe, hardships. For those of us who are nonviolent activists, it is always important to examine the nature of any struggle we wish to support, though our aims may be similar. For us the means are as important as the ends. A brief overview of the current Puerto Rican community may find no quick Gandhi or King substitute. Looking closely at Puerto Rican anti-colonial politics, we will, however, find a great deal of creative, persistent nonviolent actions. The squatter communities of Villa Sin Mito may remind one of the Gandhian campaigns of land givebacks, or the University of Puerto Rico student strikes, of the tactics of SNCC. From the educational conferences against war toys to the nonviolent direct action of the people of Vieques resisting the U.S. military, The large mass of Puerto Rican activism has been as pacifist-oriented as any found in the U.S. Of course, it is also necessary to note that armed actions have played a part in Puerto Rican resistance and that most Puerto Rican progressives will not disavow those actions or dismiss them as counterproductive. The absence of absolutist pacifism on the part of most of the Puerto Rican movement can hardly be used as an excuse, however, for withholding support from the entire freedom movement. At the very least, we have a moral responsibility to actively support those nonviolent actions and campaigns that make up the majority of anti-colonial work. At best, we need to understand how distancing ourselves from activists advocating the importance of armed struggle violates our very own principles of dialogue and reconciliation. We cannot treat these militant activists with a missionary attitude, preaching the truth of nonviolence. We must understand, as Gandhi did, that we are all experimenting with truth, with no progressive having a monopoly on tactics or strategies, especially in these tumultuous times. Our inactivity bespeaks our own doubts about the effectiveness of nonviolence against the oppressive nature of direct U.S. colonial power. We must meet the challenge of armed struggle with our own militant, nonviolent support actions. One problem raised by some North Americans is how to support a Puerto Rican movement for self-determination when it is not clear what the majority of Puerto Ricans want for themselves. The complications of the three status options facing Puerto Rico: continued or enhanced Commonwealth status, statehood, or complete independence, have caused some potential supporters to hesitate. And while neither this booklet nor the Fellowship of Reconciliation directly advocates any one option at this time, it is clear that the current Commonwealth status as it is practiced today amounts to colonialism. The leading political parties that represent each of the three options have pushed the U.S. Congress to allow some type of plebiscite or referendum to take place, because they are united in the understanding that the current realities are not the result of a real choice on the part of the Puerto Rican people. Progressive people must take up a position, similar to the United Nations position previously cited, that calls for decolonization according to the international conditions set forth by the UN Committee of 22. This demands that all powers, including the courts, police, etc., be handed over to Puerto Rican authorities, all colonial military powers be removed, all anti-colonial prisoners be released, and repression be ended. If these conditions are met, and the UN determines that a sufficient length of time has elapsed for a free and open U.N. supervised vote, then we may all witness what self-determination means. Until that time, however, it is crucial to understand that U.S. supervised plebiscites are no more genuine than the South African administered freedoms of Southwest Africa before the independence of Namibia. The question of independence, however, continues to present a controversial issue for some, since many Puerto Ricans equate an end to colonialism with independence. And while those of us who are not part of the Puerto Rican nation must not presuppose to choose a status option for them, we should also not be surprised that so many of the Puerto Ricans working with us for an end to colonialism are also advocating independence. We must take great care not to be hypocritical about our own support. We did not wait until 51% of the U.S. people called for an end to nuclear weapons before we called for an end to the production of these warheads. Most of us base our politics not on simple majoritarian, but on morality. If independence is seen by most of our progressive brethren as the moral solution to the colonial problem, we must struggle to respect and understand that position. We must also take great care not to be racist in our support. We did not dare say to Gandhi, "Yes, Mahatma, we see the truth to your teachings about nonviolence, but could you tone down your talk about British colonialism? We'd really like to meet one of your pacifist colleagues who does not support independence for India." Gandhi's Satyagraha, though much more than strategy or tactic, was born of the struggle for independence as the principal means for an end to British colonialism. Though independence may take many diverse forms, there was little room for compromise on the need for an end to paternalistic foreign rule. 4.2.b. The Costs of Colonialism. Dr. Luis Nieves Falcon, 1991. History helps us understand why colonialism has been called a crime against humanity. The original people who inhabited Puerto Rico no longer exist. Indeed, they were so rapidly exterminated by the Spanish that we must turn to archaeologists and anthropologists to know our forebears. The Spanish were haunted by the delusion that Puerto Rico was rich with gold. They hoped to extract and export the gold to Europe, using native peoples as slaves in the mines and exploiting them as a completely expendable resource. The resistance to this first genocidal phase of colonialism turned to organized rebellion by 1511, but by the middle of the 16th century, the entire Taino nation spread throughout Puerto Rico, Cuba, and the Dominican Republic had been devastated by forced labor, starvation, disease, and warfare. In 1582 the Spanish Royal Inspector General lamented that farming had practically stopped for lack of Indians and the high price of blacks and begged for 1,000 slaves to be sent at once. The Africans sent as slaves proved to be both the workhorses of the economy and a constant source of concern for the colonial masters as they conspired, ran away into the mountains, and organized guerrilla bands. The first modern rebellion against Spanish colonialism was organized simultaneously in Puerto Rico and Cuba in 1868. The Puerto Rican uprising, known as the Grito de Lares, proclaimed the First Republic of Puerto Rico and placed the abolition of slavery as the first of its commandments. The First Republic was brutally quelled, but as the result of this popular agitation, Puerto Rican deputies were sent to the Spanish court for the first time in 1869. Slavery was abolished on April 21, 1873, and the autonomy of Puerto Rico recognized in 1897. In 1898, however, the United States invaded Puerto Rico, abolishing all previously established rights of the Puerto Rican people and substituting for it, in the words of commanding U.S. Army Major General Nelson A. Miles, the largest measure of liberty consistent with military occupation. Neither the reality of military occupation nor the yardstick by which liberty is measured in our country has changed greatly, although appearances have. Today, at least 13% of the best arable land in Puerto Rico is occupied by United States military bases, including one of the largest U.S. military bases outside of the United States at Roosevelt Roads, located in Ceiba, Puerto Rico. Reported to be one of 13 U.S. military facilities on the island to have nuclear capability, the Roosevelt Roads base is in violation of the Treaty of Tlatelolco, which declared Central and Latin America to be a nuclear-free zone. Underscore 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 underscore. This paper was adapted from a presentation given at the Summit of 7 of the World's Poorest Peoples, held in Houston in 1990, to coincide with a meeting of the G7. The summit's description noted, even within the legal borders of the USA there is a 45% poverty rate on Native American reservations and a 39% poverty rate in Puerto Rico. This gathering of witnesses was part of the other economic summit. Dr. Nieves Falcon's paper was included, with permission, in Puerto Rico, the cost of colonialism. There are, according to the Caribbean Project on Justice and Peace, an additional 69 United States military installations in Puerto Rico, including the base at Fort Allen, which contains the presidential communications system known as Mystic Star, to be used in case of nuclear emergency. 2/3 of the island community of Vieques has been declared off-limits to its residents so that the U.S. Navy can practice bombing, low-intensity warfare in tropical and mountainous climates, sea landings, and other tactics essential to its military strategy for Latin America in the coming decade and century. With the approach of the expiration of both the Guantanamo Bay and Panama Canal contracts, the importance of securing Puerto Rico as a safe harbor for United States military action in the Caribbean and Central and Latin America increases, as does the concern of the United States military and financial interests in controlling their hemisphere. With these anxieties comes intolerance for all those who do not accept the idea that United States military interests should determine the degree of freedom they enjoy. Those who have actively opposed the United States exploitation of Puerto Rico often find themselves judged in an English-language tribunal of the United States. Currently 18 Puerto Ricans are incarcerated with exceedingly long sentences, e.g., 98 years under conditions designed to break their spirits, if not their bodies. And an additional 11 face sentences in excess of 160 years. Repression has been a constant in our history, because it is impossible to maintain colonialism by consent, no matter how attractive the prize for the privileged few. In Puerto Rico, this repression has served three complementary functions: first, to protect the enormous U.S. economic interests and infrastructure in Puerto Rico; second, to protect the symbols of U.S. executive and military power; and finally, to control the levels of rebellion and protest endemic to the deprivation of liberty and the economic hardship that are visited upon colonized peoples. Hand in hand with military occupation came economic occupation, making Puerto Rico a paradise for North American business interests. This exploitation relies on two devices: the depopulation of Puerto Rico and the transculturation and ideological assimilation of those Puerto Ricans who remain so that they would identify with American consumer goods, tastes, and political objectives. Depopulation has been accomplished largely through massive, economically compelled migration to the United States on the one hand, and the forced sterilization of more than 40% of all women of childbearing age, on the other. Mass migration represents more than a simple loss of population. It is also evidence of a profound transformation in the relation between the working people of Puerto Rico and their land, which in turn, has profound effects on feelings of collective and individual self-worth and self-sufficiency. In the first decades after the invasion, the economy was reoriented not to feeding the people of Puerto Rico, but to the manufacture of sugar for export. In the second half of the 20th century, light industry, especially the manufacturing of textiles, petrochemicals, and pharmaceuticals, replaced sugar production as the primary economic activity. But the fundamental character of an economy had important cultural and psychological consequences. Rather than an expression of an encounter between our people and our land, work became a mechanism for squeezing profits out of those who did not flee the destruction of independent agriculture and could adapt to large-scale agriculture or the assembly line. Forceful and continuous repression of the workforce was imposed in an effort to cultivate attitudes of conformity and dependence, rather than individual or collective initiative and independence. In order to convert Puerto Rican farmers, small business owners, housewives, clerics, and independent professionals into loyal employees of large foreign corporations, an ambitious program of cultural assimilation was undertaken. For the first two generations after the invasion, English was the official language of instruction in public schools. Teachers who dared speak to children in their shared native language were fired. The policy was abolished in 1948 following a long and militant strike by teachers and students. As the English-only movement suggests, every effort to implant American values and identities was made, and the public instruction system was viewed as the most appropriate vehicle for transforming cultural values. For those too old to learn to pledge allegiance to the flag of the United States every morning, it was made a crime to display the flag of Puerto Rico, even at home. All gatherings of nationalist character were persecuted as seditious parties, and the first of the interminable lists of suspected subversives, a practice confirmed and declared illegal in 1989, but which continues to this day, was compiled. The legalization of the invasion and occupation of Puerto Rico has been critical to the process of Americanization and transculturation. Between 1898 and 1900, Puerto Rico was frankly and formally a militarily occupied territory. In 1900, the first civilian government was installed by the United States. In 1917, 3 weeks before the United States entered World War I, Puerto Ricans were declared to be its citizens, subject to the military draft. They were still not permitted to select the judges of their own Supreme Court or even the president of their own university, let alone those who declared war. Between 1950 and 1952, a series of steps were taken culminating in the implementation of a new official title, Estado Libre Asociado. During this period, an armed uprising by the Nationalist Party in 1950, designed to call attention to the imminent peril of assimilation and declaring a second Republic of Puerto Rico, was put down only by jailing over 5,000 men, women, and children who participated in or were suspected of aiding the rebellion. Another widely boycotted effort to manufacture consent to colonialism was made in 1967. This misnamed plebiscite of 1967 was likewise so clearly invalid that in 1989, President Bush felt obliged to acknowledge that Puerto Ricans had been treated unfairly by the United States and offered to hold another plebiscite, which has subsequently been cancelled by the U.S. Congress. But in none of these successive efforts to legitimize colonialism has the United States been willing to comply with international law and transfer all the powers to the people of Puerto Rico prior to making any binding decision on their political status. To survive, Puerto Ricans must create a modern nation consistent with the real needs and priorities of Latin America and the Caribbean in the 21st century. It is a task that we cannot undertake alone, without the collective wisdom, experience, and support of other nations who have struggled to overcome colonialism and of others more experienced in nationhood in our region. We recognize the growing interdependence of the world today and look forward to participating in an international economic and social order based on cooperation, not conflict. Our first contribution to this new order is the abolition of colonialism in one of its last outposts in the modern world. 4.3. Proclaim Release, a call to conscience and action for the release of Puerto Rican political prisoners. Interfaith Prisoners of Conscience Project 1997. The Rev. Drive S. Michael Yasutake, Executive Director. Charity projects, providing direct services to the needy, are worthy and valuable. But we also need systemic change which eliminates poverty and the need for charity work altogether. Prisoners of conscience, more commonly known as political prisoners, have sided with the powerless and the poor. They are being persecuted for challenging systemic injustice. In many cases, laws have been used illegally to convict them. More frightening, laws are made and enforced to benefit those in power at the expense of the powerless. The Puerto Rican prisoners of conscience are among those who have worked for a just society, at great sacrifice to themselves and their loved ones. The Interfaith Prisoners of Conscience Project and other supporting organizations extend this call to all people to join in the common struggle for justice. Underscore 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 underscore. After years of grassroots campaigning, mainly in United Church of Christ and Methodist congregations, the national bodies of both of these denominations were moved to issue statements in support of the release of the Puerto Rican prisoners. Pressuring the rest of the Protestants, as well as mainstream Catholic Church hierarchies, these efforts were in large part coordinated and motivated by the Interfaith Prisoner of Conscience Project. This booklet, produced by IPOC as an international affirmation of this work, helped shift the consensus toward release in the last years before clemency was granted. The Reverend C. Nozomi Akuta, Chair. Although work with political prisoners was among the expectations when I began my ministry at the United Church Board for Homeland Ministries, it took me over a year to summon the courage to find out how to visit a political prisoner. Driving up to a compound surrounded by razor wire and stepping through a gate which clangs behind one is not an easy thing to do. Frankly, I wasn't sure what to expect. What I found changed my life. My first visit was with 4 Puerto Rican women at the Federal Correctional Institution in Dublin, California: Dulcia Pagan, Lucy Rodriguez, Carmen Valentin, and United Church of Christ member Alejandrina Torres. These were profoundly impressive women of gentle courage, strength, and integrity. My visit with them moved me to meet some of their compatriots: Edwin Cortez at the United States Penitentiary in Terre Haute, Indiana, Oscar Lopez Rivera at the Super Maximum Prison in Florence, Colorado, Adolfo Matos at the USP in Lompoc, California, Ricardo Jimenez and Alberto Rodriguez at USP Lewisburg in Pennsylvania, Antonio Camacho Negrin at FCI Allenwood in Pennsylvania, Alicia Rodriguez at Dwight Correctional Center in Illinois, and Luis Rosa at Stateville Prison in Illinois. In each case, I encountered men and women vibrant with life and love, whose eyes sparkle with vision and hope despite all they have already suffered and the terribly long sentences as long as 105 years for Luis which they are continuing to serve. Although these sentences seem harsh in the abstract form of the printed page, they are simply horrifying for those who have been privileged to meet the actual people who are enduring them. A peculiar form of outrage seeps into one's bones, calling forth a commitment to do all one can to secure their release. These prisoners' friends, families, and community have mounted an energetic campaign for their freedom. They have sent thousands of letters and faxes to the president, urging him to grant them amnesty, and have been joined in this appeal by legislators, artists, and religious leaders, including, most recently, Coretta Scott King and Desmond Tutu. With all their hearts, they and I urge you to join in the effort to free these remarkable men and women. The Spirit of the Lord is upon me, because he has anointed me to bring good news to the poor. He has sent me to proclaim release to the captives and recovery of sight to the blind, to let the oppressed go free, to proclaim the year of the Lord's favor. Luke 4:18-19. For over 17 years, Puerto Rican men and women have been imprisoned throughout the U.S. because of their beliefs and actions in support of Puerto Rican independence. They are serving extremely long sentences, far longer than the sentences meted out to others for heinous activities, and many of them have suffered unusually harsh treatment while in prison, including physical assault and extended periods of solitary confinement conditions condemned by Amnesty International. Puerto Ricans throughout the U.S. and Puerto Rico from all political sectors have called for their release. Now these prisoners and the families and communities they have left behind appeal to us, as Christians, to join in the growing effort to proclaim release to the captives. In 1991, the 18th General Synod of the United Church of Christ said, "The Scriptures commit us to bring to your attention the cry for justice and mercy from our Puerto Rican prisoners who are subjected to discriminatory treatment from the prison officials. Because we are called by Christ to bring the good news to the captives and to preach release to the oppressed, we have a responsibility to improve the prison conditions of the Puerto Rican prisoners and to eliminate the colonial condition of the Puerto Rican people." The 18th General Synod demands that President Bush and the Congress undertake a process for Puerto Ricans to achieve self-determination and, as a gesture of goodwill, take the following steps, which are part of any legitimate process of self-determination: grant immediate and unconditional amnesty to all Puerto Rican prisoners of conscience and political prisoners. This resolution was the fifth of 6 statements supporting Puerto Rican and other political prisoners adopted by the General Synod of the United Church of Christ from 1979 to 1995. In 1996, the General Conference of the United Methodist Church said, "The United Nations resolutions on decolonization have clearly established that colonialism is a crime and recognize a colonized people's right to end colonialism. The United Nations also recognizes that these resolutions and laws apply to Puerto Rico. For many years, the United Nations Decolonization Committee has approved resolutions recognizing the inalienable right of Puerto Rico's people to independence and self-determination. The injustice suffered under Puerto Rico's colonial reality cannot be overlooked." President Bush admitted that the people of Puerto Rico have never been consulted as equals on their political status. Therefore, be it resolved, that the General Conference of the United Methodist Church advocate for justice and freedom for the Puerto Rican political prisoners. Furthermore, that a letter from the General Conference Secretary be sent to the President of the United States asking him to grant pardon, because they have more than sufficiently served their sentence. In 1995, the Baptist Peace Fellowship said, "In the spirit of reconciliation throughout the world, we call upon the President of the United States to exercise the constitutional power of pardon to grant immediate and unconditional release to the many Puerto Rican women and men in U.S. prisons for their actions in favor of self-determination and independence." Also in 1995, the Episcopal Church of Puerto Rico said, "Whereas, political action and the struggle for self-determination of the peoples respond, in our national case, to an unresolved problem. Therefore, be it resolved that the 88th Annual Diocesan Assembly of the Episcopal Church of Puerto Rico, the 16th as an autonomous church, ask the Honorable William Jefferson Clinton, President of the United States of North America, to grant unconditional and immediate amnesty to the Puerto Rican patriots imprisoned in the United States. In the January-February 1995 issue of The Witness, an independent journal owned by the Episcopal Church Publishing Company, editor/publisher Jeannie Wiley Kellerman wrote, "In this issue, we raise the names of several political prisoners. We raise them as icons into the injustice and cruelty that are woven through our American way of life. We raise them as people willing to move past liberalism to activism with cost. Who are these prisoners? Their names are Antonio Camacho Negrin, Edwin Cortez, Elizam Escobar, Ricardo Jimenez, Oscar Lopez Rivera, Adolfo Matos, Dulcia Pagan, Alberto Rodriguez, Alicia Rodriguez, Lucy Rodriguez, Luis Rosa, Juan Seguera Palmer, Alejandrina Torres, Carlos Alberto Torres, and Carmen Valentin. Most are parents, some are grandparents. Prior to their incarceration, they were workers, professionals, teachers, community organizers, and activists. They labored in their communities for quality education, child care facilities, health services, and against drug abuse. In prison, they have done artwork, developed child care and AIDS awareness and prevention programs, and taught literacy, high school equivalency, and English as a second language classes. Church leaders who have met some of them in person have said, 'I found myself very moved. They are women of great character and are, in the midst of very difficult circumstances, holding fast to their own sense of who they are and who they want to be.' Rev. Dr. Paul H. Sherry, President, United Church of Christ. The personal impact that they had on me as Latina sisters is the personal integrity that they demonstrate, their spirit of dignity, and their gentleness about what they believe in. Ms. Linda Jaramillo, President, Council for Hispanic Ministries of the United Church of Christ. You almost feel, after a visit like this, that you should speak in lower voice than you usually do. These were three very gentle people whose vision, even after all these years of incarceration, is anything but dimmed, and that does something to anybody who makes a visit like this. Rev. Dr. Thomas E. Dupko, Executive Vice President. United Church Board for Homeland Ministries. United Church of Christ. Meeting the women was a profound honor. Their dedication, their serenity, their compassion, their commitment, and their humility along with their inner and outer beauty combine to make them exactly what they say they are not, role models. Ms. Samito Anita, Lakota, Associate for Racial Justice, National Council of the Churches of Christ. My visit with Alejandrina Torres and the other political prisoners in September was my first such visit, and I was very, very impressed with what they had to say, with their integrity, with their commitment, and with all the injustices their people have endured. I was moved by the strength they have maintained despite all the hardship and suffering they have endured, and by Alejandrina's strong religious convictions. Rev. Helen Locklear, Associate, Racial Justice Leadership, Presbyterian Church. Visiting Alejandrina was a most powerful experience. She is an incredible woman of faith. She sets a tremendous example of the willingness to confront oppression, going the road to Jerusalem, as Jesus did, regardless of the cost. Rev. Annie Gonzalez, Pastor, North Lake United Methodist Church. Why are they in prison? These 15 men and women were convicted as members of organizations involved in armed actions against corporate and military targets maintaining the ongoing colonial situation of Puerto Rico. None of the 15 was ever charged with any action resulting in bloodshed. The Macheros, 2 of the 15 were convicted of conspiracy and related charges as members of the Macheros, a clandestine group based in Puerto Rico. The Macheros took responsibility for a series of military actions, including bombings, the destruction of 9 National Guard planes, attacks on military personnel based in Puerto Rico, and the taking of $7.5 million of government-insured money. The charges against these 2 prisoners included taking the money and transporting it out of the U.S. The Armed Forces for National Liberation, The other 13 prisoners were convicted of seditious conspiracy and related charges as members of the Armed Forces for National Liberation, a clandestine group based in the United States. The FALN took responsibility for a series of bombings of government, corporate, and military sites. The charges against these men and women included possession and transportation of firearms, armed robbery, and transportation of stolen vehicles. Invoking international law, they claimed prisoner of war status, refused to recognize the jurisdiction of state and U.S. courts, did not defend themselves, did not challenge the government evidence against them, and received particularly long sentences of 35 to 105 years. What is seditious conspiracy? Webster's dictionary defines sedition as a stirring up of rebellion against the government. Seditious conspiracy is the charge for which Nelson Mandela was convicted and imprisoned in South Africa for so many years. In the U.S., it has been used primarily against Puerto Rican independentistas, proponents of Puerto Rican independence, for conspiring to use force against the lawful authority of the United States of America over Puerto Rico. It does not reflect a distinct crime, but serves as an umbrella charge which ties together all other charges. Like the charge of conspiracy, it also enables the government to charge members of an organization for actions of everyone else in the organization, regardless of their actual involvement in the specific action. For example, Luis Rosa was about 12 years old when the first bombing occurred in the conspiracy with which he is charged. How can their actions be explained? A brief history. On November 19, 1493, Christopher Columbus landed on an island called Borinquen by its people, the Tainos. Most of the Tainos soon died from slavery, disease, and murder. The Spanish brought Africans to replace them as slaves. On November 25, 1897, Puerto Rico negotiated a charter of autonomy with Spain requiring the consultation of the Puerto Rican people before the island's status could be changed. On July 25, 1898, at the end of the Spanish-American War, the U.S. invaded Puerto Rico. In the Treaty of Perez, Spain ceded Puerto Rico to the U.S. as war booty without consulting the Puerto Rican people regarding their status, in violation of the Charter of Autonomy. U.S. presence in Puerto Rico severely altered every aspect of Puerto Rican life. It shifted the economy, first from subsistence agriculture to sugar for export, and then to light industries, such as textiles and pharmaceuticals, resulting in significant environmental degradation. The government imposed U.S. citizenship, the teaching of U.S. history and the English language, outlawed the display of the Puerto Rican flag, persecuted independentistas as subversives, and sterilized 40% of the women of childbearing age. And although Spanish has been the official language of instruction since 1948, English remains the official language of the courts, and U.S. cultural influence continues through the official and popular media and through the presence of U.S. corporations on the island. Today, the U.S. maintains numerous military installations, including 11 military bases, which cover 13% of the island. Throughout the history of Puerto Rico, there have been numerous incidents of violence against the people, including more recent times. On July 25, 1978, the 80th anniversary of the U.S. invasion of Puerto Rico, two independentistas, Carlos Soto Arrivi and Arnaldo Dario Rosado, were murdered by government agents. In 1982, then-Governor Carlos Romero Barcelo ordered the National Guard to bulldoze Villa Sin Mito, a squatter's village on idle government lands. In 1985, over 300 FBI agents and members of the U.S. Special Forces armed with automatic weapons invaded the homes of dozens of student activists and trade unionists, without informing the Puerto Rican government. The island of Vieques, a fishing site, has been used for decades for bombing practice, destroying the livelihood of the people. Those who protested were imprisoned as criminals. Today, new military radar facilities are being constructed, generating massive protests among the people. In short, the U.S. colonial relationship with Puerto Rico has affected every aspect of Puerto Rican life and continues to be maintained by U.S. military occupation and corporate influence. If we call for the release of these prisoners, aren't we supporting a particular political perspective? What political status do Puerto Ricans support? Of course, independentistas are among those working most intensively to secure the release of these prisoners. But people of all political sectors in Puerto Rico have joined the call for their release in light of how much time they have already served and in the recognition that the release of political prisoners must be part of any genuine resolution of conflict in a colonial situation. The UN affirmations were more fully spelled out in UN Resolution 3103, adopted by the General Assembly on December 12, 1973, which outlawed attempts to suppress struggles against colonial and alien domination, recognized anti-colonial conflicts as international armed conflicts, and recognized prisoners captured in such conflicts as prisoners of war. International law outlawing colonialism has been explicitly applied to the case of Puerto Rico by the United Nations Decolonization Committee. Although the U.S. has consistently denied it, the United Nations and both the pro-independence and pro-statehood political sectors in Puerto Rico have recognized that Puerto Rico is a colony of the U.S., lacking political, economic, or cultural self-determination. Like the American colonists, the Puerto Rican prisoners see themselves as part of an anti-colonial struggle, and place their actions however the U.S. may criminalize them in the context of this international law. They argue that in the context of international law, the real crime is the U.S. occupation of Puerto Rico, and not their actions to resist it. In Puerto Rico today, the pro-Commonwealth Popular Democratic Party and the pro-statehood New Progressive Party each usually win approximately 45% of the vote, and the pro-independence Puerto Rican Independence Party wins approximately 5% of the vote. The relatively low electoral support for the independence position leads some people in the U.S. to discount the independence movement. Independence advocates point out, however, that support for independence has been seriously weakened by criminalization and persecution of the independence movement, such as in the exclusion of independentistas from public sector jobs. They also say that the significance of such referenda is devalued by the U.S. Congress's repeated statements that the results of votes concerning Puerto Rico's status are not binding. Such self-perpetuating effects of the colonial relationship have been recognized by the United Nations, which provides for the complete withdrawal of the colonial establishment, including the military apparatus, prior to a decision regarding political status. In addition, it should be noted that many independentistas boycott elections and referenda because of the failure of such processes to meet international standards. What do the scriptures say? The scriptures show that Jesus' battles were ideological and spiritual rather than military, but they did involve profound conflict with the colonial ruling powers. The arrest of John the Baptist propelled Jesus to begin his public ministry, and Jesus' clearing of the temple dramatically challenged the economic, political, and religious control of the authorities over the people. Like the political prisoners of our day, Jesus was clearly considered a threat by the state, charged with perverting our nation and stirring up the people. He endured both state and federal trials, where he refused to defend himself. By his silence, he may have been refusing to recognize the jurisdiction of the colonial courts over him, or he may have simply recognized the futility of a legal defense in courts run by the very forces whose authority he rejected. Like today's political prisoners, who are repeatedly strip-searched, he was stripped and humiliated, and ultimately received the harshest possible sentence, the sort reserved for political dissidents. Scholars have suggested that the two bandits crucified with him were militant revolutionaries, who, like him, were considered a threat to the state. Jesus said to turn the other cheek. Shouldn't Christians insist on nonviolence, too? Throughout history, Christians have, at times, felt compelled to break the law in pursuit of justice. In the U.S., Henry David Thoreau, the Underground Railroad, draft resistors, Martin Luther King and the Civil Rights Movement, Dorothy Day and the nuclear disarmament movement are all examples of inspiring, nonviolent courage and witness. But from the founding of the United States as a nation, people of conscience have, at times, also taken up arms in the quest for freedom. The American patriots, for example, were church members and used the churches to prepare for armed resistance against British colonialism. Other examples of armed resistance include slave rebellions and the indigenous resistance to the western expansion of the U.S. In the same issue of The Witness quoted above, Interfaith Prisoners of Conscience Project Director Rev. Michael Yasutake responds to the question of violence. The so-called radical movements that would resort to armed defense or resistance against forces of injustice are not any more violent than any nation that resorts to armed conflict for national security. International laws such as of the UN maintain that the oppressed may use any means necessary for liberation, including the use of arms. The prevalent view of the dominant society in the US is that nonviolent methods are the only appropriate means of social change. Many in the dominant society, including religious institutions, are not pacifists themselves, fully relying on armed police power for protection or on the armed services in the name of national security. As Lourdes Garcia, United Church Board for World Ministries staff person, wrote more bluntly in the Fellowship of Reconciliation's resource, Puerto Rico, The Cost of Colonialism. The oppressed have repeatedly been told by the Church that salvation lies in their capacity to passively accept their fate and turn the other cheek. It is not difficult to imagine, therefore, why a call for nonviolence put forth by some North American Christians is hard to take. What challenges are North American Christians prepared to confront regarding the power structures of their society that operate in Puerto Rico? The international community has recognized that in the case of Puerto Rico, as in other situations of colonial conflict, the release of political prisoners is critical to the reconciliation process. Because as Christians we are called to be agents of justice and reconciliation, whether we are pacifists or not, we are called to join the international community in its reconciling call for the release of these men and women. I thought the US didn't have any political prisoners. Aren't these prisoners just common criminals? When the international community including the US and President Clinton has called for the release of political prisoners as part of a reconciliation process, it has clearly included people imprisoned for their participation in armed conflicts. In the case of Puerto Rico, however, the US has resisted acknowledging that it has political prisoners by insisting that people who affirm the right to resort to arms are criminals, not political prisoners. But if we apply the same standards used in the cases of South Africa, Cuba, Northern Ireland, and the Middle East, these Puerto Rican women and men would indeed be considered political prisoners. Of course, many people will disagree with or condemn outright the activities for which these prisoners were convicted. But it should be noted that the actions for which they were imprisoned were motivated not for personal gain, but rather, for the sake of their nation. They accepted the risk of imprisonment or death because of their commitment to independence. Further, the US government has treated these cases more severely than those of common criminals. Government statistics show that common criminals receive far shorter sentences than the Puerto Rican prisoners did. As mentioned above, their average sentence is 65.4 years, or about 6 times longer than the average murder sentence. And their sentences are far longer than those meted out to police convicted of anti-independence activity. Former Puerto Rican Police Colonel Alejo Maldonado, an admitted assassin, is soon to be paroled after serving less time than the Independentista prisoners, despite press reports that he took part in police death squads involved in kidnapping, robbery, extortion, weapons trafficking, torture, and murder. The 5 Puerto Rican police who were convicted of the 1978 Cerro Maravilla murders of 2 Independentistas received sentences of 10 to 30 years, far shorter than Luis Rosa's sentence of 105 years, and the commander of the intelligence unit was released on parole after 6 years in prison. If we call for the release of these prisoners, aren't we condoning violence? No. In calling for their release, we are not making a judgment about the use of arms. We are joining people from Puerto Rico, the US, and around the world who are calling for the release of these prisoners in light of the 14 to 17 years most of them have already served, and in the recognition that the release of political prisoners must be part of any genuine resolution of conflict in a colonial situation. Shouldn't they have to show remorse before they are released? Although none of the Puerto Rican nationalist prisoners pardoned by President Carter in 1979 renounced the principle of the right to engage in armed struggle, in fact none ever engaged in it after their release. Neither were expressions of remorse required of Nelson Mandela, Irish nationalists, nor Palestinians prior to their release. Rather, the United Nations regards the release of such prisoners as a part of the process of reconciliation and resolution of the conflicted or colonial situation. Puerto Rican Bishops' Conference. April 24, 1996. Dear President Clinton, the Spirit of the Lord is upon me, because he has anointed me to bring good news to the poor. He has sent me to proclaim release to the captives and recovery of sight to the blind, to let the oppressed go free, to proclaim the year of the Lord's favor. We write to urge you to grant the pending application for the immediate and unconditional release of the 15 Puerto Rican women and men in prison for their pro-independence activities. This expression of support comes as a result of exploring not only the theological aspect, but the historical and human rights aspects, and included a pastoral visit, conducted at the behest of one of our bishops, with one of these prisoners. This visit, along with our reflections, has led to our discernment that both justice and mercy place upon us a moral claim. The Scriptures commit us to hear the cry for justice and mercy for our imprisoned brothers and sisters, and to preach release for the oppressed. We therefore stand among the many other denominations, civic and religious groups, elected officials, and community leaders ready and willing to embrace these 15 men and women in the spirit of reconciliation. May the God of justice and compassion guide you in making this significant moral decision. Respectfully, Ser. Luis Cardinal Aponte Martinez, Archbishop of San Juan. Mons. Inaki Malinat, CP. Bishop of Arecibo, President. Mons. Ulysses Casiano, Bishop of Mayagüez, Vice President. Mons. Fermio Torres Oliver, Bishop of Ponce. Mons. Enrique Hernandez, Bishop of Caguas. Mons. Ricardo Surinach, Auxiliary Bishop of Ponce. Mons. Hector Rivera, Auxiliary Bishop of San Juan. Mons. Herman Negrin Santana, Auxiliary Bishop of San Juan. Secretary. _______________________ The above was published as a full-page advertisement in the Washington Post on Friday, December 20, 1996. 4.5. A Day Without the Pentagon. Resistance in Brooklyn 1998. We dedicate our participation in this War Resisters League 75th Anniversary Pentagon action to the Puerto Rican political prisoners and prisoners of war. At this very moment, the legal case for their pardon rests on the President's desk. President Clinton, hear our voices, pardon all of these dedicated women and men. At the same time, behind the very walls of the Pentagon, military advisors are holding discussions about adding substantial personnel and bases in Puerto Rico, to counteract the diminishing forces that are in the process of withdrawing from Panama. Now is the time for universal military downsizing. We demand that the U.S. remove all of its military from Puerto Rico. Although the U.S. denies it holds political prisoners and prisoners of war, there are over 100 incarcerated freedom fighters in this country. Of these, there are 5 women and 10 men who languish in U.S. prisons for their activity in the struggle toward decolonizing and demilitarizing Puerto Rico. These 15 independentistas have been, as substantiated by international law, illegally imprisoned for over 18 years. Their sentences are over 6 times longer than the average murder sentence, yet none of them was charged with any action resulting in bloodshed. The real crime is U.S. occupation of Puerto Rico, not actions taken to resist this brutal colonial relationship. Since its 1898 invasion of Puerto Rico, the U.S. has systematically destroyed the island's agrarian-based economy and has, through strident military occupation, wrought extreme environmental, cultural, social, and political devastation. Puerto Rico has been used by the U.S. for its geopolitical positioning. Strategically, the island has served as the center of U.S. naval control for the entire Caribbean and South Atlantic. The U.S. has operated its anti-revolutionary activity in the region from its military bases in Puerto Rico and has conducted its recruitment, training, and attacks from the island, including the Contra War against Nicaragua and the invasion of Grenada. There are over 20 military bases on 15% of Puerto Rico's most arable land. U.S. military and corporations, acting with virtually no restrictions, have caused deforestation as well as river, soil, and forest contamination resulting from Agent Orange testing and mercury poisoning. There is a water crisis due to sand and rock quarrying. The island of Vieques has been decimated by bombing maneuvers that have led to soaring rates of cancer and leukemia, sterile animals, and dead fish, making sustainability impossible. Puerto Rico has functioned as a source of cheap labor for American corporations, ultimately inducing extreme poverty and unemployment. The U.S. sterilized 40% of Puerto Rico's women and has continuously forced its men to participate in fighting U.S. wars. Puerto Rico's history has been erased in U.S. education. Reflexively, systemic and compulsory acculturation has foisted U.S. history and English on Puerto Rico's people in their schools, courts and media. Underscore 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 underscore. For its 75th anniversary, the War Resisters League organized a blockade of the Pentagon. As a part of that campaign, resistance in Brooklyn decided to link the issue of anti-militarism in general to the U.S. Navy bombing and occupation of the Puerto Rican island of Vieques, and to the U.S. holding of Puerto Rican political prisoners. Dr. Luis Nieves Falcon, who was president of the Puerto Rican Human Rights Campaign at the time, addressed the preceding WRL conference and Pentagon demonstration as a plenary speaker, and served as a consultant to RNB's affinity group Presence. Veteran peace activist Dave Dellinger joined RNB for the action itself, in which 10 of us were arrested at an entrance to the building. The following leaflet was handed out at the conference and demonstration, to fellow demonstrators, WRL members, and curious onlookers. Concurrent with this century-old system of imperialism and control, there has existed a tireless Puerto Rican liberation movement on the island and in the U.S. challenging and resisting this repressive apparatus and fighting for economic and political self-determination by every possible means, from rallies, armed propaganda actions, civil disobedience and educational reform to religious services and independent trade unions. Most recently, the August 1998 general strike brought 50% of all Puerto Rican workers into a movement to prevent privatization of the national phone company. The military, local police, National Guard, FBI and the judicial system are all used to crush this movement. As independentistas have protested, they have been imprisoned. The 15 prisoners that are presently being held are severely repressed, suffering abuse, solitary confinement, frequent transfers, medical neglect and denial of furloughs to pay last respects to dying or deceased parents. These tactics are imposed to intimidate them and are an attempt to break the spirits of the prisoners and activists. There has also been an increase in FBI attacks to prevent organizing for release of the political prisoners and to destabilize the independence movement. The United Nations has declared the 1990s as the decade to end colonialism. Year after year, the U.N.'s Decolonization Committee has heard testimony from representatives of all three political status options, who disagree on much but agree on one fact: Puerto Rico's current status amounts to little more than traditional colonialism. The UN Decolonization Committee has agreed, recognizing that no true decolonization process can take place without a complete withdrawal of foreign military, police, and judicial personnel, without the releasing of all political prisoners, and without an independent plebiscite or referendum monitored by an impartial international group. No future vote, such as the one proposed at the end of this year, can be deemed legitimate if the U.S. colonial power administers and reviews the entire process from start to finish, and if the other conditions have not been met. Calls for the release of the Puerto Rican prisoners have come from 11 Nobel laureates, from members of Congress, from leaders of all three Puerto Rican political parties, and from tens of thousands of Puerto Ricans on the island and in the U.S. Former President Jimmy Carter has also called upon Clinton to exercise his constitutional power of pardon, granting immediate and unconditional release to the Puerto Rican men and women detained in U.S. prisons for their work toward Puerto Rican autonomy. We add our voices and bodies to this call, and urge all U.S. activists committed to social justice and peace to join us at this crucial moment. From a day without the Pentagon to a century without colonialism. Free them all. Amnesty for all Puerto Rican political prisoners /p.o.ws. Pentagon presence out of Puerto Rico. Puerto Rico 1998, 100 years of U.S. colonialism, 100 years of resistance. Free all political prisoners. 4.6. The ones left behind. Meyer 1999. After 19 years in prison, serving a 78-year sentence for the political thought crime of seditious conspiracy, Adolfo Matos's first steps into JFK's International Airport in New York bring tears to everyone present. The tears are mainly of relief after the intense campaigns, the long meetings and multiple strategies, and Adolfo looks so good. But they're also tears of political shock, tears of rage at the injustice of it all. Adolfo's time in New York is brief, a 1-hour stopover with his extended family and supporters, between the prison in California and the land he'll now call his home, Puerto Rico, the land whose freedom he was conspiring for. The struggle against the U.S. occupation of Puerto Rico goes back to 1898, when U.S. troops invaded the island at the end of the Spanish-American War. Since that time, a steady movement of resistance has developed, weathering both harsh colonial conditions as well as draconian measures to keep down progressive and independence activists. Puerto Rico continues to be used as the main U.S. military base in Latin America, with over 14 sub-bases located throughout the small island, and with both of the two tiny but populated islands connected to Puerto Rico, Vieques and Culebra, used at times as bombing ranges. Puerto Ricans were granted a nominal form of U.S. citizenship just prior to World War I, facilitating the conscription of Puerto Rican men while disallowing Puerto Ricans not living within the U.S. to even vote for president or governmental representatives. Sent to the front in numbers widely disproportional to their percentage in the population, Puerto Ricans have also led U.S. statistics in the area of draft resistance and evasion. When not facing conventional conflicts, colonial violence has been imposed through the forced sterilization of large numbers of Puerto Rican women, in experiments to further the interests of multinational pharmaceuticals. Economic exploitation has allowed U.S. corporations to operate in Puerto Rico tax-free, while poverty levels continue to increase in a country stripped of its natural resources. The English-language court system in this Spanish-speaking nation presides over the security work of various departments of the FBI, military police, and domestic forces. Truly resistors of these conditions, from student activists, to environmentalists, to feminists, or trade unionists or nationalists, qualify as those resisting war during wartime. Colonialism itself has always been a form of war, and Puerto Rico remains at the beginning of the century the UN had hoped to declare an era without colonies, one of the world's last direct colonial enclaves. Underscore 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 underscore. Originally published in Peace News, Newsletter of War Resisters International, December 1999. The Puerto Rican political prisoners, technically acknowledged as being prisoners of war by a number of independent international tribunals, grew out of this context of resistance and repression. All had been connected to community-based improvement efforts, including church groups, alternative schools, cultural centers, and anti-U.S. Navy efforts. The U.S. government's conspiracy charge, made when they were arrested throughout the early 1980s, united them conceptually as being members of one or another clandestine group that was engaged in symbolic bombings, bank robberies, and the like. And while a few of the 15 were found in possession of some weapons, none were ever linked to actual acts resulting in death or destruction. Nevertheless, the sentences handed down for possibly belonging to an organization that possibly could be proven responsible for militaristic acts far outweighed the sentences typically given for the proven crimes of murder, kidnapping or rape. These terms in some individuals' cases totaling as many as 105 years were carried out under tortuous conditions often condemned by human rights groups, in jails spread out across the U.S., far away from the prisoners' families or support networks. The outrageous sentences and treatment, along with the stalwart ways in which the prisoners continued to assert their justice and peace politics, led them to become symbols for the entire Puerto Rican people. It was on this basis that an amnesty campaign was waged. The Puerto Rican Human Rights Campaign, under the direction of sociologist and educator Dr. Luis Nieves Falcon, organized a multifaceted strategy that understood the need for both massive grassroots momentum and for well-placed international solidarity. Modeling the life of a tireless activist, Falcon retired from a prestigious position as head of the Department of Caribbean and Latin American Studies at the University of Puerto Rico to get a law degree so he could better understand the cases and support his imprisoned compatriots. Once the legal basis for amnesty was clearly established at conferences in Barcelona, New York, San Francisco, and Geneva, teams of students were trained to go to every town and municipality, knocking on doors and getting people to write letters, sign petitions, and pressure politicians. Careful to respect the issues that the prisoners stood for, the campaign was also committed to making the fact and conditions of their imprisonment the central political concern. Thus, in time, leaders of virtually every Puerto Rican trade union, church, and legal association joined in the call for amnesty. Representatives of every political party from left to center to right added their names. On the eve of a huge march held on August 29, a dinner was held to gather supporters. The keynote addresses were made by Catholic Archbishop Roberto González Nieves and Episcopal Bishop David Alvarez. The slogan of the march, which attracted well over 100,000 people in what has been called the largest demonstration in Puerto Rican history, had gone beyond the more common freedom for the political prisoners to liberty for our own. It's time to bring them home. On the international level, educational work became an early priority, along with mobilizing the large sectors of Puerto Ricans living in the continental U.S. By the end of last year, almost every Latino elected official in the U.S. had joined in the amnesty efforts, and the letter-writing campaign had reached groups and individuals throughout Europe, Latin America, Africa, Asia, and the Pacific. The international pacifist and peace movements played a significant role, and under the coordination of the Puerto Rican Human Rights Campaign and with the assistance of the local resistance in Brooklyn affinity group, a call from the Nobel Peace Prize community was developed. Ultimately, 11 Nobel laureates or those representing Nobel-winning organizations signed the call, including Archbishop Tutu, Mairead Corrigan Maguire, José Ramos Horta, Coretta Scott King, and Adolfo Perez Esquivel. With this type of solidarity growing, the prisoners' lawyers initiated a series of meetings with the White House pardon attorney and White House Hispanic Affairs chief, to open a channel of communication. Never relying on the honesty of politicians, the campaign believed that a subjective connection was, in fact, necessary, and the children and parents of those imprisoned began direct appeals to the very center of political power. Over the past year, after a number of implied promises of release were broken, the tactical flexibility of the campaign was also revealed. A series of nonviolent civil disobedience actions began. First, at the October 1998 Day Without the Pentagon actions commemorating WRL's 75th anniversary, RNB, joined by some Plowshares activists and by veteran pacifist Dave Dellinger, dedicated their arrests to the Puerto Rican prisoners and to the people of Vieques, who deserved freedom from the Pentagon's bombing raids. Then, last July, on the 101st anniversary of the U.S. Marines' invasion of Puerto Rico, the U.S.-based National Committee to Free Puerto Rican Political Prisoners /POWs, staged a civil disobedience action in front of the White House. Although a civil and courteous meeting had just taken place moments earlier inside the White House, the campaign had matured to the point of understanding that a strategic use of multiple tactics and approaches, of the objective need to mobilize masses of people as well as the subjective need to speak truth to the powerful, could ultimately end in success. In spite of all this, the events of August and September 1999 sped by like a blur for most amnesty workers. When, on August 11, William Clinton offered a conditional clemency to 14 of the 15, campaigners were both overjoyed and outraged. Under the conditions, 12 could be released immediately and 2 others could spend 5 and 10 additional years in prison. An oath of nonviolence would have to be signed by all those accepting the offer, despite the fact that the campaign had already submitted documents from the prisoners agreeing to participate in the legal, nonviolent movement for independence. Another condition stipulated that no prisoner could visit or see another convicted felon, despite the fact that 2 of the prisoners are sisters who have been bunked together in jail, and another is the husband of a previously released independentista. The movement shifted focus toward a call for unconditional freedom, as the prisoners themselves tried to find a way to respond to the offer as a group, despite their geographic separation. A conference was held in San Juan in late August, with presenters including this author and WRL staff person Roberto Basic, speaking on the reintegration of the prisoners of conscience of Chile following the ouster of Pinochet. At the Grand March following the conference, the key speaker was not a Puerto Rican nationalist or independentist hero, but Chicago Congressman Luis Gutierrez, who delivered a fiery condemnation of the president's conditions. Back in the U.S., the Republican Party was waging an attack of its own, focusing on the electoral aspirations of Hillary Clinton and Al Gore and the importance of the Latino vote. When Hillary noted, in early September, that the prisoners were taking a long time to decide what to do, and that perhaps the offer should be rescinded, a furious New York congressman, Jose Serrano, fired back that the U.S. had been taking over 100 years to decide upon the fate of Puerto Rico. Several days later, 12 of the 14 agreed to accept the clemency, resulting in the almost immediate release of 11. After 2 decades of uphill struggle, a real victory had been won. Alejandrina Torres is one of those 11, now surrounded by family and friends. A teacher and officer of the First Congregational Church of Chicago, her engaging smile, soft demeanor, and strong spirit belie the 16 years of hellish conditions she endured. Immediately upon arrest, Torres was placed on special administrative detention on an all-male unit, and in 1984 experienced a brutal physical assault and double strip search at the hands of 1 male and 4 female guards. One of 3 political prisoners placed in the experimental Lexington Control Unit, she faced 24-hour-a-day surveillance, sensory and sleep deprivation, and various forms of psychological and physical torture before the control unit was closed due to grassroots pressures and an Amnesty International investigation. Despite suffering a heart attack and several chronic medical conditions, Torres was never allowed proper medical treatment. In an exclusive conversation with Peace News, Alejandrina characteristically turned the discussion away from her personal suffering and toward the conditions facing her people. Her affect is one not of bitterness, but of beauty. We decided at this particular time that we needed to respond to the people, she began, speaking of the decision to accept the clemency offer. We owed a response that would be reasonable to them, and many leaders were saying that it's been long enough. It would be better, they argued, for us to be outside, to work together and deal collectively with the ones left behind. 4 of those included in the amnesty campaign remain behind bars, including Alejandrina's stepson, Carlos Alberto Torres. Juan Segarra Palmer, who accepted the Clinton offer, must serve another 5 years, and Antonio Camacho Negrin, who was out on parole 2 years ago but re-imprisoned when he violated parole conditions by traveling extensively and speaking out politically, refused the offer and has several more years to serve. Oscar Lopez Rivera, who also refused the government's offer, has 52 years left to serve. A Vietnam veteran and lifelong community organizer, Oscar's steadfast non-cooperation with the government's machinations didn't stop him from supporting the decisions of his comrades. Oscar's commitment was mirrored in the statements of the 11 upon release, who vowed to continue work for the freedom of all. Our years in prison have not made our focus wane, continued Alejandrina, responding to a question about their ability to remain united. I think that's been part of the victory. The White House thought we would just run as individuals to sign the offer. They were surprised when we decided that we wanted to somehow meet. I suggested a telephone conference call, which we eventually were able to have. They weren't expecting that we would do it so collectively. We had some interesting conversations and came to the conclusion during some of them that what we have conceded is what they had already been in control of for most of our lives. Yes, to some extent they put the prison on our shoulders, we're carrying our chains with us onto the street. There were some very strict limitations imposed, but really it is just part and parcel of the overall U.S. outlook on the case of Puerto Rico. It is a struggle for average working people just to survive. When asked about the historical context for the conditions, especially the hypocritical call for a pledge of nonviolence while the Navy continues to bomb Vieques, Alejandrina responded by stating, "We are Vieques and Vieques is us. Vieques is struggling for their life, their rights, their freedom, and at this point it is a formidable issue to be brought out. Vieques seems to be a catalyst right now, as people are opposing the U.S. military all over the world. It's an issue that people can relate to, getting the military out and getting the U.S. out of Puerto Rico. Vieques shows how clearly the issue is colonialism, and they can't just sweep it under the rug. As for us, every historical period goes through phases," Torres continued, "and we have to grow and develop in response to the times. The Puerto Rican independence movement was never a violent movement. It had its periods in history where its resistance was expressed and manifested in a more aggressive manner, but the movement itself is not a violent movement. So how do you deal with the greatest power in the world at this particular point? When the whole issue of people occupying the bombing ranges of Vieques came up, and the whole issue of nonviolence was raised, of civil disobedience, which is another aspect of nonviolence, I thought that we should run with it. This is something that the people respond to. Our people will never respond totally to violence. We are not a violent people, and the U.S. should be really thankful for that, as there are over 3 million Puerto Ricans living within the U.S. I think that the struggle of the 1990s had been one of civil disobedience. There are few enough moments when progressives have cause to celebrate, and undoubtedly the freeing of Alejandrina Torres and her fellow defendants should be heralded by all of us working for peace. The struggle of the next period for the release of the remaining 4 and loosening of the parole conditions, for a permanent end to the use of Vieques by the U.S. military, for an end to colonialism and political imprisonment everywhere, must be met with creativity and a determination fueled by the lessons of the Puerto Ricans campaign. As we learn from one another, and learn to work together, the struggle will, indeed, continue. Credit, Elspeth Meyer. 4.7. International Tribunal on Human Rights Violations in Puerto Rico and Vieques by the United States of America. 2000. The People of Puerto Rico versus United States of America. Judgment. Presidential background. In January of 1989, a special session of a permanent People's Tribunal was convened in Barcelona, Spain, to determine whether the U.S. government was in violation of human rights treaties and obligations under international law in relation to Puerto Rico and its people. After considering 3 days of testimony from experts, and reviewing numerous documents on varied aspects of the U.S. Puerto Rico relations and their effect on the lives of the Puerto Rican people, the tribunal found that the U.S. government was denying the people of Puerto Rico their most fundamental human right, the right to self-determination. In arriving at this legal conclusion, our colleagues of the Barcelona Tribunal issued the following verdict. Based on the factual and legal foundations presented, the Permanent People's Tribunal declares: 1. That Puerto Rico and its people have the right to freely determine their political, economic, social, and cultural condition in accordance with the Algiers Declaration and principles of international law. 2. That the Constitution of the Commonwealth of Puerto Rico is not the proper way for the Puerto Rican people to exercise their self-determination right, whereas in the referenda that have been carried out on the island, the required guarantees which govern the true exercise of such right, in accordance with the resolutions and practices of the United Nations, have not been observed. Underscore 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 underscore. Held on the island of Vieques in November 2000, the International Tribunal was a critical attempt at bridging the movement to free the Puerto Rican political prisoners with the movement to end U.S. Navy occupation of Puerto Rico. In addition to collecting testimony from many international experts and local survivors of the assorted human rights abuses associated with these pillars of colonialism, this tribunal was also significant in that it took place after 11 of the Puerto Ricans had been released. With almost all of them in attendance, the tribunal was both joyous and reflective of the fact that some of the Puerto Rican prisoners were still, alas, in jail. 3. That the U.S. has an international duty to respect the right of Puerto Rico to its self-determination, in accordance with the obligations it has conventionally and customarily assumed. 4. That the actual U.S. military policy in Puerto Rico constitutes an obstacle for self-determination of the island and it threatens the peace and security conditions of the Caribbean region. In returning their verdict, our predecessor tribunal called upon the U.S. government to take the following steps to ensure the self-determination rights of the people of Puerto Rico. To implement through all political, economic, and administrative means available to them, the conditions that would make possible for the Puerto Rican people to exercise their self-determination right, and especially to acknowledge the political prisoner status of those Puerto Ricans incarcerated due to their work and militancy in favor of Puerto Rico's independence and to grant a general amnesty to all Puerto Ricans currently incarcerated because of their involvement in the struggle against colonialism. Relinquish the current powers the U.S. Congress has to amend and approve the decisions made by the representative bodies and government of Puerto Rico. Completely transfer any power the U.S. Congress or the U.S. government may have over Puerto Rico, to a deliberative body with constitutional character made up of representatives from all the political and social forces of Puerto Rico chosen on an elective basis. Negotiate such measures, as a transitional status of the juridical and political condition of Puerto Rico, until the self-determination right is effectively exercised. Guarantee that the U.S. military forces currently stationed in Puerto Rico will not interfere directly or indirectly in the free exercise of the right of self-determination by the people of Puerto Rico. 2. Findings and legal foundations. 1. Introduction. This International Tribunal on Violations of Human Rights in Puerto Rico and Vieques by the United States of America has been convened to examine what steps, if any, the U.S. government has taken to follow the directives of the Barcelona Tribunal and end its colonial domination over Puerto Rico and its people. Reaffirming the principles of self-determination set out by the Barcelona Tribunal, we sought to re-examine all the areas of Puerto Rican life that were the subject of inquiry in 1989, to determine whether the U.S. government had made any efforts to comply with its obligations under international law. What we have found, as will be discussed more fully within this document, is the absence of any movement toward the decolonization of Puerto Rico. Rather, the evidence, as comprised of the testimony of numerous experts and lay witnesses, supported by a voluminous amount of documents, show a continuation of colonial domination over the Puerto Rican nation. Harm caused by this continuing colonial domination is particularly acute in Vieques, an island municipality of Puerto Rico, 3/4 of which is occupied by the U.S. Navy that persists, since 1941, in using the island for military exercises and aerial bombardment, thus destroying the environment, ecology, health, and life of its people. Despite the nearly unanimous sentiment of the people of Vieques and Puerto Rico expressed, amongst other ways, in demonstrations by hundreds of thousands on the streets of San Juan, and by hundreds of acts of civil disobedience on the U.S. military base at the firing range of Vieques, the U.S. government refuses to stop its bombing and withdraw its military force from Vieques. At this time, the colonial situation of the Puerto Rican people has not improved. What has changed is the massive support across ideological lines for the U.S. Navy to leave Vieques and to free the Puerto Rican political prisoners. This is a propitious moment for world opinion, particularly within the human rights community, to join with the people of Puerto Rico to demand that the U.S. government immediately initiate the process of decolonization. This process must begin with the complete transfer of all power in the hands of the U.S. Congress and other branches of the U.S. government, so as to allow for the creation of a constituent body of the Puerto Rican people representing all political and social forces. We want our findings and verdict contained herein to help serve as a catalyst to marshal the pressure of public opinion to support the inalienable right of the Puerto Rican people to self-determination. 2. The U.S. government is found guilty for the continuation of the denial of the right to self-determination. Despite the annual resolutions of the United Nations Decolonization Committee, reaffirming the right of the people of Puerto Rico to self-determination and independence in conformity with Resolution 1514, the U.S. Congress and other branches of government continue to refuse to take the necessary steps to transfer all its illegally held power back to the people of Puerto Rico. Without following in full the United Nations decolonization protocols, no process of decolonization can be deemed genuine or complete. In July 2000, the Special Decolonization Committee again called upon the United States government to assume the responsibility of expediting a process that would allow the Puerto Rican people to fully exercise their inalienable right to self-determination and independence. Despite these directives mandated by the United Nations to eradicate colonialism, the U.S. Congress continues to put forth schemes designed to appear as some form of self-determination, but in reality intended to maintain the colonial status. In 1993 and 1998, referenda, denominated as plebiscites, were held in Puerto Rico, but even the colonial political parties and their U.S. government sponsors could not claim that international legal requirements for decolonization were satisfied. Neither of these votes were accompanied by the guarantee of acceptance by the U.S. Congress, neither allowed for the participation of Puerto Ricans living in the United States or clearly defined the consequences of the proposed status options, all elements required by international law. Most importantly, the voting was not conducted under the United Nations or other independent auspices, or held subsequently to full transfer of power to the Puerto Rican people and the removal of the U.S. military and other U.S. influences. 2.1 The continuing effect of colonialism on the economic situation in Puerto Rico. For the U.S., Puerto Rico often appears to be little more than a military base and an economic enclave. As established before, the U.S. military complex in Puerto Rico has increased. On the other hand, since the U.S. invasion in 1898, Puerto Rico has been treated as an economic enclave, with an institutional structure favorable to the extraction of surplus, resulting in economic disadvantage to the island. U.S. capital prevails over Puerto Rican capital. Most of the wealth generated in the Puerto Rican enclave does not remain there. About 70% of the net domestic income generated in Puerto Rico leaves the island. During fiscal year 1999, the gross domestic product was $59,946 million while gross national product rose to $38,299 million. The difference, $21,717 million, represents a payment for external factors, basically, earnings remissions. From 1991 to 1999 the remissions totaled the amount of $139,695 million. One-third of the total value of the productive activity in Puerto Rico turns into payments that the residents of Puerto Rico never see. The net U.S. government transfers $8,315 million in 1999, most of them vested rights of the people as Social Security or veterans' pensions pale compared to earnings remissions toward the U.S. for $21,717 million in the same year. This comparison does not take into consideration that the U.S. military forces in Puerto Rico do not pay any rent for the bases and the 12% of the land occupied. The employees' compensation component of the net domestic income has dropped from 61.1% in 1977 to 48.7% in 1987 to 40.8% in 1999. In contrast, in the U.S. over 70% of the total income accrues to the workers. According to the 1990 census, 58.9% of the Puerto Rican population falls under the poverty level. There will probably be no significant variations for the year 2000. In Vieques, as in the other 24 municipalities, the poverty level exceeds 70%. Since 1900, the U.S. imposed maritime laws in which all Puerto Rican commercial maritime transportation has to be carried out using transport from the U.S., the most expensive in the world. If this law did not apply to Puerto Rico, transportation costs would decrease by 40%, the cost of exported goods would diminish considerably, and the competitiveness of the Puerto Rican products in the international market would greatly increase. As of 1999, over 3 million Puerto Ricans live in the U.S. Their unemployment rate is the highest of all ethnic groups in the U.S. and 3 times the number of Puerto Ricans live below the poverty level as white citizens. Puerto Ricans, through numerous devious methods, have been driven from their homeland, forced to leave under impoverished conditions, and subjected to racial discrimination, police brutality, and other forms of oppression. The situation of the Puerto Ricans in the diaspora is the direct result of the colonial situation of Puerto Rico and can only be resolved by the end to colonialism. 2.2 The increased militarization of Puerto Rico. The military presence of the U.S. in Puerto Rico has been a major dimension of U.S. rule over the island since its military invasion in 1898. The military occupies the 12% of the land of Puerto Rico. Roosevelt Roads Base, together with other installations in the island, makes Puerto Rico the center of the United States military presence in the Caribbean. There has been an increase of militarization in the island in the last decade. Recently, with the closing of the United States military installations in Panama, installations and units were transferred to Puerto Rico, thereby becoming home to the highest concentration of United States military forces in Latin America. The headquarters of Army South and Navy South and part of the Air Force South of the United States Southern Command were all transferred to Puerto Rico. The United States military installations in Puerto Rico have had an important role in illegal United States direct and indirect interventions in other countries. 2.3 The continuing assaults on the culture, language, and legal traditions of the Puerto Rican people. The invasion and conquest of Puerto Rico in 1898 initiates a policy of Americanization that, in effect, starts a process of acculturation characterized by the following. English is made the mandatory language of instruction, elimination of Puerto Rican history as part of the school curriculum, criminalization of the singing of the Puerto Rican anthem and displaying of the Puerto Rican flag. While these impositions have been removed, English is the official language in all government transactions. There has been a substitution of the Puerto Rican Criminal Code for the U.S. Code, creation of a U.S. court that may override Puerto Rican courts, extension to Puerto Rico of laws contrary to its customs and traditions and in direct contradiction with the Puerto Rican Constitution, i.e., the death penalty. The above impositions violate the Declaration and Action Program of the International Conference of Human Rights, June 25, 1993, which among other things affirms the rights of peoples to freely develop their culture. It also adds that democracy and the respect for human rights are interdependent with the enjoyment of linguistic rights and its own cultures. This cultural imposition also violates the Declaration on the Rights of Persons Belonging to Minority, National, Ethnic, Religious and Linguistic Groups, which recognizes, promotes and stimulates respect for human rights, linguistic rights in absolute conditions of equality, and the enjoyment and development of their culture. 2.4 The continuation of repression and criminalization of the independence movement. Ever since the U.S. military invaded Puerto Rico in 1898, there has been a continuous history of repression against those who resisted U.S. intervention. This tribunal heard testimony from former political prisoners and independence leaders verifying this history. The conditions of release of the 11 independence fighters in September 1999 after 19 years imprisonment underscores the political nature of their imprisonment. The prisoners' release was the result of overwhelming support amongst the Puerto Rican people, and a massive international campaign. We echo the most recent resolution of the Decolonization Committee and call for the immediate release of all incarcerated Puerto Rican political prisoners. We further condemn the continued repression against the independence movement activists in Chicago, who have been the target of an over 2-decade campaign of harassment, disruption, and criminalization by the FBI and U.S. Justice Department. 3. The violations of the human rights of the people of Vieques. In 1941, 75% of the land in the island of Vieques, 26,000 acres, was expropriated by the U.S. Navy for military maneuvers in the eastern part of the island and munitions depots in the western part. The Vieques expropriations impacted most severely tenant farmers and poor people who, under coercive conditions, were paid $12 to $25 for their homes. For years, the U.S. Navy conspired to force Viequenses off the remaining lands, in order to occupy the whole island for their war games. Viequenses, who numbered 20,000 to 25,000 inhabitants at the time of the expropriations, have been reduced to 9,300 inhabitants, with more than 15,000 people forced to migrate to the nearby islands of St. Thomas and St. Croix. Many others now live in the main island of Puerto Rico, or the United States. As stressed by former Governor of Puerto Rico Luis Muñoz Marin in a letter dated December 28, 1961, to President of the United States John F. Kennedy, in response to a U.S. plan to expropriate the remaining part of the island. The project involves the destruction of a community, which is a political and juridical entity to which people have strong emotional attachments. The people of Vieques regard themselves as Puerto Ricans, but they also regard themselves as especially identifiable on the basis of residence in Vieques. Obviously, the political and human dismemberment, which the project involves, will be a fundamental shock. We know of no truly comparable action in American history. I believe that it is the kind of action which arouses instinctive disapproval. After 1975, when the U.S. military stopped its maneuvers in the island municipality of Culebra, maneuvers in Vieques were intensified. The U.S. military and its NATO allies use the eastern part of Vieques, known as the Live Impact Area, and its adjacent waters for their military practices and weapons testings. Moreover, the U.S. has rented the firing range to the private sector and other countries for testing most conventional and non-conventional weapons. Such arrangements generate $80 million annually for the U.S. Extensive contamination of the land, waters, and air of Vieques has resulted from the U.S. military practices and maneuvers, including a large submarine wasteland of ordnance, exploded and unexploded, and ammunition depots in western Vieques, causing an ecological disaster. Some areas have been bombed for so long and often that there is no soil there. What is left is the underlying rock, which is being broken down into small pieces by the persistent bombing. Thus, unexploded bombs and shrapnel are buried deeper every time as they hit the loose rock. Some of the offshore keys have been bombed into disappearance, and the hillsides facing the Caribbean Sea are crumbling. This causes erosion and sedimentation of the seagrass beds and coral reefs, which facilitate the entry of toxic substances into the food chain. After having denied for years that it was using depleted uranium in Vieques, the U.S. Navy was forced to admit the use of such toxic materials. In its letter, the Navy confirmed the use of depleted uranium in Vieques. Heavy metals, cyanide, and explosives have been found in the Vieques soil. Under natural conditions, heavy metals should not be present in these soils, yet, laboratory analyses indicated high concentrations of heavy metals, substances that could only be explained by human activities occurring in the area. The metals found include arsenic, barium, cadmium, cobalt, copper, chromium, lead, nickel, vanadium, and zinc, all of which are highly toxic and most carcinogenic. Many accumulate in the food chain and the fish, mollusks, birds, and humans. The spread of these toxic substances by the Navy explosions, including depleted uranium and other radioactive and chemical materials, has caused serious health problems including cancer, breathing and nervous system disorders to the Viequense population. The people of Vieques have substantially poorer health than the rest of the Puerto Ricans. In 1997, the mortality rate for the people of Vieques was 141% in relation to the rest of Puerto Rico. This rate has been steadily increasing. It is indisputable that the right of the people of Vieques to life, to a wholesome environment and to health, as well as to economic, social, and cultural development, is threatened by the military presence and activities of the U.S. Navy. The situation of the people of Vieques created by the U.S. government, and particularly the U.S. Navy, is the result of the intention to destroy in whole or in part the inhabitants of this island, that have caused death and serious bodily and mental harm. The tribunal heard moving testimony from women who had suffered harassment, rape, and abusive treatment and who lived in fear under conditions of great hardship for many years since the occupation of the island by the U.S. Navy. The above findings of fact constitute multiple and gross violations of the human rights of the people of Puerto Rico and particularly the population of the island of Vieques. See International Covenant on Civil and Political Rights, Articles 1, 2, 6, 7, 9, 17, 24, 26 and 47, GA/SPD/30, October 11, 1994, GA/8841, A/AC.109/2039, August 21, 1995, GA. RES 2105, P12, GA. RES 2023, Tehran Proclamation, May 13, 1968, The Declaration of Algiers of Universal Rights of People, GA. RES 1803, The International Convention on the Elimination of All Forms of Racial Discrimination, Preamble and Articles 1, 5, 6, and 15, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, Articles 13, 14 and 16, the Universal Declaration of Human Rights, Articles 2, 3, 5, 13, 22, 23, 25, 26 and 28, the International Covenant on Economic, Social, and Cultural Rights. 3. Verdict. According to the evidence presented before this tribunal through direct testimonies and expert witnesses, this tribunal concludes that the United States has committed systematic violations of human rights regarding Puerto Rico's right to self-determination, has persecuted opponents to United States colonial policies, has increased militarization on the islands and, thereby, threatened peace in the region, has continued the economic exploitation, has forced the displacement of much of the population of Vieques, has caused the economic and political repression of Puerto Ricans in the diaspora, has caused a general degradation of the environment, has committed abuses against women and against the cultural rights of the population. This tribunal urges that the United States of America take the following steps without any further delay. 1. Transfer all sovereign powers to the people of Puerto Rico, without any conditions or reservations, to enable Puerto Ricans to exercise peacefully and freely their right to self-determination, in the manner Puerto Ricans deem most appropriate, and to secure the integrity of their national territory. 2. Release the remaining political prisoners and cease all forms of repression against those working against colonialism. 3. Take immediate steps to end the military exploitation and colonial oppression of the people of Puerto Rico, including the immediate cessation of bombing in and around Vieques and the removal of all military installations from the territory of Puerto Rico. 4. Redress all damages caused to the natural wealth and resources of Puerto Rico and Vieques, caused by the military activities of the United States, and to provide for full reparations for the injuries caused to the people of Vieques, and the damage to their environment, including all measures for the complete decontamination of the island, and surrounding air and waters, and for the economic recovery and development of the island. Only in this manner will the people of Puerto Rico be in a situation to fully exercise their right to self-determination and freely pursue their economic, social and cultural development. In Vieques and San Juan, Puerto Rico, November 21, 2000. Dr. Dennis Brutus. President. Dr. Manuel Ramon Alarcón Caracuel. Vice President. Attorney Adolfo de Jesus Solares. Vice President. Dr. Rainer Hull-He. Vice President. Dr. Graham Russell. Vice President. The Most Rev. Walter F. Sullivan, Bishop. Vice President. Dr. Antonia Pantoja. Vice President. Chiefs Designee F. Ryan Mallinson. Vice President. Witnesses' testimonies and documents Declaraciones de Testigos y Documentos. Noel Colón Martínez, Esquire. Juan Mari Braz, Esquire. Fernando Martín, Vice President. Partido Independentista Puertorriqueño. Lolita Lebrón. Dr. Ronald Fernandez. Jan Sisler, Esquire. Alicia Rodriguez. Elizam Escobar. Rafael Cancel Miranda. Jose Solis Jordan. Juan A. Justi Cordero, Ph.D. Letter dated August 8, 1947. From I.W. Silverman. Letter dated December 28, 1961. From Governor L. Muñoz Marin. Letter dated January 16, 1962, from President John F. Kennedy. Dr. Francisco Catala, economist. Eduardo Morales Cal, Esquire. Radames Tirado Guevara. Ismael Guadalupe. Carlos Ventura. Alvaro Correa del Rio, Bishop. Cristina Garay. Miriam Soba. A foot internet page. Yabira Bozenin. Lirio Marquez and Jorge Fernandez Porto. Rev. Hector Soto Velez. Carlos Zenin. Carlos Zenin. Dr. Rafael Rivera Castano. Dra. Cruz Maria Nazario. Robert L. Rabin. Elan Sayeder. Jose Lopez. Luis Gutierrez. Ana Rivera Lassen. 4.8. More than 25 years, Puerto Rican political prisoners. Jan Sisler 2007. In 1999, President Bill Clinton commuted the prison sentences of 12 of 15 Puerto Rican men and women arrested in the early 1980s, all of them long considered political prisoners and prisoners of war. Convicted of seditious conspiracy, they had served 16 and 19 years of prison sentences ranging from 35 to 90 years. Most were convicted of being members of the Fuerzas Armadas de Liberación Nacional, a militant, clandestine pro-independence group that between 1974 and 1980 claimed responsibility for more than 100 bombings, mainly in Chicago and New York, aimed at corporate, military, and government targets. None of the 15 were charged with or convicted of hurting anyone. As a 1980 Chicago Tribune editorial noted, they had been out to call attention to their cause rather than shed blood. Nonetheless, their sentences averaged together amounted to 70.2 years, about 7 times the average murder sentence at the time. That is why the president said he was moved to act, because they were serving extremely lengthy sentences, which were out of proportion to their crimes. Their supporters said then, and continue to say now, that they were punished not for what they did but for who they are and what they represent. Puerto Ricans have fought and gone to jail for their resistance to colonialism since the days of the Spanish Empire. Under U.S. rule beginning in 1898, there have been some 2,000 political prisoners whose sentences added together come to 11,116 years, and there have always been campaigns for the release of those in custody. In the 20th century, successful campaigns led the 1952 presidential commutation of the death sentence given to Nationalist Party member Oscar Collazo, convicted after the 1950 attack on Blair House in Washington, the release of hundreds of Nationalist Party members detained as a result of the 1950 uprising, the 1979 presidential commutations of the Nationalist Party prisoners Lolita Lebrón, Rafael Cancel Miranda, Irvin Flores, and Andrés Figueroa Cordero, convicted after the 1954 attack on the U.S. Congress and held in prison for 25 years, and Oscar Collazo, who served 29 years, and finally the 1999 presidential commutations. Puerto Rico has welcomed the former prisoners with open arms, and each has not only successfully integrated into civil society, but has joined the ongoing campaign for the release of those who remain imprisoned. Underscore 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 underscore. Originally published in Third World Resurgence, November/December 2007. Today, 2 of the original 15 pro-independence militants arrested in the early 1980s remain in prison, Carlos Alberto Torres and Oscar Lopez Rivera, who have now served 27 and 26 years of their 70-year sentences. They have broken every record for the longest-held Puerto Rican political prisoners, except one, that of Collazo, who served 29 years. When they and the others were arrested and charged, they immediately invoked international law, which provides that colonialism is a crime, that a colonized people may use any means at its disposal to combat this crime, and that the courts of the colonizing country may not criminalize anti-colonial militants. They thus claimed prisoner of war status and refused to recognize the court's jurisdiction. They mounted no defense and did not challenge the government evidence against them. Neither the state nor the federal authorities recognized this argument. At sentencing, one of the accused pointed out to the court that the hearing was taking place on the U.S. holiday commemorating George Washington's birthday and likened the cause of Puerto Rican independence to that of Washington and his anti-colonial efforts. The judge retorted that if the British had captured Washington, they would have killed him on the spot, adding that he regretted there was no federal death penalty in effect, since this would have been his preferred sentence. During their time in prison, both Torres and Lopez Rivera have endured mistreatment, including sleep deprivation and total isolation. From 1986 to 1998, Lopez Rivera was held in the highest security facilities in the federal prison system, in conditions not unlike those at Guantanamo under which enemy combatants are held, conditions the International Red Cross, among other human rights organizations, have called tantamount to torture. In 1988, he was convicted of conspiracy to escape in an FBI sting operation. His additional 15-year sentence is more than 8 times longer than the average sentence for actual escape. At long last he was transferred to a general population maximum security prison, only to be moved 7 years later to a new, harsher penitentiary that houses death row inmates and the federal execution chamber. After the September 11 attacks, Torres was segregated from the rest of the medium security prison population, which puzzled the prison staff, given his spotless record. But they said they were unable to do anything, since the order came from Washington. Personnel made it quite clear that his segregation had nothing to do with his prison conduct and everything to do with national security and his being convicted of seditious conspiracy. The Bureau of Prisons uses the same justification each time they deny them something other prisoners are entitled to, like family visits and attendance at funerals. Despite these hardships, both men, thirsting to express themselves, found art. Never having painted, drawn, or worked with ceramics before prison, they taught themselves the skills and patiently worked to hone them. In anticipation of the 25th anniversaries of their arrest and imprisonment, Torres conceived Not Enough Space, a traveling exhibit of his ceramics and paintings and Lopez Rivera's paintings and drawings, as a way to once again call attention to the case of the Puerto Rican political prisoners. The colorful portraits, as well as the masks, bowls, and plates, draw on Puerto Rican folkloric images and draw attention to the island's rich history, as well as to its continuing colonial status. But beyond that, the works also say to us, unequivocally, Estamos vivos y coleando, and 25 years of prison cannot rob us of our culture or extinguish our commitment to our people and their right to determine their own destiny. The National Boricua Human Rights Network is coordinating Not Enough Space, which has already opened in Chicago, Cleveland, Los Angeles, New York City, Philadelphia, San Francisco, and Morelia, Mexico, as well as in several cities in Puerto Rico, sponsored by the Comité Pro Derechos Humanos. Not Enough Space will also travel to Venezuela, then return to Puerto Rico for additional exhibitions. The Comité, working nationally and internationally, is actively garnering support for their release. In addition to sponsoring the exhibit, the work includes collecting signatures on letters to President Bush, advocating with religious, civic, labor, and governmental entities to pass resolutions supporting their release, convening educational seminars and conferences, holding vigils, marches, and pickets, and presenting at international forums, including the United Nations. 4.9. Puerto Rican independence movement under attack in New York and San Juan. Jan Sisler 2008. It appears to us to be a reinitiation of the harassment of independentists. U.S. Congressman Jose Serrano, speaking to FBI Director Robert Mueller. An unexpected knock on the door, men in trench coats handing you a grand jury subpoena. If you're involved in the movement for the independence of Puerto Rico, this isn't just a not-so-fond memory of the COINTELPRO era. It's 2008 in New York City, and you are Christopher Torres, a young social worker, Tanya Frontera, a young graphic designer, or Julio Pabon, Jr., a young filmmaker from the Bronx. Their subpoenas have aroused vigorous support for them, not just in New York, but also in cities across the U.S. and in Puerto Rico. On the island, over 40 organizations united to condemn this latest wave of repression and convened a demonstration on January 11 where over 1,000 people participated under the theme "In the Face of Repression, Unity and Struggle," with placards and banners calling for the FBI and the federal courts to leave the island. Simultaneous activities took place in Brooklyn, Hartford, Chicago, San Francisco, Los Angeles, Philadelphia, Orlando, Fitchburg, Massachusetts, and Cleveland. As resolutions condemning the repression emanated from the National Lawyers Guild New York City chapter, the American Association of Jurists, the Interfaith Prisoners of Conscience Project, and the Latin America Solidarity Coalition, the New York Spanish-language daily El Diario/La Prensa published an editorial ringing the alarm bell, and U.S. Congressman Jose Serrano telephoned FBI Director Mueller to voice his concern. Why the subpoenas? Why now? And why the resounding, unified denunciations? Underscore 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 underscore. Originally published in Monthly Review Zine, January 28, 2008. Dating back to the era of Spanish colonial control over Puerto Rico, Puerto Rican people have organized to wrest their sovereignty from foreign domination. That resistance continued after the U.S. invasion and occupation in 1898. When the colonizers repressed and criminalized public organizing for independence, clandestine organizations formed, including the popular Boricua Army Macheros in the 1980s. In 1985, the FBI arrested and almost killed its leader, Filiberto Ojeda Rios, accusing him of participation in the 1983 expropriation of $7.5 million U.S. government-insured dollars from a Wells Fargo depot in Hartford, Connecticut. After his release on bail, Ojeda returned to clandestine existence. In spite of the FBI's ever-increasing reward for information leading to his capture, he remained underground for some 15 years. On September 23, 2005, however, a squad of FBI assassins circled his home, shot him, and left him to bleed to death. The assassination outraged the entire nation, and the FBI became a pariah. Hoping to distract public attention from their own criminal conduct and justify their presence on the island, particularly in the post-9/11 era, the FBI soon went on the offensive. On February 10, 2006, allegedly in a continuing investigation of the Macheros, they raided the homes and businesses of several independence activists and in the process pepper-sprayed the nation's journalists who were covering the FBI's paramilitary incursions. Again, the entire country expressed its outrage. Since then, activists have been stopped, searched, and harassed, with the homes and offices of many others, including attorneys and movement leaders, mysteriously broken into in events reminiscent of the infamous Black Bag COINTELPRO jobs. Computers, digital cameras, and cell phones are taken, while other valuable items remain untouched. Recent rumors are that the head of the FBI in San Juan, Luis Fraticelli, is close to the end of his tenure and has given instructions to accelerate efforts to neutralize the remains of the clandestine group. For Fernando Martin, a leader of the Puerto Rican Independence Party, the FBI wants to clean up its image after the assassination of Filiberto, because they want to be able to say that in Puerto Rico, they investigate people of all parties somehow salvage their image after their selective attacks. Julio Muriant, a leader of the National Hostas Independence Movement, stated, "The legal facade of this repressive operation is directed against the Macheros, but the real intention is against the entire independentist movement, including against the people of Puerto Rico, calling it an attack which is not against any particular organization, but against a political, social, patriotic movement, and against a people." U.S. Congressman Jose Serrano, who was instrumental in getting the FBI to disclose thousands of pages of records documenting its illegal surveillance of and intervention in the independence movement, said of these subpoenas, "It certainly appears to be a fishing expedition, which," he noted, "harkens back to the days when, according to FBI Director Free, the agency engaged in egregious illegal action, maybe criminal action." The subpoenas, initially returnable on January 11, were continued to February 1. Attorneys announced they would file motions to quash the subpoenas. Frontera's attorney, Martin Stoller, noted that if the motion is denied, Tanya will have to appear before the grand jury, and may decide not to testify, invoking her constitutional rights. Organizations in Puerto Rico have announced they will protest in various towns of the island on February 1 in defense and support of the three young people subpoenaed, with the themes "Wake Up," "Barricua," "Defend Your Own," and "The Grand Jury is Illegal." Additional protests are being planned in U.S. cities as well. The consequences of not collaborating with the grand jury are well known to those who support independence. Norberto Centrone Fialo, whose home was searched during the February 10, 2006, FBI incursion, and who participated in the January 11 protest in San Juan, refused to collaborate with various grand juries investigating the independence movement in both Puerto Rico and New York in 1981 and 1982 and served close to 3 years in prison as a result. Julio Rosado, who participated in the January 11 protest in New York, resisted grand juries investigating the Puerto Rican independence movement. Serving 9 months for civil contempt in 1977, and later much of his 3-year sentence for criminal contempt. "They have always been there, whenever they want to intimidate," he said, adding that he is convinced there will be more subpoenas to come. A New York daily Spanish-language newspaper expressed editorial concern over the political witch hunt, in words which should give us all pause. "Because of laws initiated by the Bush administration and passed by our Congress, the legal protections that would give political dissidents a right to due process have been eroded. The net is wide for casting someone with suspicious political beliefs, without having been charged, tried, or convicted of a crime, as a threat. Because the attacks on civil liberties and human rights and the historical intimidation and repression of Puerto Rican independence supporters are interrelated, activists must make those links. That's all the more urgent considering the silence of most elected leaders and the virtual media blackout on the subpoenas. In the context of secret prisons, torture, detention without trial, and warrantless wiretapping, the FBI's fishing should be a concern for anyone interested in rescuing this country from a rising police state." Section V. Resisting Repression, Out and Proud. During the last 25 years, a strategic linking of peoples and struggles has also taken place between the lesbian, gay, bisexual, and transgender liberation movement and communities and the movements to free U.S. political prisoners. These links were not hurt by the fact that many key activists working for the freedom of these prisoners were, themselves, members of the LGBT movement. Also significant, especially given the extreme homophobia present in much discussion about prison life, is the fact that several political prisoners were out lesbians, and one was a bisexual man. This section includes some of the published documents of this work, as well as a couple of newly written or published pieces reflecting on these links. V.1. After the confiscation of gay community news. Laura Whitehorn 1992. There's been a terrible mistake. You've just informed me that homosexuality is not permitted in this institution. I now inform you that I am a homosexual. Therefore, I am not permitted in this institution and must be immediately released. V.2. Not something that we can postpone. Dorabo bin Wahad 1991. I've been looking forward to speaking to a predominantly gay and lesbian gathering around the issue of repression. It's very difficult to deal with the issue of misogyny and sexism and homophobia in a society that is premised upon white-skin male privilege. The issue of political repression, of course, is an ethical issue. It's an issue that touches all of us, regardless of our particular ideological tendency within the progressive movement, regardless of our sexual orientation. It is an issue informed by a system of racist class privilege that determines our relationships to one another. It has been a struggle for me, since my release, to arrive at a principled position around the issue of homophobia and sexism. It is an ongoing struggle on my part. I'm still learning. I feel that it is very important, if we are to build a movement, to deal concretely and in a principled way with the issues of sexism and homophobia. As a black revolutionary who has struggled and continues to struggle on the core issues of black liberation, I cannot but conclude that if we are to be successful, we have to deal with sexism head-on. It is not something that can be swept under the rug. It is not something that we can postpone until tomorrow, pending revolutionary victory. This is important, because as my comrade and companion and wife, Tanaquil Jones, has often said, the personal is political and the political is personal. I'm kind of taken aback that she's not here addressing you instead of me. I think that her analysis of sexism, misogyny, and homophobia is much more developed than mine. She attempted to point out to me one evening, while we were struggling over the issue of homophobia in the black movement, how we often shy away from dealing with sexism because of the establishment of a heterosexual standard of conduct, of set behaviors and of social relationships. We seldom question certain assumptions that we make. After long and arduous struggle with Tanaquil, I could only conclude that the issue of misogyny and the issue of homophobia are very much interwoven. The hatred and fear of women is part and parcel of the whole edifice of homophobic behavior and conduct in the society. Therefore, it is impossible to struggle against sexism against black women or white women, or in society at large without simultaneously struggling against homophobia. Underscore 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 underscore. Excerpts from a talk given at a New York City forum on the case of Mumia Abu Jamal sponsored by lesbian and gay folks supporting political prisoners, a group later renamed QUISP. The speech was widely acclaimed as a groundbreaking statement by a black Muslim revolutionary, and the sponsoring group later sold tapes of it at LGBT events and arranged to have it played on Pacifica radio station WBAI. I now find myself constantly struggling with brothers in the black movement in this respect. Very few of them see the issue of homophobia as being an issue that has to be addressed with principle. Surely we cannot build a new society if we premise that society on the oppression of other people. And in the course of building a new society and struggling for empowerment in our communities, it becomes clear that we have to establish the basis for our relationships with each other as we struggle. In other words, we cannot for instance build an organization that claims to liberate black people and yet instills in that organization sexist or misogynist behaviors. We cannot build an organization based on projection of male egos. Historically, we have seen that the majority of wars, if not all of the wars that humanity has faced, have been launched and initiated by men. Very few women have started cataclysmic wars. Of course there are exemptions, there are the Margaret Thatchers of the world. But I am not trying to deal with the exceptions. I'm trying to deal with the rules. I was in Europe recently, and I sat with the old comrade by the name of Donald Cox, DC. And DC had a very interesting proposition. You know the rule book, he asked. We have to build an organization and make sure that the men do not read it. I said, now, homeboy, that's a little strong. How can we build an organization where men don't participate in the leadership? DC said, no, I'm not saying that men should be excluded from the leadership per se. I'm just saying that we should experiment with a new type of organization. An organization that empowers women and ensures that women are the primary leaders of the organization. The rules suggest that we have been socialized over a millennium to react and deal with things a certain way as men. We take male privilege for granted. And the majority of the power struggles that occur in organizations occur as a consequence of male egos, as a consequence of certain presumptions that we make as men. We can see this when we look at our history, including our recent history in the Black Panther Party. We cannot have an organization with big eyes and little views. We can never have an organization that is founded upon one leader. This doesn't necessarily mean that men and women who are qualified to lead a particular struggle or a particular program at a particular time cannot be empowered by the collective to carry something forward which the collective has agreed upon. But we have to have collective leadership. It's not easy to struggle with your own privilege. As a male, it's not easy to struggle with your own privilege. It therefore should proceed, and I think everyone here can agree, that it is not easy for white people to struggle with their own racism. It's very difficult to struggle with white skin privilege in a racist society. White folks take a lot of things for granted. One thing they take for granted is that what they have to say is important. They always assume that. And men do the same thing. Men believe that what they have to say is important and what women have to say is somewhat less important. Even the most advanced men who are struggling actively and sincerely with their own sexism show some signs of this. So how do we deal with these things that we take for granted in this society? I know, for instance, that there's a predominantly gay male organization called the AIDS Coalition to Unleash Power. Here's a group that in many respects has carried out some of the most militant actions around the AIDS crisis, around homophobia, through direct action. They have carried out some very good struggles that have advanced the consciousness, the mass consciousness, of many people. But they have not principally struggled with their own racism. They have not principally struggled with their own white skin privilege and white skin male privilege, even though it's a gay organization. And we have to ask ourselves how it is that an organization like ACT UP has no people of color in leadership. How is that they do not have a principled position around the issue of political repression and political prisoners? How is it they do not support the liberation struggles of people of color? How is that they have not yet formed any operational coalitions with grassroots Black, Puerto Rican, or Asian organizations? Another example to look at is that of the Irish movement. Just about every Irish organization in New York City is an advocate for the freedom of IRA political prisoner Joe Doherty. His cause has been put at the head of the St. Patrick's Day Parade. The Negro mayor of New York City has seen fit to visit Joe Doherty in prison, to pay his respects and wear a freedom button. David Dinkins has said that Joe is a freedom fighter. Now I believe that Joe Doherty should be supported by every one of us. Joe is a man who has struggled mightily against British domination and British imperialism in Northern Ireland. He deserves our principled support. But Joe's freedom is not the issue. The issue is, how can all of these Irish groups support Joe Doherty and the right of the Irish people to wage armed struggle, but find it reprehensible when the Puerto Rican nationalists wage the same armed struggle against U.S. domination in Puerto Rico? How is it that the Irish policemen find it admirable when the IRA slay British soldiers, but find it difficult to believe that black people have an equal right to slay their oppressor? You see, they're a one-issue community. The only issue that they're dealing with is Northern Ireland. The only issue that they're dealing with is the freedom of Joe Doherty, and they don't even understand that the IRA itself expresses solidarity with Puerto Rico and with other oppressed people with color. We have gay and lesbian organizations that support gay and lesbian issues, anti-sexist issues, but they do not support freedom for black political prisoners. And I come to you this evening to ask you to put on more affairs like this, To reach out into the gay and lesbian community and accept black leadership. When a black man who is gay is attacked by the police, he is attacked for two reasons. He is attacked because he is black and he is attacked because he is gay. And I, as a revolutionary involved in trying to build a principled movement, can no more deny that black man the right to struggle for liberation of his people than you can deny that gay man the opportunity to lead in the gay and lesbian movement. Now I get a lot of flack from Muslims, and I myself am a Muslim. I say that, as Muslims, we cannot endorse the oppression of anyone. In the Quran, we are enjoined to stand up for the truth, even if it is against our own self. We are told that there should arise from amongst us a band of people who enjoin the good and forbid the wrong. That's the bottom line in Islam, to enjoin the good and forbid the wrong. And so I would always ask the Islamic scholars who challenged me, how can you enter into a coalition with people who are reactionaries and who carry out policies that are contrary to interests of our community, yet condemn me for working with gay and lesbian groups who have never oppressed one Muslim, who have never killed one Muslim? Those movements that identify the same enemy as ours, those movements who establish the right and forbid the wrong, we should align ourselves with them. And if you're telling me that we shouldn't do this because of the individual sexual orientation, I would beg to differ. So you see, I have a problem in the Muslim community, but it's nothing I can't handle. You'd be surprised how a principled struggle with well-meaning individuals can bring about some significant changes in how they deal with people. I remember when I was in prison we got word through the Voodoo Communications Network through Kuwaisi, that if we needed help in raising up on out of that high-walled prison to let them know. We did. That was Kuwaisi, for whom risks were like the air he breathed. You breathe, you take risks. I risk, therefore I am. And though it made no sense to me then that he was also the anarchist, I thoroughly understood it now. When the BPP could no longer serve his spirit, the Black Liberation Army's anarchistic style could. And he obviously liked the vision of a Republic of New Africa, free from Babylonian control and self-determining. Ashanti O'Malley Alston. We say that the U.S. has no right to confine new African people to red-lined reservations and that we have a right to live on our own terms in a common land area and to govern ourselves, free of occupation forces such as the police, National Guard, or GIs who have invaded our colonies from time to time. We have a right to control our own economy, print our own money, trade with other nations and enter a workforce where we are not excluded by design and where our wages and the wages of all workers cannot be manipulated by a ruling class that controls the wealth. We have a right to build our own educational institutions and systems where our children will not be indoctrinated by aliens to suffer the destructive designs of the U.S. government. Kuwaisi Balagoon. Brink's opening trial statement. Kuwaisi Balagoon. December 22, 1946 to December 13, 1986. He was an anarchist in a black nationalist movement, he was queer in a straight-dominated movement, he was a guerrilla fighter after it was chic, and he never backed down from his ideals, his beliefs, the struggle, or himself. And he demanded to be seen not as a revolutionary icon, but as a person, beautiful and flawed. Walida Imarisha revolutionary poet. Kuwaisi Balagoon died of AIDS-related pneumonia in 1986, while in his fifth year of a 75-year prison sentence. For more writings by and about Kuwaisi Balagoon, see Kuwaisi Balagoon, A Soldier's Story, writings by a revolutionary New African anarchist. Also visit www.urbanguerrilla.org/kuwaisibalagoon.html. V.3. Dykes and Fags Want to Know. Interview with lesbian political prisoners. Queers United in Support of Political Prisoners, Linda Evans, Laura Whitehorn, and Susan Rosenberg 1991. Quisp, I'm an activist. Why haven't I heard of you before? Laura, I think it's because there's been a long time during which the left and progressive movements haven't really tried to know who's in prison, including but not limited to political prisoners and POWs. For instance, how many AIDS activists know about the many PWAs in prison and the horrible conditions they live in? Aside from Mike Regal at Gay Community News, how many writers and media folks in our movements try to reach into the prisons to support lesbian and gay prisoners, whose lives are often made pretty rough by the pigs. In general, this country tries to shut prisoners away and make people outside forget about us. In the case of political prisoners, multiply that times X for the simple fact that our existence is a danger to the smooth, quiet running of the system. Our existence shows that this great democracy is a lie. The government doesn't want you to know who we are, that's why they try so hard to label us terrorists and criminals. Linda, political prisoners have been purposely disappeared by the US government, whose official position is that there are no political prisoners inside the U.S. This is the way that the government denies both that the motivations for our actions were political and that the movements we come from are legitimate, popular movements for social change. The prison system isolates all prisoners from their communities, but especially harsh isolation is instituted against political prisoners, restricted visiting lists, frequent transfers to prisons far away from our home communities, mail censorship, maximum security conditions, long periods of time in solitary confinement. But our own political movement, too, has ignored the existence of political prisoners. I think this has largely been a product of racism. Most U.S. political prisoners/POWs are black and Puerto Rican comrades who have been locked up for over a decade. Unfortunately, there has never been widespread support among progressive white people for the black liberation struggle, for Puerto Rican independence, or for Native American sovereignty struggles, and these are the movements that the black/Puerto Rican/Native American political prisoners/POWs come from. Also, many political activists have actually withheld support for political prisoners/POWs because of disagreements with tactics that were employed or with actions of which the political prisoners have been accused or convicted. These disagreements are tactical in nature and shouldn't be allowed to obscure the fact that we all have been fighting for justice and social change. This withdrawal of support leads to false divisions amongst us and actually helps the state in its strategy to isolate political prisoners/POWs from our communities and political movements. Underscore 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 underscore. Dykes and Fags Want to Know was a compilation of 3 separate interviews conducted by mail with lesbian political prisoners Laura Whitehorn, Linda Evans, and Susan Rosenberg in 1991, when all 3 were held at D.C. jail awaiting trial in the Resistance Conspiracy 6 case, referred to herein as the RCC-6. The interviews were conducted and released as a booklet by the New York City solidarity group called Queers United in Support of Political Prisoners. It was published by Arm the Spirit Press in Toronto in 1995. The language of Dykes and Fags reflects usage among some LGBT people, then and now, aiming to reclaim those terms from their status as hateful epithets and make them badges of pride for their own use. Susan, the activists/radicals of the late 1980s and 1990s have to reclaim the history of resistance that emerged and continued through the 1970s and 80s. As long as the government and mass media get to define who and what is important, then the real lessons contained in ours and others' experiences will get lost. People haven't heard of us because there is a very serious government counterinsurgency strategy to bury the revolutionaries who have been captured in prison. I have been in prison 6 years, and over half of that time was spent in solitary confinement or small group isolation thousands of miles away from my community and family. My experience is similar to the 100 to 150 other political prisoners in the U.S. If the individuals from different movements are destroyed, it is a way to delegitimize the demands of the movements. Quisp, did you do it? Did the government misrepresent what you did? If so, how? Laura, yes, I did it. I did resist racism, sexism, imperialism with every fiber of my queer being, and I believe we need to fight for justice. The government's version of what we did is a complete lie, though, in that they call resistance a crime. It's sort of like the way Jesse Helms calls us sick. He's as sick as you can get. On the morality meter, he doesn't even make the needle move. Same way the US government, a genocidal system, calls acts of revolutionary struggle terrorist violence, and their system of law, justice. Linda: yes, I'm proud that I've been part of the struggle to build an armed clandestine resistance movement that can fight to support national liberation struggles and that will fight for revolution in the US. Of course the government misrepresented what we did first of all by calling us terrorists to make people think we were a danger to the community, as if our purpose was to terrorize or kill people. Quite the contrary, all the armed actions of the last 20 years have been planned to minimize any risk to human life. This, of course, is in stark contrast to the actions of the terrorist government, which is responsible worldwide for supporting death squads and mercenary armies like the Contras and Savimbis UNITA in Angola, which supports the Israeli war of genocide against the Palestinians and the brutal system of apartheid, and which supports daily police brutality in black and third world communities here, even such acts as the aerial bombing of MOVE in Philadelphia in 1985, which killed 11 people and created a firestorm that left over 250 people homeless. Susan: I have been a revolutionary for much of my life, a revolutionary in the sense that I believe in the need for profound social change that goes to the roots of the problem, which I believe is systemic. Consequently I have, along with others, tried many methods of struggle to enact a strategy to win liberation and attack the state as representative of the system, first as a peace activist in the late 60s, then as a political activist in the 70s, and then in joining the armed clandestine resistance movement that was developing in the 80s. I am guilty of revolutionary anti-imperialist resistance. Of course, the government has misrepresented me and all of us. The main form that has taken is to call us terrorists, which is something that couldn't be further from the truth. Just as all opposition to the Cold War of the 50s was labeled communist, the 80s equivalent is terrorist. Now there are all kinds of terrorists according to the U.S. all of it bullshit. I don't mean to beg the question in the specific. I believe that no revolutionary captured comrade says what they have or haven't done within their revolutionary work. Quisp: Audre Lorde says the master's tools will never dismantle the master's house. How do you react to this? Laura: I don't think violence is just one thing, so I don't think it's necessarily the master's tool. If revolutionaries were as vicious and careless of humanity and innocent human lives as the US government is, then I think we'd be doing wrong. But when oppressed people fight for freedom, using violent means among others, I think we should support them. Would you have condemned African slaves in the US for killing their slave masters or for using violence in a struggle for freedom? To me, the issue is how do we fight effectively and humanely for liberation. As we build the struggle, we have to be very self-critical, very self-conscious about how we struggle as well as what we struggle for. But I think we also need to fight to win, and I think that means engaging in a fight for power. For the past 5+ years, I've witnessed close up the violence, slow, brutal, heartless of genocide against African American women. To refuse to fight to change that would, I think, be to accept the violence of the state in the name of rejecting the violence of revolutionary struggle. Linda: I disagree with posing the issue in the way she does. I don't think the issue is violence, but rather politics and power. Around the world, imperialism maintains itself, keeps itself in power through military power and the threat of violence wherever people struggle for change. Liberation movements have the right to use every means available to defeat the system that is oppressing and killing people. This means fighting back in self-defense, and it means an offensive struggle for people's power and self-determination. But reducing it to a tactical question of violent means doesn't recognize all the aspects of building a revolutionary movement that are crucial to actually mobilizing people, developing popular organizations, empowering oppressed groups within the people's movement like women and indigenous people, developing a revolutionary program that can really meet people's needs and that people will fight to make real. A slogan that embodies this for me comes from the Chinese Revolution: without mass struggle, there can be no revolution. Without armed struggle, there can be no victory. Susan: I always took the quote from Audre Lorde to mean the opposite of what you say. Funny, no. I always interpreted her saying that to mean the master's tools being electoral/slow change. Well, there you go. Quisp, why is it important to support political as opposed to non-political prisoners? Shouldn't we be concerned about all prisoners? Laura, I think we should be concerned about all prisoners, and I don't think it's ever been us political prisoners who have promoted any irresolvable contradiction between us and the rest of the prisoners in the U.S. But within that, I think there is a particular need for progressive movements to defend political prisoners, because it's a part of fighting for the movements we come from. If you are fighting racism and homophobia, and there are people serving long sentences in prison for fighting those things, I think you advance the goals by supporting the prisoners. I also think that support for political prisoners helps expose how repressive and unjust the whole system is. That can also be an avenue to supporting all prisoners. Support for political prisoners is a concrete act of resistance to the control the government keeps over all our minds. It fights the isolation and silencing of political prisoners and POWs. It asserts the legitimacy of resistance. And in my experience, it is a major way that people outside become aware of the purpose and nature of the prison system as a whole. Linda, yes, it's important for our movement to be concerned about all prisoners, and I think it's especially important for the lesbian and gay movement to concern ourselves with combating attacks on lesbian/gay prisoners and supporting all prisoners with AIDS. Concerning ourselves with all prisoners and with the repressive, warehousing role of prisons in our society is another way of fighting racism, since the majority of prisoners are from third world communities. Prisoners get locked away out of sight, out of mind, and the few prisoners' rights that were won in prison struggles are being undermined and cut back. Human rights are nearly non-existent in prison, and without community support and awareness, the government can continue to escalate its repressive policies, and conditions will just steadily worsen. This is especially true for prisoners with AIDS, since the stigma attached to AIDS in society generally is heightened in prison. Prisoners with AIDS die at an even faster rate than PWAs on the outside because treatment is so sporadic and limited and conditions are so bad. So I would never say for people to support political prisoners as opposed to non-political prisoners. Our interests inside prison are definitely not in opposition to each other. All the political prisoners/POWs actively fight for prisoners' rights and for changes in conditions that will benefit all prisoners. But it's important to build support specifically for political prisoners because we represent our movements, and it's a way for us to protect and defend the political movements we come from against government repression. For the movement on the outside to embrace and support political prisoners/POWs makes it possible for us to continue to participate in and contribute to the movement we come from, and it makes it impossible for the government to isolate and repress us in their efforts to destroy our political identities. Susan, all prisoners are in desperate need of support, and as the population gets greater and the repression gets heavier, the prisons will become a major confrontation within the society. If the prisons are to become a social front of struggle, then there must be a consciousness developed to fight the dehumanization and criminalization that prison intends. Political prisoners are important to support because we are in prison for explicitly social/political/progressive goals. Our lack of freedom does affect how free you are. If we can be violated, so can you. There is no contradiction between political and social prisoners. Quisp, how does being a lesbian fit in with your work? Laura, the same way it fits into my life. It is a basic, crucial part of my character, my outlook on things, my personality. Because I'm a lesbian, the fight against homophobia and sexism take on particular importance. But really, I think my lesbianism helps me care about the oppression of others by the imperialist system. So I think my lesbianism makes me a better anti-imperialist. It makes me fight all the harder. Being a lesbian in prison is often very hard, but being out gives me a lot of strength. I have to say that I am very proud when I hear or read about the struggles queers are waging out there. Linda, being a lesbian has always been an important part of the reasons why I'm a revolutionary, even before I was self-conscious about how important this is to me. I don't separate being a lesbian from any other part of my life, or from my politics. Because I experience real oppression as a lesbian and as a woman, I am personally committed from the very core of my being to winning liberation for women, lesbians, and all oppressed people. This makes me more willing to take risks and to fight, because I have a vision of a society I want to live in and to win for future generations, where these forms of oppression don't exist. I think being a lesbian has also helped me recognize the importance of mutual solidarity and support between the struggles of oppressed people, despite the sexism, heterosexism, and racism that often interfere in the process of building these alliances. I really believe that we have a common enemy, the imperialist system, and that we have to support each other in all the forms our struggles against that enemy may take. These alliances need to be built in a way that respects the integrity of our various movements. Susan, well, being a lesbian is part of the very fabric of my being, so the question is not really how it fits into my work, but rather how conscious do I make my lesbianism in living in prison or in the life of resistance I lead. It alternates depending on what the conditions are. Recently I have come out because at this point I have chosen to be more consciously lesbian identified. I have done this because I believe that as gay people we need more revolutionary visions and strategies if our movement is to become significant in linking the overturning of sexual oppression with other forms of oppression. The other reason I have felt compelled to be out is that my tightest, most important women in the community we live in are the butches. It is the butches who suffer most for their choices/existence in prison. In recognition of Pete, Cowboy, Juju, Slimy, and all the other sisters, it seems only right. Finally, Laura and Linda have been out since the RCC6 began, and it has been a very important political and personal experience for them and for us all. They have through their struggles created an environment of love and solidarity that enabled me to subsequently come out as well. Quisp, how have you struggled with sexism and heterosexism in the groups with which you have worked? Laura, mostly by confronting people when I think they are being sexist or heterosexist, and by fighting for women's liberation and lesbian and gay liberation to be included not just as words but as real goals. The saddest times for me have been those times when I was in groups where we didn't do this. I think it's very important for people to be able to struggle for a variety of goals without setting up a hierarchy or exclusive list. I will continue to join groups whose main program is, for example, anti-racism or support for Palestine or Puerto Rico, because those things are just as necessary for my liberation as women's and lesbian liberation are. And I won't demand that my liberation be made a part of every agenda. But I won't ever deny my identity, my right to be respected, and the urgency and legitimacy of lesbian, gay, and women's liberation, either. Susan, I have become much more of a feminist over the last number of years, and by that I mean ideologically and politically. I believe we have to examine the position of women, the structures of the society, and how male dominance defines women's position in all things. I don't think in the past I fought against the subjugation of women and gay people enough. I substituted my own independence as a woman with actively struggling against political and social forms of oppression. For example, in Nicaragua now, the women militants of the FSLN are re-evaluating their practice of struggling against sexism, and some of them are self-critical, and they subordinate the struggle of women to the needs of the so-called greater societal good. What it means now is that abortion and the struggle for reproductive rights under the new non-revolutionary society are being set back generations, and the level of consciousness among women is not strong enough to effectively challenge this development. I believe that to subordinate either women or gay people and our demands is a big mistake. Quisp, what is the connection between the primarily white middle-class gay rights movement and the struggles of other oppressed people? How do we envision a gay movement that encompasses other struggles? Laura, I believe that any struggle of primarily white middle-class people has the danger of being irrelevant to real social change unless it allies itself with the struggles of oppressed people. This country has a great track record for buying off sectors that have privilege. Once that happens, not only do things stay the same, they get worse. But even more than that, I feel that we cannot be full human beings unless we fight for all the oppressed. Otherwise, our struggle is just as individualist and racist as the dominant society. In that case, we'll never win anything worth fighting for. I think the queer movement needs to talk to other movements and communities in order to work out common strategies and figure out how to support one another. I think we need to talk to groups in the national liberation struggles in order to figure out how to set our agenda and strategy, like what demands can we raise in the fights about AIDS that can help other communities fighting AIDS. It's a struggle, not necessarily an easy process, but it's crucial. It's also true that our movement has already adopted lessons from other movements, often without even realizing or recognizing it. We've especially incorporated strategic concepts developed by the Black liberation struggle, from the civil rights movement to the Black power and human rights struggle. It's no accident that Stonewall's leadership was third world gay men and lesbians. So I think it's important to recognize whenever we pose the question of alliances and coalitions, that we don't need to encompass other people, we need to ally with them, learn from, and struggle side by side with them. We need to support them. And we need to fight for them as well as for ourselves, because the second we accept divisions or ignore the urgency of fighting racism, we lose. Linda, I don't think that struggles against sexism or homophobia or racism can be delayed, because these are forms of discrimination/oppression that actively disempower individuals and groups of people who can be mobilized to actively participate in the struggle. Racism, sexism, and heterosexism cannot be tolerated in our movement or in our alliances, because we don't want to duplicate the oppression that we're fighting against. Of course, the process of building these alliances is difficult and long-term, because building trust and respect requires building relationships that are really different from those that exist in society in general. So I don't think the primarily white middle-class gay rights movement can, or should, encompass other struggles. White middle-class gay men and women cannot set the agenda for other movements or for other communities. Rather, I think that this movement should actively support struggles against other forms of oppression as a way of making our own movement stronger, more revolutionary, less self-centered, and more supportive of the goal of liberation and self-determination for all oppressed people. Susan, this is a big question and has many aspects to it. I can only offer a small answer, as I believe that prisoners who have no social practice in a movement because of being locked up have a warped or limited understanding of the real dynamics in the free world movements. The gay movement as it is currently constituted has re-emerged since I have been in prison, so I have not been a part of its development. I don't think the gay movement can be relevant to other oppressed peoples and their struggles without an anti-imperialist analysis of the roots of gay oppression and then, correspondingly, a practice to implement change. In other words, a movement that is led by white middle-class men, even those oppressed because of their sexual identification/orientation, without ceding power to third world women and men, and dealing with their agendas, will never be anything but reform-oriented. To only struggle for gay rights without struggling for the rights of all those in need, and specifically those who are nationally oppressed, sets up a competing struggle rather than a cohesive radical opposition to the government. Quisp. What was going on in your life that led you to participate in or support armed struggle? Laura, I began supporting armed struggle in the late 60s, when I realized the government would keep on killing third world people if left to its own devices. The murder of Fred Hampton by the Chicago Pigs and FBI was a turning point, not only because it was an assassination, not only because the state tried to cover it up, but also because it made me understand that the US would never agree to give oppressed nations their human rights. That's why the government had to kill Fred, and Malcolm X, and so many other leaders. I'd hated the injustice of this society for years, but it was in the 60s, when I supported the Vietnamese, Native American struggles, the Black struggle, Puerto Rico, and saw those nations waging struggles for freedom that included armed struggle, that I started to see that there could be a struggle to win. Once I began supporting third world nations' right to use armed struggle to win self-determination, it made sense to me that I should be willing to use many forms of struggle to fight, too. Mostly, I think that it's my vision of what a wonderful thing it would be to live in a just, humane, creative world that motivates me to embrace armed struggle as one part of what it takes to fight for a new society. Linda, when I first became a political activist, I was a pacifist. I had never experienced real violence in my own life and naively hoped that the changes I envisioned could come about non-violently. Then, I got beat over the head and tear-gassed by cops guarding the Pentagon at my first major demonstration. I came head-to-head with the fact that the system maintains its power through violence on every level, from beating up protesters, to genocide against internally colonized nations, to waging war against nationally colonized nations, to waging war against the people of Vietnam. I became an activist in a time that was defined by the victories and development of national liberation struggles around the world and inside the US. I was especially inspired by the Vietnamese and by black people struggling for civil rights and then for black power/black liberation. Vietnamese women fighters and black women in the struggle were role models for me because they were dedicated to fighting until victory was won. Their courage and dedication, their willingness to risk everything for freedom, the fact that women were being empowered by the process of struggle, all were exemplary. So by supporting these national liberation struggles, I came to support the right of oppressed people to fight for liberation by any means necessary. Malcolm X, Che Guevara, and Ho Chi Minh were important influences in my life and political development. But I actually became determined to participate in armed struggle because of the rage I felt after the FBI/police raids on Black Panther Party offices and homes all over the US, and particularly the murder of Fred Hampton and Mark Clark by Chicago police. The intensity of this police terrorism against the black community in so many cities made me realize that whenever a political movement even begins to threaten the stability of the status quo, the state will act in whatever ways it must to destroy it. In order for a revolutionary movement and vision to prevail, therefore, it's necessary for us to defend ourselves and our comrades and to build our own capacities toward a day when we can seriously challenge the repressive power of the state, so that state power can be taken out of the hands of those who use it to oppress, taken over, instead, by the people themselves. I know this sounds idealistic, yet it is a struggle that has succeeded in many countries around the world. I believed then as I do now that US imperialism was the main enemy of the people of the world, and I wanted to fight on the side of the oppressed to build a better world for all. This was the era of Che Guevara's call for 3 many Vietnams, and I recognized that the US government depends on the domestic tranquility of its population to allow for imperialist interventions around the world. This is one reason the black liberation struggle was such a threat and why white people fighting in solidarity with national liberation struggles were threatening as well. That's part of the reason that the repression of the internal liberation movements was so immediate and devastating, and why there were such efforts to divide off white struggles from these struggles. Susan, the war against the black liberation movement by the FBI/US government was most influential for me in seeing the necessity for armed self-defense. The challenge placed on us who were in a position of solidarity with revolutionary nationalist black organizations was to uphold self-determination and to fight for it. The other element that most personally propelled me into armed clandestine resistance was witnessing the genocide of the chemical war being waged in the South Bronx against black and Puerto Rican people. As a doctor of acupuncture and community health worker, I watched us fail to stop the plague. Quisp, what do you do all day? Laura, my time is divided among, fighting for decent conditions and against the prison's denial of those things, working on my political and legal work, communicating with people via letters and phone calls, talking to other prisoners, meeting with my co-defendants, trying to find out how my comrade Alan is. I spend a lot of time talking to women about AIDS. By one estimate, 40 to 50% of the women in here are HIV+, yet there is no program, no education, no counseling provided. Like my other comrades, I spend a lot of time doing informal counseling and education on this. Linda, work and work out. Susan, because I am a doctor of acupuncture and a conscious person, I have become a peer advocate/AIDS counselor. It is not recognized by the jail, but I spend 75% of my time counseling women who are HIV+. The other time is spent doing my other work and talking with others. We spend a lot of the day locked down in our cells. Because of the overcrowding and lack of programs, the administration keeps us locked down an enormous amount of time. Quisp, how do you deal with your white privilege in jail? Laura, I struggle to be aware of it. I fight racism actively and organize for that fight. I try to make the resources that I have access to, available to others. Educating people about how to fight AIDS is another way, because that's information that the gay and lesbian movement have that women in the DC jail lack, and it means that women are continuing to contract HIV every day. That is a crime. Linda, I try to use the resources and education I've had access to as a result of my white privilege to benefit all the prisoners I live with and to fight for our interests. This takes many forms, from struggling as a prisoner for the institution of AIDS education and counseling programs, to helping individual women with legal problems or abuses of their rights by the jail. When I was in jail in Louisiana, we were able to win a jailhouse lawyer's legal suit forcing the jail to give women glasses and false teeth. One of the conflicts I confront is between dealing with immediate needs and crises as an individual counselor/agitator/jailhouse lawyer and always pushing the institution to provide the services and programs that prisoners should be entitled to as a basic human right: education, medical care, exercise, mental health, and AIDS counseling. Susan, well, I struggle against racism in every way I can. I have learned patience, and how to be quiet, and how to really listen to who is talking, and what they are saying. Quisp, what observations or advice do you have for lesbian/gay and AIDS activists as we start to experience police surveillance, harassment, and abuse? Laura, fight it. Don't back away. Develop clandestine ways of operating so that the state won't know everything that you're doing. Support one another so that when anyone is targeted for state attack, they can resist. That resistance will build us all. Don't ever give information even if you think it's safe information to the state. Don't let the state divide the movement by calling some groups legitimate and others not. Unity is our strength. Support other movements and people who are also targets of state attack. When the state calls someone a terrorist, or violent, or crazy, or anything, think hard before ever believing it to be true. Resist. 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 Linda, be cool. Develop a clandestine consciousness. Value your work enough that you don't talk to the enemy about it. Don't underestimate the power and viciousness of the state, and don't expect white privilege to make you exempt from repression. Take the lessons of past repression against political movements seriously, not to demobilize you or make you afraid, but to safeguard and defend your work. Remember, you're building for the future, not just for today, and keep struggling to broaden your vision. Remember that reforms are only temporary concessions, that they're neither permanent nor do they really solve fundamental problems. Susan, study other movements here and around the world and examine the state's methods in order to develop tactics that allow you to keep functioning. Very important, if one self-consciously is building a movement that knows the state will destroy it if the movement begins to pose a real or perceived threat. Quisp, what is your position on go-go girls in women's bars? Laura, take me to a bar and we'll have a scintillating discussion of this issue, okay? Linda, take me to a bar and I'll let you know. Susan, I think that anything that objectifies women as sexual objects is anti-woman. Even in an all-woman context. Being lesbian is subversive because women loving women is a crime against the state and against the bourgeois patriarchal morality of this society, but being subversive doesn't necessarily mean it's about liberation. If nothing else, I have learned that liberation and the need for it begin in oneself. Objectification/sexual stereotypes/misogyny not only destroy us in the world, they corrode our own hearts. I am not interested in a society that promotes those things, although I don't believe that they will be ended until we decide to end them. They cannot be overturned through the law of this state. V.4. 3 decades of queer solidarity and radical struggle, a rich history. Bob Lederer. Lesbian/Gay Community Center, New York City 1999. Tonight's forum is an important step toward mobilizing queers to take our rightful place in the fight to free Mumia, and it comes out of a long history. Sexual outlaws of all sorts have always fought for the radical transformation of society. For example, black gay men were key leaders and participants for civil rights, from Bayard Rustin to James Baldwin. And since the 1969 Stonewall Rebellion, thousands of out lesbians, gay men, bisexuals, transgendered and two-spirited people have participated in every major struggle for social justice. From the anti-Vietnam War and women's liberation movements of the 60s and 70s to the anti-apartheid and Puerto Rican independence movements of the 80s and 90s, just to name a few, queers have been there, both as individuals and in groups, proudly proclaiming our sexualities. Our persistence has raised consciousness and broken down barriers in every progressive movement. Over and over, we've found that the true path to our liberation lies in participating in radical movements that have the capacity to totally transform society, while at the same time being completely out and grappling with homophobia in the movement. Key to our effectiveness is recognizing two things: that racism is the fundamental issue to confront for anyone seeking radical change in the U.S., and that all of us who are serious about change will eventually come up against the issues of police brutality and or political imprisonment, and therefore we all need to support those who are fighting those forms of oppression. The April 24th mobilization for Mumia is a critical opportunity to bring together all of these issues. So let's go back to the Stonewall Rebellion. It was fundamentally a revolt against police brutality. Queers of all sorts, with drag queens of color playing a major role, said enough is enough and fought back with their voices, their bodies, and with rocks and bottles. Some leaders were leftists who later formed the Gay Liberation Front, which organized the first gay contingents in anti-war protests and marches to free Black Panther political prisoners. Those marchers paid a price in verbal and even physical attacks by homophobic activists. But their efforts, and those of white and black gay groups nationwide, led a Black Panther leader, Huey Newton, to criticize homophobia by other Panthers and to invite the new gay movement to attend a massive People's Constitutional Convention in 1970, which adopted a strong gay liberation plank written by a white gay leftist. Underscore 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 underscore. This is the text of a speech given at a forum on March 18, 1999, to build a rainbow flags for Mumia contingent at the April 24, 1999, Millions for Mumia March in Philadelphia. Among the many places that queers participated in radical politics were the underground resistance movements against genocidal wars at home and abroad. And so, inevitably, some became political prisoners. In the 1970s, lesbian and gay communities in Connecticut and Kentucky withstood fierce FBI sweeps and grand jury fishing expeditions seeking to find underground lesbian Susan Sachs and her colleague Kathy Power, who had been part of group that robbed a bank to raise money for clandestine anti-war resistance. Several lesbians went to jail rather than become informants to the grand jury, but by 1976 the FBI tracked down Sachs, who was then sentenced to several years in prison. Other queer underground fighters arrested and given long sentences in this period included West Coast anarchist B. Brown, a lesbian, and Ed Mead, a gay man, both part of the George Jackson Brigade that bombed federal buildings and corporate headquarters to resist U.S. aggression internationally. Another West Coast fighter, lesbian communist Judy Sif, was part of a spin-off of the Weather Underground organization busted for planning to bomb the office of a California senator who was heavily promoting anti-gay legislation. The period I know best begins after I came on the New York radical scene in the late 70s as a part of a sector of the left that focused on building militant support among whites for revolutionary groups of color at home and abroad. In particular, I worked mainly in a group in solidarity with independence for Puerto Rico, and I also briefly participated in a group supporting liberation movements in southern Africa. Many people I knew ended up as political prisoners, numerous queers were among them. In the early 80s, Judy Clark, a white lesbian communist, and Kawesi Balagoon, a black bisexual anarchist, were among 6 activists working with the Black Liberation Army who were arrested and charged with participating in the robbery of a Brinks truck during which 1 cop and 2 Brinks guards were killed to raise money for black community armed self-defense, alternative health care and anti-Klan infiltration. All the activists got life sentences. Judy and the others remain in prison today, but for Kawasai his penalty turned out to be a death sentence, as he died 4 years later of AIDS after gross neglect of his health needs by the New York State prison authorities. Another white lesbian activist, Eve Rosen, was falsely charged as an accessory to the Brinks robbery and finally got her charges dropped, only to then face a subpoena to testify before a grand jury, which she refused, earning her 15 months in prison. Today, Eve is a lawyer who often represents queers and AIDS activists, among many other fighters, who commit civil disobedience. And while mentioning courageous queer lawyers, another person who faced huge pressures and persecution from the state in this period was Susan Tipograph, another white lesbian. She faced all sorts of attempts to jail and defame her for her vigorous representation of radical clients of color, yet she beat back those efforts and is still in the trenches today. Finally, I must pay tribute to another speaker tonight, Joan Gibbs, revolutionary black lesbian lawyer, who has been a consistent defender of countless political prisoners, as well as activists arrested for civil disobedience, for many years. She is active in the Free Mumia campaign. In the early 80s, an underground group of white revolutionaries called the Red Guerrilla Resistance began a campaign to heighten struggle against government repression here and military aggression abroad. This group carried out a string of bombings of U.S. military, government and corporate offices in which no one was injured. Among their targets was the Capitol building in Washington, to protest the invasion of Grenada, and a naval headquarters, protesting attacks on Nicaragua and support for the Contras. The group's final bombing was at the office of the Patrolmen's Benevolent Association here in New York, to protest their efforts to get manslaughter charges dropped against a racist cop who had killed an unarmed black grandmother, Eleanor Bumpers. A month after the PBA bombing, I and novelist/activist Terry Bisson became the fifth and sixth people subpoenaed before a federal grand jury attempting to track down the members of the Red Guerrilla Resistance. Terry and I, like 4 colleagues before us, refused to name names or answer any questions. The prosecutor asked the judge to hold us in contempt of court and be jailed. We held a press conference and burned our subpoenas in front of the FBI building in Washington. I said publicly that I would never cooperate with a government that committed crimes like the recent FBI and Philadelphia police bombing of the MOVE organization, a radical black collective. That police bombing, which killed 11 people, including 5 children, was undertaken because MOVE upheld the right to armed self-defense. 7 years earlier, other police attacks on MOVE had been bravely exposed by crusading journalist Mumia Abu Jamal, undoubtedly setting him up to be targeted by the police. In my public statement, I also said that as a gay man, part of my commitment to fight this government came from my determination to help create a society free of anti-gay oppression. Meanwhile, in the preceding year, I had become involved in the gay movement, joining men of all colors together, including helping organize a forum on police abuse against the gay community, particularly gays/lesbians of color. So in my few remaining weeks before going to jail, I decided to use the time to travel to several cities, speaking to lesbian/gay forums and doing interviews with gay newspapers. My message was that queers should fight government repression because the same weapons used against other movements will be used against our movements and because we all have a stake in a more just society. For whites, that means that solidarity with people of color is key. Lesbians and gays rallied behind my case and against repression. Nonetheless, after several weeks of legal battles including our unsuccessful argument that international law protected us from punishment for resisting our government's criminal acts, Terry and I were jailed without trial on civil contempt charges. We served 3 months in federal prison, many others in that period served much longer terms. Just before our jailing, the FBI arrested several longtime activists, former colleagues of ours who had gone underground with the Red Guerrilla Resistance. Among them were 2 out lesbians, Laura Whitehorn and Linda Evans. Members of their group got draconian sentences 20, 30, 40 years for charges that are not usually punished so harshly: illegal gun purchase, harboring a fugitive, or possession of guns and bombs. But 3 years later, the feds piled on an extra charge against 7 of them, conspiring to alter U.S. foreign policy by force and violence. By this time, around 1989, I had become active in ACT UP, and several of us nationwide published an open letter to the queer community supporting the call that the charges be dropped. We noted that 2 defendants were lesbians, that all had supported ACT UP's militant actions, and that such draconian charges posed a threat to all our movements. ACT UP itself was facing government repression, and many queers worked around this case. Laura and Linda, along with their colleague Marilyn Buck, ended up pleading guilty to the Capitol bombing, for which they got stiff added sentences. All 3 remain in prison. And Laura just called me today with the bad news that her scheduled release this month to a halfway house was rejected by higher UPS, so she won't be home till August. But back to 1990, another co-defendant serving a 58-year sentence on earlier charges, Susan Rosenberg, was so inspired by the widespread queer support that she came out as a lesbian for the first time since her incarceration. Out of this support campaign, queers in my group, the Free Puerto Rico Committee, joined with others to form QUISP, Queers United in Support of Political Prisoners. Launched in 1990 in the heyday of Queer Nation and a revived spirit of queer liberation, QUISP worked from the simple premise that no one can be free until everyone is free. For several years, we sponsored forums and cultural events to educate the community and raise funds around particular cases of political prisoners. We also joined with queers of color when key issues were being fought out in the community, like the 1991 demo led by Asian American queer groups to protest several gay organizations' benefit showing of the racist and sexist play Miss Saigon. 8 years ago next month, we held a forum in support of Mumia, perhaps the first such New York event for a mostly white audience. Mumia had just lost his last round of appeals, and the situation looked grim. We wrote him to ask how he felt about our holding a forum. He thanked us profusely, said he welcomed support from all, but revealed that his philosophy, following that of the MOVE organization, was that heterosexual hookups are the most natural. He added that he sincerely hoped he hadn't offended us. After some debate, we agreed to share his response at the forum, so the community could understand the importance of defending all political prisoners who fight for justice, even if we disagree with some of their views. As one member noted, once Mumia is free, we'll have plenty of time to argue with him on this issue. But that won't happen if we allow the state to execute him. At the forum that night, our invited speaker was former Black Panther Doroba Binwahad, who had been recently released after 19 years in prison fighting to overturn an FBI frame-up. Frankly, we didn't know what to expect from this straight male black nationalist, but we were richly rewarded. Doroba made a passionate appeal not only for us to help free Mumia and all political prisoners, but also for radical movements including his own black nationalists to embrace the struggles against sexism and homophobia as integral to revolution. He also called for white lesbians and gays to respect the leadership of lesbians and gays of color. Doroba attributed much of his new political consciousness to his comrade and wife, longtime activist Tana Quill Jones. This speech was a crucial moment in building cross-movement solidarity. And if I can add a personal note, it was this speech that later led me to my lover of 7 years, John Riley. 9 months after Doroba's speech, our least favorite prosecutor, Robert Morgenthau, was trying to rejail Doroba on the old bogus charges. The black movement had set a rally for his court date. I was so inspired by his incredible QUISP speech that I leafleted all 500 people at that week's ACT UP meeting. Suddenly, this cute, very tall, ponytailed guy takes a flyer and says, "Great. I've been wondering when Doroba's court date was. I just moved here from Iowa and want to hear all about the gay left." Well, folks, the rest is history, and John and I have since maintained our romance and revolutionary commitment through many actions by ACT UP and the Free Mumia Coalition. So I can thank Doroba, and for that matter, Mumia, for bringing me the love of my life. Queer liberation in practice. It was in fact John who suggested QUISP's first street action in 1992 against Pennsylvania's then Governor Robert Casey, a so-called pro-lifer with the gall to both oppose abortion and support the death penalty. When the Village Voice invited Casey to Cooper Union to discuss abortion, we helped form a broad coalition, including members of WHAM, the Women's Health Action Mobilization, to protest Casey's policies on both issues and demand that he stop Mumia's execution. It was the first large New York demo about Mumia, and it got lots of publicity. Over the years, QUISP also organized queer contingents in several Washington marches to free Puerto Rican political prisoners and in the now annual Philadelphia marches to free Mumia. In addition, QUISP continued to hold forums, video showings and fundraisers for the case of Mumia and other political prisoners in the U.S. Today, unfortunately, QUISP no longer exists. But the spirit behind QUISP has lived on in many individuals, including all of tonight's speakers, and in several organizations. It lived on in 1997, after New York's finest assaulted ACT UP members committing civil disobedience on Wall Street, illegally strip-searching several women and seriously injuring one man with AIDS when cops beat his head into the concrete 6 times shouting, "Die, diseased faggot." Days later, ACT UP members joined the Audre Lorde Project, a center for queers of color, and numerous Black, Latino, and Asian community groups in a broad march against police brutality. That spirit lived on last fall, after police brutally attacked the October 19 political funeral for Matthew Shepard. Days later, dozens of queers joined a massive coalition march against police brutality. That spirit lived on 3 weeks ago, when 8 members of the affinity group Fed Up Queers lay down in the street next to the mass rally demanding justice for Amadou Diallo, in a brave act of solidarity. They became the first of what's now become a tidal wave of civil disobedience. And that spirit lived on earlier today, when a much larger group of queers was arrested at one police plaza in the continuing campaign against police brutality. Let's keep that spirit of resistance alive and continue our rich queer history of fighting to end police brutality and free political prisoners, by pulling out all the stops to build this rainbow flags for Mumia contingent at the April 24 march as large as we possibly can. Because remember, as we fight to free Mumia, we're also fighting to free ourselves. V.5. Queer activists join massive civil disobedience. Protests demanding liberty and new trial for death row journalist Mumia Abu-Jamal. Simon Galai Queer Crusaders in support of political prisoners 1999. Dozens of queer activists from around the country joined coordinated nonviolent civil disobedience protests and actions on both coasts July 3, demanding liberty, a new trial and urgent medical attention for award-winning African-American journalist and Pennsylvania death row inmate Mumia Abu-Jamal. At Philadelphia's Liberty Bell, amidst 100-degree heat, 95 protesters disrupted business as usual and closed the building for the afternoon, during a weekend with the heaviest tourist presence of the year. In San Francisco, after a mass march from the Federal Building to Union Square, 27 activists blocked the street and were arrested. Taken together, the demonstrations amounted to the largest civil disobedience action against the death penalty in U.S. history. The unprecedented actions, accompanied by support vigils of hundreds nearby, were sponsored by broad coalitions of progressive groups and mark 17 years to the day after Abu-Jamal's death sentence was imposed in a trial deemed grossly unfair by Amnesty International and many other observers worldwide. One of the most visible parts of the Philadelphia protest occurred when the Simon Galai Queer Crusaders for Mumia took the front position in blockading one entrance to the Liberty Bell Pavilion. Brandishing a banner reading "Queers Say, Stop the Execution of Mumia Abu-Jamal," the group 10 lesbians, gay men, bisexuals, and allies joined other activists in front of the door, to which 2 people had chained themselves, while U.S. Park Police looked on helplessly. Underscore 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 underscore. This press release accompanied the civil disobedience action for Mumia Abu-Jamal held at Philadelphia's Liberty Bell on July 3, 1999, in which the Simon Galai Affinity Group was one of many whose members were arrested. The release was circulated to the LGBT media. See also, 6.7. A How Freedom Rang, by Matt Meyer. 6.7. Why we are demonstrating at the Liberty Bell, and an urgent message from Dennis Brutus and friends. ACT UP/New York member Bob Lederer, organizer of the Simon Galai Group and one of those arrested, said, "Anyone concerned about the future of queer and AIDS activism should be outraged by Mumia's impending execution. Many of us have experienced or witnessed vicious homophobic, AIDS-phobic police brutality against our movements. The injustice against Mumia springs from his history as a journalist and activist against police brutality, and his prior membership in the Black Panther Party was used to inflame the jury to sentence him to death. That makes this a bellwether case. If Mumia can be executed without ever having had a fair trial, it sets a dangerous precedent that would make it easier to heighten repression against all types of activists. That's one reason groups which rarely work together united in action today. In addition, many of us oppose the use of the death penalty against anyone. The Philadelphia protest was made up of 16 affinity groups from queer, AIDS, peace, anti-intervention, African American, Latino, student and leftist groups. Before the door-blocking action, 4 people went inside the Liberty Bell Pavilion and unfurled a banner reading "Let Freedom Ring" for Mumia next to the historic icon. 2 student activists clambered onto the building's awning and held a banner reading "Liberty for Mumia" for 3 hours, until they were removed by police using a forklift. It took police several hours to clear all 95 protesters, including 2 blind people and a woman in a wheelchair. All were released within 10 hours after being charged with failure to obey a lawful order. They are now facing fines of $250 each, which will be contested. Along with the Philadelphia and San Francisco protests, over 100 people attended a Providence, Rhode Island prayer vigil and rally against the death penalty and in support of Abu Jamal, held in conjunction with the National General Synod of the United Church of Christ. 2 weeks earlier, 23 activists were arrested in Paris after storming the American Library, demanding a new trial and health care for Abu Jamal. Last October, Pennsylvania's Supreme Court denied Abu Jamal's bid for a new trial, upholding the ruling of Judge Albert Sabo, the original trial judge. Abu Jamal, an author and activist, was convicted in 1982 of the shooting death of a Philadelphia police officer in a trial tainted by the flagrant bias of Judge Sabo, by the deliberate exclusion of 11 black potential jurors and by a court-appointed lawyer who, by his own admission, was inexperienced in criminal law. In addition, witnesses came forward during the 1995 post-conviction relief appeal hearings, saying they were coerced by police to lie, suppress, or change their initial accounts of the December 9, 1981 incident. In recent weeks, Abu Jamal has suffered from troublesome pain, swelling and discoloration in his feet, and has yet to be examined by an independent physician. Lesbian activist Dawn Reel, another arrestee from the Simon Galai Group and a member of New York's Free Mumia Abu Jamal Coalition, said that the July 3 actions are only the beginning of a campaign of civil disobedience demanding a new trial for Abu Jamal. At this point, she said, despite all efforts by the legal team, the system has denied Mumia his due process rights. That's why we have to take this matter to the streets for the court of the people to judge. Interest in Abu Jamal's case has been growing in LGBT communities nationally. This past April, hundreds joined Rainbow Flags for Mumia contingents of 2 massive pro-Mumia marches in Philadelphia and San Francisco. Last month, large contingents supporting Abu Jamal marched in LGBT pride parades in New York and San Francisco. Among the prominent endorsers of the July 3 civil disobedience action was bisexual musician Ani DeFranco and New York lesbian activist Leslie Kagan, co-chair of the 1987 March on Washington. Other endorsers included South African poet laureate and anti-apartheid former political prisoner Dennis Brutus, African-American educator/writer Professor Manning Marable, Puerto Rican independence leader Rafael Cancel Miranda, longtime anti-war activist David Dellinger, and Rev. Lucius Walker, director of Pastors for Peace. v.6. 1. Her story of Out of Control. Lesbian Committee to Support Women Political Prisoners and Prisoners of War, 1986 to 2008. B. and Jane Siegel 2008. Chapter number 1. The U.S. Bureau of Prisons has always had some sort of extra secure lockup for women they could identify as somehow notorious, and therefore in need of closer custody. For many years, Davis Hall at Alderson, West Virginia, was that place. In the 40s, Billie Holiday was held there. Puerto Rican nationalist Lolita Lebron was there in the late 50s and early 60s. In the late 70s it was actually called the Maximum Security Unit and held New York Black Liberation Army political prisoner Assata Shakur, and B., a white dyke anti-imperialist political prisoner of the George Jackson Brigade from Seattle, Washington. In the 80s the immigrant Cuban and Haitian women prisoners were housed in the same building. This prison within a prison exists in every prison in this country. It has always been a secret place where every kind of torture imaginable can go on undetected. They are now everywhere and called control units. In 1986 the U.S. Bureau of Prisons opened its next version, the LHSU. The first official high-security unit for women prisoners. It was built in a basement at Lexington, Kentucky, federal correctional institution that once housed a hospital designed to help prisoners addicted to drugs. Now held in undeniable sensory deprivation conditions were Alejandrina Torres, a Puerto Rican nationalist from Chicago, and Susan Rosenberg, a political prisoner from New York. Both of these sisters came directly from court to the new subterranean, small group isolation facility. This was a clear violation of the B.O.P.'s own policies since they had never been in general population and therefore had violated no institutional rules. Italian national Silvia Berardini, another anti-imperialist political prisoner from New York, was transferred in from FCI Dublin, California, where she had been held for several years without incident. In fact, her custody had recently been lowered because she had no infractions and was considered no threat or risk. All three of these women were moved into LHSU because of their political beliefs and political associations. There were also two social prisoners who were doing long terms. They appeared to be the cover that allowed the BOP to deny this unit was specifically built for women political prisoners. Underscore 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 underscore. This piece was a collaboration by two of the founding mothers of Out of Control, B. and Jane Siegel, who were one half of the four women who first met in that SF Mission District kitchen in 1986. Daily mental torture was clearly the basic program in effect here. All walls were painted white. The all-male guard staff controlled all the lights. No visitors were allowed except attorneys of record. Property was extremely limited, including books, letters and personal hygiene items. Locked in cells 23 hours a day. All meals were brought from outside the building and eaten alone in their cells. No education programs of any type, and certainly there was no clear plan or method for ever being released out of the unit. That was a primary point of abuse. No way out. The diabolical design was to create despair and depression and thus break the spirits of these women prisoners. The social prisoners would simply be considered as casualties of this ongoing war against the women political prisoners. Shortly after the third political prisoner, Silvia Berardini, arrived at LHSU, four women who knew and loved her met in a San Francisco Mission District kitchen to brainstorm ways to protest her abrupt transfer and to stop this outrageous control unit. We formed a women's committee to shut down the LHSU and sent out a call to other sisters in the Bay Area. The group grew instantly, and we quickly became Out of Control Committee to support women political prisoners and prisoners of war. We joined a national grassroots campaign of activists to expose the brutality at Lexington and demanded that it be immediately shut down. This national struggle included very broad-based support from the National Puerto Rican Independence Movement, the prison abolitionists, the civil rights and women's communities, the American Indian Movement, many unaffiliated individuals, the progressive churches and pacifists, as well as Susan's mother and father. Alejandrina Torres, Susan Rosenberg, and Silvia Berardini inside the Lexington High Security Unit. Psychological torture experts were brought on board to define and document and evaluate the conditions. The ACLU National Prison Project, the Center for Constitutional Rights, the People's Law Office and other experienced movement attorneys provided their expertise. A lawsuit was filed against the BOP to close the LHSU. They did a great job and we thank them all for their good work. The evidence was so overwhelming from the beginning that the only reason Alejandrina, Sylvia, and Susan were held under these conditions was because of their politics. The courts could only rule in favor of the women political prisoners and barred the BOP from considering a prisoner's past political associations or personal political beliefs when deciding to transfer prisoners into federal prisons. The LHSU was shut down after a relatively short 18 months. We had ourselves a well-deserved little victory. However, it was short-lived, as the decision was overturned on appeal and the torture continued in other ways. In October 1988, all 3 political women prisoners were moved back to jails. 2 were placed in metropolitan correctional centers, Sylvia in New York and Alejandrina in San Diego. Susan went back to the Washington, D.C., jail. This madness continued for 2 more years while a small new women's prison was opened in Marianna, Florida. All movement was controlled in the Shawnee unit there, and it was just a little bit bigger kind of small group isolation. It was a women's prison contained within a larger men's prison opened in 1988, and the mission was pretty much the same. To control, isolate, and neutralize the women sent there who, for varying reasons, pose either a political, escape, or disruption threat to be defined by the masters of unreason within the BOP. The goal was to destroy the ability of the women prisoners to function in anything other than an institutional setting. It was 1994 before they would make it to a general population in Danbury, Connecticut. Chapter number 2. In 1989 there just wasn't much information or support for political prisoners, especially the women. So after the LHSU closed, some of us decided to continue our work on behalf of the 25 women political prisoners and prisoners of war being held in America's prisons. We knew it was our job to focus on these women because if we didn't, no one would. It was that simple. Our political prisoner sisters would be shipped throughout the federal prison system. We knew this would keep information coming from the inside about basic conditions around the country because the political prisoners would experience it and speak out. Having survived many years of typical leftist coalitions, we had come to understand the importance of choosing the correct name for our group. So, we morphed a bit and became Out of Control, Lesbian Committee to support women political prisoners and prisoners of war. Thus, we were assured that our community, the prisoners, and the world would know that lesbians were doing this work to support our sisters and to expose the myth that political prisoners did not exist in the USA. Our most important job was to help make it known that there were political prisoners in America, and many were women and some of them were lesbians. Over the years we painted several powerful banners and took them to a wide variety of demonstrations and other progressive events. One year we made these great black and silver Dykes Out of Control t-shirts that were immediately sold out before we ever got to the Pride Parade. We had enough money then to make a second run and sold it out, too. But then a local leather shop created a knockoff that was white with small black letters and cost twice as much, and they sold them for many years. That's okay because there ain't nothing wrong with having some Dykes Out of Control. We had a small contingent in Dykes on Bikes one year, complete with the lesbian political prisoners' names on the back of my bike. Lots of people gave us support as we rode down Market Street that year. Maybe it was that bare-breasted young sister on the back of another bike with "Free All Political Prisoners" written on her back in bright red lipstick. Or, maybe it was 'cause we were doing a good job at raising the consciousness of those who attended the Pride Parade events. We shared a table space with Lagi Queer Insurrection every year at the Pride Parades, where we had a sandwich board with pictures and current info on our sister political prisoners. People actually came to find us and ask about the prisoners. One year we marched alongside the Fat Dyke float carrying thousands of a lavender one-half sheet featuring an Alison Bechdel Dykes to Watch Out For cartoon strip about the lesbian political prisoners. We almost gave them all away before we got to our table. We did house parties, spoke on local college campuses, we were on KPFA and several college radio shows. We got to travel on occasion to speak at college campuses. B was asked to speak in the basement of some church in New York with other longtime queer activists during the 25-year anniversary of the Stonewall riots. In 1990 we created a Women Political Prisoner Commissary Fund with LAGI, supported by an annual garage sale in the Castro where many expert/recycler interior designers regularly shopped and cruised very early on Saturday mornings. In cooperation with many local sisters, we also began producing Sparks Fly, an amazing event that happened mostly at the Women's Building. This was a not-to-be-missed annual cultural/educational event, where we continued to bring updates on the prisoners and build community support. Many local artists donated their time and craft to help raise those commissary funds. It would be impossible to name everyone, so I'll just mention a few of the favorites: Jewel Gomez, Cherry Moraga, Christos, Dorothy Allison, Melanie Damore, Elizabeth Summers, Carolyn Brandy, Tom Amiano, Gwen Avery, and Mary Watkins with Judy G and Diva as backup, and we had our drag kings with Fresh White as Barry White, and a very convincing Frida Kahlo and Che were even the MCs one year. Out of Control was able to provide a reasonable stipend to 11 women political prisoners, including the Move Sisters in Pennsylvania. This was a very successful and fun grassroots community way of creating/involving/building ways to have effect. We packed the house year after year after year. How many years? We think it was somewhere between 10 to 12 years. We were part of a very strong political queer activist community in the SF Bay Area, and our people supported our work just as we supported theirs. In 1992, OOC participated in the International Tribunal of Indigenous Peoples and Oppressed Nations in the USA. We provided testimony on behalf of the white North American political prisoners and offered legal counsel. All testimony was presented to a panel of international judges and was presented to the United Nations. During this time we were also introduced to the case of Norma Jean Croix, a Shasta Native woman whose case we supported and included in our daily work. In October 1995, we provided more testimony, this time at the Ecumenical National Conference on Racism for the United Nations. We presented the case of Norma Jean Croix and the cases of the North American political prisoners engaged in anti-racist and anti-apartheid struggle. During the winter of 1996-97, OOC worked with the Mumia Art Show Women's Group to bring the Mumia Art Show to the SF Bay Area. The show was a collection of visual and written pieces from over 90 political prisoners from around the world. The money raised went directly to Mumia's Defense Fund. In winter and spring of 1997-98, OOC worked in coalition with Jericho 98. This national effort was spearheaded by African American activists and brought attention to the specific issue of political prisoners. Calling for amnesty for all political prisoners, that campaign culminated with a major demonstration in Washington, D.C., with a walkout at Berkeley High School and a demonstration in Oakland, CA. Out of Control was a part of the organizing committee for Critical Resistance Beyond the Prison Industrial Complex, a monumental prison/prisoner-focused conference held at UC Berkeley in September 1998. OOC presented a 2-hour workshop about women political prisoners where some of our sisters being held locally were able to call in with a live feed to KPFA radio. In total, we think we participated either individually or collectively in at least 5 different workshops over the course of the 2-day event. There are a few other things we somehow managed to get done in the 90s. They include Sparks Fly, Women Political Prisoners in the USA, a brochure used to introduce the issue of our sisters and their stories, Celebrate Resistance, a collection of biographies, photos, poetry, writings, and artwork by the women political prisoners, giving voice to the voiceless, and Sparks Fly, a 20-minute video featuring 10 women political prisoners. We created a dissolve of photos of the women political prisoners and voiceover with telephone recorded messages from jail. High-tech shit for that time period. Since 1989 we have published a newsletter, Out of Time. We are the only newsletters of this kind in the USA, with a primary focus on women political prisoners. It began as one photocopied double-sided sheet. Within a few short years, it became a 4-page tabloid on newsprint. Of the 1,000 we currently print, 600 are sent inside the walls of mostly women's prisons around the country. Various activist groups here and in Europe receive multiple copies. Out of Time is also an insert in Ultraviolet, the newsletter of Lagai Queer Insurrection, which prints 1,500 copies to be mailed as well as distributed to a variety of bookstores and coffee houses in San Francisco. Copies of current issues can be viewed on the Lagai website. This remains our primary work, and hopefully it will outlive all of us. We continue to support Marilyn Buck and the Move Women and to focus on America's political prisoners. We have expanded to include more international coverage by reporting on prisoner-related human rights violations as well as the ever-growing war on women in war-torn countries around the world. There is clearly an international increase in the torture of women and the number of women political prisoners. Rape and mutilation of women and children is not new but even more hideous in the 21st century, when the rich ruling parties of the so-called world leaders certainly know and consciously ignore these crimes. Several of us work regularly with other prison abolitionist projects. These include, All of Us or None, California Coalition for Women Prisoners, Prison Activist Resource Center, and Center for Young Women's Development, and we are working in various ways on the Critical Resistance 10 conference slated for September 2008. All these groups are in need of your support and have websites that you can check out for more information. Chapter number 3. The 90s were amazing. There was ACT UP actions, lots of anti-war demos, calls for Bank of America and Shell Oil to divest in South Africa. Political activism was strong and evident everywhere. Through it all we continued our work to build support for the concrete demands of the growing prison abolition movement. This included compassionate release for prisoners with HIV/AIDS and an end to the death penalty, as well as the closing of all control units. And even political lesbians started saying femme and butch and top and bottom out loud without fear of being ostracized. We could even find a place to live in SF for under $500, and we could still eat and get around to check out all the political things going on all over the city. It was great times filled with good politics and good work and some good victories. Our MO has not really changed much. We live our politics and function as best we can with our personal practice being as honest a reflection of our theoretical beliefs as possible. We remain a small, grassroots group with no formal board and no paid staff. We do have a 501 fiscal sponsor. And many of the women political prisoners have served in advisory capacity. For years we met at least once a month and maybe more depending on what work was happening. Some of us still work with others on broader issues, and all major decisions are made by consensus as much as possible. As we get older and older, we meet less and work on fewer things, but we are far from done. Section 6. Pulling out the stops to free Mumia Abu-Jamal. So much important work has been done around the case of death row prisoner Mumia Abu-Jamal, it has been a difficult task determining what to include in this section. In addition to wanting to include campaigns for Mumia initiated by other political prisoners, we have also decided to focus on those actions that the editors of this volume were personally closest to. Though we harbor no illusions that these were the best or most important examples of work on behalf of Mumia, we do believe that the documents and articles presented in this section shine light on a convergence of previously unaligned individuals and groups in our attempt to broaden the tactics available to the overall campaign. Insofar as the actions cited helped to bring Mumia's message to folks who hadn't heard it before, we believe that they were important successes. Insofar as Mumia is still on death row as of this writing, those successes were clearly limited ones. Besides the above areas of work, we have included documents from the important international, legislative, and judicial efforts to free Mumia. All of these aspects of the Mumia movement derive their strength from the grassroots, day-to-day, community-based organizing that continues to this day. 6.1. A brief history/her story of the movement to free Mumia. Suzanne Ross 2008. This presentation of the history of the Free Mumia movement, now 27 years in existence, is in no way comprehensive. It is meant to give a sense of its breadth, consistency, and international dimensions, as well as its leadership. Cities such as Pittsburgh, Chicago, and Atlanta, and the state of Vermont are not even mentioned, and each of these, as well as others, has played a very important role in different ways. Also, while it is appropriately heavily focused on Philadelphia, the focus on New York City as well, is partly a reflection my living in New York. In Europe, several cities that honored Mumia were also not included, not to mention dozens of demonstrations around the world that ultimately included tens of thousands of people that were not mentioned. And, finally, perhaps most important, the role of the Fraternal Order of Police, as well as that of other repressive institutions and operations in trying to destroy the movement and assure the conspiracy to execute Mumia, is only referred to superficially. Time, space, and availability of information account for most of these omissions. Hopefully, the amazing spirit and longevity of this movement, inspired by a quite remarkable black revolutionary whom the U.S. powers have been determined to not only execute but also silence, will nonetheless emerge. Mumia Abu Jamal was arrested and charged with the murder of police officer Daniel Faulkner on December 9, 1981. But before that, he had already been in close contact with the MOVE organization in Philadelphia, covering their struggles as a radio journalist. MOVE, in turn, had defended him when he refused to comply with his radio station's demand that he change his hair and his overall appearance and tone. In protest, MOVE supporters and Mumia's wife, Wadiya, created the West Philadelphia Committee for Mumia Abu Jamal. Once Mumia was arrested, that committee became the West Philadelphia Support Committee to Free Mumia Abu Jamal. MOVE and its supporters monitored Mumia's hospital and prison situation, raised money for his legal defense, and organized protests. John Africa appointed Pam Africa to lead the support work for Mumia. At that time and through the ADS, it was primarily the black community of Philadelphia and surrounding areas that supported these protests. Former Black Panthers Reggie Shell and Barbara Easley Cox, for example, were in the courtroom throughout the trial. After the bombing of MOVE in 1985, the Partisan Defense Committee also became involved, working to raise money and help MOVE supporters organize yearly indoor events focused on Mumia. In 1993, Equal Justice USA published an ad in The Nation magazine and began producing educational materials about Mumia's case. Left parties began writing columns in their papers supporting Mumia. Support began to be organized in France and Germany. In 1994, when the West Philadelphia Committee to Free Mumia was told that Governor Robert Casey was about to sign a death warrant, the organization became the International Concerned Family and Friends of Mumia Abu Jamal, with Pam Africa in leadership. ICFMJ and Pam Africa in particular continue to be at the heart of the Mumia solidarity movement today, leading it in collaboration with different organizations and individuals. Upon learning of the impending death warrant, ICFMJ began an intensive organizing effort to build broad-based support from black politicians, black churches, and black lawyers as well as from activists across ethnic lines. There were now frequent demonstrations, some of significant size, many taking place in Harrisburg, the state capital. As a result, ICFMJ and its allies, including several black politicians David Richardson, Vincent Hughes, and Roxanne Jones and Lois Williamson of Citizens United for the Rehabilitation of Errants, gained enough visibility and recognition to get a hearing before Governor Casey, where they succeeded in dissuading him from signing Mumia's death warrant. When Governor Tom Ridge was inaugurated in 1995, after promising the Fraternal Order of Police that he would sign Mumia's death warrant, a huge demonstration was held in Harrisburg by ICFMJ and other Mumia supporters. Representatives from France and Germany began coming to support the struggle here. When Ridge signed Mumia's death warrant on June 1, the movement went into full swing, both in this country and abroad. Close to 1,000 people demonstrated at Philadelphia City Hall. In New York City, the same number showed up for a street demonstration within 24 hours of the signing. This was organized under the leadership of former political prisoner, Black Panther, and BLA member Saifi Yabukari, who along with Sally O'Brien had founded the Free Mumia Abu Jamal Coalition in New York City in 1992. Herman and Iyeliua Ferguson, attorney Joan Gibbs, Black Panther, and friend of Mumia Rosemary Mealy, noted Pan-Africanist Ilambe Brath, attorney Michael Tariff Warren, and many other leaders of the Black movement were present and contributed support, as were Puerto Rican, Asian, and white activists and organizations. Long-standing leader of the political prisoner movement and revered Asian American friend of Malcolm X Yuri Kochiyama, who even when ill came to New York, Philadelphia, and even Washington, D.C., demonstrations for Mumia formed Asians for Mumia, and members of the Latino community formed Latino at S for Mumia. The political prisoners and, from exile, Assata Shakur, themselves in such a vulnerable position, spoke out loudly in support of Mumia, urging activists to focus on preventing his execution. In San Francisco, a demonstration of nearly 1,000 people was held on June 26, and 250 demonstrators were arrested. In Minneapolis, 200 people tied up traffic in a university neighborhood. They were attacked by police using mace and horses and suffered 9 arrests. By June 10, 40,000 petition signatures had been collected, and people from many sectors were mobilized. In Los Angeles, the coalition included actor Mike Farrell. The city councils of Detroit, Los Angeles, and Madison, Wisconsin, passed resolutions of support. Op-ed pieces appeared in the New York Times, USA Today, and the Washington Post, including a very widely distributed one by E.L. Doctorow. The international support was loud and effective. It was in this context that the Congressional Black Caucus called for a stay of execution, the removal of Judge Albert Sabo from the case, and a new trial. Mumia support groups and organizations were formed across the country. Trade unionists, artists, academics, lawyers, students, and many others began to write letters, pass resolutions, take out ads, contribute money, attend meetings, and hold teach-ins and conferences. Academics for Mumia took out an ad in the Philadelphia Daily News with more than 500 signatures, demanding a stay of execution, the removal of Judge Sabo from the case, and a new trial. Anti-death penalty organizations were energized by the tremendous attention Mumia brought to death row, especially after the publication of his powerful book, Live from Death Row, in which he gave voice and humanity to the condemned. Mumia's commentaries were to have been broadcast on national public radio, but this was cancelled under pressure from the Fraternal Order of Police. The determination of those who wield power not only to kill Mumia but also to silence him became apparent. In July and August 1995, Mumia's post-conviction relief appeal hearings took place in Philadelphia, with Mumia present in the courtroom. Thousands of people, including international representatives and well-known public figures, came to attend the hearings in Judge Albert Sabo's court. Sabo was the judge in the original, very flawed case and was now reviewing the very trial over which he had presided. Observers were shocked by his courtroom behavior, his obvious racism, his intense animosity toward Mumia and his attorneys, and his consistent rulings in favor of the prosecution. Pressure to have Sabo recuse himself intensified, but to no avail. Rallies in which demonstrators shouted "Sabo must go" echoed through the streets, and legal updates from the lawyers were taking place on a daily basis outside City Hall. The United African Movement, led by Alton Maddox, and the National Action Network, led by the Reverend Al Sharpton, brought busloads of supporters to the courtroom and rallies. Activists came from all communities. A huge national demonstration was planned in Philadelphia for August 12, 5 days before the scheduled execution, by the International Action Center in collaboration with ICFMJ and many other organizations. By August 7, the execution was stayed, but the 10,000-person demonstration took place as a victory for the people and a consolidation of the determination to continue the struggle. Still, despite the massive outcry and powerful legal arguments pointing to violations of due process, racial bias, and prosecutorial and police misconduct, Szabo rejected all the arguments of Mumia's lawyers and reaffirmed both the conviction and the death sentence. The case next went to the Pennsylvania State Supreme Court, a body that was strongly connected to the Fraternal Order of Police. Additionally, one of the judges, Ronald Castile, had played a major role in Mumia's original conviction and in some of its violations of due process. But when a legal and grassroots effort to have him recuse himself was mounted, he, like Szabo, refused. On October 30, 1998, the Pennsylvania Supreme Court denied Mumia's appeal and essentially rubber-stamped the decisions made in Szabo's court. Over the years, from 1996 to the present, Jeff Mackler with the Mobilization to Free Mumia Abu-Jamal in San Francisco organized rallies that included Angela Davis, Ossie Davis, Alice Walker, Danny Glover, and Michael Franti, among others. These efforts raised a total of $250,000 to pay for the legal work. There were yearly demonstrations in Philadelphia on April 24, Mumia's birthday, July 4, the day after the date when Mumia was sentenced to death, and December 9, the day in 1981 when Mumia was arrested. There were visible efforts to confront media distortions, such as ABC's Hatchet Job on 20/20 in 1998 and later Vanity Fair's publication of yet another fabricated confession. The International Tribunal putting the U.S. government and all the agencies involved in Mumia's conviction on trial in December 1997 in Philadelphia, which had its parallel in San Francisco, mobilized the movement internationally. And the movement began to prepare for the signing of yet another death warrant by Governor Ridge. Also in the period following 1995, the FMAC developed a strategy to call for a civil rights investigation, the argument being that the statute of limitations did not apply, as the conspiracy to deny Mumia his rights was ongoing. This was supported by the Million Letters for Mumia campaign, an international effort whereby 100,000 letters were collected from around the world in France, Spain, Italy, Portugal, Holland, Japan, and Israel, among other places, calling on Clinton's Attorney General Janet Reno to initiate such an investigation. The letters were finally delivered by hundreds of demonstrators who marched to the Justice Department from Howard University on May 20, 1997. In January 1999, 20,000 young people attended a sold-out concert at the Meadowlands in New Jersey featuring Rage Against the Machine, the Beastie Boys, Bad Religion, and Black Star, with MCs from Chumbawamba. This despite the Fraternal Order of Police trying to have the concert cancelled and threatening that participants would be arrested if they distributed literature. About 75 activists received complimentary tickets to the show and distributed thousands of flyers while educating the young concert audience about Mumia's case. The special appeal Mumia holds for young people, those in the hip-hop community in particular, but so many others around the world, is a pivotal aspect of the continuity of this movement, which now reaches people who were not even born when Mumia was first arrested and charged. A month later, the IAC in conjunction with ICFMAJ, FMAC, Refuse and Resist, WBAI/Pacifica Radio, and other groups organized a 1,700-person solidarity event at New York City's prestigious Town Hall. Speakers included the former political prisoner Puerto Rican revolutionary nationalist Rafael Cancel Miranda, Dennis Rivera of 1199 Health and Human Services Union/service employees, Dick Gregory, Ossie Davis, Ramsey Clark, and former political prisoner Geronimo G. Jaga Pratt. By April 1999, Mumia's lawyers were expecting another death warrant. It was in that context that IAC, ICFMAJ, the New African Liberation Front, Academics for Mumia, the FMAC, the Jericho Movement, the Million Woman March, the Bruderhof, the Black Radical Congress, the Mobilization to Free Mumia Abu-Jamal, Refuse and Resist, the Campaign to End the Death Penalty, Critical Resistance, and dozens of other organizations and networks brought together tens of thousands of people in Philadelphia. With a delegation of 50 people from France plus a representative of the European Parliament, the rally began with contingents marching dramatically from different starting points, the People of African Descent contingent led by longtime activists such as Herman and Iyeliua Ferguson, the Latin at S for Mumia contingent led by Rafael Cancel Miranda, the Asians for Mumia contingent, and the Rainbow Flags for Mumia contingent all came together at City Hall, as powerful expressions of the diversity of this movement. Kathleen Cleaver and other former Black Panther Party sisters were very visible participants. At the same time, among the many demonstrations that took place across the country and around the world, there was a huge rally of 20,000 people in San Francisco, led by a contingent of 250 members of the International Longshore and Warehouse Union. Members of this union had on that day closed down all West Coast ports from Canada to Mexico, demanding Mumia's freedom in one of the most powerful demonstrations of solidarity we have seen to date. 2 months later, Mumia gave the first of his commencement speeches, amid much protest from the Fraternal Order of Police, at Evergreen College. 1 year later, he did the same at Antioch University, as well as at the Brooklyn Friends High School graduation. Mumia might be on death row, where they may refuse to allow cameras, tape recorders, and video equipment, and NPR might be intimidated into breaking a contract, but Mumia's voice would not be silenced. Related was the regular broadcasting of Mumia's powerful weekly commentaries through the work of Noel Hanrahan's prison radio project. Sally O'Brien, longtime host of WBAI's Where We Live, has been providing updates on Mumia on her show since the late 80s and, once prison radio recordings became available, has opened all her shows with one of Mumia's recorded commentaries. Journalist Kielu Nyasha, a former Black Panther, has provided information about Mumia on her radio show on KPFA/Pacifica since the early 90s. Currently, also on Pacifica Radio, Jr., Minister of Information for the Prisoners of Conscience Committee, regularly broadcasts recorded interviews with Mumia, conducted by Jr. himself, Chairman Fred Hampton, Jr., and occasionally other members of the hip-hop community. In 1999 and 2000, Resistance in Brooklyn, in collaboration with members of the Black Liberation Movement, organized 2 very large and effective civil disobedience actions, the first on July 3 at the Liberty Bell in Philadelphia and the second on February 28 at the U.S. Supreme Court in Washington, D.C. At the same time, on January 12, 2000, an international delegation of trade union and political leaders met with a Justice Department representative and demanded that the department conduct a federal investigation of documented violations of Mumia's civil and constitutional rights. Echoing the demands of the Million Letters for Mumia campaign, this initiative was organized by Labor for Mumia and chaired by Baldemar Velasquez, president of the Farm Labor Organizing Committee. 1 year later, the Justice Department gave its answer: no civil rights investigation. Once again, the Clinton administration refused to conduct an investigation, arguing that this was the domain of the courts, when it was precisely the court's misconduct that needed to be investigated. September 11, 1999, dubbed Mumia 9/11, was organized by dozens of artists with an active role played by Refuse and Resist as a national day of art to stop the execution of Mumia Abu Jamal. Well-known hip-hop artists Chuck D. M1 of Dead Prez, Mumia's daughter Goldie Ilokks, Channel Live, and Zach De La Rocha participated on both coasts, and artists such as Don Byron, Oscar Brown, Jr., Ed Asner, Hugh Masekela, and Alice Walker expressed their support. In different venues and on different days, Mumia 9/11 had a significant presence and excitement. To this day, artists continue to play a very important role in the movement to free Mumia, while facing threats from the FOP and inspiring thousands. Just to name a few: Sonia Sanchez, Danny Glover, Harry Belafonte, Amory and Amina Baraka, and the Next Generation, KRS-One, Immortal Technique, Will Calhoun, Michael Franti, The Welfare Poets, and Rebel Diaz, among many others. On May 7, 2000, 6,000 Mumia supporters packed a sold-out Madison Square Garden Theater event organized by a coalition of groups including the ICFMAJ, FMAC, and Refuse and Resist, led by the IAC, and emceed by Ossie Davis and Ed Asner. Attorneys Johnny Cochran and Ramsey Clark, former New York City Mayor David Dinkins, and hip-hop artists Mos Def and Will Villanueva, as well as mothers of those who had been victims of police killings were among the participants in the dramatic program. On that same day, academics for Mumia bought an ad in the New York Times with over 600 signers, including Toni Morrison, Jonathan Kozol, Patricia Williams, Cornel West, and Noam Chomsky, stating that many of the signers felt Mumia was innocent. All agreed that he should get a new trial. On that day, it was hard to ignore Mumia. In August 2001, Mumia's attorneys were finally able to present their request for a new appeals process to the Philadelphia Court of Common Pleas, based on all the violations of due process in the 1995 PCRA. Mumia was prevented at the last moment from being present, allegedly due to security concerns. Nonetheless, a loud and angry crowd of 2,000 people gathered outside the courtroom and were addressed by Ossie Davis, Dick Gregory, Jesse Jackson, Sonia Sanchez, and others. Judge Pamela Dembay was to deny all the issues raised, including the significance of the racism involved in Judge Sabo's alleged comment, "I'm going to help them fry that N," overheard by a court stenographer who had signed an affidavit to that effect. Now the case went to federal court, where some lawyers had placed their hopes. In December 2001, came Judge William Yones' ruling in federal court affirming Mumia's guilt but giving him life in prison without parole. The wheels of injustice were now moving quickly to deny Mumia's freedom. This ruling was confusing and weakening to the movement. Many thought Mumia was now off death row. Others felt he was no longer in danger if he was not about to be executed. The reality was that Mumia was never removed from death row, that the prosecution appealed the decision and remained determined to see him executed, and that the doors to proving his innocence and gaining his freedom were shutting tighter. The movement had to face this challenge and also the dissent in some sectors that resulted from Mumia's firing of his attorney. In New York City, the FMAC concentrated its work more specifically in the black community, particularly in Harlem, hoping to consolidate Mumia's support where it was strongest. These solidarity events attracted Black and Latino church leaders and politicians as well as community activists. The work of raising funds for the attorneys, having cultural events and book parties, and distributing Mumia's books continued. In 2004, the French support escalated, with honorary citizenships and street namings, and seriously challenged those who wanted to see Mumia executed, the FOP and its supporters in the governmental and social structure. Our movement drew strength and inspiration from the French initiatives and from their and our refusal to be intimidated by the FOP attacks. We would not back down. We went to the Philadelphia City Council to denounce the resolution they had passed attacking the St. Denis Street naming, and then held a press conference in front of the FOP headquarters to rebut the press conference the House of Representatives initiators of Resolution 407 had held. The FOP has regularly threatened, intimidated, and terrorized those who support Mumia. In 2007, they targeted a Philadelphia jazz club where Danny Glover was supposed to speak and a New York City hip-hop club where a benefit for Mumia was scheduled. The FOP's unofficial website talked openly of the violence they would inflict on our movement, but we never cancelled an event. When the clubs were forced to cancel, we simply changed the location. Through resisting this FOP terrorism, the Mumia campaign became an important anti-fascist front. We also went to visit Philadelphia officials and regularly sat in at the mayor's office. Mayor John Street had supported the NAACP's pro-Mumia resolution and had once worked closely with PAM Africa, yet he now refused to challenge a statement attributed to him by Maureen Faulkner. Faulkner claimed that Street had said that he thought Mumia was guilty. Street tried to avoid meeting with us and even avoided meeting with the French deputy mayor, a representative to the French Parliament who had been very instrumental in getting the street in St. Denis named in honor of Mumia. Finally, in May 2007, the Third Circuit Court of Appeals announced that it would hold an open hearing for oral arguments to be presented as to why Mumia should get a new trial. Close to 200 Mumia supporters filled the courtroom, with former Congresswoman Cynthia McKinney, Kathleen Cleaver, Ward Churchill, Lynn Stewart, several international representatives, and many other movement leaders and activists present. 1,000 demonstrators were outside the courthouse with Chairman Fred Hampton, Jr., joining PAM Africa to prevent the plainclothes fop hecklers from endangering the crowd. 26 years after Mumia's initial arrest, 1,000 people were in the streets supporting him, among them many new, young supporters who had initially been attracted to a concert the night before featuring Immortal Technique. 1 year later, in April 2008, after the Third Circuit ruled that Mumia would not get a new trial, 1,000 angry protesters once again came to Philadelphia in a very militant and spirited demonstration, led by young drummers and including members of a Washington Heights Liberation Church, Iglesia San Romero de las Americas, who marched alongside longtime Puerto Rican Mumia supporter Esperanza Martel. In the meantime, in May 2007, journalists for Mumia held a press conference to publicize explosive new evidence discovered and analyzed by German professor Michael Schiffman, photographs long available to the prosecution that strongly contradicted the prosecution's version of what had happened on December 9, 1981. In December 2007, NBC's Today Show announced plans to invite Maureen Faulkner and Michael Smerconish on to promote their new book, Murdered by Mumia, arguing for Mumia's execution. Through an impressive campaign, journalists for Mumia holding another press conference and getting information to the Today Show, a national telephone campaign to get the program to present Mumia's side, and FMAC organizing a loud and visible picket line right outside the NBC studio early in the morning on a freezing day. We actually succeeded in getting coverage of the photographs and in getting a balanced presentation of the controversy around Mumia's case, but this evidence of Mumia's innocence, as with the additional extensive evidence of violations of law, precedent, and due process, has still not entered the legal record. The future remains in question. Few legal options remain for Mumia. All appeals before the Third Circuit Court of Appeals have been exhausted. The only court left is the U.S. Supreme Court. But this movement, which has lasted so long, been so strong and committed, will surely continue the fight to not allow this injustice to stand. Immediately following the Third Circuit's refusal, plans were set in motion for the next steps. The struggle to free Mumia is one of freeing all our political prisoners. It is about standing up to the police racism and terrorism that millions of disenfranchised young people of color, in particular, are subjected to on a daily basis. It is about abolishing the racist prison industrial complex and the death penalty once and for all. The Free Mumia movement has both highlighted those struggles because of the fame of Mumia's case and, at the same time, been part of them. We have joined forces around these issues in our common struggle for justice. 6.2. Death row journalist barred from National Public Radio. Bob Lederer, 1994. Amidst a wave of anti-crime hysteria, National Public Radio has cancelled a planned commentary series by an internationally known black journalist on death row in Pennsylvania. Media activists are calling the decision one of NPR's most blatant acts of censorship. Before his arrest in 1981, Mumia Abu-Jamal was well known for investigative coverage of police brutality, particularly against the MOVE organization. He won a Corporation for Public Broadcasting award for his reporting on NPR-affiliated WUHY, and he was elected president of the Philadelphia chapter of the Association of Black Journalists. Later, from prison, he was published in the Yale Law Review, The Nation, and the Philadelphia Inquirer. In April 1994, NPR contracted with Abu-Jamal to be a monthly commentator on criminal justice, and several tapes were recorded. The opinion pieces specifically excluded his own case, a death penalty conviction for the 1981 killing of a police officer. Abu-Jamal maintains his innocence, and a worldwide support movement charges his trial was filled with blatant violations of his constitutional rights. Amnesty International expressed grave concern about the inflammatory introduction into his sentencing hearing of statements he had made as a young Black Panther leader. A month of intense promotion for the series by NPR created media interest, prompting a May 13 announcement of a May 16 air date on All Things Considered, which led to the first Wire story. The Philadelphia Fraternal Order of Police then launched a furious campaign denouncing the network for giving a platform to a cop killer. Police officials went on local commercial radio urging listeners to withdraw support from NPR. Within 48 hours, NPR reversed itself. Managing editor Bruce Drake cited serious misgivings. Underscore 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 underscore. A shorter version of this article was published in the July/August 1994 edition of Extra, the magazine of fairness and accuracy in reporting. The feared signing of Mumia's death warrant by then Gov. Robert Casey was staved off by activist pressure, but only temporarily, as his successor, Tom Ridge, did the deed in 1995, only to have it stayed by court order inspired by an intense international uproar. For an update on Mumia's legal situation as of July 2008, see 6.10 This is no victory, analysis of appeals court ruling on Mumia Abu Jamal's case, on page 457. About the appropriateness of using as a commentator a convicted murderer seeking a new trial, especially since we had not arranged for other commentaries that provided context or contrasting points of view. The next day, Sen. Robert Dole attacked NPR from the floor of the Senate for even considering running Abu Jamal's commentaries. The last time I checked, we were trying to fight crime, not promote the fortunes of convicted murderers through taxpayer-supported public broadcasting, he said. He noted ominously that this mistake showed the need for closer oversight by Congress. But in a letter to NPR, Fair commented, Abu Jamal's contributions would have provoked and enriched NPR listeners, helping the network fulfill its mission of providing challenging programming that goes beyond conventional sources. The move to cancel the series is a disturbing signal of timidity at NPR and threatens to have a dangerous chilling effect. 2008 update. After NPR reneged on its contact with Mumia, various producers throughout the progressive Pacifica radio network picked up Mumia's recorded commentaries, which he gradually was able to produce more frequently, thanks to the Herculean efforts of Noel Hanrahan, founder of Prison Radio, who has recorded nearly all of them. Today these recordings can be heard weekly on Sally O'Brien's program Where We Live on WBAI/Pacifica Radio, 99.5 FM in New York City, and periodically on Free Speech Radio News, which airs on many community radio stations. An archive of many of the commentaries is kept at the website of Prison Radio, www.prisonradio.org. Graphic Eric Drucker, www.drucker.com. 6.3. The Congressional Black Caucus Letter. Suzanne Ross 2008. The following letter was initiated by Congressmember Chaka Fattah, who represents the district in which Mumia lived prior to his incarceration and who had a long history of political collaboration with PAM Africa of the International Concerned Family and Friends of Mumia Abu Jamal. When the Free Mumia Abu Jamal Coalition contacted him to urge him to initiate such a letter to Attorney General Janet Reno, Fattah responded promptly and positively. Equal justice informational packets were sent to all the members of the Congressional Black Caucus. The letter that emerged demanding a civil rights investigation circulated around the world 6 weeks before Mumia's scheduled August 17, 1995, execution. It became part of the massive international pressure that was exerted against all branches of the U.S. government that forced Judge Albert Sabo to grant a stay of execution. Other CBC members added their names in the following months: John Lewis, Major Owens, Floyd Flake, James Clyburn, Kwesi Mfume, and Eleanor Holmes Norton. Others, mostly outside the Congressional Black Caucus, later added their names as well: Congressional Representatives Gerald Nadler, Albert Russell Wynn, Patsy Mink, Jose Serrano, Henry B. Gonzalez, Adolphus Towns, and Harold B. Ford. Representative Nadler had been contacted in the beginning, and it was he who suggested that a civil rights investigation, as had occurred in the 60s in the South, might be very effective. Subsequently, the FMAC led an international grassroots campaign, the Million Letters Campaign, that also called for a civil rights investigation, while no civil rights investigation ever happened, the fact that so many congressional representatives had agreed that Szabo's kangaroo court had been a travesty, had demanded a new trial, and had added that Mumia might even be innocent, all lent great legitimacy and credibility to the movement. Sadly, by 2006, when the House of Representatives voted on the anti-Mumia House Resolution 1082, which denounced the naming of a street after Mumia in St. Denis, France, Chaka Fattah abstained. He had been publicly threatened on the unofficial website of the Fraternal Order of Police, who declared they would be present in the Congress when the vote took place to observe how he voted. Fattah was then running for mayor of Philadelphia. He abstained on this important test of standing up to police terrorism to defend an innocent man. 6.3.a. A grave injustice is about to be committed. Congress Member Chaka Fattah 1995. Dear Ms. Reno. A grave injustice is about to committed. We are rushing to execute someone in the face of ample evidence that his constitutional rights have been denied, that he did not receive a fair trial, and most importantly, that he may be innocent. Passionate and documented racial biases, both personal and societal, surrounded this man's arrest, his trial, his conviction, and his sentencing. Because we understand our history, we understand how we got to this point, but as legislators and as persons concerned with the processes of justice in this country, we cannot sit silently by and allow this travesty of justice to proceed. Mumia Abu-Jamal is an outstanding African-American journalist from Philadelphia known for his reporting of police brutality in the 1970s and 80s. In 1982 he was sentenced to death for the murder of a white police officer. Testimony of eyewitnesses was suppressed, a witness was bribed to testify against Abu-Jamal, the ballistics evidence did not match the circumstances of the case, there is no physical evidence linking Abu-Jamal to the crime, and tests which could have been done to prove his guilt or innocence were not ordered. At the trial, Mr. Abu-Jamal, a most powerful orator, was denied the right to represent himself. His court-appointed attorney, a man who was later disbarred on unrelated matters, failed to object to 11 of 15 peremptory challenges to remove African American jurors, and consented to the judges replacing an African American juror who had been chosen, with an older white male who admitted that he could not be fair to both sides. Abu-Jamal was even denied the right to confront his accuser. The judge used his insistence on his right to represent himself as an excuse to remove him from the trial. No audio transmission of the trial was provided, so Mr. Abu-Jamal did not hear most of the prosecution's case. It is apparent that these outcomes were not accidental. The presiding judge, Judge Albert Szabo, has sentenced more people to death than any other judge in this country, all but 2 of whom were persons of color. Judge Szabo is a lifetime member of the Fraternal Order of Police, ruling this instance on the killing of a police officer. No fewer than 19 instances of unconstitutional error and legal impropriety have been documented in this trial, including the use of Abu-Jamal's political affiliation as evidence in the sentencing phase of the trial. In a case regarding a member of the Aryan Brotherhood complaining of similar prosecutorial improprieties that same year, the Supreme Court ruled that the defendant's First Amendment rights barred the use of his political associations against him in the penalty phase of the trial. The appeals process through the Pennsylvania Supreme Court was similarly flawed. For example, in his summation, the prosecutor in the Abu-Jamal case insisted to the jury that they were not being asked to kill anyone, that the defendant would have appeal after appeal after appeal, incorrectly implying that the responsibility for determining a death sentence does not ultimately rest with the jury. Such implications by the prosecution were determined to be fatally misleading by courts in New York, Georgia, California, and other states and the United States Supreme Court, providing reason to overturn the death sentence. In a 1986 Pennsylvania case prosecuted by the same prosecutor, and presided over by the same judge, the Pennsylvania Supreme Court ruled that language which minimized the jury's sense of responsibility for the verdict of death provided reason to overturn the sentence. Yet in Abu-Jamal's case, the court ruled otherwise. All relief was denied in the appeals process, and this decision was made by fewer judges than in any other case in Pennsylvania's history. One of the judges who upheld the death penalty had actually engaged in a direct and bitter verbal exchange with Abu Jamal, leading some to question his impartiality. It is clear that the treatment of evidence and the application of justice in this instance have been at best arbitrary and capricious. Even if Mumia Abu Jamal were guilty, we would deserve to have more solid assurance of that before we put him to death. If he is innocent, to put him to death on the basis of the evidence at hand is to make of us the very murderers against whom we seek relief. Governor Ridge's signing Mr. Abu Jamal's death warrant on June 1 was particularly ill-timed in view of the fact that his lawyers were scheduled to appear in court on June 5 to file a petition for post-conviction relief. In light of all we have presented to you, we urge you first, to have Judge Sabo recuse himself from this case. We are convinced that Mumia Abu Jamal cannot get a fair hearing before Judge Sabo. Further, we urge you to do all in your power, and we feel it is particularly important for you, Attorney General Reno, to become actively involved to ensure that Mumia Abu Jamal is not executed on August 17 as is now scheduled, and that he is granted a new trial. Signed by the following: Chaka Fata, John Conyers, Ronald Dellums, Cynthia McKinney, Maxine Waters, Bobby L. Rush, Melvin L. Wood, Bobby Scott, Eva M. Clayton, Benny G. Thompson, Carrie P. Meek, Corinne Brown, Alcy L. Hastings, Barbara Rose Collins, Charles Rangel, Donald M. Payne, Cardis Collins, Walter R. Tucker, 3. Earl F. Hilliard, William Clay, Sanford Bishop. 6.4. Art Against Death. Political Prisoners Unite for Mumia. Laura Whitehorn, 2008. The creation of art in prison is the statement that I am still a human being. I am being packaged, I am being dehumanized, I am being abused, but as long as I can speak creatively and express my humanity, I am still a human being. I think that so many prisoners discover their ability to draw, paint, or engage in whatever creative form is because it's an act of resistance. For those of us in the resistance conspiracy case, when we were all together in the DC jail for 3 years, we all discovered that we had an interest in doing a lot of art for our case. One of the RCC co-defendants, Alan Berkman, had been in prison in Philadelphia earlier in the decade with a former Black Panther named Mumia Abu Jamal. At this point, Mumia's name was not so well known, and his case was hardly talked about at all outside of Philadelphia. Mumia is a very modest man, and he hadn't spent a lot of time saying, "Hey, pay attention to me, I'm on death row." Alan, however, was horrified. Mumia had helped to take care of Alan when he was undergoing cancer treatment at Holmesburg prison. At that point, Mumia's risk of being executed was fairly imminent, and there was very little resistance to it. After we were all sentenced and sent to other prisons, Tim Blunk went to Lewisburg, where Puerto Rican political prisoner Alberto Rodriguez was being held. They began engaging in all kinds of art projects at Lewisburg, including music and performances. And they came up with the idea to do an art show that would include art exclusively made by prisoners, primarily political prisoners. We were quite aware that people on the outside would be moved by the fact that people who were themselves in prison had this idea of something to do in solidarity with another prisoner. We wanted to move people on the outside, who had more resources and more ability to resist, to intensify work on behalf of Mumia. I have to emphasize that when you are in prison, you have very little control over your voice. You don't have the ability to talk to a group of people about what you think about what's going on in the world. The prison system tries to block communication from inside prison to the outside, especially for political prisoners. At that point in history, in the early to mid-1990s, there was not a huge recognition of the fact that there are political prisoners in the United States. So for us to have a voice was threatening to the government and to the prison administration. To say that we would be producing something that would, in turn, be shown and spoken about on the outside, was itself an act of resistance. All of us were also strongly opposed to the death penalty. and we felt that Mumia had not gotten a fair trial. This seems so obvious on the face of it, he should at least get a new trial if not a complete exoneration. Certainly the death penalty should be lifted. That was why we named the exhibit Art Against the Death Penalty and Art for Mumia, Art Against Death. One of the things that made this project so powerful was that there has always been a struggle, internationally and in the US, for the right of association between political prisoners who share basic beliefs. Knowing that there were prisoners in other units working on this, some even in isolation units not able to see anyone except for prison guards, was a high point of this project. To sit in your cell and produce a piece of art that you knew was going to go out beyond the walls and express your heart to people, it kept you alive, it kept you political and active. We were able to stand together in this way, and to actually organize people on the outside. In the beginning, there were just a few outside supporters, but as time went on, there were committees throughout the US that put this show on. The first show was at the Harlem State Office Building in New York City in 1994. When that show was reported on in Z Magazine, some artists involved with a gallery space in Soho put together a special exhibition that featured all kinds of speakers and panels on the death penalty and on political prisoners. That then reached a much broader audience and led to another showing out in California. At that point, there were a number of women political prisoners in the correctional institution at Dublin, California. Because we had pretty good visiting opportunities there, and the prison was located close to San Francisco and Oakland, we had a lot of visitors from the progressive community and were able to work very closely with the activists on the outside who were mounting that show. There is a constant, hopefully creative, tension between those on the inside and out, often relating to how much control prisoners have on the way our work and politics are presented. In California, I was in direct contact on an almost daily basis with the women who put that show together. And there was a constant push and pull. One of us on the inside would say we want this issue highlighted, and the people from the outside would say, well, it might not work the best way, and they would describe to us the material conditions that they faced. I consider myself a socialist and a Marxist, so we begin with trying to analyze the situation and how we can affect change in a given historical moment. So if someone says to me, Laura, those words don't mean anything to anyone, you have to say that differently, then I have to listen to that. What's the point of just spouting off something that people won't understand, especially when the folks on the outside who I trust and love are telling me that I need to say it differently? One of the things that used to drive me nuts and still does from the other side now, is when people on the outside act as yes men for political prisoners, based on the principle that the prisoners are the political leadership. There needs to be interaction and dialogue, where people can give their ideas, and also say, let me tell you what I think would work better. I guess the main issue is respect in both directions and trying to strive for a high level of political communication. It is so important for political prisoners especially to have some avenues for political expression. So they must be treated as human beings who deserve to be talked to with honesty and respect. Reaching a broader audience is my #1 priority for this work. So these successful shows, which had people coming together and talking about Mumia, the death penalty, and political prisoners in general, were to me a major, very exciting achievement. Our job as activists supporting political prisoners today is to go broader. There is now a whole new generation of political prisoners from different movements. This is an opening, where people should be talking to a broader sector of people. I still go to sleep thinking about comrades who have been in jail for 30 years, like Herman Bell and Jalil Muntakim. But we can't rely on the old guard to keep this issue alive, especially at a time when things have become more repressive. But the struggles that we came out of, that turned us into political prisoners or for which we became political prisoners, should never have been isolated from the progressive movements in this country. We were struggling against racism, against killer cops, against colonialism, against the US government invading other countries and going to war. And all of those issues are still urgent problems. There are other issues that we were concerned about on a deeper level than in past generations, such as environmental racism and the environment in general. The increasing crisis in the economy, and the increasing incarceration of poor people, are also particular to this period. If we cannot make the issue of political prisoners relevant to people in all progressive movements, I don't think we are doing our job. I don't think we should view the question as why isn't the rest of the movement paying attention to political prisoners. I think that we haven't tried well enough to make this an issue that relates to everyone else's work. Prisoners are put in prison in order to repress any social change. We have to be able to talk about that. My personal goal is that every major progressive or left organization in this country should add to their program a position calling for the freedom of all political prisoners. There are many movements around the world that automatically have that, because they understand that in the course of struggle people go to prison for their political actions and beliefs. For those of us whose hearts are in the struggle for social change, we must recognize that part of our hearts are in prison. The struggle for liberation, for peace with justice, is broader than the issue of amnesty for political prisoners, but political prisoners are a central part of the struggle. 6.4.a. Mumia Abu Jamal. Susie Day 1995. For years, Mumia Abu Jamal, a black man in Philadelphia, tried to speak of injustice as a radio journalist. He is now struggling to speak from death row. Sentenced to death for killing a police officer, Jamal has spent nearly 15 years in Pennsylvania prisons, continuously maintaining his innocence. In order to prevent his execution, over 70 political prisoners around the world, along with numerous artists and community activists, have joined forces to produce art and writings against the death penalty, a traveling art exhibit that opened in Harlem, New York, December 1994. Jamal was a reporter at Philadelphia station WUHY and other local stations. His stories were usually about people without money or power. In fact, they often questioned those whose power devastated the black community, notably, the Philadelphia police force. Jamal's coverage of a police raid on the black naturalist group MOVE in 1978 had much to do with the Philadelphia Inquirer's calling him the voice of the voiceless. It was also a probable catalyst for then Mayor Frank Rizzo to denounce a new breed of advocacy journalism that bred dangerous contempt for local authority. I simply did what any so-called objective reporter was trained to do, writes Jamal. I got both sides, the systems and moves. Because his work was so controversial, Jamal was forced to work freelance, and drove a cab to supplement his income. In December 1981, at about 4 in the morning, while driving his cab, Jamal caught sight of a police officer beating a black man. Rushing to the scene, Jamal recognized the beaten man as his own brother, Bill, who had been stopped for a traffic violation. What happened next is unclear, except that the officer was shot and killed and Jamal took a bullet in his abdomen. When more police arrived, they badly beat Jamal at the roadside, and again after he was taken to a hospital. Underscore 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 underscore. This article was published in Z Magazine, March 1995. One of the many reasons that events of the shooting remain hazy is that state prosecutors prevented over 125 eyewitnesses from testifying at Jamal's trial, even though some bystanders claimed to have seen a man, not answering Jamal's description, shoot the officer, then flee. Although the prosecution identified the murder weapon as Jamal's legally registered gun, the police ballistics expert testified that the bullets that killed the officer belonged to another as yet unrecovered weapon. But concrete proof was probably unnecessary for the predominantly white jury, which appeared to have been persuaded of his guilt by the prosecution's characterization of Jamal as a dangerous former Panther, with current radical affiliations. Seemingly oblivious to the First Amendment right of free speech and association, the state selected one of Jamal's political comments made over 10 years before, when he was 16, to the effect that all power grows out of the barrel of a gun, as evidence that Jamal had only been waiting for his chance to kill a cop. Jamal, who had no previous criminal record, has for years spent 22 hours of each day locked in a tiny cell. He is given 2 hours outdoors every weekend in a 20 x 8 foot cage. With scant prospect of a new trial, legal appeals are all but exhausted. Already, Tom Ridge, newly elected governor of Pennsylvania, has promised to make Jamal's swift execution a priority for his administration. The idea of art and writings against the death penalty came from Pennsylvania's Lewisburg prison, where a collective of inmates decided to draw attention to Jamal's case and to the escalation of the death penalty in the U.S. The collective also wanted to heighten public awareness that there are now about 150 leftists and progressives in U.S. prisons, convicted for various anti-government protests, from peaceful anti-nuclear demonstrations to acts of armed struggle. Scores of these political and some social prisoners have painted, drawn, or sculpted art for Jamal's campaign. Most of the artwork is for sale, the proceeds going to replenish Jamal's legal campaign. From Harlem, art and writings against the death penalty will move to various locations in New York, and throughout the country. Word has it that the governor of Pennsylvania plans to sign Abu Jamal's death warrant by March 16, at the latest. 6.5. The People's International Tribunal for Justice for Mumia Abu Jamal. 1998. The People's International Tribunal for Justice for Mumia Abu Jamal convened in Philadelphia on December 6, 1997, to investigate the facts surrounding Mumia's conviction and death sentence and to call attention to the ongoing effort to save Mumia's life. The tribunal examined the denial of Mumia's civil and human rights and the actions of Pennsylvania Governor Thomas Ridge, the Pennsylvania Department of Corrections, the Philadelphia Police Department, Judge Albert Sabo, as well as the FBI and the Counterintelligence Program. Internationally renowned jurists, political leaders, artists, and community activists reviewed testimony concerning the effort to execute Mumia, and at the end of the day they rendered a verdict. The international team of judges, organized through the Office of Stevens, Hines and White, included Walter Brooks of the NAACP, Gamal Kruma, international editor of Kairos Al-Aram, and son of the late Pan-Africanist president of Ghana, Kwame Nkrumah, Yuri Kochiyama, the revered Japanese-American activist, and Julia Wright, Parisian journalist, activist, and daughter of famed author Richard Wright. The prosecution was led by attorney Michael Tariff Warren in consultation with Mumia's attorney, Leonard Weinglass. The Tribunal for Justice for Mumia Abu Jamal, like the Bertrand Russell tribunals on the United States war against the Vietnamese people, applied principles of customary international humanitarian law. Article 38 of the Statute of the International Court of Justice recognizes the authoritative effect of the findings of such tribunals on contemporary standards on international law. A verdict of guilty was delivered by a distinguished panel of 25 international judges who also proposed several remedies, including the United Nations assignment of a special rapporteur to investigate the human rights violations in the case of Mumia Abu Jamal. Underscore. This report was published in 1998 by the tribunal's initiators, International Concerned Family and Friends of Mumia Abu Jamal and the Ad Hoc Coalition for a People's International Tribunal for Justice for Mumia Abu Jamal. Attorneys Lennox Hines and Richard Harvey played a key role in organizing the team of judges. Complete tribunal findings. We find as a fact that those charged are guilty of a criminal conspiracy to deny Mumia Abu Jamal's human rights, and we call for his immediate release, exoneration, and compensation. We find as a fact that the human and constitutional rights of Mumia Abu Jamal were blatantly violated in numerous and systematic ways, resulting in his unjust conviction, unlawful incarceration and illegal death sentence. We recommend that a thorough, independent, international, and impartial judicial investigation, with full subpoena powers, should be conducted into the historical and current operations of the Philadelphia Police Department, particularly in relation to its treatment of people of color, and into the FBI's counterintelligence program, and all similar repressive programs, particularly in relation to their treatment of the Black Panther Party, MOVE, and other political organizations led by people of color, and into the actions of all federal, state, and city elective, judicial and law enforcement officials that had any role in relation to the bombing of MOVE headquarters in 1985, and that all public officials found responsible for the deprivation of Mumia Abu-Jamal's human rights should be removed from office and declared unfit to hold such office in future by reason of their breach of public trust. We therefore urge the Secretary-General of the United Nations and the UN High Commissioner for Human Rights to call for reports on the case of Mumia Abu-Jamal from UN special rapporteurs, especially those with jurisdiction over 1. Extrajudicial, summary, and arbitrary executions. 2. Torture, cruel, inhuman and degrading treatment and punishment, and 3. Independence of the judiciary. Signed. Tribunal Judges, Francesi Arrheniou, Christophe Arnold, Barbara Nimri Aziz, John Black, Dennis Brutus, Gilma Camargo, Phil Chinos Su, Asia Coney, Miriam Falco Mere, Herman Ferguson, Marita Golden, Rev. Cecil Gray, Martha Grivet, Maddie Humphrey, John Judge, Yuri Kochiyama, Pierre Leroy, Jim Lester, Gamal Kruma, ULF Panzer, Queen Ivory, Father Paul Washington, and Julia Wright. Rationale for organizing United Nations support. The Tribunal, and the critical international follow-up effort to bring to fruition the judge's verdict, comes at a crucial stage in Mumia's legal battle. The decision to call for the tribunal was made last fall in an effort to maintain momentum for resisting the planned execution of Mumia during the seemingly endless wait for the Supreme Court of the state Pennsylvania to rule on Mumia's motion for a new trial. The tribunal has educated and continues to educate the public about the egregious violations of commonly recognized due process and basic international human rights in Mumia's case. The prospects for a new trial are grim. First, Judge Albert Sabo's consistent rulings that all of the powerful new evidence submitted by the defense since 1995 is irrelevant severely hampers Mumia's ability to have a fair review of his case. Second, since President Clinton signed the Anti-Terrorism and Effective Death Penalty Act, the availability of federal habeas corpus review has been severely curtailed. Given these circumstances, the tribunal, and the ability to implement the judge's recommendations, is critical to our ability to impact the decision of the state Supreme Court, subsequent appeals to the federal courts, as well as international opinion. There is considerable potential for exerting moral and political pressure on the various institutional structures of the United States through the delegation's presentation of the tribunal's verdict to the United Nations. The delegation will present the verdict of the distinguished and international body of jurists which ruled that human and constitutional rights of Mumia Abu-Jamal were blatantly violated in numerous and systematic ways, resulting in his unjust conviction, unlawful incarceration and illegal death sentence. Additionally, the delegation will formally present the judge's recommendations that the UN assign a special rapporteur who will investigate issues such as extrajudicial, summary and arbitrary executions, torture, cruel, inhuman, and degrading punishment, and independence of the judiciary, which is a crucial step in documenting the myriad ways in which international and U.S. constitutional laws have been violated in the case of Mumia Abu-Jamal. We will also be able to highlight how many other political prisoners and death row prisoners have been, in direct violation of constitutional guarantees, denied a fair trial. We intend to expose how the U.S. government's counterintelligence program, which aimed to neutralize black and other progressive political leaders, resulted in the incarceration, exile, and murder of some of the most effective leaders of the 60s and 70s. We expect that the delegation's presentation at the United Nations hearings will encourage mainstream organizations such as lawyers' groups and human rights groups to take more forthright positions in the case of Mumia Abu-Jamal, as well as, in other cases involving prosecutorial and judicial misconduct. The UN hearings will also add weight to the mounting opposition to the death penalty. Finally, it is our hope, through this process, not only to gain Mumia Abu-Jamal's freedom, but to create a more democratic climate in this country so that those who are critical of government policy can express their views without risking illegal arrests, trials, convictions and even death. In addition to the presentation to the Human Rights Commission, we wish to send at least one member of the delegation to Germany, France, Belgium, Spain and Italy while in Europe, to report to Mumia coalitions and Mumia supporters in those countries. European support of Mumia Abu-Jamal has been extremely effective in pressuring the governor of Pennsylvania and other U.S. officials. In 1995, European efforts played a key role in gaining a stay of execution from Governor Ridge. Tens of thousands of Europeans demonstrated in the streets in support of Mumia, and thousands sent letters to Governor Ridge, to Attorney General Janet Reno, and to President Clinton. We want to support the international nature of this movement as it has maximized the pressure to free Mumia. Human Rights Day presentation. Our follow-up work began immediately after the tribunal. On December 10, Human Rights Day, a delegation from the People's Tribunal delivered the tribunal's indictment and the judge's verdict to the United Nations High Commissioner for Human Rights office in New York. Dr. Purification Kwesuming, director of the New York office of the High Commissioner for Human Rights, greeted the delegation, which included Gamal Kruma, international editor of Kairos Al-Aram, Julia Wright, author and political analyst, and Ramona Africa of MOVE. Dr. Kwesuming accepted the findings of the tribunal and made several recommendations regarding international action on the findings. Veronica Jones, a key prosecution witness in Mumia's original trial, testified in the 1996 post-conviction relief hearings that in 1982 she had been working as a prostitute, and was threatened with losing her children and 10 years imprisonment, if she did not change her story to suit the police. While recanting her forced 1982 testimony, Jones was threatened by Judge Sabo with 5 to 10 years imprisonment for perjury if she continued. He then allowed her to be arrested, while being cross-examined, for writing a bad check years earlier. With tears streaming down her face, Jones declared, "This is not going to change my testimony." She was introduced at the tribunal by Michael Tariff Warren and received a standing ovation. Specifically, Dr. Kwesuming recommended that the findings of the tribunal and a complete package of materials concerning Mumia's legal case should be presented to Mary Robinson, Kofi Annan, Bill Richardson, and Gay McDougall. The 30-minute meeting was filmed and has already aired on public access channels. The delegation is presently working to secure the support of several NGOs in advance of its presentation to the UN High Commission. The delegation will include Michael Warren, lead prosecutor for the tribunal, Ramona Africa and Sue Africa of International Concerned Family and Friends of Mumia Abu-Jamal and MOVE, and Linda Thurston, former director of the program to abolish the death penalty of Amnesty International USA. The Tribunal for Justice for Mumia Abu-Jamal and the follow-up work required to activate the tribunal's findings, is a truly international endeavor. On the day of the tribunal, December 6, there were solidarity rallies in San Francisco and Vancouver. Solidarity messages were sent to the tribunal from around the world, including messages from Ramsey Clark, former U.S. Attorney General, Leoluco Orlando, mayor of Palermo and longtime death penalty opponent, Assata Shakur, exiled leader of the Black Liberation Movement, and Leonard Peltier of the American Indian Movement. The 1998 People's International Tribunal for Justice for Mumia Abu-Jamal in Philadelphia. 6.6. An appeal from U.S. political prisoners/P.O.W.S., mobilized to save Mumia Abu-Jamal. Herman Bell, David Gilbert, Abdul Majid, Bill Dunn, Jihad Abdul Mumit, Marilyn Buck, Dr. Mutulu Shakur, John Lohman, Tom Manning, Richard Williams, Ray Luke Levasseur, Linda Evans, Edward Africa, Sundiata Akalai, Chucky Africa, Teddy Yahith, Phil Africa, Larry Giddings, Robert Seth Hayes, Russell Maroonshotes, Yuki Kumura, Janine Africa, Janet Africa, Debbie Africa, Juan Segura Palmer, Oscar Lopez Rivera, Jalil Muntakim, Leonard Peltier, Veronza Bowers, Na Washington 1999. We are prisoners of war and political prisoners within the United States. We were variously imprisoned for a range of activities: struggle against white supremacy and colonialism, opposition to the economics of global plunder and class exploitation, efforts against sexism and discrimination, a general unwillingness to abide the multiple ways human beings are demeaned and delimited in this society. We stand for self-determination for all oppressed peoples, for an end to racism, for women's liberation, for economics centered on human need rather than corporate greed. The reason for this unprecedented collective statement is the urgent situation of fellow political prisoner Mumia Abu-Jamal on death row in Pennsylvania. His legal challenge has now moved to the federal courts, the final arena available to him, and these proceedings could be completed within months. While there is overwhelming evidence of his innocence, most of it has been excluded from judicial review. Many of you who have worked hard to save Mumia's life are to be commended. Without your hard work the state probably would have already executed him, but we need to alert you to the urgency of the situation. A measure of the importance of this case can be taken from the recent big lie slanders of Mumia by ABC's 20/20 on TV and by Vanity Fair magazine. The Fraternal Order of Police, the reactionary criminal justice system, and the corporate media are determined to execute this articulate and courageous brother. It will take a very determined and strong movement to stop the plans for cold-blooded murder. Underscore 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 underscore. This appeal was circulated nationally among POW/political prisoners for sign-ons. It was then published by various political prisoner support organizations. The urgency is not just because a precious life is at stake, but also because of the implications for political and social movements. Mumia has been a singularly eloquent and effective voice of the voiceless. He has spoken and written powerfully for more than 3,000 persons on death row within the U.S. about the fundamental flaws of the criminal justice system, on the foundations of racism and injustice. We want to encourage the range of activist and social justice groups to make Mumia's case their lead project, their key example, in the coming months. Such a focus would not at all mean abandoning broader politics and programs. Mumia's case can powerfully illustrate the general issues of the death penalty, of POW/PPs, of the criminal justice system, and of racism and injustice. He can personify these crucial concerns and help energize each area of work. We call upon all people who care about life and social justice to mobilize for Mumia. Free Mumia, end the death penalty. 6.7 Direct action for Mumia. 6.7.a. How freedom rang. Matt Meyer, 1999. When actor-activist Ossie Davis proclaimed early this year, "Every generation has its historic task, and ours is to free Mumia Abu-Jamal," he was not simply calling for increased attention to the case of one death row inmate. Mumia, a former member of the Black Panther Party and a distinguished Philadelphia-based journalist, has become an international symbol of much of what is wrong with the U.S. criminal justice system, from unfair courtroom practices disproportionately affecting poor defendants, to imprisonment based upon political beliefs, to racially unequal application of the death penalty. The prison industry, which has begun to overshadow even the military-industrial complex as far as U.S. economic growth priorities are concerned, has only recently received significant attention from peace movement and pacifist groups, despite the grim cycle of violence that the building of jails implies. One recent action, a nationally coordinated civil disobedience held at the Liberty Bell in Philadelphia this past July, saw significant peace movement participation and the seeds of coalition work that could lead not only to a new trial for Mumia, but also to a new linking of issues and organizations calling for justice. July 3, 1999, was 17 years to the day after Mumia's death sentence at the end of a trial deemed grossly unfair by Amnesty International, and one day before President Clinton visited Philadelphia's Independence Mall to award a Freedom Medal to the President of South Korea. That day, 96 activists from across the country, holding banners reading "Freedom Rings for Mumia," shut down the Liberty Bell. In 100-degree heat, on one of the busiest tourist days of the year, protesters from 12 affinity groups representing diverse sectors of progressive thought asserted their conviction that so long as Mumia is on death row, there is no true liberty in Pennsylvania. In nonviolent waves, demonstrators handed out leaflets inside the Liberty Bell Pavilion, unfurled a banner on the pavilion's roof, and formed a semicircle around the bell, blocking its entrance doors, while a legal vigil held across the street shouted words of encouragement and solidarity. One affinity group, which linked Mumia's case to that of Native American political prisoner Leonard Peltier, performed street theater for demonstrators and passers-by. A simultaneous prayer vigil took place in Providence, Rhode Island, at the site of the annual General Synod of the United Church of Christ, a major national Protestant denomination. The vigil, focusing both on Mumia and on the immorality of the death penalty itself, marked a unique moment in church-based coordination with secular civil disobedience campaigns. In San Francisco, 27 additional people were arrested in conjunction with the direct action efforts. Taken together, the demonstrations constituted the largest civil disobedience action against the death penalty in U.S. history. Underscore 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 underscore. This article was published in the Nonviolent Activist, the magazine of the War Resisters League, September/October 1999. Photo credit previous page, Diane Green Lent. Countering a setback. The idea of a national civil disobedience campaign around Mumia's case developed late last year after the Pennsylvania Supreme Court upheld a decision by Judge Albert Sabo, one of the nation's most notorious hanging judges, upholding his own original 1982 trial decision. The setback in Mumia's bid for a new trial, despite substantial evidence of police coercion of witnesses presented at a 1995 post-conviction relief appeal hearing and legal irregularities also noted at that hearing, enraged many long-term Mumia supporters. Emergency demonstrations were organized by the Free Mumia Abu Jamal Coalition, and the New African Liberation Front called for increased militancy, including the possibility of civil disobedience in Mumia's name. At that point, small groups of primarily New York-based activists, including the local Resistance in Brooklyn Affinity Group, began discussing the possibilities of pulling together a broad coalition for civil disobedience, creating a bridge between leaders of the Black liberation movements and Mumia activists on the one hand, and potential Mumia supporters from the peace movement, church organizations, gay and lesbian groups, and anti-death penalty activists on the other. Student organizations, some affiliated with the Hunter College-based Student Liberation Action Movement known as SLAM, were also discussing possible civil disobedience scenarios. Hosted by the War Resisters League and WRL staffer Chris Nee at New York City's Peace Pentagon, SLAM, Resistance in Brooklyn, the New African Liberation Front and others formed a Free Mumia Abu Jamal Coalition Civil Disobedience Subcommittee, which quickly consulted with the International Concerned Family and Friends of Mumia Abu Jamal, the major group coordinating work around Mumia's case. PAM Africa of ICFMJ agreed to cooperate with and assist these efforts, however, because of both heightened police repression against the Philadelphia-based MOVE organization and the International Concerned Family and Friends' own annual call for July 4 demonstrations, the decision was made to keep the July 3 and July 4 coalitions separate and distinct. Thus, a positive model for collaboration and cooperation was developed, and the national call for a civil disobedience action was put forward. The first step in putting together the Civil Disobedience Coalition was to solicit political support from diverse individuals and organizations. From those who had already called for Mumia's release or for a new trial, a list was developed of people who would be willing to risk arrest. Some, such as Columbia University's Dr. Manning Marable, a spokesperson for the Black Radical Congress and the Committees of Correspondence, added their names even though they could not attend the action. Marable wrote about the historic and strategic importance of civil disobedience in his nationally syndicated column, and Ossie Davis did several radio spots on the same topic. Author Julia Wright, daughter of novelist Richard Wright, got arrested at a civil disobedience action for Mumia in Paris 2 weeks before the Philadelphia actions. Folk/rock artist Ani DeFranco, who was scheduled to be on tour at the time of the protests, lent her name and gave a generous contribution for possible bail costs for those arrested. Organizations not directly connected to Mumia or death penalty work, but with substantial civil disobedience experience, like the Committee in Solidarity with the People of El Salvador and the AIDS Coalition to Unleash Power, also joined the coalition at this time, along with activists from the Green Party, Women for Justice, Westchester People's Action Coalition and the Cairo/Catholic Workers/Plowshares Movement. Ron Daniels, director of the Center for Constitutional Rights, agreed to speak at the legal rally, and Rev. Lucius Walker, director of the Interreligious Foundation for Community Organization, just back from leading a Pastors for Peace delegation to Cuba, agreed to be in the lead group blocking the Liberty Bell. With initial endorsements in place, the task of building a working coalition began. As in all coalition work, an array of ideological perspectives had to be included, and representatives of most of the left's political parties, from communist to anarchist, ended up taking part and playing some role in the action. The central coordination, however, came not from the national parties but from grassroots activists with their own philosophical and tactical differences. "I've never given myself voluntarily to the police," noted Zayed Muhammad, a new African Liberation Front member and founder of Frontline Artists. Although coming more from the tradition of Malcolm X than Martin Luther King, Muhammad nonetheless organized a full nonviolence training to prepare for July 3rd in his home base in Newark, New Jersey. He concluded, "If this is what folks are doing to raise the stakes for Mumia, then we have got to participate." Militants vs. militarism. On the other hand, said longtime Cairo/Plowshares activist Dr. Anna Brown, many within the pacifist movement have felt that the rhetoric at recent demonstrations for Mumia has gotten dangerously militaristic. Brown, a professor at New Jersey's St. Peter's College and a leader of academics for Mumia Abu Jamal, added, "But this moment is crucial for all justice-loving people to come together, both to take a principled stand against the violence of state-sanctioned murder, as well as to stand in solidarity with our brethren in the Black liberation movement, especially those such as Mumia, who have spoken out so eloquently despite decades of repression." The nonviolence trainings, always a crucial element of building for any successful civil disobedience, also provided key opportunities for discussing the role of nonviolence and militants, between people not often in contact with one another. Each of the pre-action trainings took on a different character based on the participants involved. As the trainings took place, the need to allocate a full day of time and to schedule frequent small group discussions became clear to the CD organizers. Civil disobedience coordinator Meg Starr of Resistance in Brooklyn reflected, "Even many of those leading the trainings had not done so for some years, and an intensive effort was made to ensure that the coalition nature of the event be reflected in the team of trainers." Despite some moments of confusion, participants did get practice in working together, in making quick and disciplined affinity group-based decisions, in building for nonviolent civil disobedience. Commented War Resisters International Chair Joanne Sheehan, who conducted one pre-action training with both Brown and former Black Panther political prisoner Ashanti Alston, "We carried the banner together, coming from different places and politics, but working together for the same goals." One controversial issue, raised squarely at several trainings but not fully resolved there, was the nature of affinity groups' relations to the police. The agreed-upon guidelines for the action, modified from WRL's guidelines for the 1998 Day Without the Pentagon, required that participants act with dignity toward but not necessarily respect for the authorities who would be handling them. And though there was clear agreement that no violent provocation would be allowed, the gray areas of what constituted verbal abuse led to some important, fascinating and sometimes difficult discussions. To avoid alienating any constituency and because many potential participants were coming from communities under constant police attack, coalition leaders decided that affinity groups should be able to exercise autonomy regarding the slogans or banners they wanted to carry, as long as both fit the broad guidelines. Did, then, calling the police pigs as the Black Panthers often do violate the guidelines regarding verbal confrontation? Debates took place regarding political appropriateness, the difference between singling out an individual cop versus critiquing the overall system of policing, and questions of safety and de-escalation. Ultimately, one affinity group from an organization that has always chanted Panther slogans decided, after many of its members attended a nonviolence training, not use the word pig in its chants on July 3rd. This spirit of real dialogue and a commitment to coalition consciousness is part of what made the day so powerful. In hindsight, perhaps the guidelines from the coordinators could have been sharper or spelled out more clearly, but the openness and commitment to autonomy undoubtedly allowed the greatest number of participants to feel empowered by, and part of, the process that made the action possible. Singing in the cells. When July 3rd came, the good feelings carried on well after the protesters were carried off, with singing and discussions continuing in the federal holding cells. Media work also continued, with coordinator John Riley of ACT UP sending audio, video, and still photo clips to news agencies well into the night. Ultimately, the story of the action was carried around the world, from a color photo of the action on the cover of Sunday's Philadelphia Inquirer, to articles in Italy's daily newspapers, to an Associated Press piece published in Puerto Rico. There was mention on every local television station as well as on CBS TV and Radio News, BBC Radio, and National Pacifica Stories, New York's Daily Challenge, a newspaper reporting on events relating to the African American community, gave the story 2 days of full coverage with numerous color photos, terming the action a Force of July. Philadelphia activist Marie Bloom noted that the action garnered some of the best coverage ever for a Mumia demonstration. All 95 protesters, including a woman in a wheelchair from California who single-handedly blocked the doors to the Liberty Bell long after most demonstrators had been carted away, were ticketed out of detention within 10 hours, having already called for a follow-up meeting based on conversations in the cells. The high spirit of resistance was exemplified by coordinator Kai Lumumba Barrow of SLAM who, after being admonished by the federal judge not to return to the Liberty Bell and to go in peace, responded firmly with the call, "Free Mumia. Tomorrow will be too late." The power of the July 3rd action lay not in any major celebrity participation, nor any major funding or national staff effort, but in the strength of genuine local organizing, linking issues and a willingness of people to truly listen to one another. Civil disobedience, in this instance, was used as a catalyst to build bridges and movements. Contrary to a sectarian but all too common notion, civil disobedience can be used to both raise the stakes and broaden the work. A young woman from Refuse and Resist, who did not get arrested but was part of the legal support vigil, reported to her organization that July 3rd was a once-in-a-lifetime experience. Everyone was so emotional, intensive, and supportive. Everyone in the movement was supporting each other regardless of factions, which is new. South African poet laureate and former political prisoner Dennis Brutus, inspired by this spirit, has called for an ongoing campaign of civil disobedience against the death penalty and for Mumia's release. In struggling for justice, Brutus remarked, "We are discovering that our voices are not heard, our efforts are ignored, and in fact what is confronting us is injustice. We have to take this matter to the streets for the court of the people to judge." Brutus is part of building for new national civil disobedience actions, to take place sometime in late October and November. This fall, in fact, is a crucial period in Mumia's legal efforts. Under constant threat of a renewal of Mumia's death warrant, his lawyers are awaiting a Supreme Court ruling on the appeal of the previous Pennsylvania court's decision. Both the Supreme Court case and another federal procedure based on one of Mumia's motions are expected to be heard as early as October, with the ultimate appeal process after that lasting only several months. History suggests that the judicial system does, in fact, respond to political pressures and also that political executions, such as those of Sacco and Vanzetti or Julius and Ethel Rosenberg, do take a great toll on the entire progressive movement. Thus, we now face a historic opportunity. Now is the time to take the words of Puerto Rican leader Rafael Cancel Miranda to heart. "Our silence would be complicity," he said, in a special message sent to the July 3rd action. "Let us fight for Mumia today because tomorrow may be too late for all of us. By fighting for Mumia, we are fighting for ourselves. All of us are on death row with him. Mumia is everyone who cares for one another, Mumia is all of us. Stay strong and united. We are but one people. Together we are powerful." 6.7.b. Why we are demonstrating at the Liberty Bell. Ad hoc Coalition for the Liberty Bell Action 1999. Let Freedom Ring for Mumia Abu Jamal. New trial for Mumia. Medical care for Mumia and all death row inmates. Free Mumia. Many come to Philadelphia on the July 4th weekend to visit the Liberty Bell. This is an affirmation of essential values like liberty, justice, and freedom. We share these values, as do most people in the United States. We are demonstrating here today to affirm, but even more to deepen our commitment to liberty, justice, and freedom in this country. We insist that these ideas must become more than mere words on paper. They must be put into practice. Today prisons incarcerate more people than ever before in our nation's history. The U.S. prison population is the highest, per capita, in the world. Many have been jailed simply because they could not afford a proper legal defense, or because as people of color they faced a racist court system. For these, and others unjustly imprisoned, the promise of freedom and liberty in the United States is a hollow fraud. We therefore choose the symbol as an appropriate location for us to call attention to that fraud and, in particular, to point out the plight of an award-winning journalist who has now been on death row for 17 years as a result of a completely unjust trial, for a crime that growing numbers around the world are convinced he did not commit, Mumia Abu Jamal. Mumia was convicted in 1982 for the killing of a Philadelphia police officer and sentenced to death. He faced a racist judge, Albert Sabo, who holds the U.S. record for death sentences handed down, and in whose court no defendant could get a fair trial. Mumia had no money to hire crucial experts to investigate on his behalf and testify in court. An incompetent attorney was forced upon him, and he was denied the right to represent himself. It has now been well documented that the pretrial investigation and the trial itself were rife with improper actions by the police, prosecuting attorney, and judge. Tens of thousands of people have protested worldwide demanding a new trial for Mumia, including such figures as the former First Lady of France, Danielle Mitterrand, and that country's current president Jacques Chirac, Nelson Mandela of South Africa, along with Hollywood celebrities like Ed Asner and Mike Farrell. Underscore 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 underscore. This was the flyer distributed in Philadelphia on July 3, 1999, to accompany the rally and civil disobedience action at the Liberty Bell. The European Parliament passed a resolution last year demanding a review of the case and a new trial for Mumia. Dozens of unions have also endorsed the same call, including the International Longshore and Warehouse Union, which organized a one-day work stoppage in support of Mumia along the entire west coast of the U.S. on April 24, 1999. Despite all of the facts and protests, in October last year Mumia's conviction was upheld by the Pennsylvania Supreme Court. His appeal for a new trial is now before the federal courts. However, legislation passed by Congress in 1996 means that it is possible, even likely, the federal courts will simply rubber stamp decisions made at the state level, without ever undertaking an independent review of the facts in this case. We cannot allow this to happen. We therefore take this nonviolent, militant action to demand, let freedom ring for Mumia Abu Jamal. We hereby express our outrage at what has been done to Mumia and to all the other death row inmates who find themselves trapped in a legal quagmire, where the word justice has lost all meaning. Join us. We are here today and tomorrow beginning at 9 a.m. Credit, Diane Green-Lent. An urgent message from Dennis Brutus and friends. February 2000. We join together at this crucial moment to alert you to an important action that will send a strong message to the decision-makers in Washington, D.C. On Monday, February 28, a legal demonstration and a nonviolent act of civil disobedience will take place at the steps of the U.S. Supreme Court, at 9:30 a.m. These actions will be preceded by an interfaith prayer service across the street at the Chapel of the United Methodist Building, 100 Maryland Avenue / at 9 a.m. The focus of these acts will be our unconditional opposition to the death penalty, and our particular concern for the case of journalist Mumia Abu Jamal. The many irregularities in Abu Jamal's case, unfortunately typical in so many death penalty cases, necessitate our call for a new trial even as Pennsylvania's governor and police associations increase their pressure to put an end to Abu Jamal's life. The recent moratorium on executions called by Governor Ryan of Illinois must only strengthen our efforts. February 28 is a significant day for our cause, in part because the case of Williams v. Taylor is being reviewed by the High Court. This case, coming about in reaction to the Effective Death Penalty Act, could strip the federal government of its ability to hold fact-finding hearings in the cases of inmates who failed to develop successful habeas corpus briefs on the state level. As the Supreme Court conducts its session, we must stand up for those whose lives are on the line, and make our voices heard as we cry out for justice. Some of us will be praying that morning, others speaking at the legal rally, others of us risking arrest in a nonviolent sit-in on the steps of the court, and some of us doing all three. We ask that you join us in spirit and in person to help build our movement and let freedom ring in peace. Dennis Brutus, South African poet and former Robben Island political prisoner. Jennifer Harberry, attorney, activist, author of Bridge of Courage. Stephen Hawkins, director, National Coalition in Abolish the Death Penalty. Rev. Nozomi Ikutu, president, National Interreligious Task Force on Criminal Justice. Sam Jordan, Death Penalty Coordinator, Amnesty International USA. Dr. Manning Marable, Professor, Columbia University, Black Radical Congress. Bishop Walter Sullivan, President, Pax Christi USA. Rev. S. Michael Yasutake, Director, Interfaith Prisoners of Conscience Project. For IATA formation on February 28, DC Logistics, on pre-action nonviolence trainings, or to make a contribution, contact, mumiact@hotmail.com, 202-722-4783, 914-353-5032. 6.7.c. Face reality. Mumia is one of over 100 political prisoners in the USA. Resistance in Brooklyn 2000. Though the U.S. government has always denied it, there are well over 100 political prisoners held across the country. Mumia Abu Jamal, whose case has catapulted the racist nature of the U.S. criminal justice system and of the death penalty itself to a position of international concern, has always linked his own struggle to that of the other U.S. political prisoners. It's time for the movement to do the same. Today, as we face the steps of the highest court in the land, Resistance in Brooklyn Affinity Group members will don the masks of heroes and heroes, whose faces represent a history of repression and resistance. These faces from past and present, jailed and free, and from a variety of movements are meant to remind us to face reality: all U.S. political prisoners must be free. U.S. political prisoners and repression of our movements. The majority of political prisoners today come out of the movements of the 1960s and 1970s. At that time, as the civil rights movement and liberation struggles threatened the status quo in America, the FBI developed a program called COINTELPRO. COINTELPRO's mission was to destroy liberation struggles and eliminate political opposition in the U.S. Methods of disruption included surveillance, infiltration, intimidation, harassment, violence, and even murder. The government's counterintelligence program actively harassed, framed, and murdered political activists, resulting in incarceration or death. In 1971, COINTELPRO was exposed to the public, and Congress slapped the FBI on the wrist. However, no reparation was awarded to any of the victims of COINTELPRO, and many of them continue to sit in prison after more than 2 decades framed on charges of crimes they did not commit. The government continues its own criminal activities, though COINTELPRO, in name, has been shut down. Similar government campaigns of disruption, intimidation, and infiltration attempt to target radical movements today. The drive to execute Mumia is only the most drastic example of U.S. intentions to silence us. Underscore 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 underscore. Though RNB helped initiate and organize the Supreme Court direct action for Mumia, we also maintained an independent affinity group presence at the demonstration. As some chose to highlight Mumia as part of the larger anti-death penalty movement, RNB linked Mumia's cause to that of all the U.S. political prisoners currently and through history. With placards and poster board images of Leonard Peltier, Marilyn Buck, Assata Shakur, Rev. Martin Luther King, Jr., Abbie Hoffman, and many others, we handed out this flyer to help make the connections. Today, the masks we wear represent the following faces of resistance. Mumia Abu-Jamal, death row journalist, former Black Panther Party leader. Anna Mapektu Akwash, American Indian movement activist, killed as a result of an FBI COINTELPRO smear campaign. John Brown, militant abolitionist, hanged by the state on December 2, 1859, but his spirit lives on in this 200th anniversary year of his birth. Marilyn Buck, current anti-imperialist political prisoner, anti-racist ally of the Black Liberation Movement. Standing Deer, current Native American political prisoner. Abbie Hoffman, peace activist and former prisoner of conscience, hounded by FBI COINTELPRO sting operations throughout the 1960s and 70s. Martin Luther King, Jr., civil rights leader, target of one of the FBI's most extensive red-baiting efforts. Oscar Lopez Rivera, current Puerto Rican prisoner of war. Assata Shakur, leader of the Black Liberation Army, former political prisoner, and FBI's most wanted, escaped and now in exile in Cuba. Alejandrina Torres, recently released Puerto Rican political prisoner, granted clemency after close to 20 years of intensive amnesty campaigning. Bartolomeo Vanzetti, Italian anarchist and labor activist, executed by electric chair in 1927, never again. 6.7.d. Supreme Court and Weekend Actions United Press Release. Free Mumia Abu-Jamal Coalition 2000. For immediate release, 185 arrested at U.S. Supreme Court as it hears landmark death penalty case. 348 arrests nationwide. Activists demand new trial for death row journalist Mumia Abu-Jamal and abolition of the death penalty. Washington, D.C. Grant a new trial/abolish the death penalty was the call Monday morning at 10 a.m. February 28 as 185 people, including former South African political prisoner Dennis Brutus and Jennifer Harberry, lawyer and widow of a slain Guatemalan resistance leader, were arrested during a dramatic, nonviolent civil disobedience action at the U.S. Supreme Court. This action and its companion support vigil called for a new trial for award-winning journalist and death row inmate Mumia Abu-Jamal. The 3,000-strong demonstration also demanded abolition of capital punishment in the U.S. All of the arrested protesters were charged with unlawful conduct and impeding traffic on the Supreme Court grounds. Rev. Nozomi Akuta, President of the National Interreligious Task Force on Criminal Justice, and Rev. Michael Yasutake, an officer of the National Council of Churches Racial Justice Working Group, were also arrested. The CD and companion vigil brought together renowned labor leaders, religious figures, entertainers, human rights activists and academicians. Among human rights leaders speaking at the support vigil were Sam Jordan, director of Amnesty International's program to abolish the death penalty, Stephen Hawkins, executive director of the National Coalition to Abolish the Death Penalty, and Pam Africa, director of International Concerned Family and Friends of Mumia Abu-Jamal. At a simultaneous demonstration in San Francisco, 163 people were arrested for blocking the front entrances of the U.S. Court of Appeals. The arrest total for the day was 348 for the two civil disobedience demonstrations. Demonstrations were also slated for Los Angeles, Toronto, and other cities in the U.S. and Canada. As people were arrested outside, the U.S. Supreme Court was considering Williams v. Taylor, a landmark case challenging restrictions to habeas corpus law by the 1996 Anti-Terrorism and Effective Death Penalty Act. This decision will greatly impact Mumia's case because it will set the boundaries for federal judges. Either they will be able to conduct independent reviews of state cases, or they are going to be severely restricted in independent reviews in what they do, said Abu Jamal's lead attorney Leonard Weinglass. What Williams is about is whether or not federal judges have to accept the findings of state court judges, or whether or not they are independent. Habeas corpus is our most valued human right. Underscore 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 underscore. This press release was distributed shortly after the Supreme Court civil disobedience action on February 28, 2000. Mumia Abu Jamal's case has shone an international spotlight on the arbitrary use of the death penalty in the U.S. On January 31, Illinois Republican Governor George Ryan instituted a temporary halt to executions in his state after 13 Illinois death row inmates were found innocent. 2 weeks later, on February 10, the Philadelphia City Council joined many other municipalities nationwide in passing a resolution calling for a moratorium on their state's executions. And on February 22, the Judiciary Committee of Pennsylvania Senate held hearings on Senate Bill 952, which calls for a 2-year moratorium on executions in Pennsylvania. At present, Pennsylvania Federal District Judge William Yohn is reviewing Abu Jamal's petition for habeas corpus to overturn his conviction based on 29 constitutional violations during the initial trial. Noting that this celebrated author has thus far failed in the courts, educator Herman Ferguson, co-chair of the New York-based Free Mumia Abu Jamal Coalition, said, "Civil disobedience is as American as apple pie, from the Boston Tea Party to the labor movement, from the civil rights sit-ins, anti-war and anti-nuclear activism, right up to the recent police brutality protests. Civil disobedience has always shown the people's willingness to prevail against injustice." Today's actions followed a July 3, 1999, action at the Liberty Bell and a simultaneous one in San Francisco where 122 people were arrested. That was the first action of a civil disobedience campaign that organizers plan to continue until Mr. Abu Jamal gets a new trial. The cumulative arrest total for the two actions is 470. The demonstration was organized by the Free Mumia Abu Jamal Coalition and the February 28 Coalition for Mumia. In October 1998, Pennsylvania Supreme Court denied Mumia's bid for a new trial, upholding the original trial judge's ruling. The journalist, MOVE supporter, and former member of the Black Panther Party, was convicted in 1981 of the shooting death of a Philadelphia police officer in a trial tainted by the flagrant bias of that judge, the deliberate exclusion of 11 black jurors and a court-appointed lawyer who, by his own admission, was inexperienced in criminal law. In addition, witnesses came forward during the 1995 post-conviction relief appeal hearing saying they were coerced by police to lie, suppress, or change their initial account of the December 9, 1981, incident. 6.8. Worldwide solidarity with Mumia. Suzanne Ross 2008. The international component of the Free Mumia movement has been strategic in exerting political pressure. Its activity peaked in 1995 and 1999, when death warrants for Mumia were signed, with highly publicized demonstrations in Europe, Asia, Latin America, and South Africa, and official government statements in France, Germany, Japan, and Cuba. There were also delegations from France, Japan, Germany, Spain/Catalonia, Denmark, and Egypt who came to attend court hearings, visit Mumia, meet with government officials, participate in events, or join street demonstrations. Some of the international visitors to Mumia were Danielle Mitterrand, wife of the former French president, numerous French mayors, French Communist Party officials, Julia Wright, daughter of author Richard Wright, and Mireille Mendès France, daughter of Frantz Fanon, and most recently the Archbishop Desmond Tutu. In 1995, the African National Congress and President Nelson Mandela urged Governor Tom Ridge to grant Mumia a new trial, while the Congress of South African Trade Unions requested clemency. Within days of the signing of the warrant, there were protest actions in London, Berlin, Paris, Frankfurt, Amsterdam, Tokyo, Toronto, and Vancouver. A year later, in a meeting of church leaders in Guatemala, 51 of them, including 4 Catholic bishops, formally joined the international campaign for a civil rights investigation. The Zapatista National Front called for a stop to the execution, Amnesty International demanded a new and fair trial, members of Workers' Russia called for commutation of the death sentence, and unions in Britain, Australia, the French Confédération Générale du Travail, the Metro Toronto Labour Council, the Vancouver Public Employees, Section 10 of the Mexican Teachers Union, and the Brazil National Confederation of Educational Workers all gave support to Mumia. Demonstrations in Europe and Latin America continued. In 2001, at the World Conference Against Racism in Durban, South Africa, support was again expressed for Mumia. As late as April 2008, when there was an angry protest in Philadelphia against the Third Circuit Court of Appeal's rejection of Mumia's appeal for a new trial, demonstrations were reported in Mexico City, London, Dublin, Vienna, Paris, and St. Denis, and on July 4, there were die-ins in Marseille and Paris. The French support has been particularly notable because the grassroots work never stopped. Weekly vigils at the U.S. consulate in Paris were started by Julia Wright and Catherine Grupper in 1995. The focus was on Mumia embodying the arbitrary nature of the U.S. death penalty and grew to include all political prisoners, particularly Leonard Peltier. That same year, the Unified Collective to Save Mumia was formed. It continues its work to this day. Smaller solidarity groups were created throughout France. About 20 Communist Party-led suburbs surrounding Paris, with working-class and primarily African immigrant populations, presented honorary citizenship to Mumia, Bobigny and its famous late mayor being the most well-known. Marseille, in southern France, began a yearly street naming in honor of Mumia, which though not official because of the right-wing mayor's opposition, involves putting up the Mumia Street sign across the street from the U.S. consulate. It was partly these smaller solidarity actions that led to the 2 big French events, the granting of honorary citizenship of Paris to Mumia in 2004 and the naming of a newly built street in the largely immigrant, working-class city of St. Denis in 2006. Approached by the Unified Collective, the socialist mayor of Paris agreed to grant Mumia honorary citizenship, the first such awarding since 1971 when Pablo Picasso was its recipient. At a very prestigious event at City Hall in 2004, with international concerned family and friends of Mumia Abu Jamal's PAM Africa and Free Mumia Abu Jamal Coalition Suzanne Ross present, Angela Davis accepted the award on behalf of Mumia. Hundreds were present, including many African immigrants and expatriate Black Americans, who were very eager to meet with both PAM Africa and Angela Davis. In 2006, after much preparation, the mayor and other officials of St. Denis, a town adjacent to Paris, worked with the St. Denis Mumia Committee to name a street in Mumia's honor. This modest street on Human Rights Square was named with fanfare, linking it to the Spanish Civil War, the South African liberation struggle, and other anti-fascist struggles. Young Mumia supporters followed with an international arts festival of music, dance, and food cooked by African immigrant women. U.S. activists, led by Pam and Ramona Africa, attended. Despite the ensuing blistering denunciations from 4 U.S. legislative bodies, St. Denis refused to back down, stood strong, and had an anniversary celebration with city officials, and another U.S. delegation, a year later. 6.8.A. Conscious of his own destiny. Angela Y. Davis 2004. The movement for the liberation of Mumia Abu Jamal, who has been on death row for more than 20 years, has taken on new meaning in light of American unilateralism, the aggression against the Iraqi people, and the racist attacks against immigrants, all of which merely erode even further the vestiges of democracy in America. Mumia was our guide and showed us the best possible way to mourn the victims of September 11, a mourning not stamped with nationalism, xenophobia, and violence, but rather with a spirit of peace and worldwide solidarity. Mumia showed us how to denounce the war and the state-supported violence which is the complement to the epidemic of violence done to the bodies of women. In my opinion, What has touched us the most in Mumia Abu Jamal is his profound sense of humanity, the fact that he is conscious that his own destiny is tied to that of thousands of men and women who are in death row in the United States and around the world. Underscore 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 underscore. Mumia Abu Jamal was made an honorary citizen of Paris in October 2004. Bertrand Delanoue, socialist mayor of Paris, praised the occasion as the first of its kind since 1971, when Pablo Picasso received the honor. Delanoue added his denunciation of this barbarity called the death penalty. Angela Davis attended the ceremony on Mumia's behalf. Speaking in French, she made these remarks in her speech. 6.8.b. Regarding U.S. resolutions condemning the naming of a street for Mumia Abu Jamal by the French city of Saint-Denis. Patrick Broizek 2006. Concerning Resolution 407, introduced by persons close to the FOP, I first want to say that I condemn the murder of the police officer. I believe that everyone must condemn this act. That is clear. This draft resolution claims that the murder was undoubtedly committed by Mumia. But everybody knows that the point of naming a street in Saint-Denis in honor of Mumia Abu Jamal is to underscore the fact that Mumia has always maintained his innocence and has always demanded a fair trial. These are entirely two different matters. Condemning the murder of a police officer is one thing, but the absence of a fair trial for Mumia is an entirely different matter. Finally, it seems outrageous to me demands that the French government force the city of Saint-Denis to reverse its decision. Cities in France have the right to name streets in honor of individuals. We have experienced in our recent history many unamings linked to political change. It is true that in choosing the name of Mumia Abu Jamal we made a choice, a political choice, a choice aimed to show that we stand at his side in the struggle he is waging to obtain legal recognition of his innocence, and we proclaim our choice for all to hear. In the same manner, a few years ago, we named a street for Bobby Sands, who had resisted the British occupation of Ireland. We have also named other streets in honor of other resistors, other individuals who fought unconditionally against the bullying established orders that refused to acknowledge injustice. One last thing concerning the proposed resolution's third paragraph, commending all American and police officers worldwide, I must tell you that, while I recognize the role played by the police today, under certain circumstances, I am not willing to consider all police officers of equal valor whether those officers are American or hail from other parts of this planet. Because I know for a fact that many of them do not act in the constitutional way we would expect of them under all circumstances, especially as far as minorities are concerned. This is so whether we are speaking about the United States or certain other countries where the police abuse their power and do not play the role we expect of them as custodians of the equal treatment of all citizens. So let us not put the entire police force in the same basket. Statements such as those made in the proposed resolution regarding police forces as a whole constitute a false generalization, since it holds these police forces immune from any suggestion that they are capable of breaking or abusing rules. Concerning the current situation confronting PAM Africa and the movement in Philadelphia, I have two reactions. First, when one is reduced to resorting to fear, to imposing the law of silence, it means that somehow there is a degree of uneasiness, somehow there is a lack of confidence, somehow there are those who are afraid of the final verdict of truth. So my first reaction is that when a group of individuals tries to impose the law of silence in this way, it means that the final truth is not what we are led to think, nor is it what is made to appear as such. And my second reaction is to say that one should definitely not allow oneself to be intimidated. Beyond the struggle Mumia is waging to gain recognition of his innocence, he is also waging another struggle to abolish the death penalty, and this struggle should be waged by all Democrats worldwide. Also, it is obvious that by exerting this type of pressure, very strong, almost physical pressure, a certain number of police unions, not to mention right-wing or extreme right-wing unions, are intimidating all those who are waging a struggle today against the death penalty, whether it be in the United States or in other countries. This struggle against the death penalty is a vital one. In my opinion, it is not permissible to play games with the lives of people. There are too many examples in the world, and first and foremost in the United States, of people who were sentenced unjustly. Sometimes they have been condemned to death or to very heavy prison sentences while proof of their innocence is established either after execution or after they have spent a great many years in prison. So we must not allow ourselves to be intimidated by these types of actions but rather recognize that the show of pressure is more a form of weakness than a demonstration of force. As far as raising the FOP's proposed resolution in the French National Assembly, I believe that we must work on some type of action at that level. I do not know at this stage whether it can be a current events issue like the ones we raise every week, which take the form of a written question to the government. It is necessary that we elected representatives initiate action against the death penalty at both the national and other levels. I am speaking also of those who, as elected representatives, support Mumia in his struggle, for example, by adopting him as honorary citizen or conferring other tokens of support. I believe that all these people should raise the issue with the French government in a very direct manner, including a request that our government should react explicitly even if in the end the American government does not challenge the French government in response to the proposed draft resolution that some are attempting to introduce today. But this would be an opportunity for the French government to take a clear-cut position concerning this affair and cut through any ambiguity there might be. So I am completely in favor of raising the issue in one form or another through the voices of a certain number of elected representatives, deputies, mayors, or municipal councillors, because there is also within cities governed by the political opposition a great deal of political mobilization for the defense of Mumia. I think raising the issue at government level today would be useful. Concerning the question from a youth as to whether we should take orders from American capitalism, I say no. I take orders from no capitalist even if we are compelled to accept capitalism as part of our lives, even if we have to make accommodation at this juncture with the situation it creates. We know perfectly well that we are living in a capitalist system, but the issue is much larger than the American capitalist order. I believe that there are American Democrats, as well as Democrats throughout the world, who fail to question capitalism but who nonetheless adhere to certain human rights, and that, even in the absence of challenging capitalism, there are still many citizens in the world who are probably against the death penalty and consider that Mumia Abu-Jamal has the right to an honest trial. As far as our media notoriety in the US is concerned, as mayors who named a street in honor of Mumia Abu-Jamal, our only objective as far as any media interest is concerned is to enhance the fairness of our claim. What is our claim today? We are among the many people who simply ask that Mumia be granted a new trial so that the evidence of his innocence can be heard. That is all we ask, and I think that all the exposure we can obtain in the media should establish the claim concerning this issue. So let us make efficient use of the mics or cameras that seek us out to validate our claim. My thoughts are very much today with Mumia Abu-Jamal and the situation that entraps him. I am currently reading the most recent book by Michael Connolly, The Lincoln Trial, which exposes all the blemishes, all the abuse at the core of America's legal procedures, including the ways a trial can be manipulated. And we are made to see that it is money that fuels the neurological system of American justice, and that is a fact we can only condemn. If our statements, my statements, are known throughout a number of radio stations and their networks, so much the better. I think it is useful for Mumia, useful for the issue of abolition, useful for the totality of democracy, whether it be in the United States or other countries that call themselves democracies today but are really undemocratic. 6.8.c. South African Robben Island press release. Dennis Brutus 2000. South African Archbishop calls for new trial for U.S. prisoner Mumia Abu-Jamal on Freedom Day, Robben Island service to focus on death row prisoner and human rights. An interfaith church service on Robben Island, South Africa on April 26 will focus on the escalating call for a halt to the execution of Philadelphian death row prisoner Mumia Abu-Jamal and on a global need to commit to restorative justice. Robben Island, the internationally infamous former high-security island prison, has been converted into a symbol of justice and peaceful transitions and includes a museum and a newly renovated chapel. The Church of the Good Shepherd is administered by the Anglican Church of Southern Africa, whose presiding archbishop has recently joined the campaign for a new trial for Abu Jamal. Underscore 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 underscore. Following Dennis Brutus's participation in the Liberty Bell and Supreme Court actions, he was eager to bring the message of Mumia's plight to his native South Africa. At this time, the infamous South African prison fortress, Robben Island, was being converted into a pubic museum. Robben Island was the site that held Brutus, along with Nelson Mandela and scores of other anti-apartheid prisoners, as well as Mohandas Gandhi. In conjunction with the South African Anglican Archdiocese, and with the U.S.-based Art Against Death, a showing of artwork by U.S. political prisoners accompanied a press conference on Mumia at a special opening on the island. The service will coincide with the opening of a poster exhibition of art dedicated to Abu Jamal. The aim of this show, which is traveling to galleries throughout South Africa, Europe, and the U.S.A, is to escalate international pressure for a retrial. Announcing the service and the art show, Anglican Archbishop Njongonkulu Ndugana said it had been organized in association with Amnesty International, at the request of South African poet laureate and former political prisoner Professor Dennis Brutus and recently released U.S. political prisoner Laura Whitehorn. Very serious questions have arisen about Abu Jamal's trial and the evidence used against him. A February 2000 Amnesty International report raised concerns about Abu Jamal's initial inadequate legal representation, about the fairness of the trial judge, and about the politicization of the judicial process and possible bias of appeal courts in Mumia's case. Known as the voice of the voiceless, Abu Jamal has been a leading critic of police violence against minority communities in Philadelphia. He was convicted of killing a white police officer, and sentenced to death. He has written extensively from his jail cell against the wars in Iraq, Kosovo, and Colombia, and also about the racism of the American judicial system. The Archbishop, who is the keynote speaker, said that the matter was of grave concern because South Africa, which had set an example to the rest of the world with its commitment to restorative justice, is in dire danger of shifting towards retributive justice. We in South Africa look in horror and great sadness at the United States, stated Archbishop Ndugana, which historically has made tremendous contributions towards the achievement of universal human rights, yet where 27 states now apply the death penalty. Apartheid South Africa applied the death penalty. The culture of violence that still grips South Africa is without doubt a consequence of the apartheid era, and its depraved contempt for other human beings. From that experience, we have learned of the brutalization of society which results when the state resorts to killing as a deterrent to killing. In noting particular concern regarding the case of Abu Jamal, the Archbishop continued, "We remind our friends in the United States that Nelson Mandela and many other South Africans were saved from the gallows only because of the outrage expressed during the 1960s by the international community. Here on Robben Island we remember the brutality of the past, and commit ourselves that never, never again will such acts of inhumanity be repeated." During the apartheid era, both Ndugana and Dennis Brutus served time as political prisoners on Robben Island, along with former South African President Mandela. The service begins at 10 a.m., and the participants include Methodist Bishop James Gribble, Professor Brutus, and Judge Dennis Davis. Prayers will be led by Guru Krishna, and Imam Rashid Omar and Peter John Pearson, of the Roman Catholic Parliamentary Office, will read from the Quran and from the Bible. An Amnesty International candle will be lit by former political prisoners who had been held on Robben Island. April 27 marks Freedom Day in South Africa, a national holiday commemorating the transition to democratic rule. At that time, the poster exhibition, taken in part from a collection of the Los Angeles-based Center for the Study of Political Graphics, will open at Cape Town St. George's Cathedral. In addition, prominent U.S. artists Leon Golub and Nancy Sparrow have contributed works to the show, as have Art Against Apartheid founder Cliff Joseph and former prisoner Laura Whitehorn. In a statement by Golub and Sparrow accompanying their work, they comment, Mumia is symbolic of the innumerable situations where justice has been denied. When one such imprisoned individual is brought to international light, perhaps that helps ignite local and world attention to so many nameless prisoners in so many different countries. The fight for Mumia is a fight for all such prisoners, that essential vigilance that freedom demands. The show, Robben Island ceremony, and Freedom Day activities come at a crucial time in Mumia Abu Jamal's proceedings. It is expected that an announcement from Federal District Court Judge Yoon could come at any time, possibly summoning Abu Jamal into court in Philadelphia for the first time in many years. These efforts coincide with an appeal from U.S. political prisoners to intensify work around Abu Jamal's case. 6.9. Confronting the NAACP. Suzanne Ross 2008. 2 years of grassroots struggle to get the NAACP to take a pro-Mumia position, focused on its highly publicized annual July national conventions, preceded the passing of this resolution. In 2003, at the Miami Convention, Sundiata Siddiq, former president of the Ossining NAACP chapter, made his first attempt to pass such a resolution. The proposed resolution was informally approved but later squashed by Ben Andrews, National Resolutions Chairman, and Hazel Dukes, leader of the New York State NAACP, and others in national leadership. In 2004, the Ossining chapter once again tried to have the resolution raised at the National Convention, scheduled that year for Philadelphia. Activists insisted that the NAACP could not ignore Mumia in the city where he was framed and sentenced to death and where the MOVE organization was bombed and members were murdered. With media and heavy security present on the first day of the convention, activists held a rally in front of the convention hotel and distributed flyers to all who entered. Having announced in advance that they would attend the death penalty workshop, which ICFMJ Pam Africa was promised she could attend, the activists now protested the NAACP's cancellation of that workshop, explained the significance of Mumia's case, and asked for support in passing the resolution. On the day presidential nominee John Kerry was addressing the convention, Mumia activists returned for the third time and insisted that they would be peacefully protesting the NAACP's refusal to budge. With a letter of rebuke to Julian Bond from the son of legendary NAACP founder, W.E.B. Du Bois, support from Mayor John Street, and members of the more progressive chapters, the resolution crafted by the NAACP with Max Bill Bachmann, was passed just hours after Kerry spoke, with only one dissent. Word spread around the world of this victory, and Mumia thanked the organization. Unfortunately, the NAACP has done nothing since that day to implement this resolution, and within a short time of its passing, the Ossining chapter that initiated the struggle was suspended indefinitely from the organization and continues to be suspended to this day, despite endless unfulfilled promises of reinstatement. Still, the resolution stands as an example to other organizations and remains as a basis for challenging the NAACP again. Aluta continua. 6.9.a. Emergency resolution reaffirming opposition to the death penalty. National Association for the Advancement of Colored People 2004. Whereas the NAACP adopted a resolution in 2001 reaffirming our opposition to the death penalty due to its racially disparate application, and whereas the NAACP has reaffirmed its 1975 resolution opposing the death penalty on the grounds that it constitutes cruel and unusual punishment in violation of the Eighth Amendment of the United States Constitution, and whereas many people, including Mumia Abu Jamal, are incarcerated on death row and face possible execution, and whereas more than 320 people on death row have been exonerated, and whereas though African Americans make up only 12.4% of the U.S. population, we make up 38% of all the Americans that were sentenced to death and later freed after being found innocent, and whereas African Americans make up 35% of those being found innocent after being executed, and whereas African Americans make up over 80% of those awaiting execution on federal death row, and whereas 145 people have been exonerated based upon DNA evidence, and Whereas there is no possible way of restoring the life of an innocent person killed by the death penalty, and whereas the implementation of the death penalty raises concerns regarding bias identification, police and prosecutorial misconduct, judicial apathy in protecting the rights of the accused, faulty evidence, inadequate defense representation, coerced confessions and fabricated testimony, and, therefore be it resolved that the National Association for the Advancement of Colored People reiterates its strong opposition to the death penalty, and underscore 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 underscore. Text of NAACP resolution for a new trial for Mumia Abu-Jamal and a national death penalty moratorium, adopted at the NAACP National Convention, Philadelphia, Pennsylvania, July 15, 2004. Be it further resolved that the NAACP calls on its units throughout the United States and the world to support the international call for Mumia Abu-Jamal to be released from death row, and be it further resolved that the NAACP reiterate its support of the international movement for a new and fair trial for Mumia Abu-Jamal, and be it finally resolved that the NAACP renew its call for new nationwide studies on racial discrimination, the adequacy of counsel, access to modern research technologies such as DNA analysis, the sentencing of children and women to the death penalty, and that the NAACP reiterate its call for a national moratorium on all executions. Kwasi Mfume, President and CEO. Julian Bond, Chairman of the Board of Directors. 6.10. This is no victory, analysis of appeals court ruling on Mumia Abu-Jamal's case. Lynn Washington, Jr. 2008. The long-awaited ruling by the Third Circuit Court of Appeals in the Mumia Abu-Jamal case released on March 27, 2008, again displays the dismaying pattern of U.S. courts ignoring precedent to deny relief to this death row journalist whose plight generates international support. Precedent in American law means courts following previous court rulings when determining specific legal issues. Precedent is the bedrock of American law. American law requires courts to follow precedent unless significant evidence and/or compelling rationales necessitate changing precedent. This Third Circuit ruling changes precedent. This ruling changes precedent by applying legal procedures in a highly questionable manner to dismiss compelling evidence of injustice against Abu-Jamal. The Third Circuit did uphold the elimination of Abu-Jamal's death sentence. This is no victory because the ruling upheld his conviction, thus condemning Abu-Jamal to life in prison. This ruling refused to grant Abu-Jamal a new hearing or new trial on three compelling issues: prosecutors using racism to exclude African Americans from the jury during Abu-Jamal's 1982 trial, the prosecutor making improper comments to that 82 jury at the end of the trial, and pro-prosecution bias by the 82 trial judge during a 1995 appeals hearing. The Third Circuit previously granted relief to persons convicted of murder in Philadelphia after ruling that Philadelphia prosecutors had illegally excluded African Americans from juries. However, in this Abu-Jamal case ruling, the court found no fault in evidence of exclusion of African Americans from the jury in his 1982 trial. Curiously, the evidence of exclusion at Abu-Jamal's trial is of equal or greater magnitude than proof of exclusion previously found acceptable for relief by the Third Circuit. Underscore 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 underscore. This article was published on the website of the Philadelphia Independent Media Center, www.phillyimc.org, on March 29, 2008. These previous rulings on jury discrimination formed the precedent on that issue for the Third Circuit. That precedent stated it is wrong for prosecutors to discriminate against even one black potential juror. Additionally, that precedent stated defendants did not have to object to jury selection discrimination by prosecutors immediately when it occurred. Yet, this ruling reversed precedent on those 2 points of legal procedure. A week before this Abu-Jamal ruling, the U.S. Supreme Court granted relief to a death row inmate in Louisiana because of a discriminatory jury selection process. That Supreme Court ruling was written by a justice on that court who formerly served on the Third Circuit. That justice, Samuel Alito, had approved relief to Philadelphia murder defendants due to discriminatory jury selection practices by prosecutors. Alito, in a February 2005 Third Circuit ruling, stated prosecutors commit a violation by removing any black juror because of their race, a position similar to the position contained in that recent U.S. Supreme Court ruling he authored. Third Circuit ruling. The Third Circuit's ruling rested on a procedural finding by 2 of the 3 judges on this appeals court panel. This finding stated that lawyers for Abu Jamal during the 1982 trial and the 1995 appeal hearing failed to follow the procedures legally required to properly raise the issue of prosecutors improperly using racism during the jury selection process. The panel's majority asserted that Abu Jamal has forfeited his Batson claim by failing to make a timely objection to improper procedures by prosecutors, referencing the U.S. Supreme Court's 1986 Batson ruling that outlaws the exclusion of black jurors for reasons rooted in racism. Philadelphia area author and investigative reporter Dave Lindorff notes the absurdity of holding Abu Jamal's lawyer responsible for not strictly following procedures during the 1982 trial that the U.S. Supreme Court did not create until 4 years later in that 1986 Batson case. No lawyer in the United States could have predicted what procedure the U.S. Supreme Court would order 4 years in the future, observes Lindorff, author of the seminal 2003 book on the Abu Jamal case, Killing Time. In reaching this conclusion against Abu Jamal's jury discrimination claim, that Third Circuit panel's majority created a new standard for persons raising Batson claims in that court. This standard requires that a Batson violation claim must be raised at the time of jury selection, a contemporaneous objection. Interestingly, in reaching this conclusion of procedural errors by Abu Jamal's attorney, the panel's majority failed to note that this lawyer at 1982 trial was unfairly thrust into the jury selection process after that process was underway without the opportunity to do any preparation. The trial judge granted the prosecutor's request to remove Abu Jamal from selecting his own jury, a decision without merit that unfairly benefited the prosecutor and stripped Abu Jamal of his right to represent himself. Plus, this action aggravated tensions between Abu Jamal and his attorney. Further, the panel's majority faulted an Abu Jamal lawyer for not properly raising the jury selection racism issue during Abu Jamal's first appeal in the late 1980s to the Pennsylvania Supreme Court without acknowledging a major error committed by the lawyer who filed that appeal. That attorney prepared that appeal without ever reviewing the trial transcript. There is no way that attorney could have prepared a legally valid appeal without knowing what specifically had happened at trial. In creating this new standard, the panel's majority makes it harder to prove Batson violations. Plus, this standard changes that courts precedent on procedures needed to raise Batson claims. The judge who dissented from his 2 colleagues faulted them for creating this new standard, a standard not ordered by the U.S. Supreme Court. This case's newly created contemporaneous objection rule goes against the grain of our prior actions, as our court has addressed Batson challenges on the merits without requiring that an objection be made during jury selection in order to preserve future appellate review, the dissenter said. This judge, speaking specifically to changing precedent, said since Third Circuit precedent did not have a federal contemporaneous objection rule, I see no reason why we should not afford Abu Jamal the courtesy of our precedents. Additionally, this dissenter stated that jury discrimination practices displayed in a now infamous videotaped training session at the Philadelphia DA's office gave a view of the culture of that office during the 1980s when Abu Jamal was tried. This dissenter criticized his 2 colleagues for failing to make the obvious connection between the discrimination instruction given at the taped session and discriminatory practices used by Philadelphia prosecutors before, during and after the 1980s. Indeed, given that Abu Jamal's trial preceded Batson, it is not far-fetched to argue that the culture of discrimination was even worse, the dissenter declared. Previously, the Third Circuit ordered new federal trial court hearings to collect more evidence to enable full and fair determinations on jury discrimination claims. The Third Circuit's ruling rejected that procedure for Abu Jamal. Major flaws in court rulings. This practice of creating new court standards to only apply to Abu Jamal was criticized in an Amnesty International report of the Abu Jamal case controversy released in 2001. Amnesty International criticized the Pennsylvania Supreme Court for altering its prior rulings precedents to reach results against Abu Jamal. In 1986, for example, the Pennsylvania Supreme Court overturned a Philadelphia death sentence after ruling that a prosecutor named Joseph McGill made improper comments to the jury during a trial presided over by Judge Albert Sabo. McGill prosecuted Abu Jamal in a 1982 trial presided over by Judge Sabo. Abu Jamal's attorneys had alleged that McGill engaged in jury selection discrimination, a claim documented by evidence but a claim that the Third Circuit panel's majority rejected. Sabo's rulings during that 1982 trial aided this documentable discrimination. During Abu Jamal's 1982 trial, McGill made the same comments to the jury that the Pennsylvania High Court faulted in its 1986 ruling. But when the court upheld Abu Jamal's conviction in 1989, it refused to find any fault with McGill making the same comments it had faulted him for in its ruling 3 years before. Then, in 1990, the Pennsylvania Supreme Court reinstated its 1986 standard regarding prosecutors making improper comments like McGill made. The Pennsylvania Supreme Court's flip-flopping on this form of prosecutorial misconduct led Amnesty International to state in its 2001 report that, this contradictory series of precedents leaves the disturbing impression that the court invented a new standard of procedure to apply it to one case only, that of Mumia Abu Jamal. McGill's improper comments to the jury faulted by the Pennsylvania Supreme Court in 1986 were an appeal issue before the Third Circuit Court. That federal court panel found no fault in McGill's comments, denying Abu Jamal relief he should have received if those federal appeals judges fairly followed established law. The Third Circuit panel also rejected allegations that Judge Sabo was biased during a major 1995 appeals hearing. Sabo's biased antics during that 1995 proceeding were so outrageous this misconduct provoked strong, caustic criticisms from even Philadelphia's normally anti-Abu Jamal media. An August 1995 editorial in the Philadelphia Inquirer blasted Sabo's injudicious conduct that included verbally badgering Abu Jamal's attorneys and even briefly jailing one of those attorneys for objecting to one of his improper rulings. Scores of newspaper articles from the New York Times to the ultra-conservative Law and Order Washington Times reported on Sabo's pro-prosecution bias at that 95 appeal hearing. The Pennsylvania Supreme Court curtly dismissed this widespread journalistic criticism by contending that the view of a handful of journalists did not convince that court of Sabo's bias. 5 of the 7 Pennsylvania Supreme Court justices that upheld Abu Jamal's conviction in 1998 received campaign contributions from the lead group seeking Abu Jamal's execution, Philadelphia's police union, the Fraternal Order of Police. One of those 98 justices was the ex-DA of Philadelphia who as DA fought to execute Abu Jamal. The Third Circuit agreed with the Pennsylvania Supreme Court's 1998 ruling that no evidence exists showing a settled bias by Sabo against Abu Jamal. The Third Circuit panel made this assertion despite noting Sabo making a series of intemperate remarks against Abu Jamal and his defense attorneys during that 1995 appeal hearing. In another flip-flop ruling, the Pennsylvania Supreme Court in March 1988 found that a single statement uttered by the judge during the murder trial of a former Pennsylvania state trooper was extremely prejudicial to this trooper who killed a woman inside a judge's office. Where the Pennsylvania Supreme Court granted a new trial to that killer cop because of that judge's one improper comment, 1 year later the same court found no fault in numerous opinion-laden statements Judge Sabo made during the Abu Jamal trial. Sabo rejected requests to remove himself from hearing that 95 appeal made by Abu Jamal attorneys citing his pro-prosecution bias during the 1982 trial. News articles, editorials, and commentaries all faulted Sabo for not removing himself, stating his failure to recuse himself graphically displayed unfairness in a proceeding where fairness was desperately needed. Journalistic watchdogs normally hostile to Abu Jamal sought the face of fairness in that 95 proceeding both to follow established law and to quell critics claiming Sabo's unfairness against Abu Jamal undermined fairness. The federal panel's majority employed a legal procedure to sidestep Szabo's clear and illegal bias, an Achilles heel of that federal ruling and this entire case. It is incredible to contend that the widely condemned Judge Szabo, who presided during most trial court proceedings in Abu Jamal's case, did not violate any of Abu Jamal's rights at any time, despite his history of violating rights in this case and other cases. Judge Szabo handled 32 murder trials that ended in death sentences before his retirement. But 24 of those sentences in Szabo's courtroom had been vacated for errors as of June 2007, according to the American Civil Liberties Union. Some of those death sentences were reversed due to misconduct and/or mistakes by Szabo. Szabo had once ordered prosecutors to pursue a death penalty when the death penalty had been ruled illegal in Pennsylvania. Szabo's ordering that illegal procedure led to overturning that death sentence. What next? This March 2008 Third Circuit ruling leaves Abu Jamal with few legal options to challenge his conviction. Abu Jamal can appeal the panel's ruling to the entire Third Circuit Court, hoping for that full court to overturn the panel's ruling. Further, he can appeal any Third Circuit ruling to the U.S. Supreme Court. There is a slight prospect of new action in Pennsylvania state courts. The Third Circuit issued an order stating Abu Jamal will receive a life sentence unless Philadelphia prosecutors hold a new penalty phase hearing seeking to reinstate his death sentence within 6 months. This mini-trial style hearing would allow Abu Jamal to present evidence, including new evidence of innocence that has emerged like a flood since his first trial. But it is unclear if prosecutors will pursue this route that could create evidence and procedure that could secure a new round of federal appeals for Abu Jamal. Overlooked crux of the case. Sadly, the federal judges at the trial and appellate court levels, like judges in Pennsylvania state courts, have refused to uphold the most fundamental issue in the contentious Abu Jamal case, the right to a fair trial. Critics of Abu Jamal's conviction from Philadelphia's Francisville section to France all feel he was denied a fair trial. Police and prosecutors blatantly engaging in misconduct to secure a conviction destroys fair trial rights. A trial judge openly biased toward police and prosecutors destroys fair trial rights. Courts applying the law in the Abu Jamal case differently than they do in other cases destroys equal justice rights. The Pennsylvania Supreme Court declared in a 1959 ruling involving a Philadelphia murder case that every defendant is entitled to all the safeguards of a fair trial, even if evidence of guilt piles as high as Mt. Everest. Abu Jamal was 4 years old when the Pennsylvania Supreme Court issued that 1959 ruling against judges and prosecutors cutting corners during a trial. Abundant evidence documents that corners cut by the prosecutor and judge during Abu Jamal's trial and by judges during his appeals corrupted his rights to a fair trial and equal justice rights guaranteed by the U.S. Constitution. In June 2007, state courts in Pennsylvania overturned the 200th death penalty case since 1978 when that state reinstated executions, the ACLU stated. It is incredible to contend that 200 death penalty cases contained errors egregious enough to be vacated, but not a single element in the Abu Jamal case warrants either a new hearing or a new trial. Section 7. John Brown and beyond. In the heat of the work around Mumia Abu Jamal and the Puerto Rican political prisoners, resistance in Brooklyn felt it important to bring together as many activists in the white anti-racist left as possible, along with leading members of domestic national liberation movements. The occasion of the 200th birthday of radical abolitionist John Brown seemed an appropriate opportunity for such a gathering. With national leadership from the newly developing Jericho movement seeking amnesty for political prisoners, local co-sponsorship from City University of New York's People of Color-led Student Liberation Action Movement, and involvement of other white anti-racist activists in the planning, a major national John Brown 2000 conference was held at Hunter College on May 12 to 14, 2000. What follows are a short political recounting of John Brown's anti-slavery struggle, the transcript of a preparatory panel discussion held 6 months earlier, original writings by 21 political prisoners for the conference, and early Jericho resources, all of which were distributed at the event. Wrapping up the section is a recent interview with Dr. Barbara Zeller on the ongoing medical work to protect the health needs of political prisoners, so often purposely neglected by the jailers. 7.1. Who was John Brown? Terry Bisson 2000. One dark night in 1856 in Kansas Territory, in a remote area known as the Swamp of the Swan, 5 men appeared at the door of the leader of the pro-slaver border ruffians that were terrorizing the anti-slavery settlers. They beat on the door and awakened the man, in this case a federal judge. While his wife and children watched in horror, they led him into the night and killed him with swords. 4 other pro-slavery ringleaders were killed the same way that night in what radical black historian W.E.B. Du Bois called a bold act of terror that laid to rest forever the notion that only the slave owners would fight, and Kansas must fall to their will. John Brown, who led this midnight raid, is one of the most controversial figures in U.S. history. Born in 1800, he committed his life to destroying slavery. Brown believed that no one would be free until black people were free and wanted to see a society organized on a less selfish basis. Because he preferred action to words and fought against the slavocracy as well as U.S. federal troops, he was, and in some circles, still is, considered a fanatic. Yet, among black people and abolitionist whites, Brown was honored as a great warrior and anti-slavery hero. Much of Brown's early work against slavery was with black people. In 1851, he helped organize an armed self-defense group in Springfield, Massachusetts, in response to the 1850 Fugitive Slave Law. This law, which said that any alleged runaway slave could be seized and re-enslaved without trial or defense, extended the power of the slave owners and endangered all black people. Brown called his group the League of Gileadites and wrote their principles. Hold on to your weapons, and never be persuaded to leave them, part with them, or have them far from you. Stand by one another and by your friends, while a drop of blood remains, and be hanged if you must, but tell no tales out of school. Make no confession. Union is strength. In the 1850s there were 2 vital questions facing all people in the U.S., the political/economic conflict between the Southern slavocracy and Northern industrialists, and the future of 8 million enslaved Africans. The Southern planters were trying to expand the slave system into the newly conquered territories Texas and New Mexico, stolen from Mexico, and Arkansas, stolen from Native Americans. Northern capitalists and free labor were against this, not primarily because they believed in freedom for black people, but because they wanted to develop the land differently for the growth of industrial capitalism. In 1854, Congress passed the infamous Kansas-Nebraska Act. This strengthened the pro-slavery forces by revoking the Missouri Compromise of 1824, which had made Kansas a free state. The act included a plan for white popular sovereignty, which meant that the white people living in the territory would vote to decide its political and economic future. This wasn't democracy, it was a setup for war. Moving to Kansas became a partisan political act. In 1854, 5 of Brown's sons moved their families to Kansas to help claim the land for the anti-slavery settlers. At first they, like others, thought this could be accomplished through voting and negotiations. The Free State settlers, as they were known, were largely unprepared for the fight ahead of them. When elections were held in March 1854, thousands of pro-slavery residents of Missouri poured into Kansas and took control of the polls. A total of 831 legal voters cast ballots, but a total of 6,320 votes were counted. All the members of the legislature were pro-slavery, except 2. When the Free State settlers rejected the outcome of the bogus election, armed pro-slavery mobs came in to enforce order. Despite the readiness of the Missourians to use violence and ignore legality, the majority of anti-slavery settlers hesitated to go beyond peaceful appeals to Congress. John Brown, Jr., wrote to his father asking him to raise money for arms so that the settlers could defend themselves against the Missouri border ruffians, a Southern pro-slavery mercenary army, 3,000 strong, that raided across the border from Missouri to burn, pillage and terrorize anti-slavery settlements in Kansas. Brown's sons hoped he could win the support of the abolitionist movement in the North. In 1855, Brown went to the abolitionist Syracuse Convention to make a plea for money and arms. He told what his sons and other anti-slavery farmers were facing in Kansas. Writing home, Brown said of the convention, "I have met with a warm reception from all, so far as I know, and except by a few sincere, honest peace friends, a most hearty approval of my intentions of arming my sons and other friends in Kansas." Brown then decided to strike a blow for freedom and take the supplies to Kansas himself, disguised as a surveyor. This disguise enabled him to walk unnoticed through pro-slavery bands and overhear their conversations. The Free State movement that Brown found in Kansas reflected the same struggles and conflicts as the entire anti-slavery movement. There were those, like himself, who hated slavery and respected the humanity of black people. There were those who saw slavery as a competitive threat to free labor, but also were prejudiced against black people. There were those who believed that they could appeal to the Southern slave owners to change their ways, or thought that Congress would intervene if only petitioned urgently enough. These were precisely the issues that black people had been debating for 200 years. In 1829, David Walker's appeal attacked the economic system of slavery as the basis of white supremacy. Walker called for resistance and self-determination for black people. His fiery writings were smuggled into the South, causing slave owners to panic. "Our sufferings will come to an end in spite of all the Americans this side of eternity. Then we will want all the learning and talents among ourselves and perhaps more, to govern ourselves." In 1843, another black leader, Reverend Henry Highland Garnet, echoed Walker's call for rebellion. "Brethren, arise, arise. Strike for your lives and liberties. Now is the day and the hour. Let every slave throughout the land do this, and the days of slavery are numbered. You cannot be more oppressed than you have been, you cannot suffer greater cruelties than you have already. Rather die freemen than live to be slaves. Remember that you are 4 million. Brown was influenced by these and other black leaders who argued that freedom for black people demanded the complete destruction of the slave system. Further, Brown was committed to setting an example and creating an alternative for white people who did not want to be part of the slave system. Brown came to Kansas with the view that slavery itself was a state of war, and that slaveholders would never give up their slaves until they felt a big stick about their heads. On many issues, Brown found himself in disagreement with the other Kansas freemen settlers, and sometimes horrified by their racism. Yet because Brown was a serious political and military leader, they united in the goal of making Kansas a free state. Brown commanded defense patrols and was a respected member of the community. In December 1855, when a treaty was made between the government representatives of both sides, Brown publicly denounced it as a compromise with slavery. Though he initially won many supporters to this view, they were pacified by the politicians who made grand assurances that nothing had been conceded. However, when Brown saw that government troops were being put under the command of the slave supporters, and armed bands from the South were camped directly outside his own settlement, he began to move. Donning his old surveyor's disguise, he coolly walked into their camp and overheard their plans to whip, drive out or kill all the abolitionists. They named Brown and others as their targets. Brown warned his allies and they finally began to question their passive resistance. But it was too late for this battle. On May 21, the border ruffians burned the town of Lawrence to the ground. There was virtually no resistance or defense because the false hopes and pacifism of the settlers had left them unprepared. Brown knew that the time had come for decisive action, or the Free State forces would be wiped out and their movement destroyed. Gathering a small army, including 4 of his sons, he made a plan to bring the war home to the slave owners. In the words of W.E.B. Du Bois, the men condemned were among the worst of their kind. One was a liquor dealer in whose disreputable dive the U.S. court was held. His brother, a giant of 6 feet 4, was a thief and a bully whose pastime was insulting Free State women. The third was the postmaster, who managed to avoid direct complicity in the crime, but shared the spoils. Next came the probate judge who harried the Free State men with warrants of all sorts, and lastly, 3 miserable drunken fools, formerly slave chasers, who had come to Kansas with their bloodhounds and were ready for any kind of evil. Brown's band left late in the night. They visited each man at his home and, knocking on the door, roused him from bed. 5 pro-slavery terrorists were brought to the woods, shot, and stabbed with broadswords that night. The Potawatomi murders, as they were called, ended the uneasy peace and influenced the entire country. No longer was there even discussion of winning a vote. The question of slavery was going to be settled on the battlefield. Some Free State people condemned the executions and loudly disassociated themselves from them. Others switched sides. Others took up arms and joined John Brown. Kansas was plunged into civil war. The war spread, creating clear terms for white people to participate in the struggle against slavery. In Missouri, the homeland of the slave owners, the slaves staged an insurrection armed with scythes and other farm tools. Though Brown never claimed the Potawatomi slayings, he became a hunted fugitive. He took 35 followers deep into the woods to train for war. As the pro-slavery forces mobilized, the Free State towns began to ask Brown's guerrillas to defend them. He refused to do this without their own active participation in fighting slavery. "I am not willing to sacrifice my men without having some hope of accomplishing something." Brown became a legend as he appeared here and there, striking, then swiftly retreating. By August 1856, the Free State forces were clearly winning. The slave staters gathered their forces for a massive attack on the town of Osawatomie in an effort to turn the tide. Though newspaper reports of the Battle of Osawatomie on August 30 put the numbers at 250 slavers to 200 abolitionists, the truth was that Brown, leading no more than 30 fighters, was able to fight off 400 enemy troops and kill or wound 70 of them. 5 Free State men were lost, including Frederick Brown, and John Brown was injured, but all agreed it had been a decisive battle. A rumor was spread that Brown had been killed, but when he emerged very much alive, he became known as Osawatomie Brown. In September, John Brown left Kansas to begin work on a new idea he was developing. He began to meet with some of the most prominent abolitionists of the day, Thomas Wentworth Higginson, Samuel Gridley Howe, Theodore Parker, Franklin B. Sanborn, Gerrit Smith, and George L. Stearns, who became known as the Secret Six for their clandestine financial support of Brown. He traveled extensively to speak to abolitionist groups, black and white, about his plan to strike slavery a death blow. His plan was to seize an arsenal and to arm the slaves throughout the mountains of the South. He hoped a successful slave insurrection would destroy the slave system and lead to the establishment of an independent black state. He even had the target picked out, a small town in Virginia where the Shenandoah and Potomac rivers cut through the Blue Ridge Mountains. It was called Harper's Ferry. A long continuous mountain range from 2,000 to 5,000 feet high, running south and west from Pennsylvania to Tennessee, the Blue Ridge is aimed like a spear into the heart of the South. The town of Harper's Ferry is situated inside the point of a V where the Potomac and Shenandoah rivers join and then plunge through the mountains, which are here about 1,800 feet in elevation and, as everywhere, rocky, steep and thickly wooded. In 1859 there was a railroad bridge connecting the town to the Maryland shore, and a rifle factory and a federal arsenal in the town. John Brown came to Harper's Ferry fresh from his victories in Kansas, a controversial figure widely known as Osawatomie Brown, already a wanted man by the federal government and a hero to abolitionists who funded and sheltered him, and respected even by those who didn't agree with his conviction that only armed struggle could defeat the slave system. Brown's plan in the raid on Harper's Ferry was to launch a guerrilla force which would move along the Blue Ridge, using the mountains as a base of operations to strike at slave owners and draw off slaves. Harper's Ferry was chosen because of its strategic position at a mountain gap, because Brown hoped to deny the Hall's federal rifles to the slave catchers and local militias, and because he hoped that a lightning attack on a federal position in the South would heighten the anti-slavery debate already raging in the U.S. government. His friend Frederick Douglass had urged him to gather his force and slip into the mountains, but Brown had political as well as military goals, and he wanted to start things off with a bang, knowing that a daring raid would embolden the slaves, inspire the abolitionist movement in spite of itself, and strike terror into the hearts of the slave holders. The raid was not aimed, as some historians have mistakenly claimed, to get rifles. Brown's abolitionist fighters were already equipped with the most sophisticated weapons of the day, the breech-loading Sharps carbine. These rifles, brought from Kansas, were faster firing and more accurate than the weapons used by federal troops, and far outgunned the musket-carrying local Virginia militias. Ironically, the Sharps, which was to help make possible the genocide of the Plains Indians, was first used as a weapon of liberation. Brown's force also had 10,000 pikes, for they knew that most slaves had been prevented from knowing how to use rifles. On the night of October 17, 1859, after months of preparation and training in which two of his daughters played a major role, gathering and hiding the men and weapons, a column of 20 men marched into town, their carbines hidden under their long coats. Their captain wore a lucky hat given to him by an Indian friend in Kansas. Taking the town with little bloodshed, the abolitionists seized hostages such as the grandson of George Washington, a local slave owner, and forced him to turn over the sword presented to Washington by Frederick the Great to one of the black freedom fighters. Brown took other prominent hostages, hoping to use them to bargain with the governor of Virginia and the federal authorities. His mistake was he put far too much emphasis on these propaganda moves and lost sight of the military objectives. The hostages, in particular, kept his force pinned down long after his men had urged him to pull out. Out of concern for the hostages' safety, faced with the drunken trigger-happy Virginia militia sniping from barrooms and rooftops, he missed his chance to shoot his way out and get his men up the mountain. Meanwhile, the federal forces gathered Marines led by a U.S. officer named Robert E. Lee, later to become commander of the Confederate Army. His second in command was a young officer later to be known as Stonewall Jackson. Brown's most trusted lieutenants, John Kagi and Aaron Stevens, both seasoned Kansas fighters, urged him to pull out. But their captain hesitated. Why didn't Brown strike and withdraw as planned? His hostages were distinguished white slave owners, and Brown treated them politely and tried to justify his actions to them. He mistakenly came to think he could use them to bargain his way out of town. Because of the white supremacy in him, as in all white people, even the most anti-racist, he wavered between the war that would arm the slaves and the vain hope that he could negotiate peacefully with the slave owners' government. In the end, he put more value on his hostages than on his objective or the lives of his men. It was his fatal error, and his defeat is still felt today. It is often said that even in death John Brown was victorious, and it's true that he and his men inspired millions. The black Union troops used John Brown's body as a marching song 5 years later. Yet history would look different if he had succeeded. Even a small army of abolitionists and freed slaves, in those days before the helicopter, would have been untouchable in the laurel thickets of the southern Appalachians. Others might have sprung up, arming the black masses the U.S. was afraid to arm, hastening the beginning of the Civil War, hurrying its end, and ultimately saving thousands of lives. And a war fought on abolitionist terms, with black liberation the explicit aim, would have changed the balance of power after the war. John Brown went into battle with a constitution drawn up by black abolitionists calling for a free state for black people. Instead, the war was fought to unify the white nation rather than free the black nation. Black soldiers were disarmed after the war, the Klan rode, and slavery was exchanged for the new domination of Jim Crow, sharecropping, and segregation. John Brown hesitated too long. The Marines attacked, and after a fierce fight the abolitionists were killed or captured. After a spectacular show trial, which gained worldwide attention, all were sentenced to hang for treason. Robert E. Lee, who 2 years later led a much larger army against the U.S., is of course still honored for his treason. The fighters. Most of Brown's men were in their 20s, 15 white and 5 black freedom fighters. They were not zealots or religious fanatics as many historians pretend. They were revolutionaries, almost to a man conscious and proud participants in the worldwide struggle for freedom that was shaking the old order of Europe, Latin America, and the Caribbean as well as the US. In Europe, their counterparts fought with Garibaldi or manned the barricades of revolutionary Paris. In America, the fight was against slavery. Most, including Brown's own sons, were freethinkers, not fundamentalists. Their captain read them the Bible, but they quoted him back Tom Paine, David Walker, and Victor Hugo. Among the black fighters, Leary and Copeland, educated young craftsmen from Ohio, had fought bounty hunters and U.S. Marshals to defend escaped slaves. Dangerfield Newby and Shields Green had worked with Frederick Douglass and left him to join Brown. Osborne Anderson, who escaped and wrote the best account of the raid, was a black intellectual. He was offered a leadership position but turned it down in favor of Kagi and Stevens, who were more experienced. Harriet Tubman was supposed to be Brown's second in command, but she got sick at the last minute. Among the whites, Aaron Stevens was a former U.S. Army officer who had been imprisoned for defending an enlisted man from a beating. Escaping, he had lived several years with the Delaware Indians. Will Lehman was a wild, reckless factory worker. The Coppock brothers were Quaker idealists. Brown's own sons were veterans of Kansas. These men followed Captain Brown because of his proven ability as a military leader. After Kansas, it was widely believed that if anyone in the U.S. had the ability and the will to strike at slavery successfully, it was Osawatomie Brown. Today these men are maligned as fanatics or, at best, misguided idealists. What a lie! They were revolutionaries, the fighting youth of a revolutionary age, among the best their day had to offer. The response: their raid electrified the country as few acts before or since. John Brown and his men were seen as martyrs for freedom, or traitors to the human race. Among abolitionists, the reaction was split between those who stood fast in support and those who fled or shut up. For the most part, the split broke down along national and racial lines. Black people liked and understood John Brown and his men. White people had problems supporting them. In the first weeks after Harper's Ferry, the Abolitionist Liberator, a white-owned reformist newspaper, called the raid misguided, wild and apparently insane, though disinterested and well-intended. They did admit that Brown had struck terror into all Virginia. The racism of this white-centered view was coolly exposed in the leading black paper, the Weekly Anglo-African. John Brown did not frighten all Virginia. There were in that state some 500,000 of slaves, and we have no reports that they were terrified. Radical black ministers such as Henry Highland Garnet spoke out immediately. Garnet told his congregation that anyone who could not support the captured raiders had better keep still. Others were apparently more timid. An open letter to black ministers from New Haven reminded, "You are expected to do your duty in pressing this matter home to the hearts and consciences of our people. Do not let us hear any uncertain sound from you on this point." The highest form of support was, of course, a rescue attempt, and this was actually planned. Blueprints of the jail were printed in northern newspapers to encourage the idea. A spy was sent to Virginia as part of Brown's legal team. An armed force was gathered, including 100 European socialists, exiled veterans of the 1848 revolutions. But Brown knew how closely he and his men were guarded and discouraged the plan. Another form of material support was raising money for the widows and orphans of the fallen fighters. Black women led this work, and thousands of dollars were raised at church suppers and socials around the country. White people also contributed. A white man named Hyatt raised $6,150 in 6 months selling photographs of old Captain John Brown. He explained his work, saying, "It places in the hands of every contributor a likeness of one of the great men of the world, the man of the 19th century. Secondly, the family of the noble old man beyond the place of want, so that the icy finger of tyranny may point at them in vain." Hyatt was also a grand jury resister of his day, spending a year in prison for refusing to cooperate with a Senate committee investigation into Harper's Ferry. At first the Brown family received almost all the relief funds, but this was criticized by the weekly Anglo-African, and funds were distributed to the families of the black fighters and others as well. 10 years after the raid, supporters were financing Leary's daughter's education at a private school. December 2, 1859, the day John Brown was hanged, was called Martyrs' Day, and ceremonies were held in 12 cities and Canada. Black people were the main organizers, businesses were closed and black armbands were worn in mourning. At Yale, students broke into the chapel and draped it in black, too late for school officials to remove it before Saturday service. In Albany, New York, thousands gathered and a 4-minute ovation greeted the declaration that in a just society the Virginia governor, and not John Brown, would hang. In Detroit the church bells tolled all day. The day was also observed by the slaves. In Virginia 3 plantations were torched, and 3 of the jurors that found Brown guilty were poisoned. 2,000 troops surrounded the scaffolds as the abolitionists were hung. The only voice to break the silence was that of an old black woman, the only civilian allowed within miles, perhaps unnoticed because she was so old. "God bless you, old man," she shouted defiantly. "If I could help you, I would."